Yes. So, welcome to CA Foundation Business Laws Marathon. So, I'll keep it as marathon. I'll be trying to cover almost every topic in your laws, almost everything. If at all there is anything which I only feel it's complicated, I'll be explaining it like a regular class only. It might not even be like marathon. Let's try to keep it in marathon hours, but yes, we'll be trying to touch almost every topic. Meanwhile, from you guys, if you guys have any questions anywhere, I'll try to take up as many questions as possible. Even if I'm not able to solve it, we can even solve it post the class hours also. That's okay. Yes. And the scope of marathon, I'll be doing every chapter and if possible, now say for example, if we can finish Indian Contract Act or if we can finish Indian Contract Act and Sale of Goods Act, we'll try to take up a paper. Let us try to take up past papers. Let us try to solve the questions from those particular things. So you guys will have a clear idea of what your institute is expecting out of you versus where do we stand. And from my end, I'll try to give you got the sections thing. Okay, so I'll give you what is it? Probably a chart sort of thing which has important sections in it. You guys can have it for your reference. It'll have more weightage when you guys write your exams. Try to quote sections wherever possible because we will not be able to remember everything. That is for sure. So I'll try to give that as well. Probably by the end of the day, I'll try to forward it to you. That's one thing. And I'll be using one chart book in the class. We are so sorry. With heavy heart, I'm saying it will not be available for me to share it to you as a soft copy because of intellectual property issues. We have seen in the past that people just take up this material and we have seen them teach from these materials. We stopped circulating these particular things from then on. But if you still want it, I would suggest still don't go for it. When your exams are nearing, go with the materials you guys have been following till now. But if you still want it, you guys can place an order on ArivuPro website itself. You will get a hard copy. Soft copy is no longer being forwarded. Clear all of you? I recorded this is especially for you. ಅಲ್ಲಿ ಆ ಕಮೆಂಟ್ ಸೆಕ್ಷನ್ ಅಲ್ಲಿ ಹಂಗೆ ಯು ಗೈಸ್ ವಿಲ್ ಸಾರ್ ದಿಸ್ ಮೆಟೀರಿಯಲ್ that now don't even get into any new material. Whatever you guys have been following, it's a good material. Whichever you guys follow, because no one will give you a half and half material. So whatever you guys have been following is a very good material. So go ahead with that. You guys will be definitely able to achieve it. Clear? And before I start, I'll also tell you what are the chapters you guys have to maximum focus on. Try to have your utmost attention towards these chapters. You know the main one. Which one is the main one? Indian Contract Act plays your major role. That will have at least 30% weightage of your marks. So make sure you guys are thorough with everything in Indian Contract Act. It is required. And next becomes Sale of Goods Act, equally important from your exam point of view. Next comes your Companies Act, equally important. Even though it's a one chapter, a standalone chapter, you guys can expect at least 2 questions to come from Companies Act. So again, equally important. And then you can go with Indian Partnership, and then with LLP, and then with Negotiable Instrument. LLP is one chapter where you guys can, it is like playing goalie. 10 papers, 1 question, pakka. You shouldn't leave LLP at all. Because there will be 1 question for sure asked. And there is no rocket science in LLP. That's the most easiest chapter you guys can, master in. So, if there is one chapter you guys are trying to focus your maximum attention towards, that will be LLP. Are you getting it? Hello? Yes? Okay. So, can we write provisions in exams from the chart book? See, chart books will be a summary. I hope all of you are writing this May attempt. Yes. May attempt, all of you are writing May attempt. Okay, see, if you guys have not yet started preparing at all, anyone of that sort, we have come here and this is what is our first preparation. Anyone? You guys have studied something before? You guys can be vocal, absolutely be vocal. I'll understand whether you guys are understanding or not. So, if you guys are thinking on, this is what is my first thing. From here I'm starting on. I'm not yet prepared. If you don't have any other choice, then rely upon a chart book. If no, just a chart book would never be sufficient. Yes, but yes, if you're a college going person, you have multiple things to manage, then you can rely upon the chart books. Clear? Okay. Very quick question. I mean, if you are uncomfortable, you cannot share it. It's absolutely fine. Has anyone given an attempt specifically with regards to law, and what went wrong with you? You guys can share so that I'll try to focus those points more. First of all, you tell me which subject went wrong. Also, you can tell me, and what could be worked on. We'll try to figure it out. Huh? How? What?
In January 10th, I lost 36.
Law 36. Other?
All
All passed. Okay. Huh?
now is 26.
Others passed. Law is 26. Huh? Law 33. Others passed. Huh?
Law 34.
Law 34. Others passed. Account certified. Then I don't. We have a problem. Okay. We have a friend. Okay. Huh? Law. Huh? Law 30. Others passed. Okay. Huh?
Law 30.
Law 32. Others passed. Okay. Wonderful. Huh? Anything. So, first thing before I go forward, we have 7, 8 people. Why I'm saying that is, try to remember the biggest mistake where we go, or where or what we do in law. The biggest mistake. See, I'll try to explain you the concepts. Trust me, you guys know the concepts. You know it. But the problem is, you do not know how to apply those concepts. The biggest problem in law is, when you guys speak to me, you guys will know the example we have given in the class. With the same example, if I give you one more story, you will not be able to relate. So always remember, when I am explaining you one story, that is an example I am giving you to explain one concept. Your analytical skill has to come in and say, okay, there is a similar scenario. We had already discussed this in the class. If we put the same scenario here, we will get the result. But the problem that happens with regards to law is that we will just stick on to the examples that will never go until the concept. If I ask the same example to you, you will be able to tell the answer. If I ask a similar case, you will not be able to analyze it. Now, we have two things. One, if it's from day one, I would say go back, read everything again from scratch, read all the examples. Do not just rely upon the book. You guys have to rely upon the PDF. That is a main material, not the chart book. I'll say go word by word, practice everything, and I would have said. Now for you guys, how many days are there for your exam? 30 days. Make sure every day, irrespective of which subject you guys are studying, one question, any random question, take it from your ICI, past papers, take that paper, take one question, write it. From today, make it a habit. It will work out for you. So at the end of your exam, you should be able to write at least 25 questions on your own. If you are going wrong, if your pen is getting stuck there, that means fundamentally something is wrong. I'm saying you guys have to figure it out not in the exam hall, you have to figure it out in the process you are doing it. Are you getting it? So from today, make it a habit until your day of your exam. Start writing at least one question. Now if you guys can write 2 in a day, it's nothing like that. That's the first thing. Second thing, don't be vague in your answers. What do you mean by vague? When you only read it, you will be able to understand I did not answer the exact provision. I wrote what I think is right. That's not the answer, right? What you think is never the answer. Now the problem is, how do we know that, see, first thing you will be able to read the entire provisions. You have it in your mind. The biggest problem, the toughest problem is to know which provision to apply to which question. Today we will try to also decode a question. When we will take up a random paper, we will see how to read a question so that you will understand which provision I have to apply here. So the biggest problem again I have seen in my experience is that people fail to read or people fail to interpret how the question needs to be read. You do not know where to start. You will read a complete question. You will not know which topic they're asking the question from. I'm saying these are all the places where people will go wrong. Try to rectify it. Third thing, people, you have to write 100 marks. Now, if I ask people, whoever have written, what is the number of marks you guys were able to attempt in the exam? 60, 80. Can I say average of 75? Now, when you have written the exam for 75, how can you expect your marks to be on 100? When you have written only 75. So, what you got, 30 to 35, you have technically got 50% of what you have written. Unlike other papers, you will be able to complete the paper. Law, remember, it will be the toughest challenge. You will not be able to complete the paper. Complete in the sense, the paper will be voluminous. It will be huge. There will be a lot to write. Our hand has to be used to it. So what I'm saying, never take any exam. I don't know if you guys wrote those midterms. You guys wrote anyone? There was this midterm thing that was conducted. The whole purpose of it was that the exam hall should not be your first place to take up the 100 marks. You need to be used to writing that so that your pen doesn't stop in the exam hall. So the third thing you all have to work towards is to write towards 100 marks. Your attempt has to be 100 marks. See, I'm saying 100, but if it is anywhere between 90, 95, it is very good. You have to at least attempt it, right? Now, when I say I've written for 90, I might end up in 50, 60. That is possible. When I've written 70, when I've written 80, how do I expect 60 to come? These are all the fundamental mistakes people have been doing. Do not do it. Be conscious from minute one. Have a clock. Keep a watch. For every hour, you have to complete at least 30 marks. See, I cannot divide 100 divided by 3. You have to write 34 marks every hour. I can't say that. It's okay anywhere if you are between 26 to 30 marks. After the end of first hour, you are still safe. Because in the last 1 hour, your hands are so much accustomed, you guys can write 40 marks. In the last 1 hour, you can write 60 also, but 40 will be sensible. That rest 20 you also don't understand, they will also not understand. You only know that. You'll write our charitra and all you'll write. Yes or no? So remember, your target is to be anywhere between 26 to 30 in the first hour. Second hour, again same thing. Try to touch 60. In the last hour, you will be able to manage 40. Yes or no? No. So try to do these so that you guys will be able to work around with that. Clear all of you? Yes. So with that, let's start your marathon. And all the bars agreed, but all the provisions were right except 3 questions. I have checked with the analyst video. Okay. Yes, very unfortunate. We do not have revaluation. We have only recounting. So I know we have all had our own stories. Let us put a pause for that. Let us try to open a fresh page. So hopefully that this attempt will be yours. So yes or no? This attempt will be yours, no? You all will pass, no? Yes or no? So page will only write down how much you guys are expecting. In law, how much are you expecting? Pass, sir. Are you on? Sir, pass out, sir. I'll somehow manage of the rest of the things. Yes. So do not give up. Every day is a new day. Your past attempt should not or never influence your second attempt or third attempt. It's absolutely fine. Do not get demotivated and all. Attempts never matter in real life. As long as you reach or you finish the race, that's more than sufficient. So just be confident. Don't feel nervous. Don't feel anxious. It's absolutely fine. Yes, this is just an exam. One of the exam in your life. This does not define who you are. So don't take it too personally. Don't feel anxious. Not required for your age. It's okay. It's just one exam in your life. Take it with light heart. Manage it with confidence. Success will be yours. Yes? Okay. So let's start the okay, let's start with the first chapter. Screen is not visible. Avaginda idira. Now you guys are telling. Why do you do this? Hello. The screen is not visible in the TV. Downstairs. Yes. Now visible? Yes, yes. Okay, okay. Thank you. Thank you. Yes, people. Indian regulatory framework. Let's start from here. Yes. Okay. The first chapter, Indian regulatory framework. So in this you will be seeing more on the three organs of the government. What are the three organs of the government? We call them as legislature, executive, judiciary. What is the job of legislature? To make the laws. How do they make the laws? Who select the legislature? It is us, the public, who select it. We participate in elections. You guys will nominate your ministers. They will go and sit in the parliament. They will debate over a subject matter. Now let us imagine if we want to make a law for GST. There will be a committee that will be formed. They will say this country needs a act on GST. Can we do something there? A three people committee will be formed. The three people committee will do their research. They will come up with something called as a draft. It's called as a draft bill. So the three people will come with the draft. Now the draft will be given to the parliament. Now the draft has to be agreed by Lok Sabha and Rajya Sabha, lower house as well as upper house of the parliament. Once the bill, the draft bill is agreed in both the houses of parliament, it next goes to President of India. The President of India will sign it. Once the President of India signs it, it will be published for the public to know that this law is official from today. And that is only called as official gazette notification. Official gazette means nothing but it's an official publication of the country. You should not believe until something is published in the official gazette. You should not believe if an uncle or auntie forwards from today this law is official in WhatsApp. It's not official until something comes in official gazette notification. So official gazette of India, once a law is published there, the law is final. And this is the process of law. You can expect one question here. What is that? It's called process of making law. What is the process of making law? You will always form a specialized committee. They will come up with a draft bill. The bill will be submitted first in Lok Sabha and then it will go to Rajya Sabha. It will be next agreed by President of India, official gazette of India. Agreed? Yes. Now how do we know? Now we have so many laws in India, right? There are so many laws. Close to 3,000 odd laws we have in India. Now we have some laws which is applicable to the entire country. We have some laws which is applicable to only the state. We have some laws which is applicable to both state and center, meaning both of them have a right. And how do we know who can make a law where? So remember, the law making power has been distributed by the center only, in constitution only. This is only called as what people? Union list, state list and concurrent list. What is this? Constitution of India itself has clearly made a distinction between who can make a law where. Now we have clearly given items where only central government can make law, center can make law. So example of that is finance. Now how much tax you need to pay? Does your state governments determine it? No. Once in a year, in the month of Feb, one lady comes and decides the entire country. Whether the country should be peaceful. Hey, illa edit. Illa. Okay. So one lady is deciding everything, right? No? Okay, at least one lady is expressing it. Ah, yes, sir. That's the right way. Now, people, you call it as a budget. Now, whatever is set in the center, it is applicable to the entire country. Now, you call it as union list. A state government cannot make a law there because Constitution of India has said that belongs to the central government. It's with the central government. You do not have power to poke your nose. Who cannot poke its nose? State government cannot poke their nose. Now state government will come and say, then what are we? What should we do? Our people have nominated us also. State assemblies, your state legislature, you have appointed them also. Your Vidhan Sabha, Vidhan Parishad, what are they doing then? They will also make law, but not for the entire country, which is applicable for your state. They are making their laws. Example, people, agriculture. Agriculture falls in your each state. The law will be different. And the state legislature will make a law which is applicable only for that particular state. Now, center will not come and poke its nose there. Are you getting the point? So that is called as what? It is called as state list. The third thing is called as people concurrent list. That is only called as what? People. Education. Example. State also will make a law. Center also will make a law. Best example. Education. You guys have state syllabus. You guys have central syllabus. State decided by state. Center decided by center. Center. I don't know if anyone in government employees, part and parcel, transfer. My father is central government employee only. This and all is normal. 1 year they will be in this state, next year they will be in another state. Don't you think if I am under state syllabus, it will be extremely difficult for me to cope up with the syllabus? With that intention, central syllabus came into picture. There are people who are going around the country. How do you keep up with your education? We have something called as uniform syllabus throughout the country. That is only called as central syllabus. Next one is state. Varies with every state. Are you getting the point? Now both of them can make a law here. Now this is how the law making power has been distributed amongst state and center. Any doubts here? This clear? Okay, wonderful. Next one is people, executive. What is executive? Law is implemented by them. What do you mean by that? Now, for example, a law is made. Is it mandatory that you guys will follow it? Now, you should not drive without DL, driving license. But all of you have a DL? No, sir. But you all drive? Yes, sir. Ayo, 3-4 people. At times, we will not know if a bike or auto rickshaw, share auto. We take so many people with us. Why? I understand you're saving fuel, being economical, friendly. Chetty buddy and all, I understand all that. Now people, what we are trying to tell is here, executive is nothing but a person stands there and says, what you are doing is wrong. Who is that person? If that person is not there, you guys will not follow the law itself. Yes or no? If that person is standing, imagine this is the road. If the person is standing here, this lane no one will use. Everyone will be going here only. Who is this person? Police mamana. Police inspector. Police officer. When this person is standing here, irony of the country, we should feel confident when they are standing. But we feel scared. You guys will not use that lane at all. You all will go like this. Yes or no? This person is what? What is his role? Executive. Collectors, what do they do? Executive. They implement collector. I'm speaking about collector officer. Yes. So, what is their role? Their role is to implement the law. They make sure that you guys are following the law. If not, there will be punishments, investigations. They will arrest you. Now, what is the first thing, people? When a police arrests you, what is the first thing you will say? Anna, gotte. I didn't know, Anna, please. Correct? One way. They will catch you. What is the first thing you will say? Sir, I didn't know, sir. I didn't know it was a one way. Agreed? But what you did is a mistake. Yes or no? But should we leave you people? Should the police officer leave you? Imagine you never knew this was a one way. You came in the road. Should the police officer leave you? No? Yes or no? But let us imagine you genuinely didn't know that it was a one way. You did not know. Mistake of law, Indian Contract Act. You have two mistakes. One is mistake of fact, mistake of law. If at all you do not know your country's law, it is your mistake. Country's law won't change. Are you getting it? Yes. So mistake of law comes there. So will you be excused? The answer is no. Why? We have an executive authority here. In your book, we have some examples of executives. Who are the executives we have done in our book? What is Ministry of Finance? They might ask you one body. They can ask you. They can ask you to write about this body. I'll also try to tell you which specifically has more weightage. What is Ministry of Finance? It's an authority which governs your taxation, budget, RBI, securities market, your SEBI, stock exchange. Everything comes under Ministry of Finance only. I hope you guys know what is ministry. What do you mean ministry? Ministry means what? Ministry means people. Let us imagine. We told that we'll be doing CA Foundation Marathon. Who took your first subject? Now Nitin sir only can handle all the subjects, right? Now I'm coming. I can only handle all the subjects, right? Why don't we do? Oh, you illa sir. How can you handle? Yeah, you don't know. Yeah, sir, you can't. You demotivating fellow. Yes, people. So now why can't I only come and handle? Can I say that it is to make sure that that particular purpose is served better? We divide the work. We divide whatever we are doing. In the same way, you have nominated one person in the center. That person is called President of India. It's like a king. Now the king cannot know what is happening. You go back to your history. Same way, your kingdom. There was a king. There was ministers who was taking care of every department. Today we have ministers who is taking care of every department. So one person cannot handle everything in the country. What has that person did? What has that person done? That person has created ministries, nothing but departments for every specific thing. Ministry of Education, Ministry of Tourism, Ministry of Corporate Affairs, Ministry of Finance. It's like a company where there are so many departments. They meet, they get to know what is happening in each of the department. That is the meaning of ministry. Ministry means nothing but a specific department created by the center, so that the job is being handled in a proper way. Getting the point? So under Ministry of Finance, who and all will come? RBI, the best example. Finance only, no? And who else will come? SEBI will come. Stock Exchange, Ministry of Finance only, no? IBBI, the IBBI is IBBI will come under Ministry of Finance and Ministry of Corporate Affairs. I don't know, I'm asking question only. Ministry of Finance only or Ministry of Corporate Affairs? What is MCA? What is Ministry of Corporate Affairs?
Ministry of Corporate Affairs, because of they take companies and
So IBBA, where does it come?
MCS.
MCA, So remember, MCA takes care of all of these bodies. That is your Companies Act. It takes care of Insolvency Bankruptcy Code. It takes care of LLP Act. All this comes under Ministry of Corporate Affairs. Yes? Okay. And remember, they can ask you specific questions with regards to MCA. What is MCA? In the same way, however we have Ministry of Finance, we have Ministry of Corporate Affairs. Another ministry. But jackpot is, the minister is same. Who is the minister? Nirmala Sitharaman only. The person who is taking care of Ministry of Finance also same. Ministry of Corporate Affairs also is same. So you can imagine like this. There is one person. Under this person there are lot of ministries. Now in this ministry, I am telling Ministry of Finance. Under this a lot of things will come. Ministry of Corporate Affairs, MCA. What and all they will take care of? They will take care of your Companies Act 2013. They will only take care of your LLP Act 2008. They will take care of your IBCA 2016. All of this are coming under this particular ministry. Remember, you can expect a question directly in any of one executive. The questions on judiciary, the questions on the source of law, how a law is made, it has been exhausted. They have asked enough number of times. You can expect a direct question on what is SEBI, what is IDBI. You will get pakka one question. Getting it? Market Ratamar, meaning by heart. Understood? Okay. Next, who else do we have? We have Ministry of Home Affairs, basically who takes care of border management, internal security. All of this will come under Ministry of Home Affairs. Next one is Ministry of Law and Justice. If you guys fight against your government, someone should fight a case for the government. No. Who will fight? It will come under Ministry of Law and Justice. SEBI. What is SEBI? Securities Exchange Board of India, a capital market regulator of the country who works under Ministry of Finance. Now remember, this is what I tell you. This is where you go wrong. Now when I said what is that process of making law, have circled some words. In your exam, this only I call it as keywords. Unless the keywords are there, you will never get a mark. Hello? What do you mean by keyword? Sir, I'll say ministers will come, they will accept in the parliament, or they will accept in one place. That one place, you need not write the stories at all. If you have these words in your answer, what you write before that word or after the word is absolutely your discretion. But that word is keyword. If you have the keyword, you will get the marks. If you don't have keyword, you will not get the marks. That's how law paper is defined. Are you getting it? Yes? Okay. Next one, what else we have? RBI. What is RBI? Central Bank of the country, which takes care of banking regulation in the country. The banks are accustomed and function under RBI. Even this also comes under Ministry of Finance, Government of India. And they also takes care of what? Printing, Mudrana. Yes? Yes. Next one, sir. This one you guys can have a question. Deposit Insurance and Credit Guarantee Corporation. What is this? DICGC. What is it? It's a subsidiary of RBI. What is DICGC? It's nothing but today I've done a FD in with some bank. What if the bank shuts down? What will happen to my money? It's a mandatory that they have to take an insurance on all your FDs, RDs, savings bank account. If at all the bank fails, this particular company will give you the money back up to one limit. Today the limit is 5 lakh rupees. You will get your money back. It acts as an insurance company on your FDs and RDs. Tomorrow if a bank fails, they will give that money to you. Even that works under RBI. Are you getting the point? Understood all of you? Okay. Next one is Insolvency and Bankruptcy Board of India, IDBI. What is IDBI? IDBI takes care of tomorrow if at all a person wants to recover money from some company. I've given a credit, a loan. The company has not repaid. Now what is my right? If a company has not repaid my loan, what is my right? I will go and file a case on this company to recover my money. Now we have a option, people. We will ask one question. Sir, are you able to recover the money? The company, are you able to repay the money or do you need time? If you need time, the court will give you time. Provided you need to pay with interest. Sir, even if you give time, we will not be able to pay. What do we do? That time, people, so remember, we have an act only. That act is called as Insolvency Bankruptcy Code. As per that act, there are two things that happens in the act. What is that? Imagine a patient comes to the hospital in a critical condition. What is the first thing we try to do? As a doctor, they take this, adeno anta gottilla, iron box. CPR. Sir, CTR, those are there. What is CPR? Shock will happen, no? That's the first step in this act. They will take this, they will try to treat the company. Will you get up? You will see. Innonsari idi. Idtane idi. Will this person survive? Again keep it. Will this person survive? Sir, we tried our best, sir. The person was not able to survive. What is the last stage? WhatsApp open RIP macha. That's the second stage. Same thing happens here. The first stage is called as what? Resolution process. We try to save the company. Getting the point? The last stage is called as liquidation. Now, sir, this and all process is there. Someone should take care of everything, no? Who will take care? The person who takes care. Now, like we have a stock exchange. Who is taking care of stock exchange? SEBI. Now we have banks. Who is taking care of the bank functionality? RBI. Like that, this also someone should take care. Who will take care? The person taking care is called as a board. That board is called as IBBI. You can expect a question on IBBI. Insolvency Bankruptcy Board of India. A relevant question. Understood all of you? I hope you are understanding. Yes? Okay. Any doubts here? Done? Okay. Next one, types of law. What are the different types of law? One is called as criminal law. What is criminal law? It's a public wrong. Whenever you are violating a public wrong or a public rule, and what will the public feel? The public will feel that we lose the faith over the system. Agreed? Now imagine if a murder happens in this particular road. For next 1 week, you guys will not even come to this road. It can be a personal grudge, but you guys will lose your faith over the society. You will think that police are incapable. That is what happens. Now people, that is called as public wrong. Whenever something happens which is not personally related to you, but it is also related to the public at large. Imagine kidnap happens. You will start feeling unsafe as a citizen to go around this place. Agreed? Yes or no? Now it is whose responsibility is to fix that. Now imagine someone has been killed. Now whose responsibility was it for avoiding this particular thing? That's why we have police, right? That's why we have states. That's why we have governments. So remember, whenever there is a public wrong. Now let us imagine, I have given money to Darshan, Allah. Chetan. Now I give money to the Chetan. Now he does not repay. I will go and file a case against Chetan. Yes or no? It is my responsibility to recover. Now let us imagine the same thing. Mr. A killed B. Mr. A killed B. B's family should come and file a case on A, right? Now I gave, I should fight. Now he killed, his family should come and fight for the justice. Remember, that's not how the criminal law works. Why? Criminal law, when A killed B, he just didn't kill B. He killed the faith of the entire society. You're making us feel we are unsafe. So it is whose responsibility to bring that confidence back? The government's responsibility. That's why murders, kidnaps, rapes, you can see the person coming and fighting the case will be government. State of Delhi versus Mukesh. Was the Mukesh anyone? Illa? Okay. So State of Delhi versus Mukesh was a case law of Nirbhaya case. Delhi. Delhi fought for it, not the girl's family. Getting it? That is what is called as criminal law. What is criminal law? A public wrong. Where the government fights a case for you, not the person individually. Getting it? And in criminal law, remember, money is never a justice. What is justice then? Punishment. You want the person to be arrested. Capital punishment. You want that person also to be killed. So vengeance. In criminal law, you want the person to feel the pain. Hello? Yes, sir. Correct, no? Civil law. What is civil law? Now imagine I gave money to Chetan. Chetan didn't give me my money back. What will I say? Sir, arrest him, sir. 10 years, keep him in jail. Is it even rational? Not required. Then all I need is my money back. That's called civil law. Civil law means what? If money is given, everything will be okay in this particular world. If that is a belief, that is civil law. Getting the point? Third one, common law. What do you mean by common law? Common law means people? past decisions. Remember, you need to write a maxim here called as stare decisis. Stare decisis means people to stand by what is already decided. What do you mean by that? In our country, you guys have already read everything, you know the law. If at all there is a case, there is already a particular judgment that is passed by a court. If a similar story repeats again, we will take the same decision. Agreed? Now let us imagine a particular, now for example, what is that? You take the best example is this only. Now whenever there is this rapes and murders that is happening in this particular country, in one place it was given that, you take the Nirbhaya case only. It was said that it was a brutal kill. If any such incident happens, they said all the 4 accused should be hanged. So capital punishment was given and they were hanged, all 4 people. In that one was a minor. They waited that person to become a major and then hanged. Good, no? Very good. So they waited for that person to become major and then hanged him. Yes, all 4 are no more. Now, remember if a similar incident again happens in the country, what will the accused be? What will they do for him? Same thing, it's already decided. Why do you break your head? Getting it? Now, will I again hear everything? Yes, you will hear the case, but judgment is already done. In this case, you will come and say, Your Honor, in Delhi it is already done. You can also give the same judgment. That is only called as stare decisis. Stare decisis means what, people? It is already decided once for this type of story. This is what we should do. You also do the same thing. Getting it? The last one, principles of natural justice. What is principles of natural justice? So, you should not take the law to your hands. You should not be your own judge. Second one, people, before you punish any person, you have to give an opportunity to the person to hear him out. What that person needs to say, you have to hear them out before punishing them. We gave this even to Ajmal Kasab also, terrorist. In who else we should give? Everyone we have given. Yes? Okay. Next one, sir, structure of Indian judicial system. The function of, the last one is judiciary. What is judiciary? The police will arrest us. Now what is the guarantee? Now we will say, no sir, we didn't do the mistake. They will say, no, Chetan only did the mistake. Now how do we give a conclusion then? We go to the third independent party who is not favorable to you nor favorable to me. The third independent party will decide this case. The independent party, we call them as judiciary. Judiciary is nothing but judges, the third organ of the government. The judiciary system is, what is the function? They can ask you this also. The regulation of interpretation of the act, meaning how to read an act whenever there is a confusion. How do you read it? Whose role is to tell that? It is the role of the judge to tell that. Whenever you are confused, the judge will say, this is how you need to interpret this particular law. Yes? Second one, dispute resolution. When 2 people fight, who will resolve the fight? Judge. Third one, promotion of fairness amongst the citizen. Live peacefully. Types of courts, Supreme Court. Hierarchy of courts. What do you mean by that? Whenever there is a problem in the country, even you remember, whenever there is a problem in your schools or colleges, will you directly go and report to the secretary, principal? No. You will go to a class leader. Next, teacher, head teacher, department, vice principal, the principal. Correct? There is one chain. The principal, I know, sir. You can't directly go and tell them. So when you follow a hierarchy in every place, you need to follow a hierarchy in the judiciary also. You cannot come for everything to Supreme Court. You need to go from here. The first 2 courts you guys will come across is metropolitan courts or court of session or district courts. So what do you mean by court of session or what do you mean by district court? They come under high court. It deals with civil law. What do you mean by court of session? It deals with criminal matters. So you can remember like this. If at all you have a criminal matter, you want to go and report it somewhere, the first court you guys have to go to is called as court of sessions. If at all the first case you guys have is a civil in nature, the first court you guys will go to is district court. Sir, I come from a metropolitan place. in such places, they have or they might have created special courts called as metropolitan courts. This is generally done for population of 10 lakh or more people. Now imagine you come from a place which has 10 lakh or more of population. Now imagine Bangalore. We have little more than 10 lakh, around 8 crore. So now, okay. So in such cases, we have a court here. We call it as metropolitan courts. Now you will go and report it here. But not every district will have it. It depends upon population. Clear all of you? So my criminal will start with court of session. My civil will start with district court. Now sir, on-field umpire says out. Will the player walk away na? Illa sir, we don't trust you. What do you say? DRS. Now people, that DRS is there in cricket. Shouldn't it be there in your real life? One court is telling you did the mistake. Don't you have a right to say no, I didn't do? Can't you do it? When they say DRS for a wide also now, can't you say it for your life? You can. Now that process in cricket is called DRS. In real life, T becomes A. It becomes what people? Appeal. Appeal means what? When a lower court gives a decision, when an umpire gives a decision, a third umpire may reverse it. He says out. A higher court can say illa, not out. Yes, the lower court has that much visibility. That is what they saw. Higher court might see something more in the case. Possible. So remember, when you are not satisfied with the decision passed by a district court or court of session, you will run and go to the next court. That is called high court. The highest court of a state. Sir, high court also, they will give the best decision. They can't go wrong. They may go wrong. If you are not happy here also, again do. Where will you go? Supreme Court. There also they passed. Sir, again and they die. You don't have any more. That's all. That's where everything ends. Supreme Court, highest body of the country. That's why we call it as an apex body. Apex means highest of its authority. It is a point? Yes. Sir, illa sir, I want to go to Supreme Court only directly. This and all I will not follow. I want to directly go to Supreme Court. Can you go? Can you go? You can go only in one case. You can go either to Supreme Court or High Court directly. It is your choice. If your fundamental rights are affected. Only for this, no other thing. Only my fundamental right. I'll lock you in this room and I'll go out. It's affecting your fundamental right of movement. Yes, that's called as fundamental right. I will not allow you to stay peacefully. It's your fundamental right. I will not let you speak. It's your fundamental right to speak. I will not treat you as equal. I will do differentiation in my job hiring. Can I? Yes. Now this is called as what again? This is called as a fundamental right. Now if you think your rights are affected, you can go to a court. Where will you go? You will go to Supreme Court or High Court. It is left to you. Chetan says, yes sir, where is it all written sir? You will say whatever you want. It is written in Constitution of India. Where? Remember, you have to write the article also. As per Article 32 of Constitution of India, you have a right to go to Supreme Court. As per Article 226 of Constitution of India, you have a right to go to High Court. Done chapter 1. Any doubts?
So what is the difference between judiciary and arbitration?
What is the difference between judiciary and arbitration? Judiciary is court settlement. Arbitration is out of the court settlement. What do you mean out of the court settlement? Now in our India, not every case comes to the court, right? We have some cases which get settled outside the court also. Example, if you guys come from villages, we have panchayati. What is panchayati? Group of people gathering. Tamte will come. After everything, they'll have lunch. Correct? One person will be there. Padiyappa. Natamalai. Natam. Sorry, I'm not getting it. Natamai. Natamai. Correct? Whatever I say, that is a decision. We have it. Yes, panchayat. Arbitration. Not exactly, but yes. We have all our channels also, Noda, where people, host will come. Baduku Jataka Bandi, Katevella Jeevana. There will be one lady host. The people with problems will come. And I don't know, it's just my observation. Only ladies will be there. Have you seen? Irrespective of the language. Huh? Gothilla andre now, I don't know anything, no controversies. But yes, all the Gothilla, bit pretty. Yes, there will be, yes. Now, for example, your case, your case, Allah. I mean, the divorce case and all, extramarital affairs and all, that will all come there. That wife will come and says, yo, this husband is there, no. She's, she'll come and say, in that channel only she'll be going and hitting him. You see, husband will not do anything. He will be simply sitting there. That's how these shows are designed also. You have seen? Now there, she says, going forward, this is a decision. That 6 months here, 6 months there. There's some decision. Yeah, I don't know if you have seen or not. That is how it will happen also. Now they will follow that rule. What, you came to the court? No, but dispute settled? Yes. Yes or no? We call it as outside court settlements. This is only called as arbitrations. But this is not arbitration. Similarly will happen. Yes, getting the point? Okay. Arbitration is nothing but again a judicial authority, or there is a requirement. There will always be something in the legal field only. Independent neutral person without going to court will settle your disputes.
Only civil cases.
Only civil cases. A divorce also can come there. Getting the point? So we have one in Shantinagar only here. It's called arbitration cell. You know Shantinagar bus stand, it is opposite to that. So there will be rooms, around 20-25 rooms are there. Your hearing will be there. There will be you can imagine like a lawyer. Judge will not be there. Lawyer only you can imagine. But they are authorized to act as an independent person. Now they will hear, they will resolve the disputes. They will need not have to go to the court. Yes, that's why they are also called as friendly settlements. What is the beauty? You can meet here, or if you want, if you are comfortable in cafe coffee day, you can meet there also. It's such why it's called as an informal dispute resolution. I'm seriously saying, corporate disputes get settled in cafe coffee day only. They will not come here. I'm seriously saying that. Why will they come here? They have money. They will pay money. They will get it settled in a very posh places. Yes. Okay. Let's start our next chapter. If they ask about the types of courts or any other question from this chapter, would the points written in the chart book be sufficient? One thing I got to know. You have relied upon chart book. One thing I would say, go ahead. Yes. Yes, people. Let's start with chapter 2, your Indian Contract Act, important from your weightage of marks. Indian Contract Act, Unit 1, nature of contract. So, what do you mean by contract? Contract means contract. What is a contract? An agreement enforceable by law. Directly, let's take a question. What is the difference between agreement and a contract?
Agreement is the promise and set of promises.
Agreement is for promise and set of promises. Forming consideration for each other is called as agreement. What do you mean by contract? An agreement which is enforceable by law is called contract. All the agreements are contract. All agreements are contracts, no? What, sir? You heard it, sir? I know, sir. No, sir. All contracts are agreements, but not all agreements are contracts. As an example, what is an agreement? Macha, let's go to a movie tomorrow. We'll go, yes. Now I'll not come tomorrow. You will file a case on me. So this is an agreement. Now what type of agreement is this? We just entered into social agreements. Not every agreement can be decided in the court. He cannot come and say, Sir said, let's go to a movie tomorrow. He didn't show up. He cannot say that. He cannot go to the court and ask for justice. So, not all agreements has a resolution in the court. Some things can be taken to the court, some things cannot be taken to the court. So all agreements are not contracts, but all contracts are agreements. What are the difference we have? Legal obligation will definitely be involved in contract, that is not involved in agreement. And remember, agreements are wider. There are too many things that will come under agreement, whereas contracts are narrower. Not everything will become a legally enforceable one. That's a difference? Yes? Done. Okay. Yes, sir. Essentials of a valid contract.
Is there any act for a social agreement?
Like?
Any act for social agreement?
It can be many, right? Depending upon the case. Depending upon the case, that's all. Because I cannot say this particular thing will come under this particular act only. If it's a product, I can say, say for example, now if you take wedding, matrimonial things can come. If you take property, succession act can come.
That's the same example, sir.
No. No. Yes, sir. Next one, people. Essentials of a valid contract. Now, for a contract to come into picture, there are some essentials that should be there. If it's not there, it is not a valid contract. So you can take it like this. There is an agreement which is enforceable by law. It becomes a contract. Agreed? Sir, if a particular agreement should be enforceable by law, there are some conditions you need to satisfy. If these conditions are satisfied, there should be a tick mark for everything. So there is an agreement enforceable by law, then it becomes a contract. Clear? Now what are these? Sir, some things are given in act, some things are not given in act. Some things which are not given in act, why are you following? Whatever is given in act, you should follow. When it is not given, why are you following? Then where was it formed? Where was it said that it is necessary?
Common sense.
Common sense will not become a law. Huh? Section 10 is given. Not given, why are you studying?
So in other act it gives.
Other act you study there, then why are you studying the Indian Contract Act? Necessary means again common sense. See, if it is necessary, then so many things will come. If it is necessary, Balfour should have won the case. Yes or no? If necessary, Lalman Shukla versus Gauri Dutt. He should have won the case. There is a cheating that happened to him. Then where did your necessary go? Mitro! Tilda, that's what I say. Applicability. In first chapter I just explained. There is something called as stare decisis. Now when first time Balfour versus Balfour came, even the judge would be shocked. Hey, husband and wife, he casually made a promise, for that you will come off to the court. Yes or no? Even judge will be shocked. So that day he would have decided, okay, going forward many such cases might come. He said domestic and social agreements don't entertain. Now that is how it became a law. Now is it written in the law? No. But because of the judgment, it became one of the aspects to be followed. That is what stare decisis. That is what common law means. Common sense law. Understood? Huh? Hello? मित्रों वो यूपी में okay. See here, not given under section 10. What is not given under section 10?
Two parties.
There has to be two parties. Nityananda, me talking to me. You cannot enter into a contract. There has to be two parties at least. Intention to create legal obligation. Case law, Balfour versus Balfour. What happened in Balfour versus Balfour? Husband promised to pay monthly postal money order to the wife. After 2-3 months, he did not pay the money as promised. Wife filed a case. Your Honor, how dare he not pay me money? So the judge said, husbands will keep making promise, they will never fulfill it. So, not every promise that happens between husband and wife or friends or closely knitted relatives, not everything should be decided in the court. It is your domestic or it's your social matter. It's left to you guys. So it has to be decided amongst you. The courts cannot interfere between you guys. So in such cases, we will not entertain in the court. Court will not accept the matter at all. That is the meaning of intention to create legal obligation. Who won the case? Husband won the case. Other formalities to be complied, meaning a contract has to be in written. Yes or no? No. It can be in oral also. A con- Whenever some other act is telling, it has to be in written. It has to be in written. Example, people, insurance. Insurance clearly says a contract has to be in writing. You need to follow both. Next one, a contract has to be certain. Your contract has to clearly say today there will be a marathon of CA foundation law. Can I say today is a marathon for law? It's a vague contract because it's not certain. Law can be of any level. It can be inter also. It can be CS also. It can be CMA also. That's the meaning of the contract should be certain. Meaning you need to be precise on what your contract is. Getting the point? Yes. The last one is it should be possible to perform. It should not be impossible to perform. Yes. Yes, sir. Okay. Next one. Next one is given under section 10. Law only has defined it. What all has been defined? First one, offer and acceptance. There has to be an offer. There has to be an acceptance. Next one, free consent. We'll be seeing in the next chapter. So, capacity of parties will be seeing in chapter unit 3. Consideration unit 2. Lawful consideration unit 3. Unit 3. We'll be seeing everything. We'll see it there only. Okay. Next one, types of contracts based on validity or enforceability. A biggest question for a lot of people. What is the difference between void contract, void agreement, illegal agreement, voidable contract, and unenforceable contract? We will see one by one. Important, remember. There is something called as first one, valid contract. Easiest one, agreement iruko. Essential elements iruko. Contract iruko. Yes, sir. Yes, sir. Next one, people, let us take illegal agreement. Easiest one. What do you mean by illegal agreement? Now are you getting? I'm asking illegal agreement. Now you test your knowledge. What is illegal agreement? You all know. But tell me, please. Smuggling is called illegal agreement. Example it is. Keyword. Forbidden by law. An act to do anything which is forbidden by law is called as illegal agreements. Now what do we write in exam? Illegal agreements, sir. Anything not legal is illegal. Otherwise, what? You are asking one question, I am answering that. So remember, this is where we go wrong. Now you guys only tell me. You tell me as per the act. I am telling you where we are going wrong. Illegal is yes. Whatever is an act you guys have entered, which is forbidden under the law. If your contract is allowing to do that, that is called as illegal agreement. Yes. Example, kidnap. Example, murder. Example, to deal with white powder. Brown sugar is legal now. Coffee yesterday they gave. Oh, that brown. Okay. So all this cocaine and all this will come under illegal. You are not supposed to deal with it. Yes or no?
Yes, sir.
So that will become illegal contract. That is illegal agreement. Yes. Okay. Next, what is illegal agreements? Which is forbidden by law. Next one. Let us imagine what is a void agreement. Void agreement. Impossible to perform initially only. Void ab initio. Void agreement. Is void agreement and void contract the same? Void agreement means people. From the moment you enter this particular agreement, it is void. Void means people. Invalid. Example of void agreement. Minor agreements. You cannot enter into an agreement with a minor, but you entered. From the moment you entered, it is invalid. Example. Best example of void agreement. Second one, what else you can give? Unsound mind. Third one, you give the entire competency of parties, everything will come. Wager, void only, no? Everything is an example. Agreement in restraint of trade, forever. I cannot stop anyone from entering into a contract or from doing a particular business forever. Yes or no? All these are examples of what? Void agreements. Agreed? So what do you mean by void agreement? From the moment you entered into the agreement, from that moment itself, from the first second, this particular contract, this particular agreement is invalid. That means court will not help you if something happens. Next one, tell me, what do you mean by void contract? The word used is void contract. That means it was first a contract, then it became void. So what do you mean by void contract? Initially it was possible. Later on it became impossible. Remember, a contract which is initially valid, later on becomes invalid. So a contract which is not enforceable by law is a void contract. Now what is it, people? Example. Say for example, you entered into a contract with probably an artist. You say that you want a particular painting. Now it is something which is done with skill. When you enter the contract, it is valid. After he dies, the contract will come to an end. When you entered, valid. Later on, invalid. In this case, what will happen? We call the contract as void. If a contract is void, remember people, whatever benefits you have taken, it is your responsibility to return the benefits. Are you getting the point? Meaning if you have taken any advance, you have to return it. Sir, I'm not alive. I'm saying legal representatives will return it. But you have to return it. Understood? Hello? The last one, unenforceable contracts. What is unenforceable? It's proper in every aspect, but there are some technical errors in it. Technical errors like there is a mistake in the name. That's a technical error. Yes, correct. Stamp duty underpaid. It's a technical error. Absence in return. If the law has specified so. Now all this will come under unenforceable contract. For example, if there is a person called as, say, Karthik. Now, in the contract you have entered it as, say for example, now we do not know, according to the law, this is not me, I do not exist. Yes or no? Imagine you take a flight ticket in a wrong name, will they allow you? Will they allow you? You try in even your Indian Railways, if it does not match with your Aadhaar, they will not allow you. Have you ever done? You take a ticket in your name, you could not travel, you send your friend. Try. What is there? Try. Try. Possible. Try. Walk to TC and say, sir, I didn't come. On behalf of me, he came. You try. Allah. Legally not possible. Sir, when TC is coming, I'll sit in washroom. That all is definitely possible. Yeah, yes or no? Understood, huh? They will not allow you. Yesterday only, fresh example, in yesterday's class, there was a girl who paid a fine of 500 rupees. Her father booked a ticket for her to come here. By mistake, father has booked the ticket in his name. And she was like, it's okay, she has taken the train. And in the train, TC has asked for Aadhaar. 500 rupees she has paid penalty. Clear? Not possible. Why? Unenforceable. Hello? Sir, I'll give my childhood Aadhaar. Next one, people. Based on formation, a contract can be express contract, implied contract. Express means people, You discuss everything and you enter into a contract. Implied means people based upon the conduct of the parties. What do you mean conduct of the parties? Give me an example of implied contract. Bus, railway station coolie automatically takes and keeps it on the head, keeps walking. It is your duty to stop. Anyway, someone is taking. Why should I stop? You will also go means you have to pay. Yes, checking your weight in the vending machine. It is also an implied contract. Yes or no? This is also called as tacit contracts. What does tacit contract means? Silent contracts. Quasi contract? We'll see. We have a chapter. We'll know. E-contracts means all the contracts entered in electronic form. Based on for performance, a contract can be classified into executed contract. Executed means a contract which is already completed, done and dusted. Obligations of both the parties are completed. That's how we need to write. Obligations of both the parties are completed. What do we write? Completed. Second one, executory contract. What do you mean by that? Depends upon executory, unilateral, bilateral. Unilateral means people. When a contract has been entered, the question is, should both of them still perform or one party has already performed his obligation? One party has already performed. That means unilateral. Best example, I buy something on Amazon. I pay it online. My obligation is done. But the Amazon has to still deliver in the future date. That is called as unilateral. Bilateral, we enter into a contract today with Amazon. I want to purchase one particular product. He says I will deliver it to you after 3 days. I will also say I will pay it after it is delivered. Cash on delivery. He should also deliver. I should also pay. It's called as what? Bilateral executory contract. Then classification of offer. Offer can be classified into express, implied. I will expressly say, people, I want say 100 liters of coconut oil at a price of 300 rupees per liter. Express offer. Everything I'm saying. Implied offer. Implied offer. Implied offer. Implied offer means I will not express anything. Pack it and keep it. Yes. Shop and all. Yes. That is also called as implied offer, implied acceptance. Bus coming and stopping in front of you. It's an offer. I'm going that way. Do you want to come in? I'll drop you. Will they come and ask you? No. But if that goes in your route, you guys will take that bus. It's an implied offer. If you get inside, it's an implied acceptance. You guys won't speak and enter, right? Not everyone will speak to conductor and say, it will go there, other right to left to there, you will stop. Not everyone will speak. Of course, some people will speak. Some people will get in. It's their routine. So, implied offer, implied acceptance. Next one, general offer. What is general offer? Offer made to public at large. Anyone wants, anyone apply. CA Foundation Marathon. You want, come. Anyone want, anyone can come. Did we just say it is only for the existing students? It's a open offer. Anyone can accept it. It's a general offer. Example, Carlyle versus Carbolic. What happened? Influenza. There was a disease. The company gave an advertisement. Whoever consumes our medicines, you will not get influenza. One lady took it. She still got it. So directly she filed a case on the company asking for the reward money that they had announced. The company didn't pay. She filed a case in the court. It was awarded. It was a general offer. Anyone who accepts or anyone who follows the instructions. Instruction is taking the tablet twice a day. She followed it as it is. And still she got influenza. Then you need to compensate her. That is what is called as general offer. Remember, in general offer, you will never communicate your acceptance. In general offer, you will never communicate your acceptance. Following the terms itself is an acceptance. Rule ಹೇಳಿರಲಿಲ್ಲ. Okay. Rule ಹೇಳಿರಲಿಲ್ಲ Papa. Okay. Implied. Okay. So specific offer. So the rule of the class is, if your phone rings, you have to sing a song. Okay. Next one is people cross. Okay, specific offer means what, people? Offer made to a specific person. There is a case law here. That is a case law. Bolton versus Jones. In short, what is the thing? If at all I make an offer to one person, another person should not come and accept it. Now I'll tell any person, now I'll tell him, are you interested to buy my shares? He cannot come and say, I will buy. Or he cannot come and say, I will pay for it. It's an offer made to him. He should only accept, not you. That's the meaning. Understood? Huh? Specific offer means an offer made to a specific person. Yes? Okay, next one, cross offer. What do you mean by cross offer? Exchanging an identical offer with an ignorance of each other's. Meaning, sir, I have a car. I said, A, do you want to buy my car? A also saw my car. He also wanted to buy it from a long time. He also proposed. You have your car now. Can you please sell that car to me? Now, I don't know that he has written a letter. He doesn't know that I have written him a letter. Without knowing each other's letters, if we write a letter to each other, it's called as cross offer. Exchanging the same offer without knowing that the other person also made an offer. It's called as cross offer. Remember, cross offer is never a contract.
So offer should be price should be similar or not?
Even if it's similar, let us imagine I said I will sell, if you are okay, are you interested to buy my car for 5 lakh rupees? A also wrote a letter to me on the same day, but he has not yet seen my letter. He says, I want to buy your car for 5 lakh rupees. Will you sell? Both of us are speaking on the same car, same price. Is this a contract?
No.
Answer is no. Because no one has given acceptance. For a contract to come, offer plus acceptance has to be there. Both of them have given offers only. Hello?
Yes,
So whenever there are identical offers exchanged, it is never a contract. It's a cross offer. Next one, counter offer. What do you mean by counter offer? Counter offer means nothing but people, negotiation. I will sell my car for 5 lakh rupees. Are you interested to buy? A replies, yes, I am interested to buy. Here it is. I give 1 lakh rupees advance as a check. The next to 4 lakh rupees, I will give it to you in 2 EMIs. Is this a contract? Yes or no?
no.
Why no? I've said yes, no. Counter offer means what, people? I just told I will sell my car for 5 lakh. Did I agree for this EMI and all? That is a condition you have put. Now I need to say yes or no for that. So remember, counter offer, the party replaces the original offer. Original offer was from me. Now that gets replaced by A's offer. What is A's offer now? He will buy it for 5 lakh, but money will not be settled immediately. It will be settled in EMI. So you should be okay with that. So now I have to say yes or no. I need to give acceptance. That's why counter offer rejects the initial offer. Getting the point? Again, counter offer is not a valid contract. Is clear? Hello? Okay. Next one, that is counter offer. Next one, standing or a continuing offer. What do you mean standing or a continuing offer? An offer which is open for a certain period of time. Remember, people, they will ask one more question. Okay, a question to you, again an exam question. A contract was said, it will be open for from 1st of April to 10th of April. On 5th of April only, this company ended the contract. They said, now say for example classes, you could register, we said, the registrations will be open from 1st of April to 10th of April, we said. But on 5th of April, we have hit the maximum number. Now we cancelled our contract, meaning what? We said from 6th April, we will not take any more admissions. One student comes and files a case. The offer was valid till 10th. The company closed the offer on 6th. Now the question is, can the student file a case on the company?
Yes, sir.
Yes or no?
Yes, sir.
Because it's a standing offer. Remember, you cannot file a case. Why?
The organization should
It is an invitation to offer.
give notice, right, sir, to close the offer.
I'll tell you something. This is where your acceptance and offer, when it is complete, it's still an offer. You have not accepted. Can I cancel my offer before acceptance? Yes. Have you accepted it?
No.
Then, this is what I tell. You know everything, but you can't put it into place.
Sir, standing offer can be.
Standing offer, yes. Yes, it is.
There is no required of.
What I'm saying, you have not yet purchased. Can I cancel it? Logical. Hey, what does the contract say? Offer plus acceptance is contract. Hey, where is acceptance? You have not come to me at all. Can I cancel it? Yes. What is your last topic in the first unit? Revocation of offer and acceptance. Now, before it is accepted, I can cancel. You would have seen completion of offer and acceptance. When does an offer and acceptance gets complete? After acceptance is communicated. Here, where is acceptance communicated? Beautiful question.
What if, because you said April 1st to 10th, he wanted to register on April 6th? He can claim any damages, sir?
No.
Relying that information he wanted.
No.
And he rejected some.
No, because it's a private law. Meaning what? It's not a public law. I will take whatever is beneficial for me. It's a civil offense. Meaning, end of the day, it's a commercial organization. Now, can they change? The answer is yes. Now, I cannot change. Now, let us imagine. I said, I'll be teaching you all 4 subjects and I've taken money from you. Now, I cannot just teach 3 subjects. This I cannot do because acceptance is done. Now, before acceptance is done, can I change anything? Answer is yes. Remember, if 100 people have wrote this question in the exam, 99 people have written the answer as standing offer and hence it cannot be cancelled. 99. Are you getting it? Class became silent? Yes? Yes. Understood? That's what I'm saying. You need to see more and more and more and more questions. The more questions you see, the more you understand the law. In the class, you just understand examples. If I ask again the same story in a different way, you'll again answer wrong. My students know it. By the end of not even one answer I would have said, yes, you are right. This into mark is their everyday scenario. Because we cannot answer that scenario in a different way. Again, I am telling we have time. Try to see more questions in your time. If wherever possible, solve more questions. Getting the point? Yes? Okay, done. Next one, communication of acceptance can be done. Okay, completion of offer acceptance. When does an offer come to an end? How does an offer come to an end? So see, first thing people, when does an offer come to an end? When does an acceptance come to an end? Offer and acceptance will come to an end whenever it is communicated to the other person. When both the parties, buyer and seller, are standing next to each other, we don't have this problem at all. But remember, it is an Indian Contract Act 1872. That time, how was the contracts made? WhatsApp was not there, email was not there, letters. That's why we have this particular provision. People were discussing everything through letters. Now, I write a letter today, it will reach you after 15 days. Now, when is the offer and acceptance? When is it coming to an end? That's what they're trying to ask you. Getting the point? When does an offer come to an end? Offer will come to an end when the other party, that is offeree, to whomever I have made an offer, if he gets to know what I have made, upon him getting a knowledge of what I have written, meaning he will take a letter, he will read it, we will say offer comes to an end. Meaning offer has completed. Next one, when does an acceptance come to an end? Meaning when is an acceptance completed? This is where most of the people will feel confused. When does acceptance get completed? I hope you are understanding. A wrote a letter to B, do you want to buy my car for 5 lakh rupees? B gets the letter on 20th of March. When is the offer complete? The day you got the letter and you read it. Just because you got the letter, the offer is not complete. You need to know what is there in the letter. Now the question, D wrote yes. and he posted it on 22nd March 26. A got the letter on 24th March 26. Let us imagine he read it also on 24th March only. When is the acceptance complete? Is it when I wrote it and I put it in the post box, or when I received it and I read it? When is the acceptance complete?
For A 22.
For A, when is it complete? 22. For, okay, one second. All of you know that acceptance is complete for each of the party in a different date. That we know. For A, acceptance will be complete on a different date. For B, acceptance is complete on a different date. We know this. Very good. For A, you tell me when is the acceptance complete? 22, 24, 22. Now let the auction begin. Okay, all of you think it is 22? For A it is 22? For A it is 22. Why? On 22, B has written his decision. You cannot take it back. Are you getting the point? Yes? Okay. Now for B, when is acceptance complete? Why? Now remember, I wrote a normal letter on 22nd. I want to change my mind now. Take immediately. Take a speed post. Write it. It might reach on 23. Now imagine B has written yes. In speed post write no. Now whether offer, are you saying yes or a no?
No.
Whatever reaches first will be valid. Now take a hypothetical. What if both reaches at the same time? Whatever is read first will be valid. Now if you get yes and no, you are not you will not read. You will take one letter at a time and you will read. Whatever you read first will be valid. Getting the point?
Yes, sir.
Yes. Remember, exam point of view, important. Is this clear, all of you? Yes? Hello? Okay. The last topic is revocation of offer and acceptance. How and all can an offer and acceptance can be revoked? First one, by notice of revocation. Notice of revocation means I am telling I want to cancel the contract. I am taking it back. Can I cancel? Yes. Before acceptance, this is where it will come. Next one, by lapse of time. What is lapse of time? I have given you a prescribed time. Within that time, if it is not accepted, comes to an end. By non-fulfillment of condition precedent. What is the condition precedent? For you to get a free delivery, you need to shop at least for 400. If you do not shop for 400, you will not get the offer free delivery. Condition precedent means for you to be eligible for a particular offer, before that there is some condition you need to satisfy. If you do not satisfy that, this offer will come to an end. If you do not shop for 400, came to an end. By death or insanity, remember, death or insanity only if a special skill is involved. But if it's a loan and a party dies, the legal representative will be liable to repay. Contract won't come to an end. Yes? Okay. Provided only up to the property. Now imagine if at all I have to pay a loan of a person. I will be only paying to the extent of the assets I get. So if loan is 5 lakh, if I get an assets of 4 lakh from that person, I will be liable only to the extent of 4 lakh. Next one, counter offer. I told you, the initial offer will come to an end. Non-acceptance in prescribed mode. Meaning, I have clearly told you to accept the contract by an email. I have clearly told you to pay it in cash. If you do not do that, I have to communicate that to you. Sir, I have told you to reply in email. You have replied to me in WhatsApp. I will consider this as invalid. You have to communicate that. If you do not communicate, it will be treated as acceptance only. Remember that. That point they can ask you a question. Last one, sir, subsequent illegality. When you entered, it was valid. Later on, it became invalid, meaning illegal. It is nothing but an example of void contract. Any doubt? Any doubt? Hello? Okay. This clear? Okay.
it was a crossover. You message me in a WhatsApp. I will message in the SMS. So you will tell like I will sell for this for 1,000 rupees. I will ask like can you sell for 990? That is a crossover approach. Sorry. Crossover.
No counter.
No, crossover. Like a youth are like same time.
My only question, do I know about your message? Have I read it?
Both are
No.
I don't know at all. Do you know I have messaged? Then it's a crossover.
Now you tell me that 1,000 rupees, I tell 999.
Huh.
amount, sir.
Then no. No, it's not a crossover. But end of the day, it's an offer on the same material, that's all. Done na? Hello? Okay. Next one, people, consideration. We'll taka do off, huh? You guys had your breakfast? We'll do this and go for a break? Probably another 15 minutes will be done. Consideration, people. Okay, what is consideration, people? Something in return. Now tell me the definition of consideration. Tell da. Mantra ಹೇಳ್ತಿದಿಲ್ವಾ? Where are the desire of the promiser? The promisee or any other person has done or abstain from doing, does or abstain from doing, promises to do or abstain from doing an act of abstinence or doing is called as consideration. Oh, we don't know, sir. We just said you were saying loud, that's all. Okay. Rules regarding consideration. Understand the rules, you will understand the definition. Consideration must move at the desire of the promiser. What do you mean by that? I should have asked for it. If I do not ask for it, you cannot hold me liable. People, exam question, answer. There was one fire accident. A person dialed for the fire extinguisher team. They came, they put off the fire. This person, out of gratitude for the thing that they did, he promised to pay 10,000 to that lady, whoever fought really hard there. Now, after promising, lady na, andre you racist society. Okay. Now, people, you give 10,000. You agreed to give 10,000 rupees tomorrow. You go home. You come back tomorrow. I'll give you 10,000 rupees. That lady said okay. She went. She came back tomorrow. The next day he felt, that adrenaline is done. So when you have to do charity, you have to do in that adrenaline only. If not, you will feel, hey, why did I promise? I have to pay my bills and all. So the next day when the lady came, he said, sorry, I won't pay. The lady wants to file a case on this person to recover the money. The question is, can she recover the money or not? How many of you think, yes, she can recover? It's okay. Answers can be different. I know one of you, two of you will feel it's no. Yes. She can recover. She can recover. Come on. Jago, Grag, Jago. 3. We need more hands. 4. Any more? Sir, more than 50% we feel she can recover. Yes? Remember, can she recover? Now my answer. Whoever said she can recover, you tell me under what provision you are writing this answer. Why you are telling it is recoverable? Sir, heart, sir. Provision wise, sir. Heart says she has fought. Why do you need provision and all? Compensation for past voluntary services. Very good. That's the provision. Agreed? Allah, that's the provision. Compensation for past voluntary services. Very good. But remember, there is one more provision also in the same law which says, if it is your duty to do something, doing your fire extinguishing is your duty. You cannot claim it as a consideration. What one is legally bound to do cannot be claimed as a consideration. So she did not do any extra service there. It was her duty. You cannot claim money for that. It will not give you a legal right. So can she claim? Answer is no. Getting it? Hello? If you write this, you will get 5 marks. Ange examiner will come and hug you. That's how you need to write. Provision. That is how important it is. You need to go to that level. But very good. You are able to at least link it to the other provision. For whoever said yes, she can recover. If it is yes, you should be able to write that compensation for past voluntary services. Getting the point? Hello? Okay, good. Next one, it must move from promisee or any other person. Chennai versus Ramaya, what do you mean by that? I can give it or anyone else on my behalf also can give it. I took a loan, my friend repaid. Can it happen? Answer is yes. But once you have taken it, you cannot ask that same thing again back from me. Example, case law, Chennai versus Ramaya. Property was given by the grandmother, mother. There was a brother. The lady had, if you remember, there was a mother, there was a daughter, there was an uncle. Mother gave property to daughter. Daughter gave an acknowledgement to the uncle, I will give you monthly pension. After taking the property, mother died. Daughter didn't give the property. Uncle cried. And now they went to court. Now the question is whether uncle will recover the money. Yes. Answer is yes, because I did not give anything. Agreed. But on behalf of me, consideration may move from promisee or any other person. So this Rangoli is called as what? Consideration. Understood? Got it? Okay. And remember, what is quid pro quo? The contract will be valid only if it is give and take. Exceptions are there. Consideration may be executed or executory. We saw Amazon case. It need not be adequate. It need not be same. Value of pen. Say for example, 10,000 rupees. Now, I want to sell this to you for 10 rupees. Now, tomorrow morning I realize, how did I agree to sell this for 10 rupees? And I will say, I will not sell it. Can he claim damages? Is this a valid contract? Yes, people, a contract, the value of the product need not be the same value in your contract. Even if I agree for 10 rupees, it's same. But imagine I told I will give it to him for free. Can he claim it from me? Answer is no. Anything which gives you free is never a right. So you will not get a right over it. It's not a contract. Why? Quid pro quo. Something in return. That's the provision. You need to write the provision. Hello? Performance of what? One is firefighter.
Can it be voidable contract?
Which one?
Adequate. It will not be an adequate voidable contract.
No. It is not optional. It is mandatory right. Voidable means what? Optional. It must be real and not illusionary. Illusionary means something which is not possible to perform. Black magic, as the case may be. It should not be unlawful, immoral, opposed to public policy, fraud, smuggling. Okay, understood? Next one, sued by third party, doctrine of privity of contract. What is the doctrine of privity of contract? Whenever two parties are fighting, a third party cannot come and interfere. Meaning A and B are fighting, C cannot come and file a case on B or A. A third party to a contract will never get a right on the party to the contractor. Example, Dunlop pneumatic tire versus Selfridge. There was a manufacturer, there was a wholesaler, there was a retailer. Manufacturer clearly told wholesaler, you cannot sell the tires for less than 1,000 rupees. And not only you, whoever buys the tire from you, you should tell the instruction to that person also. Wholesaler agreed. Wholesaler purchased the tires from the manufacturer, sold it at 1,100. The retailer wants to sell the tires to the customers at a discounted price. Now the manufacturer got to know that this retailer is selling the tires at 900 rupees, which is less than 1000. Now the manufacturer wants to file a case on the retailer. Can he file? The reason is the retailer will ask you only one question. Who are you? Did you ever come and speak to me before? If someone has to come and file a case, it has to be a person who has entered into an agreement with me, not you. That's the whole purpose and meaning of a third party to a contract cannot interfere. Agreed? Okay, but this rule has some exceptions. What is that? First one, truster, beneficiary. So whoever is your colleges, all the colleges are trusts. As a student, have you signed any document in the trust deed? But can you go and fight for any of infrastructural damages? Yes. It is your right because it is for your benefit that particular thing is made. Even though you are not party to the contract, you can still go and file a case on that particular parties. Valid. Next one, family settlement. Family settlement, nothing but people, let us imagine, when the property was, distributed also, property split. That's a word. Now imagine one person's name, the property will be there. That person would have passed away. Now we do not know where and all the legal heirs are. Some can be legal, some can be illegal. It happens, right? You remember Batuku Chataka Bandi? No, whether you do not know how to treat it. Yes or no? Then that will come under family settlement. Whether your name is there in the agreement or not. But you have a right. You are a legal heir. You have a right. Are you getting the point? Next one, marriage contracts. The person to whose benefit it was made. Khwaja Muhammad Khan versus Hussaini Begum. Case was, there were two people. A had a son, B had a daughter. A promised B, if your daughter marries my son, I will give 500 rupees. Daughter married, but B passed away. A did not give 500 rupees. Daughter-in-law, daring daughter-in-law, went and filed direct case on father-in-law. You promised my father that you will give 500 rupees. Give it. 1920 case like this. 500 rupees only this amount. 500, 1920 is like easily 5 lakh rupees. Yes. So give it to me. So father said, hey, who are you? I entered into a contract with your father. With your father, the contract also died. She went and filed a case on the father-in-law. It was decided. End of the day in a marriage contract, the marriage contracts are always made for the benefits of the successors. Basically, they were the beneficiaries. So in a marriage contract, people, for whomsoever benefit the contract is made, they can go and file a case. It's an exception. Privity of contract does not apply here. That is what happened in the case of Khwaja Muhammad Khan versus Hussaini Begum. Understood? Next one, assignment of a contract. Assignment means what? Negotiable instrument. I transferred my right to someone. A contract was between A and B. I negotiated. I transferred. I endorsed my instrument to C. Now if B doesn't pay money to C, can C file a case on B? Yes, it's an assignment. Transfer. Hello? Acknowledgement or estoppel. What is estoppel? Whatever the daughter gave to the uncle in the case of this pension, she agreed, I will give the money to you, is called as an acknowledgement. You have agreed once, you cannot go back. She said, I will give, you have to give. Then why did you agree? Hello?
Yes, sir.
Okay, the next one.
That acknowledgement it can be wrong or right.
Yes, both are valid. Next one, covenant running with the land. What do you mean covenant running with the land? Whenever you have attached any conditions when you are selling the land, the conditions also will go to how many ever people you sell it. With every sale, even this condition also will go. Correct? Yes. People, I'll be telling it. If you guys feel anything you don't know, feel free to raise and ask, sir, can you explain this? I'll try to explain it. Clear? Next one, contract by agent, the principal. Agency only we have it. Whenever a contract is entered by an agent with a third party, it is being entered on behalf of the principal. So can principal come and interfere? Answer is yes. Third party, but still valid. Agreed? Last one, validity of an agreement without consideration or exceptions to quid pro quo. Meaning, generally it should be give and take. But even if it is not, it will still be valid, it seems. When is that, sir? First one, natural love and affection. When a father gifts something to a daughter, when a husband gifts something to his wife, will it be valid or invalid? Then what is Balfour versus Balfour then? When you said social and domestic agreements there,
It is not registered.
so when you are writing in your exam, you need to write these points. I don't mind to write one more point also.
Intention.
It's not there, but this is also a valid point. Getting the point? Hello? For example, imagine that Balfour versus Balfour. He agreed to give money order on a written document registered, but it can be even casually you guys could have entered. Intention is required. I'm telling you in real life. So it's okay to mention that point also, provided they had an intention to create legal relationship and written and registered. It will be a valid document. Getting it? Okay. So when a husband or a wife, if they have to have a legal contract, what are the conditions you need to satisfy? First thing, the party should be in near relationship, meaning relatives, husband and wife, father and son, all those things will come here. Next one, must be in writing, oral, not valid. Third one, the document has to be registered. Sub-registrar, go, register there. Only then this particular thing will be valid. If not, it is invalid. So then you will say it is domestic or social agreements. If these three things are there, plus I say there is intention, then I will say even a husband and wife, father and son, anyone can enter into a contract. Are you getting a point? Yes. Compensation for past voluntary services. Whatever is the answer. Whatever firefighter already did, voluntarily, she only did it as a duty or whatever it is. Duty won't come here. Imagine someone helps you voluntarily. After that, you promise them to compensate. Example, you lost your purse. Someone sees it, finds it, voluntarily brings it to you. Now you say, I will give you 500 rupees. Now you promise to pay 500 rupees. The question is, are you liable? If you don't pay 500, can I file a case on you in the court? Answer is yes. Because you have promised for something which I have done in the past voluntarily. I searched it, voluntarily came and gave it to you. Now you are liable. You have to pay money. Understood? That is what will come here. Next one, promise to pay time barred debt. What do you mean time barred debt? Limitation Act. Now imagine A gave loan to B. It is B's duty to repay. If B doesn't repay, what should A do? He'll ask. If he doesn't repay, what I will do? I'll go and ask in the court. Correct? Sir, within how many days I need to go to the court? Generally, if it is a loan transaction, you need to go within 3 years. If you do not go within 3 years, court will say, don't come to me forever. That is only called as Limitation Act. If you have suffered any loss, you need to come to the court within time. You cannot come whenever you want. Hello? Now let us imagine 3 years is done. A did not go to the court. But B, out of goodwill, after 3 years, voluntarily comes and agrees, I know I need to repay you money. I will repay. I will give you a fresh check today. But for this check, did I give anything again?
No.
No, because earlier we have agreed. Now for this check, what did I give again? On this check, do I have a right? The answer is yes. So, second time B agreed to repay. My limitation will start again from the second time. 3 years will start. So, can I recover? The answer is yes. Last one, to create agency. So you can appoint anyone as your agent, even free of cost also. That's fine. You need not have to pay them money. You will see this point in agency also. Next one, completed gift. In gift, obviously there will be no gift and take. It is valid. Bailment. We'll be seeing charity. What is charity? If someone, you have agreed to donate money, you said I will donate. Late tomorrow you will say I will not donate. Is it valid?
Yes. If it is not used for anything, we can.
Yes, remember, I have just like that said I will give money. Tomorrow I will say I will not give money. Is it valid? The answer is yes, provided one condition. Imagine people, they are raising donations. Why? They want to construct one, let us imagine one building, a community hall for all of the residents. For that they are raising money. I said I will give money for this. Tomorrow I see lot of people have donated. So I see lot of money has already been collected. Now I say, why to give? I want to take back my promise. The question is, based upon your promise, if they have accounted for it, and accordingly if they have budgeted in your building, they have already taken up a liability for the money you have given. Now you cannot take back your promise. Because based upon your promise, they have already created a liability. Getting the point? Yes? For example, nowadays you get this app also, K2, Milap, this child, some operations and all will be happening, you can donate money. Now imagine you have said, I agree to donate money. You can agree. You will have 2 days time to give money. When I agreed, let us imagine 10,000 rupees was raised. The total operation cost is 30 lakh. When I see after 2 days, they were able to raise 40 lakh. Now I will say I will not give. The question is, based upon your word, if they have undertaken a liability, you have to give. Now you guys will feel, sir, anyways 40 lakh is there, no sir. Okay, then everyone will take back. I allow everyone to take back then. Why should I give only the choice to you? Isn't that sensible? So you have to pay, you cannot go back. Once a liability is undertaken based upon your word. Is it clear? All of you? That's your chapter. Consideration. Any doubts? Kedarnath versus Gori Muhammad. That was a case law where they they wanted to build a community hall. One person agreed to donate. Later on said he will not donate. A construction contract was already taken up. Because it is taken, you are liable. Clear? Charity, if a if a provision is made, if a liability is undertaken, you are liable to pay charity. If nothing is undertaken, you just like that said, I will offer some money to some your religious place. Now later you say I will not give. It's okay, absolutely fine. Getting the point? Yes? Okay, go for a break and come. Tarak, clear ada? Okay, unit 3 people, other essential elements of valid contract. So section 10, whatever was left, we'll be seeing it here. What are other essential elements? First one, people, the person should be major. Next one, the person should be sound mind. Next one, not expressly disqualified. So regarding the minor, there are some rules. What is that, sir? First thing, a minor agreement is always void ab initio. What do you mean by that? Initial, from the day one, when you enter into an agreement with a minor, it will be considered as void, invalid, basically. Agreement is always considered as void if you enter it with a minor. Example was Mohiri Bibi versus Dharmodas Ghosh. In this case, what happened? A person gave money to a minor as a loan. When it came to the recovery, the minor said, I am a minor, hence I will not be liable. The question was whether a person will be able to recover the money. Is it possible? Remember, we can answer it in 2 ways. One, people, if you still have the article or the money with you, there is something called as doctrine of equity. Doctrine of equity means, people, on a normal day, whether you be a minor or any person, you take a money, the money is still in your pocket. The court cannot say, when we can see that money in your hand, I cannot say you cannot recover. The courts will help you to recover the money, provided the money is still there. What if the money is spent? If the money is spent, then court will not come and say, because it is gone. Now I cannot say, minor, you go for some work, earn and come and repay. That and all we cannot say. But if it is visible, if it is with you, the court will never keep quiet. The court will tell you to repay only. I hope you are understanding. Yes, but according to Indian Contract Act, if it is a minor, if you file a case, minor only will win as per Indian Contract Act.
So if a minor invest on that money on assets, he can take
You can recover. You will order to sell it and recover. That is possible. But what if minor spends it? You cannot recover. Spends it in a sense. Imagine I go on a vacation. Can recover? Answer is no. I use it for some experience. Can I? Huh? Okay, next one, people. No ratification. What do you mean by ratification? When I took a loan, I was a minor. The lender waited for me to become a major. After I became a major, he made me sign one more agreement. Whatever I took as a loan when I was a minor, he is making me sign today one more agreement. I promised to pay all the loans I have taken when I was a minor. Now, the question is this agreement valid? Which was signed by me once I became a major.
No, sir.
Once I become a major, I signed.
No consideration.
That's the meaning of no ratification. Once void is always void. It will not become valid after 1 year, 2 years and all. This rule has only one exception. What is the exception?
Partnership.
Very good. Partnership has the only exception. What is the exception? Minor will be liable once he says yes to the partnership. Meaning after 6 months, after attaining majority, he has to give his decision. If he says yes, he will be liable for all the contracts since he was admitted as a beneficiary. Meaning he was 15-year-old. From that time they have taken him as a partner, meaning beneficiary. So whatever contracts you have entered from the date you are 15, from that day all contracts will be liable on you. If you say yes in a partnership, that's the only place where ratification will come. Getting the point? When we see the minor contract, partnership, I'll tell it to you again there. He can be a beneficiary. He can plead minority. Plead minority means he can take it as an excuse in the court. I'm a minor, please leave me. Next one, his estate is liable for necessaries. Now what do you mean by necessaries? Education, shelter, even fighting your legal case is also necessary. Medical grounds, necessary. So if a person has given you money to meet that, now it's a loan, but can they recover? Answer is yes. But how much can they recover? They cannot recover money from you personally. They can recover the money from your property. Now imagine if I don't have any money, you will not be liable. But if I have property, that property I will be liable. Sir, I took a loan, education loan of 10 lakh. I have a property worth 6 lakh. Your liability is 6 lakh only. Getting it? Yes. Sir, I took an education loan of 10 lakh. I don't have any property. Then you are not liable for 1 rupee also, even though education is necessity. I hope you are able to understand. If you have a property, you are liable. If you do not have a property, you are not liable. Understood? Okay. Enter into contracts by guardian. Can he enter into a contract? Yes. Just that he need to be represented by a guardian. He cannot be insolvent because he cannot incur liability only. How can his liabilities become more than asset? Impossible. Next one, no specific performance. Meaning, in a contract, you can never demand anything from a minor. You cannot say, sir, he promised to do. You cannot go to the court and say, sir, he promised, sir. Please tell him to fulfill the promise. You cannot fight against a minor. You cannot ask for it. Not possible. Next one, he can be an agent. In agency, we'll see this rule. He cannot bind parent or guardian. I cannot enter into a contract and say, my parents will come and pay the money. If you enter also, it is invalid. For example, imagine you are going for imagine Arivu, you came and attended a demo class. You attended 3 days demo and you said my parents will come and pay money. And you attended the class for another 1 month. Now, can we go and file a case and say that your parents have to pay us money? We cannot recover. Getting the point? You cannot bind your parents. Okay, next one. Joint contract. Major and a minor together borrowed loan. Major will be liable, minor will not be liable. Major will be liable for the complete amount. Same thing with surety also. If at all there is a person, minor has borrowed money, major has given a surety. Major will be liable, minor will not be liable. Shareholder, can a minor become a shareholder? Directly no, through a guardian yes. Liable for torts. What do you mean by torts? Civil wrong. If at all you do something mistake, I can file a case on you, you can be punishable. Except Indian contract. In any other case, you are liable. Getting it? You have a juvenile board and all. A person can be arrested.
They will keep in jail.
Jail. Yes, what is that? Master movie. Master movie. They made a movie only on that. It's a loophole. Whether it is good or bad, we don't know. But it's a loophole. Yes or no? If you tell a minor to kill, you cannot punish a minor in all the places. In fact, minor will be educated.
Yes, sir.
That's the whole movie of your Vijay Sethupathi and Vijay Talapati. Okay. Sound mind. Usually, a contract is to be entered by people of sound mind. Sound mind means a person who is able to understand whatever you are saying. Correct? Now, a person, if he is unsound, whenever you are unsound, you cannot enter into a contract. On a normal day, everyone will be sound mind only. That time you can enter into a contract. At some times, Friday nights, it will become unsound mind. Chetan Cheta. At times they will become unsound. That time, can you enter into a contract? No. So, whenever Atma meets Paramatma, you cannot enter into a contract. Yes or no? Unsound mind, right? A person who is not in a conscious decision, he is not able to understand anything. You cannot enter into a contract. Next one, whenever a person is usually unsound mind, it can be a person who is mentally ill. A person who is not able to understand what you are saying cannot enter into a contract usually, but can enter into a contract whenever they are sound intervals. Next one, people not disqualified. You cannot enter into a contract with foreign souvenirs or ambassadors. I'm not saying you cannot enter into a contract with foreigners. You can enter, but you cannot enter into a contract with Trumpo, or anyone who belongs to the sovereign, meaning government. Sovereign means what here? Government. Private people, you are free to do. Understand the purpose. We are telling here because if you screw up something, you are not screwing up your contract, you are screwing up a relationship with the country. Trump will increase tariff on India also. If we do that. Correct? He is increased, but China go Namgo, there is a lot of difference. If that much is increased to India, we all should shut down our business and go home. Seriously. China has made, I don't know, Bidi. Alien enemy. What is alien enemy? Example. Alien enemy and meaning is not Pakistan. They are examples. Alien enemy means Papada. Alien enemy means what, people? Alien enemy means a country with whom we have a war. You cannot enter into a contract with such citizens. Insolvent. A person who has been declared as an insolvent by the court is disqualified to enter into a contract. Remember, insolvency is not a permanent disease. Insolvency can be cured. It's a statement. What do you mean by that? A person can become rich again. It's possible. Yes. Next one, convict. A person who is arrested and in prison right now is called convict. When he is in jail, you cannot enter into a contract. Once he is out, you can. Sanjay Dutt did KGF only. Next one, corporation. Corporation, it's nothing but here we are speaking about ultra wires transaction. MOA. Ultra wires, sir.
Yes, sir.
Okay, we'll see in Companies Act. Next one, people, free consent. A person, whenever two parties are entering into a contract, The consent should be free or no? Meaning they should have not pushed you, they should not have forced you, compelled you to enter into a contract. That's the meaning of free. What do you mean by coercion? No one should have forced you. Coerce means what? Force. They should have not used force on you to enter into a contract. Force here means what? Doing anything which is punishable under IPC. Force here means what? They should not threaten you. They should not say if you don't sign the contract, I will shoot you. They should not say if you don't sign the contract, I'll kidnap you. Avella, you should not say. If you say, and that's why with the fear if they sign, is this contract valid? Then what will you call such contract as? Can you define what is voidable contract? A contract which is enforceable at the option of one party and not at the option of other. So only one person has a choice. If he decides the contract to be valid, it will be valid. If he says it is invalid, it is invalid. So everything is decided by one party. It is valid. Then it is valid. No, no. Understood? That's the meaning of voidable. We did not do voidable there. This is a voidable contract. Clear? Okay. Next one, undue influence. What is the difference between undue influence and coercion? In undue influence, there is always relationship, close relationship, and there is always one person in a dominant position who is influencing the decision. So there can be okay. So there is always a relationship and there is always one person in a dominant position. Example is what? A creditor, debtor, a doctor, a patient, a student, a teacher. Oh, sorry. Student. Today student teacher only, no da? Okay. In our days, teacher, student. Today, if school and all, if I don't know if they have sticks also, in the class you should not take stick, then namgella gottalva. We belong to the morally, physically, mentally suppressed society. Just because we did not say 5 5s are 25, capital punishment. Today we feel what did our teachers do with us? Okay. Okay. Next one. Undue influence. So always there is one party in a dominant position, one party in a inferior position. So remember, dominant position is not a sin, but if you abuse your dominance, then only this particular thing will come. So imagine I will come and say, Chetan, if you do not sell your bike to me, I will give 10 marks less in your class test. Now Chetan will start worrying, ayyo. Now Chetan will sell his bike to me. Now what will this contract be called as? It's called voidable. He has a choice. He can go to the court and cry. He can say, I was cheated. Now people, if at all he goes and proves, then people, he can get the bike back. This is called undue influence. Clear? Okay, next one, fraud. People, this mic is not working. I sold to you. What is this called as? This mic is not working. I just sold it to you. What is it called as? What is it called as? Fraud. Allah. Is it a fraud? It's a mistake? People, I knew it. I knew this mic was not working and I still sold it to you. What is it called as? I knew. Is this fraud? Is it valid contract? I knew it was not working. I only hit it like this and I sold it to you. What is this called? How many of you are still feeling it is valid? How many of you feel it is fraud? I knew it was not working and I sold it to you. Others, in Ilaya Talapati movie hakbeka illi. Hey, yes or no da? Is it fraud or not? How many of you think it is fraud? You put yourself here and think. Who thinks it is not fraud? Huh? Not fraud. Not fraud. Fraud. Not fraud. Not fraud is what you are saying. Okay. People, I'm telling, I will only hit like this and I'm selling it to you.
Fraud.
It's obviously fraud. Remember, people, the only question I will ask you, isn't it your common sense? Inge adjust ಮಾಡಿ it's working or not? You will not check kada. Isn't it your common sense to check before you buy? This is what is a concept. Caveat emptor. Let the buyer also have some sense. Sorry, let the buyer be aware. So people trust. Yes, people understood. No, remember, silence does not amount to fraud. When a seller is selling a product, it has defects. Seller need not disclose it. However, now let us imagine I'm selling a product. I'm selling this bench. What is this? This table. On this we have a laminate. Now inside this laminate there is a crack. On this they have put this laminate sheet and it is covered. Now I sell this to you.
Fraud.
Again silence only, no? Concealment of a particular thing. Concealment. You cannot check it out. See, buyer be aware. You will, if there is a scope for you to check, you need to check. How? And you will jump. Then how will you check it? So that's the difference. Silence does not directly amount to fraud, but there is an exception. Exception, caveat emptor. Let the buyer be aware. But in some contracts, even silence amounts to fraud. Marriage contracts, you cannot cheat any person. Side?
She did not say that she has side.
For that divorce, Anna? Okay, she did not say she has high power, so divorce it seems.
No, sir, silence only.
Silence?
She did not say after marriage.
But I say, like that, what all we can say, da? Okay.
Example.
I say no, da. It should be major. I said it's not there. We can cheating at other. Okay. Angandra, you guys know what and all you guys are doing. But all these are capital punishments only. Yes or no? So example, people, medical history. Imagine, in my close relative circle it had happened. The girl had fits, but it was never disclosed by the family. They hurried up the marriage. After the wedding, it was disclosed. They got to know, and they filed for divorce. On the grounds, yes, you're laughing. Papa, someone's life, humanity ne illa. Okay, understood? One is marriage contracts. Next one, insurance contracts. You cannot hide anything.
But what if the mic is purchasing from you? It is 10th mic. All 9 before 9 mics it was perfect. We bought the 10th mic also. It was checked.
Even then, it is your responsibility. You have to check because you cannot say it is. That's the thing, no? In next one, what will come? Contract of utmost good faith. So wherever trust is involved, that is also fraud. Now what is trust? Let us imagine a father is selling a mic to his son. Can it happen? Yes, it can happen. Now you think, will a son expect a father to cheat? The answer is no. At least today we do not stand in that day. Now a son has acted in a good faith because he knows father will never cheat me. But if he is cheated, kaise aadmi ho tum? So people, father has done fraud. It's a contract of utmost good faith. It's a Uberima Fidus. That is a contract of utmost good faith. Insurance contract and prospectus, share allotment contracts are the examples for Uberima Fidus. That is exceptions to silence amounts to fraud. Okay, last one, people. Misrepresentation. Was it misrepresentation? Then what is mistake? Oh, sorry, said by mistake. What is misrepresentation? Misrepresentation means, people, same example, I kept here. I wanted to sell this mic. I just went out. Mic was perfectly working. You know Chetan. When inside the class, when I'm not there, he'll come here, he will check everything. He will do all of this. Accidentally it fell. And you know Chetan what he'll do. He'll keep and he'll go. I'll come back.
It is there only. And now I'll come and say, people, this mic is for sale. Someone will ask, sir, is the mic working? I'll say, yes, it's working. Sir, is anything done? It's a no, everything is perfect. Has it fallen? No, 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 it's perfect. And I'll sell. After selling, you will know it is not working. Now you tell me, what I did, is it fraud? Then what I did? Misrepresentation. Misrepresentation means me telling something which I also feel it is true. Fraud means me telling something in spite of knowing it is not true. I say it is true. That's the difference between fraud and misrepresentation. Misrepresentation, even I don't know that it is working. I genuinely feel it is good. Getting it? All of you? Yes? Okay. Next one, people. Mistake. What is mistake? Ade sir, by mistake. What is mistake, da? By mistake only. Mistake can be of two types. One is mistake of fact, mistake of law. Mistake is nothing but you enter into a contract on a different terms. For example, A agreed to sell his car to B. B agreed to buy the car. Agreed. A was thinking, I am selling my Tata Nano for 2 lakh rupees. B is extremely happy. Why? He thought he is buying A's Mercedes Benz. Because the contract was for a car. Remember, mistake can also be considered as offer not being certain. It'll come under both. This will be called as mistake of fact. What do you mean mistake of law? Mistake of law? One way. You ignoring the presence of a law. If you go by a train, you cannot say, "Ayyo, sorry, sir." You know that what is the one express that recently came by in India? Train, Vande Bharat. One person when it recently launched, that influencer, he wanted to shoot a video inside. He did not take a ticket. He went inside. He was taking a video. Doors closed.
I want to go outside.
He wanted to go out. You know Vande Bharat. Here and there. That's all it will stop. Annapurna had to go to the destination by paying fine. Doors didn't open. So it will come here. No, we'll say, sir, by mistake, sir. I didn't know, sir, it will close off. I thought next stop at least I can get down. He had to pay the ticket. He had to pay the penalty. And he had to go to the destination also. He cannot say, "Ayyo, sir, between." You cannot. You are liable. You have to pay. He said, "No, I didn't know." You didn't know also you have to pay. Implied contract it is. If you travel, you need to pay. Yes or no? Mistake of fact. Understood? Sorry, mistake of law. Indian law, it is valid. It is enforceable. They can collect the money from you. What if it is foreign law? It is treated as mistake of fact. Mistake of fact can be two types. Unilateral, bilateral. If it's a bilateral mistake, void. This is an example for bilateral mistake. You are also thinking something, I am also thinking something. Unilateral mistake. Example. I ordered, say for example, for me it had happened. I had ordered one lamp from Agio. One lamp. This height 5 feet lamp. What I got was 2-inch bulb. They sent it to me. And it took me 1 month to return the product. They're telling this is not the product that is there here. That is what I said. Hey, this is not the product I also ordered. Agio. Yes, no. Geo, they took my life only. But yes, understood. Then I know which product I had to get. It was lamp. Unilateral mistake. I am with clarity. I know what I need to get. They don't know what they delivered. Unilateral, single person's mistake. Is it a contract valid or void? Valid contract. You cannot say, "Ayyo, sir, by mistake." Bitbidi. I need to get my product. Or I have a remedy. Mistake of foreign law is treated as mistake of fact. Both of them no. Void. One of them no. Valid. Understood all of you? Okay, next one. Legality of object and consideration. It will be considered as unlawful. Whenever, whatever agreements you have entered, it will be considered as unlawful if it is entered for this purpose. What and all? forbidden by law. Child marriage. Defeats the provision of law. Okay. Defeats the provision of law. What do you mean defeats the provision of law? You enter into an agreement. Say for example, I'm clearly telling that you cannot enter into a contract with a minor. But I'll enter into a contract with a minor. I'll make him sign one point. Indian Contract Act will not apply to this agreement. And I'm signing. Now will it apply or not? You cannot take away a right which is given by some law to you. Even if you sign it, it will still be valid only. A minor agreement is still void only. Understood? You cannot defeat some other law. Next one, fraudulent, smuggling. Involves injury to a person or a property. Take 5 lakh, go and destroy his building. Bomb hakbidu. We cannot, we shouldn't. Immoral. Correct? A gives money to B. Who is B? B is C's wife. A gives money or false promise to B. You divorce your husband and come. This is true. It's a legal case. One case, what happened? One person has influenced a wife and said, you divorce your existing husband and come, we'll get married. She divorced the existing husband and came, and this person did not marry that lady. And she suicide. She committed suicide. But the question was, can this person be accountable for it? Yes or no? Now, what is that we'll ask? What you did, is it right? What you did, is it that right? We'll not get into that and all. But yes, what happened in this particular case? You cannot say this. Is this contract? Let us imagine this B was still alive. Can B go and file a case on, yes, sir? What am I doing in life now? Can you go and ask for compensation? You cannot. It is immoral. This contract itself is immoral, is what they are telling. Understood? All of you. Consideration opposed to public policy. What are the considerations that is opposed to public policy? First one, trading with enemy. Alien enemy. Example was TikTok. All your apps and all that. What is that game? PUBG. That all is disqualified now, no? You cannot download it, right? Can you, TikTok you can download? No. You with VPN and all, I'm saying normally you cannot. Yes or no? Because China was taking away the data. Yes or no? Trafficking of public office and titles. What is trafficking? Selling. You cannot sell public offices and titles. What do you want to become? Commissioner, income tax officer, what do you want to become? I know, sir, what I want to become. Okay, 2 lakh rupees agate. Understood? You cannot sell it. What do you want to become? Sir, I want to become Padma Vibhushan. 5 lakhs agate. You cannot sell them. Agreed? Agreement creating monopoly. Vodafone and Vodafone Allah. Sorry, it's done and dusted. So sorry, no controversy. What is that? Airtel and Jio will enter into a merger. Is it okay? Our lives will just become ulta. They will tell call rates per month recharge is 10,000 rupees. You will say no. But where else you will go? You don't have a choice. Monopoly. Such agreements are against public policy. Next one, marriage brokerage agreements. You cannot broker a marriage. So remember, January 2025 attempt. This I have been telling as an example. Finally, they asked also. Marriage brokerage agreements is where one party, middleman, will go and speak on both the parties. He will convince them so that he will get his commission. Now, because he gets commission, he will say, yo, madam, Asti, 100 acres they have. Even if they sit and eat, 10 generations they can eat. What is he, beggar? No. Now the thing is, why did he tell all of this? Because he's getting his commission. Yes or no? Now, That's what they are telling. Such agreements are invalid. Then what does matrimony do? Matrimony will not convince you. Now imagine. Now, say for example, Chirag, now imagine Chirag will open one matrimony website. He will get registered on Shadi.com. Now in Shadi.com, now when he is opening, even one profile will not just come like this. Hi Chirag. They will not. All that they won't do. They don't get commission by doing that. Then what do? They have a data of all the girls and boys. That I'm seeing that is how it works. That's how it works. How does Shadi.com works? You pay money, you get 30 days time, you can access that website for 30 days. You can take details of, say for example, if you are looking for a girl, you can take the details of up to 10 girls with the subscription fees you have paid. And after that, you need to take it outside Shadi.com. You have to. I'm saying you have to contact them. Very confidential, I'm saying you have to contact. It is left to you. They will not come and promote. That and all will not happen. Understood? So that is valid or invalid? Matrimony sites is valid. In Jan they have asked. Jan 2025 question it is. Next one. Interest against obligation. What is interest against obligation? Now, let us imagine people. Arivu sends me to promote Arivu in some college to give an orientation. I'll stand on the stage. Our politicians will do this. They will work for Congress. They will promote BJP. Have you ever seen this? The politicians will come and say, Congress party, any party can say, no, I'm not taking any sides. But they will say, slip off. They will do no. Can you do that? You're not supposed to do that. That is what is interest against obligation. You're working for a company. I go and promote some other company on a stage. Can I do it? You're not supposed to. If at all you're taking money to do that, it is considered as interest against obligation. Understood? Such things are opposed to public policy. It creates rift. Okay, next one. Consideration unlawful in part. There is a whole contract. In that, half of it is legal, half of it is illegal. Legal part will be valid, illegal part will be void. Yes. Next one. Interference with course of justice. What do you mean by interference with course of justice? You give money to you give bribe to a witness. You will tell him not to come to the court tomorrow. You are basically stopping the justice, right? You are buying the opponent lawyer. What is the easiest way to win the case? No, you have to fight for it. You what mindset? Legal vandu varalla. Sir, pay that sir. No legal at all. Ella illegal. Okay, understood? Such things are not valid. So that means what? They can give you a case in a court. They can give you a case in the exam. What is that? They can ask you, imagine a witness has taken money from one of the party, that if I do not come to the court tomorrow, he has agreed to pay 1 lakh. He doesn't come. Can he recover that 1 lakh rupees? I will ask you. You need to write the provision as this. He cannot recover the money because this contract is interfering in the course of justice.
Can we write the provision as interest against obligation?
Interest against obligation, no. Interest against obligation is at one point you have entered into 2 contracts. Contracts are valid, but you are doing injustice to your role. Here you taking money is invalid only directly. Now for example, I have to tell you interest against obligation. I appoint a manager. Now we have printing department. We need books. I have appointed a manager to take papers, whoever is giving it as a cheaper cost. You give the contract to him and buy papers from them. Now what does my manager do? He takes quotations from 3 people. A says I will give you the paper at 100. He gives it 120. C says I will give it at 130. But C says, you give the contract to me, I'll give you 1% of the entire contract. Whatever I get, I'll give you 1%. Now, whom will my manager select? But whom should he select? This is only called as creating an interest against your obligation. Your obligation is what? To do something good for the company. But what is the interest you created? Something which is beneficial for you. Such contracts are opposed to public policy. If you look at it, individually they are valid. But in your role, you have to favor to one, not both. Understood? Huh? Okay, next one. Stifling prosecution. Stifle. What do you mean by stifle or stifling of prosecution? You cannot trade a felony. Felony means crime. Course of justice is what? You buying the witness. You buying a lawyer. You buying a judge only. I don't know. Yes, sir. Now that is what interference means. What? You're stopping the way the case is going. Stifling of prosecution means what? Settlement. You're directly going to the opponent party. A killed B. B's family, A offered settlement. You do not go to the court. You do not complain at all. I will give you guys 1 crore rupees. You settle it off here. Can they settle?
No, sir.
I told you, criminal offences can never be settled. Civil can be settled. Civil means what? Something which can be dealt with money can be settled. Dealt with money means I had to recover 1 lakh rupees from you. Now you come and hit my vehicle with your bike. We can settle it. You need not go to the court for this. But if it is criminal, you can never settle. Theft, robbery, kidnap, murders, all this cannot be settled. Burglary. Burglary means what? Chain snatching. Imagine they're snatched. You immediately click the picture. You say, sorry. You don't complain, I'll give you back the chain. You agreed. Now can you complain? Can you complain? Yes. You have to. That's what they're telling you. You cannot settle the crime. It's a crime. Getting it just because you got back your chain, you should not say, okay, we'll leave it. Getting the point, it is your duty to go and complain.
But they will give me.
See, one, I'll explain you law. In reality, will it happen? Maybe. I will say police will not take bribe. In reality, also they will not take, no? They will take? Are they taking? Anyone tell me your name, I'll tell whether they are taking or not. Tell, are they taking? Are they taking? Who is selling? What is your name? Adu, this is our country. Okay. This is only called as known secrets, open secrets. Okay. Maintenance and champerty. What do you mean by maintenance and champerty? Whenever someone helps you to fight your legal case in the court. Now, for example, a person, imagine is a poor person. He doesn't know how to fight. He doesn't have money to fight. You want AC? You've turned off, huh? He's confused. You do something, sir. You want it? I'll give you the remote. You want? Take it. If you have a button, press it off. No, right? You opened it, but the air should come, no? For that, you should press on. No? It's on. It's on. He's again showing the same thing. Yede no bantu. Okay. You know, Madri. ಆಯ್ತಾ ನಿಮ್ AC adjustments ಆಗಿದ್ರೆ. Okay, what is maintenance and champerty? There is a poor person doesn't have money to fight a legal case. I give money for this person to go and fight a legal case. Now, what is this called as? Help. It is not at maintenance and champerty. Very posh English. It's a proper help. When will it be called a maintenance and champerty? Now I'll go and tell him, I will help you now. But you know what? Once you win the case, I need 50% of what you win. This is called Allah agreed. Yes, but yes, this is called what people champerty.
But lawyer can take it.
In India, we are not supposed to take a fees which is based upon percentages. It's not actually directly valid. If you want to charge upfront,
Sir, that's professional.
professional ethics and like that. But okay, let us imagine someone is helping you, but they are expecting something very less in return. You win. I want 10% of your case. Now, this is only called as maintenance and champerty. Now, sir, this is good only, no, sir. Someone is helping. Why is it coming under opposed to public policy? It is becoming opposed to public policy if what you're expecting is unreasonable. If it is reasonable, meaning I'm asking 10% or I'm asking my money back with interest. Now, this is reasonable. It is not opposed to public policy. Those contracts are valid and enforceable in court. I gave my money, I asked my money with interest. Is it good or bad? It's good only. I'm helping you. You won the case, you pay me with interest. It's good only. Now I give money, I'll say you give half of your property. He will say enough or you want kidney also. There is always a reasonability, right? Now that is when it becomes opposed to public policy. Agreed? Yes? Okay. The last one, sir. See, maintenance and champerty are valid, generally valid, unless it is unreasonable and made with malicious motive. What do you mean by malicious? Malicious. Bad intention. That is, you helped him not to help him. I don't like that person. I don't like the third party. That's why I'm giving him. I'm provoking him to go and file a case. Your intention is wrong. We will not support you. Getting it? All of you are understanding it, huh? Okay. Huh? All of you are understanding? Backbenchers, so. Yes? Anyone physically present? Atma is going around and coming? No? No exorcism? No? Okay. Next one, people. Wagering agreement. What do you mean by wagering agreement, people? Nothing but gambling. Wager means nothing but people bet. Correct? In India, betting is void, it is illegal and hence unenforceable. In class we have seen,
But states can.
yes, in classes we have seen people, state governments, it's a state specific law. In some states, betting is valid. Goa, Kerala, you will lottery is valid in Kerala. But because we have only Central Act, I'm discussing only with regards to Indian Contract Act. As per Indian Contract Act, it is void, it is unenforceable. We have online gambling itself is one more act. Yes? Yes, sir. Lottery transactions are illegal in India and hence punishable. This is as per Indian Contract Act. If lottery is run by government of India, it is still a wager only. But you will not punish the person who is conducting it. Will it be done? Yeah. In Kerala, all state government has it. Yes, no? I was also shocked. When I went to Kerala, if I am not wrong, every third shop, you will get lottery ticket. There will be specific shops for lottery tickets. Yes? So it is legal. In Kerala, it is legal. Because state specific act it is.
That they can go by there and come here.
Yeah.
But recovery will be there only, no? So it will be...
We can go there and recover.
You are saying you will buy and come here. You will take money also after going there.
After I don't know whether I will win or not. I simply bought and came, sir.
That's
I
okay.
got money, so I went back.
Possible,
and
yes, yes.
spent it here.
Yes, possible. But you need to go and collect the money from there only. Is it clear of you? Yes. But as per Indian Contract Act, it is illegal. There is one whole state running with gambling. Goa. Casino. Ade, Kavade. You put no. That only in posh is called as casino. Nothing but Ludo only. Andar bahar.
They'll keep in ship.
Huh?
They'll keep in ship. They'll take.
They'll put it in ship, charge 5,000 more with tax. And they'll give water, tender coconut, mojito,
Sprinkling water.
J silent. That only they will do, no? Sprinkling water. Nothing but soda. Even I realized. I got to know sparkling water or sprinkling water means it's soda. Nothing but soda. Kinless soda. 20 rupees. 180 rupees they charged. I thought some water. This Kohli, no, someone they'll be drinking, no. I thought they'll give me that water. Soda kottu, they took 180 rupees. Extortion it is. I really. Okay. Crossword puzzle. What is crossword puzzle done? Sudoku. And they will put this blanks will be there. They will give hint. You need to answer. But have you ever thought the hint will be there? Answer can be two things. Agreed? I hope you are able to connect to what I am saying. They would be given 5-letter word. And what is that word? They would have given a hint. But if you actually think, now in generally my home what happens, my mom will be asking this. I'll be telling one answer. She'll say, no, it's wrong. I said, you tell me what is it, I'll tell that only. What is right according to me, as per that hint I will tell, that will also fit there. Yes or no? Now, you need to be lucky to tell the exact word what the creator of the crossword puzzle is he thinking. Even if I am also able to tell that, then it's a luck. When is it I'm winning with skill? It's a luck. Or imagine, all of us will solve a crossword. They will put it in a dabba. All our winners list, they will put it in a dabba. Jaga. They will take. Now if at all my name is coming here, then it's a luck. I did not win because of skill. If like that the winner is decided, crossword puzzle will be considered as a gamble. No sir, first come first serve. Now I'll create a crossword puzzle in the class. Whoever solves first, I'll give you the money. That's all. I do not have a pre-solved nothing. Whoever is solving first, fastest fingers first. You are coming here because of your skill. It's not a gamble. Provided the prize money does not exceed 1,000 rupees. Even if it is skill, if prize money is 2,000, it's a gamble. Understood? Huh? So when will a crossword puzzle become gamble? When a winner is decided by luck, if the prize money exceeds 1,000, it's a gamble. Next one, speculative transaction. Nothing but people, share market. If you do it inside the share market, it is valid. But imagine two idiots seeing a monitor and they're settling the money here. That is a bet. Getting the point, huh? Next one, horse race. Dream level. That's what all this come under online betting apps.
They won't invest, but they will see that graph and they will predict.
Dream level, you invest in the app, right?
Yes, sir. Yes, sir.
You have to invest in the app. 49 rupees, 59 rupees.
Bitcoin will be, it will be going up and down,
Trading is telling, sir. In trading.
Trading. You said dream level.
Sir, some apps, it will go up and down.
Share market.
Normally, they show Bitcoin, sir. At 10, it is this much value. If we have to predict and take the amount.
Not illegal.
Fraud.
But it is legal app.
It's legal only.
Yes, sir. Probo.
Probo. Okay, now people, once again, what I'm saying, I'm not saying gambling is illegal. If that is the case, dream level is also illegal only, no? Gamble only, no? What is that? 823 Rummy Circle. All of these are gambling only. For this, we have different acts. We are only seeing from Indian Contract Act. Actually, in reality, will this act govern all this? The answer is no. That's what I said. Kerala was an example. As per Indian Contract Act, it is invalid. But as per state governments, Kerala State Government Act, it is valid. Clear? Okay. Next one. Transactions resembling wager but still considered as valid. One is chit fund, share market transaction, game of skill does not exceed 1,000 rupees, contract of insurance. We'll be seeing in indemnity and guarantee. Then now, Okay, next one, unit 4, performance of contract. Performance of a contract, people, can be of two types. One is actual, one is attempted. What do you mean actual? When a party has performed his obligation, it's called as actual performance. Actual is always, people, executed contract. Obligations are done. Next one, people, attempted performance. Attempted means, people, you take Flipkart, I try to deliver to your address, you did not pick the call or you were not present at the address, they will go back. Attempted, meaning one party tried to fulfill his obligation but the other party did not accept it. Whoever tried, they are free from the obligation. Understood? Yes? Okay. Next one, who can perform the contract? Whoever has promised should perform the contract. Promiser himself. In a contract, A said I will give you 5,000 rupees. A only has to give 5,000 rupees. Agreed? But at times what will happen, let us imagine A and B. B agreed to draw something. He is an artist. He agreed to draw something and give it to A. But B died. Who is a promiser here? B. Technically, as per our first point, who should deliver? Promiser only should deliver. Now he is passed away. Who will deliver? Legal representative. Yes or no?
No.
Yes, sir.
It's a skill and hence dies with the person and hence it's a void contract. Impossibility of performance, subsequent impossibility. And what is this? It's a void contract because skill is there. Imagine it's a loan. Just delivery is different. Now let us imagine, people, on OLX, in my home there was one, a painting. There is A who has taken a picture of it and he has posted it on OLX. Now A passed away. B replied, I want that post. And A had agreed also and passed away now. Now he has come to the home to collect it. Now the question is A's legal representatives, are they liable to give it? Yes, it does not require skill. Of course you need the skill to take it out of the nail. But or else it does not require any other skill. So is it valid? Yes. Who will perform it? Legal representative. That's the second person. Remember, whenever there is any special skill or confidence involved, then if the party dies, the contract dies with that person. It becomes a void contract. If it does not involve any special skill, the contract should be performed by a legal representative. Imagine money is taken, loan. A took loan and A died. A's legal representatives should repay, provided it will only be to the extent of assets inherited. How much ever assets A's legal representative got from A, only to that extent the liabilities also will pass on.
Sir, at the time of death or else before property that he passed also will be liability.
Yes, whatever at the time of death.
Before making contract only he transferred some 100 acres to his son. After contract he did so.
Then no. Inheritance means what? After death whatever comes, only that will be considered as the father's property. Before death if you have transferred, that will not be considered as father's property. Now on the date of the death it is your property.
Then that's true.
Yes. Clear? Next one, agent. I can only do or I can appoint an agent and enter into a contract. Possible, no?
Yes, sir.
Next one, third person. Chennai versus Ramaya. I took loan, my friend will repay. All of this is possible? Yes, possible. Imagine, people, A entered into a contract with Anirudh. Hukum. Now people, Anirudh obviously is performing hukum in more than one place. He did not come to our place. Anirudh sent one more singer in his place. Who? Let us imagine Arjit Singh came. Yes? Arjun Reddy Allah, Arjit Singh. Yes, na? Now people, Anirudh should have come. Specific contract. Hello. Now, Anirudh did not come. What is the right A has? What right does A have? A has a right to cancel the contract immediately and claim compensation. Now, I did not cancel. I left the contract open. Instead of Anirudh, Arjit Singh came. Arjit Singh came and performed. A did not speak anything. Later, he wants to file a case on Anirudh. He wants to claim compensation. Can he file? Remember, if you have accepted the contract from the third party, later you cannot enforce it again on the party to the contract. If you have accepted the performance from Arjit Singh, you cannot again go back and file a case on Anirudh. You have accepted it. If you want to stop, you stop it there only. Are you getting the point? Exam question it is. Anirudh Allah, A and B they will ask. Next one, joint promisor. What is joint promisor? Two people took loan together from one party. They took 5 lakh. In between them, they agreed to share it 2.5 lakh each. When we have to repay, how much should we repay? We have to repay 5 lakh only. Imagine one person became insolvent. How much will you repay? 5 lakh or 2.5 lakh? Okay, let us imagine insolvent Allah. One person passed away. Legal representative has to pay 2.5 lakh and this person has to pay 2.5 lakh.
He will pay 5 lakh, sir. He will recover from legal representative.
Okay, he will pay 5 lakh, he will recover from 2.5 lakh from the legal representative. Huh? Okay. Got it. Yes. Yes, sir. But end of the day, legal representative, will he be liable? Answer is yes, will be liable. Up to the value of the asset inherited. That also you need to remember. Agreed? Yes. Sir, what if there are two people who have given loan? Same rule will apply. Instead of two people taking loan, two people gave loan. Now I have a right to recover the complete money. If this person dies, his legal representative will get the money. Clear? All of you going inside Ada? Okay, rule over the joint promises.
Sir, limitation act will work here, sir. At the time of taking loan.
Yes. It will apply. 3 years is 3 years only.
Legal representative doesn't know until 3 years that his father should get that money. After 3 years,
Exceptional cases, they will give you a waiver, but not beyond very crazy time. Generally, now I'll tell you, if you have to go to High Court, you have to go within 45 days. If you could not go within 45 days, extension of another 45 days will be given. So extension will be given, but it will not be very crazy days and all. Medical grounds and all that, yes, still they will consider. But not because of lack of awareness, no. Time and place for performance of the contract, where will you perform? As per the contract, if nothing is agreed in the contract, reasonable. If what time you will deliver the contract? Business hours. If nothing is prescribed, it is your responsibility to ask and deliver at the reasonable time and at the reasonable place. Agreed? Okay. Next one, reciprocal promises. What is reciprocal promises, da? What is a reciprocal promise? Hello? What is reciprocal promises? Future contracts are called as reciprocal promises, also called as bilateral executory contract. Hello? What do you mean by bilateral executory contract? Amazon says, I will deliver it to you after 5 days. So today, Amazon is promising to deliver after 5 days. Today, this person also delivers. This person also promises, I will deliver the money whenever you deliver the goods. Amazon is also promising, customer is also promising, when? Today, to deliver and pay the money in the future. Such type of contracts where both the parties are exchanging only promises and not the goods and money. We call such things as what? Reciprocal promises.
is it a contract?
Reciprocal, yes, it's a contract. Executory, no? We saw in consideration. Consideration can be past, present or future. Valid only. Clear all of you? Now what is the rule of reciprocal promise here? Promise are not bound to perform unless reciprocal promise ready and willing to perform. Amazon will not deliver it to you until and unless you are willing to pay the money for it. Simple. When one fails to perform, he cannot compel other party to perform. I did not give money, but I will tell, hey, you give the, I will not pay, but you have to give your mobile. Can you say that?
No.
Answer is no. When you did not perform, you cannot compel the other party to perform. Simple. Performance. Who should give first? Whether Amazon should give first or money should be given first. As per Amazon policies, money should be given first, only then the product will be delivered. That is a policy. Sir, what if contract is silent? If contract is silent, people go as per the nature of transactions. What do you mean nature of transaction? If you
We did that do now also.
correct. Now you look at the industry, how it is working. Say for example, hotel. You have pay and eat. Nowhere it's a rule, but that's what everyone is following. You first pay, they will give you one cheaty. You go and say, Anna, masala dosa roast. Correct? Second one, you go sit, you eat and then eat. Both are followed. So what is the order of performance? You go as per the transaction, as per the nature of transaction. If contract is silent, building contracts, construction contracts, money will be paid after. First the money will be paid and then one slab will be done and then money will be paid. Next floor will be done. No one will give the entire money at once. It will always be given in EMIs. You perform, they perform. You perform, they perform. That's how it is. Getting it? That's the nature of transaction. Hello? Reciprocal promises which are legal in part. If severable. No. Understood? Huh? If at all in a contract, we have two parts. Half of it legal, half of it illegal. Agricultural land. ಅಲ್ಲ ಇಲ್ಲಿ ಯು ಗ್ರೂ ಇದು ಏನದು ಹಿಯರ್ there is brinjal. Here ಏನೋ ಒಂದು ಇದು ಹೇಳು ಏ ಗಾಂಜ ಎಲ್ಲಿಗೆ ಹೋಯ್ತು ಇದು ಬೆಳೆಯೋ ಅಂದ್ರೆ ಹಾಕಿ I know you want to become rich. Okay. So there is a contract. Imagine lease of a land. You have given a land for lease to cultivate. Half of it you have grown some paddy or brinjal. Other half white powder. So sir, the question is, can I recover the rent for this part? Yes. Contract is separable. In the same piece of land, you have done half legal, half illegal. You cannot say I will not pay the rent for both. He can say I can recover it because it's brinjal. Here, you cannot. Understanding it? That's what they are telling you. Wherever there is a contract involving separable contracts, half of it legal, half of it illegal, legal part is enforceable. Next one, liability of party preventing. Contract becomes voidable and entitled for compensation. Liability for party preventing the event means people. Now, what do you mean by this? I think I've given you an example also. Let us imagine people. I book on Urban Company. You have that app, Urban Company,
Yes.
where you can book the service of the technicians. Let us imagine I wanted to paint this entire wall. Now, what I'll do? I have an option to book a service of a particular person from an app called as Urban Company. I'll say tomorrow 10 o'clock is a slot. You please come. Remember, they just come for giving the service. What is that? Now imagine I've called them to paint this wall. They will not bring this, paint. It's on me. Because I've just booked the service for service. That's what I've booked. He will not bring me the, what do you call this? The paint box. Materials will not be brought by him. Now he came. It was my default. I did not get the paint on time. Now he came. Now he is here. I did not give him the paint. He had to go back. Now he is charging me money. I said, why will I pay? You have not done anything. Now you tell me, can he charge me money or not? This is the meaning of party preventing other party from doing a contract. I am only preventing him, no? Who is a whole cause for this? It's me. He came as per the contract. I did not give what I told I will give. Now, can he, what can he do? He can treat the contract as voidable. He can go back. He can claim for compensation for coming. Hello? I hope you are able to understand. Next one. Impossible act. We have seen this. Initially only impossible. It becomes void. Of course, it depends upon whether both of them know, one person knows. If both of them know, it will become void agreement. Subsequent impossibility, death, change of law, voidable. For example, Gujarat, all of a sudden they said dry state. What about the people who have entered into rental agreements to start a bar? What about the people who have taken license to sell alcohol? What will happen to all these? It's a void contract, change of law. You have to go with it. You don't have a choice. KKR, Kolkata Knight Riders, had taken Shoaib Akhtar for 5 years. Shoaib Akhtar. You know Shoaib Akhtar? Shoaib Akhtar gotilva. You know cricket. Okay.
Sir, that does not come at alien
Enemy only.
How they made such contract?
No, India-Pakistan was always not alien enemies. Now today is India-Pakistan alien enemy? Today it is fine. So it's not like once it's an alien enemy, forever it's an alien enemy. They'll be friends. They'll again put bomb in that friendship. Well, it's a usual game. Illa? So whenever some heated affairs happen at the border, we declare a war. That is when it become alien enemies.
That time Shoaib Akhtar will go to Pakistan.
Now he's in Pakistan only.
That time of playing will come.
So I'll tell you, do not get confused. In general, whenever the country declare the other country as alien enemy, only that time contracts become void. With regards to cricket, BCCI took a stance. Indians will not go to Pakistan. It is never. That's why recent Champions Trophy. Gottal. All Indian games happened in Dubai, noda. Why? Because of that only. The power of money, da. India said only one simple thing. Champions Trophy was being conducted in Pakistan. India said simple thing. If you play it in Pakistan, we won't come. For a country, it's not a big thing. They can say, okay, we will play with other countries. Correct? No. Simple, da. You conduct, but people won't watch. Broadcasting rights. We want Indians to watch. So no satellite channels came to purchase Champions Trophy rights. If Indians do not watch it. Inge, power of money. 143 na. 150 it became. 150 it became. Yeah. Now 151. Yes, sir. So it is going on. Now people, that's the power. That's why all Indian matches were held in secondary India. Sorry, Dubai. That's India only. Okay. Understood. Next one. Effect of failure to perform. Time is essential. Time is not essential. Check an example. What are the example? Da? Marriage suitor. So, what is time is essential? Whenever you buy something, at times people, time is very essential. They have to deliver it by that time. If they deliver it after that, what is the use? So, whenever time is essential, if the product does not reach you on time, you have a right to cancel the contract. That is, get back your money and say, I do not want your product forever, and I can also claim compensation. At times, time is not essential. What do you mean time is essential, not essential? Imagine you have ordered some dress for your wedding. Wedding will postpone, huh? Based upon your dress? No. Then the dress has to arrive by the time of wedding. Imagine it comes after the wedding. You have a right to cancel. I'll say I will not buy it. And you have a right to claim compensation also. Imagine where time is not essential. You're casually shopping on Myntra. And they will deliver it to you. They said they will deliver you in 3 days. But they delivered you on 4th day. Okay, it's a delay only. But because of that, what, Trump lost elections or what?
No, sir.
Nothing happened, but you lost. It's actually true. For that, they will give you compensation, but you cannot cancel the contract. Meaning you have to take that shirt. They will give you compensation, but you cannot cancel it. If time is essential, you can cancel it. Getting it? Hello? Now, people, this compensation, what type of compensation will ask? What type? Vindictive is revenge.
Nominal damages.
Very good. Nominal damages. Have really not suffered any damage. Some, even giving me 50 rupees also, I'll be happy. Yes or no? Zomato order. So these things will come here. Understood? Hello? Done. Appropriation of payment. What is the appropriation of payment? When a debtor has taken loans from a creditor, he has taken more than one loan. Let us imagine he has taken 3 loans. One is 1 lakh, one is 2 lakh, one is 35,000. Now when debtor is repaying the money to the creditor, when he is repaying, A has an option to choose which loan I am repaying. You can choose 1 lakh first, you can choose 35 first, you can choose 2 lakh also first. It is your choice. So this is called as appropriation. When I have taken multiple loans, I can repay the loan in the any order I want. The first option is given to the debtor. Clear? All of you? I can either choose verbally, I am saying I am repaying 1 lakh loan, or I can choose it based upon circumstance. What do you mean circumstance? Imagine I give you a check for exactly 35,000 and I won't say anything. Towards what or towards which transaction you will take this 35,000? This is circumstance. Because the money is so odd, 35,000, and I am repaying also exactly 35,000. So you are indicating that you are repaying the third loan first. Getting it? Exam question. The first one, this one only, circumstance. If at all any circumstance indicates. Circumstance indicates means you repaying the exact amount. Circumstance. First one, debtor chooses. Second one, circumstance. See, if debtor also didn't choose, circumstance also did not choose anything. Imagine you exactly repay 20k. Nothing is 20 here. Now what will you do? It is left to the creditor. Now what if creditor also did not say anything? You will go as per FIFO. First in, first out. Whatever the first transaction, 1 lakh, you will take towards 1 lakh. Clear all of you? Hello? You can expect a question there. Next one, contracts which need not be performed. What is this, people? It's nothing but a contract once entered. The old contract they're telling you need not perform, it seems. What are those contracts? First one, novation. Novation means what? Old contract getting replaced by a new contract. A and B had entered into one contract. Now in this, we are keeping aside this contract. We are introducing new contract between us. Old contract need not be performed anymore. Next one is called as alteration. Alteration means what? In the old contract, A told B, you need to pay interest 10%. Now for this, they are making some change. They are making 10 as 8%. Now going forward, I need not pay 10. I will pay 8 only. Old contract need not be performed. Hello? Yes. Alteration. What is the difference between alteration and novation? Alteration? Changes the original contract. Okay. What is novation? Novation, a new contract comes into picture. Remember, alteration is change of terms in the existing contract. Novation, altogether a contract gets replaced. Specifically, let us imagine a party gets changed. The contract was initially between A and B. Now C says, I will repay B's loan. Can it happen?
Yes, sir.
I have purchased a house with a loan. After 2 years, I want to sell that house. The loan is still there. Who will repay? Whoever is the buyer, he will have to repay that loan. That is how it happens. Didn't understand. I took a house. A purchased a house on a loan from ICICI Bank. How much is the loan? 1 crore. Every month EMI of 70,000 should be paid. Now after 5 years, A transferred to a different location. A sold his house to B for how much? 1 crore. That is the value he quoted. Now entire 1 crore A won't take. Imagine if A has taken entire 1 crore, he will take whatever he has already paid as EMI, rest of the amount he will give to ICICI and the loan is done. Let us imagine B says, I don't have so much of money. Even I will also pay EMI only. Now what they will do? They will do something called as loan transfer. Whatever was in the name of A gets transferred to the name of B. Same terms. He was paying 70k till now. Now you will pay 70k. Now if you look at it, agreement is as it is. Same property, same bank, everything is same. A was paying, now B will pay. Now what will you call it as? Alteration or novation? Alteration only, right? Because in the existing agreement there is a change happening. Yes or no? No. Change of party can never be called as an alteration. If a party changes, you need to always call it as novation. It's just one name changed. I understand. But the whole contract itself will change off. Change of name is always a novation. Any other change, you can take it as alteration. Is clear? Pakka?
Yes, sir.
Okay, that is alteration. Next one is recession. What do you mean recession? Cancellation of a contract. When a party does not perform the contract within time, you guys have a right to cancel the contract. Cancel means what? Today I am saying I do not want your product anymore. Give back my money and don't bring your product tomorrow. I will not be under an obligation to buy it. You don't bring it at all. Getting it? Okay, next one. Remission. Remission means what? Waiver. Giving up your right. A has to repay ICICI total loan of, let us imagine, 10 lakhs. A doesn't have money. After 2 years, after fighting everything, finally ICICI says, okay, do one thing, how much money you have? A says, I have 6 lakh. Okay, do one thing, you give 6 lakh only, let us settle the matter. A gave 6 lakh. They settled the matter. They left it there. Means what? ICICI felt 6 lakh is better than nothing. So ICICI took 6 lakh and left the matter. Now imagine tomorrow after some days A earned money. Can ICICI go back and ask that 4 lakh back? No. Legally you guys have put an end to that 4 lakh in the form of settlement. Now that settlement is called as remission. Remission means nothing but to give up your right. You had a right on this 4 lakh. You gave up your right on that. This is called as what? Remission. Is clear? Hello?
Yes, sir.
Understanding? Next one, promiser need not perform when promisee neglects the performance. You can take the same example of urban company. I was willing to perform. The other party neglects his performance. Paint. That paint example. You can take the same thing. You can take teacher student example also. Teacher is willing to perform. Teacher says I will give you 100 marks. Student does not revise and come. Student neglects the performance. Teacher is not bound by the contract. Understood? Okay. Discharge of a contract can get discharged by performance, meaning when does a contract come to an end? You perform your obligations, it's done. Mutual agreement, waiver, neglect, we saw up. Impossibility by performance, we already seen. Initial, subsequent. Discharge by lapse of time, within time if you do not do. This is nothing but time bar debt. If you do not go to the court within time. Next one, by operation of law. What do you mean operation of law? Change of law, death, etc. Breach of contract, next unit. Merger of rights, what is merger of rights? What is merger of rights? What is merger of rights?
Rent. So I'm paying rent to a property, then I purchase it.
Correct. What is merger of rights? That's an example. What is merger?
Coming together. Take rent for rent.
Example ಅದು. Example. ಇದೇನೆ I tell. You guys will remember the example and not the concept. Tell merger of rights means nothing but people, one party enters into two contracts with the same person and both the contracts will coincide. Hello?
Yes, sir.
What do you mean merger? So now you tell the example. What do you mean by coincide? There is a person who is staying in a property for lease for 5 years. You take Arivu only. This property has worked out really good for Arivu. We have taken a lease for 5 years. After 2 years, because of good dhanabhagya of students, Arivu got good money. Arivu just called the owner and said, "Hey, why da lease and all? Come here. We want to buy this property." After 2 years, technically you have a lease for 5 years. After 2 years, we give him an amount which he cannot deny. He said, "Okay, I don't mind." Now Arivu purchased the property from the same person. We entered into a sale deed. Hello?
Yes, sir.
So there is a sale deed, there is a rental agreement. Correct? Huh? Same parties, two contracts. Now according to the contract, I am a tenant also. According to this contract, I am a owner also. That means what? I should pay rent to me. How is it possible? This is only called as merger of rights. Understood? One person entitled for two things. In such case, what will happen? In both the contracts, whichsoever is a superior contract, that will prevail. Rent is superior, sale is superior. Sale is superior. Sale will override rental agreement. Rental agreement will automatically come to an end. You need not perform this contract.
Yes.
Understood?
Yes, sir.
Yes? Pakka? That is this particular chapter. Okay, unit 5. Taka. Breach of contract and remedies. Breach of contract means what, sir? There is a breach of contract. What do you mean by that? ಏನು ಏನ್ ಹೇಳಿ ಸರ್ ಅಂದ್ರೆ ವಾಟ್ ಇಸ್ ಬ್ರೀಚ್ ಆಫ್ ಕಾಂಟ್ರಾಕ್ಟ್ ಟರ್ಮ್ಸ್ ಅಂಡ್ ಕಂಡೀಷನ್ಸ್ ಆರ್ ನಾಟ್ ಫಾಲೋಡ್ ಓಕೆ ಏನ ಜಿ ಡಿ ನಡೀತಿದ್ಯನ್ರು
Can we take 5 minutes break?
You want 5 minutes break? 12:30 or 12:40 we'll go for lunch only. Huh? Now what we are doing unit 5, no? After unit 6 we'll take for a break. Hey, easy only, da. I think we'll be done in 20 minutes. Max. Both the units. Okay? If you want a quick inge on snap, then just go for some 2 minutes break and come back. Or if you guys can sit, we can sit. 2 minutes break? Okay, go back and come. Okay, on a whole, I'll just tell off. Actual breaches, people, which you guys are ending a contract on the day of a contract, when the contract is going on. Next one is called as anticipatory breach. Anticipatory breach means when a party informs to you prior to the date of the contract, I will not be able to perform the contract. Now people, anticipatory breach, you will have two remedies. One, immediately cancel, claim compensation. Next one, cancel on a future day, claim compensation. Here it comes with a risk. What is that? Imagine on 15th of April, I did not cancel the contract. The contract was entered on 10th. It has to be delivered on 20th. 15th, he called and said, I am not able to deliver the product as promised. Now you have a right to cancel immediately. Or you can cancel on 20th and claim compensation. What is the risk of not cancelling immediately, but cancelling on the last day and then claiming compensation? What is the risk? The risk is, imagine if this factory catches fire, if it burns. Now the party will not be able to perform the contract. It is called as what? Supervening impossibility. The contract will become void. What if contract becomes void? You cannot claim compensation. If you had cancelled immediately, you would have got compensation. Now you will not get compensation. Simple. Hello?
Yes, sir.
There is a case also. Rochester versus Delatur. What is the case? A person called up, okay, there is a French person who wanted to come to India. On 1st Jan 26, he called and said, I want to visit India on 1st June 2026. Can you please accompany me as a guide for the next 6 months? This person agreed. I will accompany you as a guide. On 1st April 26, he again called and said, there's a change in plan. I'm not visiting India. Now the guide wants to file a case on him and recover some money as compensation. The question is, can the guide recover the money as compensation? Is it possible? Is it possible?
Yes, sir.
Can he recover? The reason is, first of all, the performance will start from 1st June, right? 1st April is intimating. How will you be able to recover compensation? He's telling you we never started the contract only.
No, sir.
Sir, if you have slots, I will get.
So remember people, contract started from the day you gave an offer, from the day he gave an acceptance, contract started. Agreed? Not from the day you actually give your services, from the day you said offer plus acceptance, contract started. Agreed, huh? So from this day to this day, for how many people he would have said, no, not possible. I'm already, occupied for that season. I've lost some money. So can I recover money, compensation? Yes, possible. Understood? Okay, done. Rochester versus Delatur. Next one, sir. What are the remedies for breach of contract? What are the remedies done? Suit for damages. What are all damages I can recover? One is general or ordinary. What do you mean general or ordinary? As I speak, I don't know, I told you no. Yesterday, this week I had traveled to one place. Last Monday. I was going in this train. Two-tier you call it, right? Two-tier AC. What is that? Two-tier AC only? In that I was traveling. So I kept my bag underneath the seat. This is Monday it is. So on the bag, there are these rat bites. 8 bites are there. Rat bites. So now I have written an email for IRCTC asking for compensation for this particular lack of service. I paid not to travel with rats. I'm saying real life. This Monday only it happened. Now it's going on. They said we have forwarded your thing to a concerned team. I'm yet to hear. If not, consumer forum only. Battalva. You also put. You only bite and put. Case means consumer forum.
It takes time, sir. We cannot settle.
What will take time? You have to go with it. It's not like non president today only your hearing will happen. You have to have that patience.
Damages for patients also.
Yeah. Now I'm claiming mental trauma and all. Yes, and I'm saying what is that? Unhygiene. And I'm saying it's two-tier AC. You're charging bomb only there. And then
So how many months can take to solve this problem?
can go up to 6 months.
How much compensation you get, sir?
When they give, it will be the product's cost. I'll be okay, I'll be happy only. My bag, I'll get product, I'm happy. That's what will solve my issue. If not, it becomes anger. You could have settled. I'm right in what I'm asking. You correct me if I'm wrong. Am I wrong in what I'm asking? No. I'm right in what I'm asking. And I'll ask. If it's my right, I will definitely ask. Wherever it is, I'll ask. Yes? Clear? Okay. Now what I'm asking for general damages. That's the word yesterday, in that thing I've mentioned. It's general damages. What is general damages? So, perfect. Now I'll tell you. You tell me in IRCTC where will you keep the bags? You show me a place. That's it.
Next to you have to book one more seat if you're carrying a luggage.
Oh,
I don't know if you guys know it. There is luggage restriction, but it doesn't say you cannot take even one luggage. Okay, I will keep it. My neighbor should be okay with it because IRCTC says I can take luggage. Okay, first thing. Okay, let us take, sir. You can keep it on your lap. Now, what is the meaning of a sleep berth?
Sleeper. Yeah, service.
Does it make sense? Okay. They recorded to you and all. If at all there is anything, I'll tell you. Don't keep asking what happened to this case. Compensation of any loss which naturally occurred in usual course. I can only recover that. Agreed? Natural course. I need to get back my back cost. I'll get back. Hadley versus Baxendale. If you remember the crankshaft case, there will be one floor mill, one instrument, one tool in that floor mill will not be working. He will send that for repair. I hope you guys know, Noda. So, you guys have to either say yes or a no. That's how life works. Yes, sir, you know, huh? You know it now.
No, sir.
So, one person will be running one floor mill, rice flour, wheat flour, he'll be running one flour mill. In that big machine, one part will be there. The part is called crankshaft. It will not be working. He will see, can anyone service or repair this particular part? No one in the town will do it. There is someone else in the next town. Now, how to give this part to that person in the next town? He will hire a service of another person, like a courier. He will say, can you please go and give this to him? He will repair and give it back to you, bring it back and give it to me. He says, forget about the time taken to repair. How much time will you take to give and give it back? He says, I need 2 days. Now he takes the product, he says 2 days, but he will in reality take 10 days to give the product. Not because of repair, his delay. Now this person, the owner of the flour mill, will file a case on him asking for compensation. For 8 days, his factory was shut. He asks compensation of whatever money he will make in 1 day into 8 days as compensation. The question is, whether will the courier be liable to give this particular money as compensation?
Not serious.
If they mention,
If they mention that date,
So people remember, if at all, have I mentioned him what is at stake? You are a courier as a responsible person, you have to take it and give it back on time. If you don't do it, for whatever deficiency of service I did, for not giving it to you on time, for that I will be liable. Because I do not know what is the story at your end. Have you told me? If I do not come and give it to you on time, your factory will be closed. Have you told me? Have you told? If the answer is yes, the answer will be special damages. I can recover the money for all the 10 days your factory is shut. If the answer is no, what you can recover is only general damages. That is for deficiency of service. Meaning, I can say waive off the complete courier charges. That's the maximum you will get. Getting the point? Yes? Okay, next one, vindictive or exemplary. What is vindictive? Someone has cheated you. You want to take revenge on them. Generally, wedding. I promise to get married. I will not get married. Dil ka darkan ka ek tukda. It will become a heartbreak. So people, for that they will file a case. Now what will be given? Of course court can never say you have to get married to him. Court can never insist to do something. It can just give you a monetary compensation. Clear? Next one people, wrongful dishonor of a check. I gave a check to a person. When he went and deposited in the bank, it is telling people this account does not have money at all. But technically my account had money. Don't you think there is a loss of reputation?
yes, sir.
My account has money, you are saying it is not there. So I can file a case for wrongful dishonor. Dishonor means what? Check bounce. Wrongful means even in spite of having money, you are telling there is no money. Understood? Next one, nominal damages. When time is not essential, Mintra delivers it to you, not in the 3rd day, 4th day. Can you get some money? Yes, you can get money, but you will not get 5 lakh, 1 lakh and all. You can even get 10 rupees scratch card. It's nominal because you have not suffered any loss. But it is just to satisfy your ego. Go Corona, go. Understood? Huh? Next one, deterioration caused by delay. Meaning, I have to deliver you some product. I delivered it to you, but it is not in the same state as it had to be delivered. There is a deterioration, meaning fall in value. Agreed? If at all imagine, I have ordered for some apples. I'm a, what is that, wholesaler. I'm a dealer. Manufacturer, that is a producer, if he had given me an apple today, I could have sold it at 300. But instead of today, it got delivered tomorrow. Getting the point? Now, loss of value. Now, from where will I recover? Today, if you had got, the apples will be fresh. I can take it for 300. Now it will go for 280. 20 rupees. It's a loss. You have to pay to me. You gave it to me day after. I cannot sell it for 280. I have to sell it for 250. So 50 rupees I can recover it from you. It's a damage. Last one, prefixed damages. What is prefixed? First one, concentrate of here. Little complicated. Prefixed damages means what? Prefixed damages means something which is already agreed in the contract. Meaning when we are entering into a contract only, A and B entered into a contract. A wanted to supply apple. 1000 kgs. Now if at all A does not supply the apples on time, in the contract it is clearly written, A is liable to pay a compensation of 20,000 rupees in case of failure to deliver the apple. Hello? Now people, you guys only have agreed what you need to pay if you fail to deliver the product on time. You have only agreed. You have agreed to pay 20k. This is called as what? Prefixed damages. Hello? What is the difference between prefixed damages, that is liquidated damages, and penalty? Remember people, let us imagine I purchased the apple for, let us imagine 1000 rupees into 1000 kgs into 100 rupees. The value of the transaction was 1 lakh. Yes? Now people, now because A did not supply the apple, B had to purchase it from C. How much did C quote? C quoted people 110 rupees per kg. Now how much did it cost me to purchase the same 1000 kgs? It costed me 1,10,000. Now the question, you only tell me, as per the contract, A is liable to pay 20,000. But what is the actual loss suffered by B? 10,000. Now when I go to the court, will I get 20,000 as compensation from A or will I get 10,000 as compensation from A? 10,000 or whatever is agreed in the contract. Remember, whichever is less. So whatever you guys have agreed, whatever is the actual loss, whichever is less is what you will be able to recover. I'll be able to recover 10,000 rupees. Sir, what if C supplied to me at 130 rupees per kg? Now what we have agreed is 20,000. What I had to pay extra is 30,000. How much will court order? How much will I be able to recover from A? You can recover agreed or actual loss, whichever is less. So I will be able to recover 20,000 only. Indian courts will never give you more than what you have lost or what you have suffered. If I have suffered is 10, even though I have agreed for 20, Indian courts will not give you 20 because court is not a profit making place. It's a place to make good your loss. You have lost 10, I'll give you 10. Getting the point? Yes? But however, if you only have agreed 20, if you lose 30, I will never order for more than what you guys have agreed. You have agreed 20 only, I will give 20 only. So to understand this equation, we wrote actual loss or agreed loss, whichever is less. Remember that and go. Understood all of you? Pakka? Yes? And the main purpose of penalty is to induce terrorism, to create fear in your mind. We have seen that. Hello? You understand that? Difference between liquidated damages and penalty. What is the difference? In Indian court, there is no such difference. Okay, liquidated damages is, how did you arrive at 20,000? It is reasonable, calculated, logical numbering. How did you arrive at penalty? Arbitrary. There is no derivation. You do not have any formula. It's an arbitrary number. And what is the purpose? To create fear in other party's mind. Agreed? Yes? Now that is called as what, people? That is called as penalty. Clear, all of you? Okay. Remedies. Next ones are rescission of contract. You can cancel the contract. Suit for specific performance. What do you mean suit for specific performance? A agreed to sell a particular mic to B. A did not sell the mic. B is going to the court and asking, Your Honor, I don't want compensation. I want this mic only. Tell A to deliver the mic only. The question is, can you ask for a specific product and not for money from the court as a compensation? Whenever specific performance will be awarded only when the product has some specific value, some unique value, antique item, special emotion attached to it. Is mic having a unique value? Is it special to you? Emotionally attached? Court will never tell that, okay, you need to get it. Imagine A agreed to sell B some ancient antique item. Yesterday in my group, someone had posted some Tippu Sultan's knife, it seems. Now, someone per 12,000 rupees they are quoting. It's small knife. Yes. Now, will we be? Now imagine B agreed to buy. Simultaneously, someone said, I will pay you 20,000. Now the question is, can B recover the contract because A has agreed? Can I recover? Can I ask for specific performance?
No, sir. It's
Can I?
already been delivered.
Yes, sir.
See, A asked B, do you want to buy this knife? Tippu Sultan antique knife. Antique knife. B said yes. I will come and collect tomorrow. Meanwhile, A got one more offer from C for 20k. He closed his eyes and he gave it off. What did he think? To B, I'll give some 2,000 rupees as compensation. Anyways, I'm profitable, no? Here I agreed for 10,000. I'll give 2,000, I'll only give as compensation. I'm making 10k extra here. So A sold the knife to C. Now B is asking, no, I don't want compensation, I want knife only.
He is in good faith, he cannot recover.
He cannot recover?
So what if C also has on specific problem?
If he is in good faith.
You will see this in future also, whether if C has acted in good faith, a person who continues to be in possession,
Yes.
if he sells, will he get a good title? Answer is yes, he will get a good title. Now suit for specific performance will get this property into litigation. On a normal property, yes, what you answered is 100% right. Suit for specific performance, it will get into litigation. Money is not a proper compensation because it's an antique item. Can you get a similar knife again? Now he will say, I want it. This is how it will happen. Understood?
C also.
Litigation.
That's what litigation. Now, who is the rightful party?
No one. Both of them will go to court.
See, now one person will have to get a compensation. Yes, sir. Because it is suit for specific performance, the chance of B getting it is more. But on an ideal scenario, if C gets it, what will B do? You saw that a person who sold the property but continues to be in possession. That time C will get a good title, B will get the compensation. Because it is specific item or antique item, you are getting compensation. Understood? Hello?
Yes, sir.
Yes, sir. Okay. Next one, suit for injunction. What do you mean injunction? Injunction means what? Injunction means what? Stay order. Stay order means what?
We should not do anything.
When something is happening, you get an order from the court stopping the party from proceeding ahead. It's called as Injunction. Generally our activists will do no. For example, in Hyderabad, they are doing the deforestation. Activists are going and saying, they're getting a suit from High Court, saying that pause, tell them to stop whatever they're doing. Now if a court gives an order, it's called as injunction. Telling them to stop from whatever they're doing. Until that is clear, you cannot go forward. That's called as injunction. Got it?
In that case, how the case will be written, so like state government versus state, public will be represented.
Public will be represented by, it is called as class action suit. Like investor associations are there, public associations are there, they will represent you. So it will be written as public only. It will be written as, imagine if there is one person, what's your name? Varma.
Chidananda Varma.
Chidananda Varma, no Varma, now take. Now Varma and others, that's how it will be written. Others means there are many people involved. You call such things as class action suits. Yes, sir. Now, suit for quantum merit. What do you mean by quantum merit? As much as performed. What do you mean by quantum merit? Whenever in a contract, let us imagine, sir, you have hired a particular person. Imagine you have hired me to deliver law. Now imagine I had to deliver law in 100 hours. Now because of some reasons, people, after 50 hours, Arivu discontinues the contract. They will say, let us end this contract. And they will say, I will not pay you. The answer is, am I entitled to get paid or not? I am entitled to get paid for whatever I have taught. I have been here for 50 hours. I am entitled to get my half of the money. Now this is called as what people suit for quantum merit. Quantum merit means people as much as performed. Are you getting the point? Let us imagine, sir, I will take your law. I will take it in the most possible hatred way. You didn't understand even one word. 100 hours is done. Arivu decides that this does not serve the purpose. We will not even pay you 1 rupee. Have delivered complete law. They will say we will not even pay you 1 rupee. The question is, can Arivu hold my complete payment?
No, sir.
Remember, whenever there is a shabby work done, you need to deduct some money. What is deduction? Now imagine, they might have to hire someone to do a crash course. That person can charge some 20,000. Now, whatever they are charging him, they will deduct that money from whatever they are paying me. Because of me only that happened, right? Yes or no? So this is also called as quantum merit. Quantum merit means, people, if the contract is not yet completed, you will be entitled for whatever is the amount of work you have done. If the contract is already completed, they can deduct the money for the shabby work you have done, incomplete work you have done. They can deduct the money. Understood, all of you? Hello? Yes, this is only called as what people suit for quantum merit, as much as performed. Clear, Ram?
Yes.
Okay, go for a break and come. We'll see this after the break. How much? What time you guys will be back?
1 hour. We have to go to hospital.
1 hour, ada?
1.5 kilometers.
45 minutes?
15 minutes, 20 minutes.
145, 2 ಆಗೋಗುತ್ತಲ್ರೋ. Okay. Probably I don't know, 3:30. No, 3:30.
Sir, then we will come, sir, give 20 minutes. 50 minutes. Hey, you want to come back. He is not hostel.
People will have class till 3 or 3:30. 3:30, I think we'll be ending the class. By what time you guys will generally sit? 6. So because I'll tell you, if it is one day, we can finish off everything today only. If you sit till 8 and all, I'll finish off today only. Anyways, we have 2 days, not required. Today, even if we can finish till sale of goods and more than sufficient. That's what we have second day. Monday you have no. You have Monday, right? Second session. You have it. So go for, then how much time? 3:30 we'll end it. 45 minutes is good. Okay, come back by say 12:30, 12:35. I mean 1:30, 1:35.
Okay.
Yes?
That is okay. There will be something, no, to automate it then. If you want to take this, Okay. But do not do it manually is what I'm saying. Imagine someone sees it, they will come and tell something. Can you stay peacefully? Yeah? Huh? Done na? You adjust and you give. Don't settle out. In that washroom, don't put paper. They were coming and complaining. In the sink and all, do not throw paper. What and all we have to. Okay. Okay, Unit 6, contingent and quasi-contract. Had full lunch? Yes. So we'll sleep? Yes, sorry. Okay. Contingent and quasi-contracts. Okay. Contingent contract. A contract to do or not to do something. If some event collateral to such contract does or does not happen. First of all, what do you mean by a contingent contract? A contract which depends upon an uncertain event. It may or it may not happen. Example of contingent contracts? Indemnity contracts, insurance contracts, guarantee contracts, wager contracts. These are the examples of contingent contracts. Meaning it may happen, it may not happen as well. So, example, insurance. We take an insurance for our bike. We pay premium. Just because we pay premium, you will not go and meet with an accident, right? To recover the money, you will not do it. Yes or no? So, ಏನಾಯ್ತು all good turned off I think turned off. Okay, ಏನೋ ಮಾಡಿ. I turn off the swing you give me. I turn on the swing. He is not okay. Your friend only. Wait for it on 2 minutes. Once it is up. Before lunch it was good, no? Then. You're saying this is hitting you. If it is this, it is hitting you. You should actually go up, Noda. You're okay, now it is not coming to you, no?
So just put it on the hour code.
It will come, see.
Fine, sir. It's coming.
After 5 minutes, it will get over. Okay. Yes, people. Concentrate. Yes. Let's quickly do it off. Okay. What are contingent contracts? What is the contingent contract, people? A contract which is depending upon a collateral event, meaning an uncertain event. For example, there is a contract, people. I will take a insurance contract. How does an insurance contract work? I will pay a premium per year. Now imagine for a bike you will pay 3,000 rupees per year. Now what is a contract? In this year, if you meet with an accident, whatever is the damages that your bike undergoes, that money will be paid by the insurance company. So I am giving 3,000, they might give me up to the value of my insurance contract. Let us imagine it can come to even 50k. Yes, I am giving them money, they are agreeing to give me money. Depending upon some event items. What is that event? What is the event? Wedding, birthday party,
Uncertain event. What is an uncertain event? There has to be an accident. Accident is an uncertain event. Are you so sure that the accident will happen this year? Or you have taken the insurance. Yengadru madi you want that money back. You will wantedly go and hit some tree just because you have given premium. You will go and hit. Oh yes, sir. You will hit it. Now, people, that is what is called. You never know. It may not happen. It's called as what? It's called as contingent contract. Contingent contract, people, example, indemnity guarantee. Next unit we will see. See here, that's an example. Okay. Contingent contract. Essentials of contingent contract, as we saw. Uncertain event. It should not be part of consideration. It should not be under the party's control. Is the accident under your control? Is the accident under your control? Yes, sir. Drive slowly. In the end, if it comes from the behind, what will you do? So you can never know. So it is not under your control. Contingent contract, that's the main essential thing. It should not be under your control. Agreed? Yes? Okay. Next one, sir. What is that? Rules relating to enforcement of contingent contract. You guys know those rules, right? How does these rules done? How will you enforce the contingent contract? How will you enforce? First of all, tell me, you guys know this or not? It will take me some 5 minutes to explain. If you want, I'll explain. Okay, what is this, sir? Let us imagine when can I enforce a contingent contract? The first thing, what are they telling people? On an event happening, on an event not happening, or on an event happening within fixed time. Now, what do you mean by that? Now, for example, let us imagine I have taken an insurance contract by paying 3,000 rupees as premium. When can I recover my money from the insurance company? When can I recover? When will the insurance company pay me money? When damages happen. So, when can you enforce the contingent contract? You can enforce the contingent contract whenever an event, whatever is promised in the contract, whenever that event happens. Once it happens, you can enforce the contract. Enforcing the contract means what? You will go to them and you will ask for the money. Until the event happens, you cannot enforce the contract. Here, event means what? Accident. Whenever you meet with an accident, you will recover the money. As long as you do not recover, as long as you do not meet with an accident, you obviously cannot recover the money. Getting it? So when can you enforce a contingent contract? Whenever that uncertain event on which your contract is built, that uncertain event should happen. Until it happens, you cannot get the money. I hope all of you sitting here, you know how insurance works.
Yes, sir.
Yes, I give my 3,000 rupees as premium. Imagine in this month or in this year, I did not meet with an accident. Can I get back my 3,000?
No, sir.
No. Now what if I meet with an accident this year? I will get the sum assured. It can be 50, 60, whatever is the damage cost. When can I get that money? I have to meet with an accident for that. So when is a contingent contract enforceable? You can enforce when the event as per the contract happens. Hello? Sir, 3,000 I have given, sir. I paid. After 5 years I meet with an accident. Will you give me money? Now second condition comes. What? The event should happen within the fixed time. What is the fixed time? Your insurance contracts are valid for 1 year. Your accident should also happen within 1 year. It's not like one time I give insurance premium, it will cover me for my life. It will cover you for 1 year. Next year again you need to pay. So now accident should happen, not whenever you want. It should happen within this year for you to get the money. That is what is enforceability on an event happening. When a time is prescribed, on an event happening within fixed time. Here our time is 1 year. Getting it? Hello? Pakka? Okay, next one. On an event not happening, you can enforce a contract. On an event not happening. You know, best example for an event not happening, easy example, guarantee contract. What is a guarantee contract? Surety. A has taken loan from ICICI Bank. What if A doesn't repay? ICICI Bank says, I want someone to give a surety. B says, if he doesn't pay, I will pay. He doesn't pay, I will pay. Now you tell me, ICICI Bank, when can they recover money from B? When A doesn't pay the money on time. Correct? When an event not happening, you can enforce the contract. So one contract you can enforce when event happens. One contract example can enforce when event doesn't happen. What is the event? Repayment of money not happening. I can enforce. Mitra, lunch break, Mitra. You understand that? Yes, so. Okay, if there is a contingent contract for an impossible event, is it valid, invalid? Impossible event. Impossible event obviously is void. Upon conduct of a living person, what is conduct of a living person?
One person should do that.
Frost versus night. What happened? Boy promised girl, I will marry you. After his father dies, the entire contract is living, it is depending upon this person's life. So the girl knows this person should die for him to get married to me. Yes, sir. That is what it is. The contract depending upon a conduct of a living person.
We have this negotiable instrument.
It's valid only. Where did I say invalid? Huh? I said invalid? What did you do? Right? Okay, understood, huh? Got a fair idea, na? Yes, sir. Conduct of a living person. I hope it is clear. Illa. Second example. Buy one get one free. Difficult part and give an example. You will understand example only. That's the problem. Now see here. One more thing I told you. Now say for example. Now Verma is Chirag's friend. Verma is my student. Verma, Chirag. Say hi. Hi to the class. Chirag, hi. Now people, I ask Verma, I like his bike, da. I want that bike. Verma says, sir, okay sir, I will speak to him. Now people, me and Verma enter into a contract. Why? To buy this bike. But Verma says one condition, sir, I will give you that bike, provided Chirag agrees for it. That I don't know. But he gives it to me, I'll pakka give it to you. Hello? Now what is this type of contract? This is called as what? It is depending upon a conduct of a living person, a third party. If he says yes, we will get it. If he says no, we will not get it. Uncertain only, no? How can Verma speak on behalf of Chirag? Getting it? In class, you can also see this example as Sachin's Ferrari. That's the example. Agreed? This is also called as a contract entered based upon a conduct of a living person. This will come in Sale of Goods Act also. Remember, I will tell you same, you should also think. Clear, huh? Okay, done. Next one. Quasi-contract. What is a quasi-contract? Quasi. The word quasi means resembles. It's not an actual contract. It is similar to a contract. It resembles a contract. Meaning what? There might not be offer. There might not be acceptance. There might not be consideration. But still the contract is valid. Example of quasi-contracts, people. Easiest will take. Finder of lost goods. What is quasi-contract? Imagine whenever you find something missing item on road. Imagine you find a purse. What will you do? You will take it. What will you do to the purse? You will take it, sir. Depends, sir. Whether anyone is. Correct, no? Depends, sir, whether someone is watching or not. Someone is watching, then I will make an attempt. Hello? If no one is watching, hello? Yes, sir. So people, quasi-contract, best example, it is your duty, it's a moral obligation for you to return the product whatever you found. Is there an offer plus acceptance? When you took it, was it written there? You accepted to return my product? But it is your moral obligation to return it. Where is it written? It is not written anywhere. That's why law wrote it. That's why it's called as quasi-contract. Quasi means it is similar. There is no offer, no acceptance, but you are bound to return. Getting it? Pakka, you'll be reading about this even more when we go towards bailment, finder of lost goods. Next one, claim for necessaries. Claim for necessaries is also quasi-contract only, no? Correct. Minor, unsound mind, not a valid party to enter into a contract, but you have a right to recover the money, whatever you have paid for their necessaries. That's what you're seeing here. One questionable point here is, you can also recover the money paid to them. You can also recover the money paid to anyone dependent upon them. Understood? There is a minor. A minor has a old aged grandmother who is dependent upon him. So you give a loan to the minor to support his education. You also give money as a loan to take care of his grandmother's medical, fees or whatever it is. Now when I have to recover, what all I can recover? I can recover the money given to his education. I can also recover the money given to the medical fees of the grandmother as well. I can recover the money that is given to a minor or unsound mind. I can even recover the money, given money to any person who is dependent upon such minor or unsound mind. This is clear? All of you? Okay. Of course, to an extent of assets, that is same. That will not change. Payment by an interested person. What do you mean by payment by an interested person? Tax paid, or as the case may be. Now, what is this example? People imagine Arivu. Now, this particular place is on lease. Now, who should pay the rent? Arivu will not pay the rent. It is agreed that the owner will pay the rent. It is included in our, who will pay the electricity? We will not pay. It is agreed that the owner only will pay the electricity. He will charge a fixed rent from us as a monthly rent. Irrespective of your electricity bill, it is less also, you should pay the full. It is more also, you have to pay the full rent. Who will pay the electricity bill? Owner will pay in our case. Now what has happened, people? This owner has taken money from us as rent, but he has not deposited the electricity bill to the electricity department. Now what will they do? They will wait for 1 month, 2 months, 3rd month, people, when the class was going on, they pulled off the fuse and they sent a notice. We are not going to pay it anymore. We are not going to give you the electricity supply anymore. Now what will we do? We know what is at stake here. What will Arivu try to think? Let us try to clear off the debt first. Arivu only will pay the electricity bill. Now we will ask the owner to pay to Arivu. As per the contract, you were supposed to pay. You didn't pay. Now we paid. You give it back to us. Now the owner is telling, did I ask you to pay? I would have paid. Why did you pay? Did I ask you to pay? The question is, can we recover money from the owner? Is it possible? You can recover. Provision you will be writing is payment made by an interested person. Interested means, people, whatever right as an owner you have on the property, I also have some interest in the same property, and the interest is I am making my living out of it. If you do not pay, even my interest is also affected. So can I pay? I will pay because I am losing my money. Are you getting it? All of you? This is called as payment made by a interested person. Clear? It's cold, huh? You are feeling cold, huh? We'll do one thing, let's keep it fair. Let us do it swing. Yes, sir. Huh? Okay, now. Done now. So we will do this. Next one, person enjoying benefits of non-gratuitous act. What do you mean non-gratuitous act? Not free. So as simple as that. So someone came here, Zomato. They are asking, sir, where does this person stay? You will say, sir, give, I will only take. You will eat off. Of course, no one meant to give you food for free of cost, right? It is your duty to pay that money to them. So if anyone did not mean to give you something for free, you had a benefit of it. It is your duty to repay that. Yes, this can happen in hotels also. You would have ordered for 3 items. On hotel, 4th item will come. Someone would have ordered. It comes on your table. You guys will have. You know for a fact in commercial contract, no one will give you free of cost. Or you can confirm at least, right? If you have it, you need to pay. Agreed? Okay. Last one, money paid by mistake or coercion. What do you mean money paid by mistake?
Bank by mistake deposit.
Now I will tell you my scenario only. From last 3 days, when Rapido has become a big problem. You know this UPI, I don't know what is happening. It's not working only. 3 days back I came in an auto. UPI didn't work. I tried. It said that money is debited, and his money was not credited. You know, he didn't leave. I said no, it is debited. I got a message. One is UPI failure. One I got a message that amount is debited from my bank account. I said it is debited. He said no, you pay again. If it comes, I'll give you back. So I said okay. What else I'll say there? I'm getting late to my class. I paid twice. And the night I got a message that that account is also credited. I called. Of course, switch off. What more you will expect? Last 3 days it is switch off only. And you know what is it? Auto, this was 191. I paid 200. I raised the concern with Zomato. Sorry, Rapido. Rapido it was. I raised the concern with Rapido that I have paid money twice. Excess money has debited. They asked me to send the screenshots. I sent that also. They are one bidi. They sent me 9 rupees refund. I said, bidri, what will I do?
What they give, sir, reason?
That's what, sir, our system is showing you have to pay 191. You are saying you have paid extra 200. We are refunding 9 rupees. And one of the pathetic customer care I have ever seen. One of the most pathetic customer care. I can come and tell it to you on. I'll make one video only on it. I don't mind also. They will reply just within 1 hour. You message, tuck, just till 1 hour they will reply. Most fastest the reply I have ever seen. Who will reply? Within 1 hour? They will say connect me to an agent. They will connect. And when I message, within just 1 hour they will reply off. 1.5 hour. Who will reply so fast? So they will say, hi, how can I help you? You will say, this is my concern. And they will reply, okay, we are looking into it just within 45-50 minutes. I mean, I'm literally very impressed. Everything happens to me only, huh? Illa. Huh? Seriously. That also simultaneously it's going. Now I have filed one, this one with them. Huh? You can see here, I don't know. Shout out at Rapido. Money debited twice. Wednesday. You can read. Why is your customer care so pathetic? I will not leave anyone. If you look at my email box now, I would have been fighting with 100 companies simultaneously. All, Oh, put legal case, sir. You do one thing, you just keep roaming around the high court. Put legal case. Put, tell them to do something to me. Put.
They took my video, like concerning about the food. He took my video. You want to say show it to the other.
Don't hesitate. If at all I was in your PG and all, you would have got 5-star food till today. Food and all, I was in one PG. One day you will not believe. When I was a student in BCom, one day we went on a strike on the PG, sitting in front of the PG. How did we? We brought their chairs only. We sat on road and we said Dikara Dikara. Half an hour we had what is that? Banana plant food. Ange gottallva. In India, nothing will change without revolt. You have to revolt. If not, nothing will change.
My clothes they stole and I asked them for 3 times they stole. I asked means they are giving me the PC and you only check camera, we don't know.
File.
Sir, they
And the last thing that is I got it open and sleeping inside my room.
Ah,
Because they are stealing.
correct. That can true.
They are saying whatever you want, if you want, you want to check it. They are not even.
They are taking any action. Yeah.
They don't know English also.
I'll tell you, every page is like that only.
They don't know Kannada, they don't know Kannada, they don't know English. They only know Hindi. We have to speak it Hindi. If anything happens, easier.
Now you also share all your problems, huh? Huh? Nangu inge aitu sir, for me also. Okay. You have to give work to the legal teams in the companies, da? Yes or no? No, they have legal teams. You have to give work to them. I will give. You feel to give also. Okay. No. I will not take up any third party case, only my case. Mine only it will become 1 year to handle. So many are there. Huh? See, no, nothing fighting. 95% it is settlement only. 95%. But you have to fight for it, that's all.
Sir, I have a question.
Hmm.
If anything happen in future, like, is it fine? Like, if I call you as
If anything happens,
case happens.
Any case on
okay, don't call me. As a student, I'll help you. Okay. He is selling, he is reserving, sir, in future, anything happens to me, even anything it can happen, I'll call you. Okay. Next one we will contract of indemnity and guarantee. Contract of indemnity and guarantee. Okay, concentrate. Now, what is contract of indemnity? Indemnity means what, people? Indemnity means nothing but a contract where one party agrees to compensate the other party. If you incur any loss, I will make good the loss. Now that is called as what, people? Indemnity contract. For example, you take this cab example only. I trust Rapido and I pay this person. Now, whenever there is a conflict, I am not going and asking money from him. We have a trust on the third party. If he doesn't repay me, I know you are there for me. Correct? Of course, they are also not there. But yes, that's the whole purpose, right? So, such contracts are called as indemnity. Indemnity means what, people? Someone agrees to make good whatever loss you suffer. Someone will come and say, you don't worry, we will make good your loss. This loss happened, we will make good your loss. Now, who can this generally be? The popular example we all know is called insurance contracts. Correct? In an indemnity contract, in total, how many parties are there? There are 2 parties. One is called as indemnifier. Who is indemnifier? The person who agrees to compensate. Indemnity holder, the person who is getting compensated, is called as indemnified or indemnity holder. Okay, next one, modes of contract, it can be express or implied. Next one is, remember, life insurance can never be considered as an implied contract. life insurance. Health insurance is different. General insurance is different. Life insurance is different. Health general will come under indemnity. Life insurance will not come under indemnity. The reason is life insurance means what? If you die, we'll give you money. I mean, anyone dies, we'll give them money. We are not making good the loss, right? A person has passed away. You can't make good that. How will you compensate that? You're just giving money. That's why it cannot come under indemnity. It must fulfill all other essential elements. Okay. Right of indemnity holder when sued to recover from promisor. They have asked this 3 to 4 times. What is your right whenever indemnity holder, right of indemnity holder when sued? What do you mean by that? Now imagine people have taken an insurance contract. On the date of insurance, when I meet with an accident, they are telling we will not give you money. If you had paid the 30,000 rupees, whatever the damages, we could have settled it there. You did not pay. Now if I fall, what will I do? I'll definitely drag you to the court. What and all I'll recover from you? I will not just ask 30,000. What else I'll ask? 30, mental trauma 70,000? Round figure, huh? No, 30,000 plus 70 is round figure, 1 lakh. And who will pay for my legal charges and all? My lawyer charges? 50 crore. Defamation also. And you guys also should give something. You are listening to all of this. So, on 2 lakhs, so 2 lakh rupees. So, 2 lakh rupees we took. Yes. Now, this is what I can recover. 30 kote 30 aage. If you had given for 30, it would have been done with 30. You did not do. It came to 2 lakh. Agreed? Yes. Always remember, for a company, from a company's perspective, whenever you see a complaint, that's why I always say, problem can be created by a fool, but a problem will always be resolved by a wise man. A problem solving department, customer support is there, no? That's why you should not just treat it as a process. Keep wise people there. Because remember, customer support is where a company can dupe, a company can get down. If you had handled an angry man properly, if you handle an angry man properly, he will never create any mess. They are already messed up. He will come and say, for this press 8. I'll say, you come, I'll press your neck. We are already irritated. And to talk to them, 18 buttons I have to press. Yes or no? Okay. Damages, cost, compromise. I will recover everything. Yes. Next one, contract of guarantee. Contract of guarantee, huh? How many parties are there in contract of guarantee? 3 party. एक है principal letter. दूसरा creditor. तीसरा surety. In contract of guarantee, in total, how many contracts are there?
2.
How many contracts are there? How many contracts are there? Yes, 3 contracts are there. Visuals can be deceiving. Now people, in contract of guarantee, there is a first contract, primary contract between debtor and creditor. That's the loan agreement. Second contract between the creditor and the surety. If he doesn't pay, you should pay. Third one, silent contract, impaired contract between surety and the principal debtor. If you pay, if you do not pay, if surety paid it, it is your right to recover the money from the principal debtor. That is, if the debtor didn't pay the loan, surety paid, why should I pay? With good gesture, goodwill, I agreed to be a signature. Who knew that you will not pay on the date of maturity? Now, why should I suffer the loss? I have a right to recover. Yes or no? Okay. Surety, principal, creditor. Principal contract, secondary contract, implied contract between surety, principal, debtor. People, you tell me, upon the date of maturity, after 1 year, debtor did not pay the money to the creditor. Now, creditor wants to recover the money. With whom he should recover the money first? Is it with principal debtor or is it with guarantee? To whom should I go first?
Principal debtor.
Principal debtor, okay. His wish? Remember, upon the maturity is done. What is the guarantee? If on the date of maturity you don't pay, I will come to you. I have this right. Now upon the date of maturity, it is the option of the creditor whether to go to the debtor and recover or to go to the surety and recover. Option, it is his wish. Yes,
Before we should.
before he should not go, of course, because there is a timeline, right? Hello, exam question. Next one, essential features of guarantee. What? Existence of principal debtor. Obviously, debtor only not there, no guarantee. Consideration, guarantee. People, guarantee. Should we take any consideration, Ada? In surety. Remember, there is always a consideration for the principal contract, that is between debtor and creditor, that there may not be any consideration between surety and the principal debtor, but the principle of consideration may move from promisee or any other person will apply. Yes, surety will repay the money because on behalf of him, principal debtor has taken the money. Agreed? Okay. Can a surety be a minor? Surety.
Surety cannot be minor. Principal debtor can be.
Can a principal debtor be a minor? Principal debtor. Can be a minor.
Yes, yes.
Okay. If you're confident, okay. Borrower can be a minor. Because end of the day, if borrower doesn't pay, surety will pay, no?
Yes.
So surety should always be a major. If surety is a minor, it's a void contract. Hello? Okay. Existence of liability. Liability should always be there, of course. No misrepresentation or no concealment. What do you mean by that? Let us imagine A took loan from ICICI Bank. They insisted for a surety. Why? Because in the past, A has a record of default. He has not paid it once. Hello? Now they did not disclose this particular thing to B. This is only called as what? Concealment. If you conceal something and if you take or if you make him sign a contract, you cannot hold B liable. He will not be liable if at all something happens to their contract. Remember this. Understood all of you? Next one, need not be in writing. Oral is also valid. Guarantee is not valid until some other person joins. What do you mean by that? If I say I am not okay only if I am a surety, you please get another surety. That is B's condition. There should be two sureties. So until C joins, B also will not be liable. Who will impose this condition? B can impose this condition. Why? To make sure my life is also secured. What if the loan is 5 lakh? I should pay everything. Why is that? Not required. Yes? In my childhood, some person had cheated my father. My father was a surety. If I only remember, he repaid that loan for almost 6 years. So, guarantee, remember, that day I decided, let it be your closest, bestest friend. When time comes, there is always a theory called as mother monkey theory. What is that? It seems they say, you put a mother monkey and its baby in a pool and you start filling the water in the pool. When the water rises until its legs, the mother monkey will lift the baby monkey and it will keep in its hand. You still increase. It will come to the level of neck. It will keep it on its head. It will try to protect it. You still fill it. Now the mother monkey is about to drown. The mother monkey will put the baby monkey underneath and it will stand on it. So what is this theory? When a person is about to sink, they will forget the morals, they will forget the ethics, they will forget morality. You are never saying a no to a person. You are saying no to a situation. You should help. Humanity should be there. But never sign anything blindly. Getting it? Some days it will come and hit back very hard. When they are about to sink, who will care who you are? Yes or no? They will be in their own world. Come back. Types of guarantee. Specific guarantee, continuing guarantee. What do you mean specific guarantee? Specific guarantee means people, a guarantee given to one specific transaction. My liability is only for that. Next one is continuing guarantee. Continuing guarantee means I will give a guarantee for 1 year. In this 1 year, you give how many ever loans you want. For everything I am liable. Now my question, can I revoke a continuing guarantee? Can you revoke a continuing guarantee? Can you? Remember, whatever has happened cannot be revoked. Whatever are the future transactions can be revoked. Can you revoke a specific guarantee? If it has happened, you cannot. Not yet happened, you can. If it has already taken place, then what will you revoke? Clear? Now my question, imagine if there is a guarantee. If a guarantee also dies, then what will happen? Who will be liable? Principal debtor did not repay. The next liability is on guarantee. Guarantee died. Who will be liable? Who's legal representative? Debtors or guarantees? Who will be liable? Guarantees legal has to be liable. The reason is, I have a right to recover. If you don't, I will recover it from him. Remember, the moment we took guarantee, that means already the debtor does not have anything. That's when guarantee will come. When you have everything, we will definitely take some other thing from you. We will not go till guarantee at all. At times what happens, people will make sure, that's why they will take asset also, they will take guarantee also to be safe. That type of loans also exist. It's called credit backed mortgage loans. Both will be there. They will take you your property also. They will make you sign a guarantee also. Now you never know, right? If such scenarios happen, how will we make sure our rights are protected? The banks will always take an extra step. They want to be safe. How much ever they want, they will try to recover. Vijay Mallya kate bere. I don't know if I've told you in the class and all. No? I'll tell you in CA intercom. Nature and extent of surety is liability. But to create that sense of, yes, we need to come, I'll tell you. One day. In Vijay Mallya's getting loan, Congress played a very big role. Congress government. I'm telling it on the camera means it's true. Yes. How did Vijay Mallya get so much loan? Yes, there was a recommendation letter that went from Parliament that give loan to Vijay Mallya. And then CA Inter. Bunny. Nature and extent of surety is liability. To what extent is a surety liable? Examination, again question, coextensive. What do you mean by coextensive? If debtor has to pay principal, you should also pay principal. Debtor has to pay interest, you should also pay interest. If his principal decreases, your principal also decreases. How much ever he needs to pay, you need to pay. Simple. Next one, liability of surety is secondary in nature. Secondary means what? The principal liability is always first on the principal debtor. If he fails, I'll be liable. Correct? But upon maturity, it is the option of the creditor. Liability arises immediately on default. Correct? Next one, defect in document. It discharges debtor also. It discharges surety also. Unenforceable contracts. Creditor can sue surety directly without upon maturity. That's important. Clear? Hello. Next one, discharge of surety. When is the surety discharged? First thing, by revocation. Continuing guarantee, only future transactions. Death of surety, estate is liable. Agreed? My property will be liable. Remember, death happens. After the death, future transactions are automatically revoked. Imagine I've given a continuing guarantee for 1 year. After 6 months, this person passed away. Whatever has already happened, the surety is liable. Not happened will come to an end. Clear? Hello? Yeah. By novation, what is novation? Old contract replaced, then obviously I am not liable. By conduct of creditor, variance in the contract without surety consent. What do you mean by that? the main principal contract, without asking the surety, you are making some changes. Rate of interest you are increasing. Of course, I should also be consulted. I am also party to that contract. Without asking me if you do any changes, I am discharged. Next one, by release or discharge of principal letter, enters into French contract principal letter, does any act omission, legal, what is this, people? If at all the creditor enters into a compromise with a principal letter, meaning I am discharging, it's okay, you go, I will catch hold of the surety. Expressly, if you guys are doing or entering into any private deal to book the surety, they're telling surety is also discharged. See, by release or discharge of principal debtor, you're releasing principal debtor. Why? He is the person who should be first liable, right? Why did you discharge? Surety is also discharged. Simple? Okay. Next one. Creditor compounds, gives times or agrees not to sue principal debtor. What do you mean by that? Creditor compounds. Compounds means people compromises. Whatever we saw previously. Gives a time. He should have repaid the loan within 1 year. He's saying it's okay, take 3 years. Again, alteration only, no? Agrees not to sue principal debtor. I'm telling specifically, I will not file a case on you, I'll file on him only. You just sign, it's okay. So I'm telling, surety is discharged. Creditor's act or omission impairs surety's eventual remedy. What do you mean by this? In class, I think we would have seen that, what is that? Tomco's Bank. What is this case law, people? A creditor had taken some gold as collateral and he had given some loan. He thought gold alone is not sufficient. There was also one surety. Because of bank's negligence, they lost this gold. Eventually, this debtor became insolvent. What was the total money that was to be repaid? He had to repay 10 lakh. The value of the gold was 6 lakh. The bank sent a notice to the creditor to repay 10 lakh. The surety said, because you guys lost this gold, I could have recovered some money from that. You lost it because of your negligence. Whatever is the value of the gold you guys lost, that money we will also reduce it. We will not be liable. In this case, it was held that whatever could be the surety's right. Now, gold could have been my right. Because of your negligence, we lost it. So, my liability will also go down by that amount. So, to what extent was the surety liable? Surety was liable for 4 lakh only. That is the meaning of this. Understood? Next one, sir. By invalidation of contract of guarantee, there is nothing but whatever we saw up, misrepresentation, concealment or co-surety joints. Until that time, surety will not be liable. Yes? Okay, next one. Rights of surety against principal debtor. Right of subrogation. What do you mean by subrogation? If debtor does not repay the money, the surety would have paid the money. So my right now will become a right of creditor. I can recover the money from principal debtor. This right is called as right of subrogation. You will be assumed in the shoes of creditor. Whatever right a creditor will enjoy, you will also enjoy that right. Next one, implied promise to indemnify surety. It is an implied contract, right? A contract between the surety and the borrower, principal debtor. Next one, right to benefit of creditors, security, gold. Right to set off. What do you mean by set off? Imagine in 10 lakhs, if the principal debtor has already paid 3 EMIs, my liability will be reduced by those 3 EMIs. How much ever he has paid, I can set it off against my liability. If total amount I need to pay is 10 lakh, if 3 EMIs he has paid is 2 lakh, my liability will be 8 lakh. Clear? Hello? Set off only, right? Okay. Next one, right to share reduction. When principal debtor becomes insolvent, what is the right to share reduction? If at all, let us imagine a principal debtor is not able to repay the loan. Now there is a surety. I need to repay the loan. Let us imagine if the principal debtor has some assets. Now, whatever is the value of the assets, I have a right to recover that money from the principal debtor's assets. My liability will be reduced by that amount. I can recover from that. I can share the reduction from that. It is my right. Simple? Hello? Yes, that's why they are saying right to share reduction. I can take it. I can recover it later. That I have my right. Next one. Against co-sureties. I can recover the money from co-sureties? Yes or no? What is co-sureties? I have taken the money. There are 3 sureties. If one person pays, he can recover the money from other sureties. Possible? Yes. How will you share the debt data?
How much I guarantee?
According to the
If nothing is mentioned, you will equally. Or it will be in the
Guarantee they given.
proportion.
No, sir, equally only. Extra amount also again the remaining portion.
contract, they told maximum.
Let us imagine the loan is 6 lakh. The principal letter took 6 lakh and 3 guarantees were given. One person said 3, 1, 2, one said 1 lakh. This is a guarantee. The principal letter has repaid 2 lakh. The outstanding amount is 4 lakh. 4 lakh was not paid. How will you distribute 4 lakh amongst these 3 people?
First 3 lakhs.
Sir, 1 lakh 50, 1 lakh 50, 1 lakh.
Sir, 1 lakh.
1.5,
Next another 1 lakh. 2 lakhs, 3 lakhs.
Sir, I feel like 1 lakh 50, 1 lakh
1.5 lakh, 1.5.
1 lakh 50, 1 lakh 50, 1 lakh. Okay.
I do get the same thing.
All of you saying the same thing? 1 lakh 50, 1 lakh 50, 1 lakh?
Yes, sir. Yes, sir. Yes, sir. Yes, sir.
All of you convinced? All of you convinced? 1 lakh 50, 1 lakh 50, 1 lakh?
Sir, 3 lakh and 2 lakh are
So remember, people, you cannot do, if people are wondering, you cannot do 4 lakh into your 3 divided by 6. You cannot do proportion. You will not get the answer. Whenever they have given the guarantee in, different amounts, you need to distribute it equally to whatever is the level they can share. Now let us imagine people, there is 1 lakh, 2 lakh, 3 lakh. C is the responsibility. Let us imagine this is A, this is B, this is C. C is 1 lakh. Up to that amount, all of them has to share equally. Up to that amount, all of them have to share equally. Don't you think it will be unfair if not? You're saying 4 lakh, just because A has given higher guarantee, you will recover more from him. Why? That will be unfair, right? So what we will do, we will take 4 lakh. In that 4 lakh, up to 1 lakh, we will share it equally. A 1 lakh, B 1 lakh, C 1 lakh. Now that is a C's maximum. C is done. Now still how much is there? 1 lakh is there. Now in that 1 lakh people, I will put 50 here, I will put 50 here. I will try to share it equally as much as possible. So the ultimate proportion will be 1.5, 1.5, 1. Now you guys only tell me, if the total repayment to be done is 2 lakh, how will you divide it?
2 divided by 3.
equally.
2 divided by 3.
2 divided by 3?
2 lakhs divided by 3.
Yes?
Yes.
Okay. All of you got it?
Yes, sir.
When it is 2 lakh, obviously it will be equally. It will be 3. So whatever is the number, you will divide it accordingly. Now tell me, what if it's 3 lakh?
3 lakhs. 1 lakh, 1 lakh.
It will be again 1 lakh each only. What will be if it's 5 lakh?
First 1 lakh. After that, you have to divide it.
Correct, huh?
Yes, sir, 2 to 1.
Correct, sir.
ಇದು ಕಾಣಿಸ್ತಿದೆಯಾ ಇದು able to see, huh? Okay. Yes, sir. If it's 6 lakh,
3 to 1.
so are you getting it? Wherever, to whatever extent possible, you will first divide it equally. So up to 1 lakh, everyone can take it. So it will be shared equally. Beyond 1 lakh, C is no longer liable. You will try to divide it between A and B. Clear? You may expect one question. Remember and go. Done, huh? Okay. Unit 8, bailment and pledge. Bailment and bailment and pledge. Yes, people, what is bailment? Bailment. There are two types of bailment. Bailment along the types. What is bailment?
Delivery of goods to for some purpose.
Temporary transfer of possession. Ownership of possession. If you put to ownership of RIP, chapter only came to an end. Temporary transfer of possession of goods to some other person for a particular purpose. Once the objective is achieved, the goods will be transferred back, returned back. Example of bailment: mobile repair, tent, your.
What is the difference between possession and custody?
We'll do that. What is the difference between? Okay, we have a question. What is the difference between possession and custody?
In possession, we can make use of the goods as if like we are owner. In custody, we cannot make use of the goods. We have to just custody, like bank loss.
Correct. What is the difference between possession and custody, people? In both, you will have the goods with you.
Consideration will be optional in the payment. But gradually,
ಅದು ಬರ್ತೀನಿರೋ. No, people. What is it, people? Now, in possession, there is a difference between possession and custody. For example, I will hire Zoom cars. Zoom car? Zoom car, what did I say, Okay. Zoom cars. So I will take it on rent. Now when I have it, I will take it for rent for 5 days, 10 days. Am I the owner? Zoom only is the owner. I am temporarily using it. I will use it for 8 days. After 8 days, I will pay the rent. I will give it back. Now my question, do I have custody or do I have possession? Possession only, Pakka na? Okay, Mukesh Ambani appoints a driver. Again driving the car only. The car is with him only. Car does not belong to him. Now my question, does Mukesh Ambani's driver driving his car, is he having possession or custody? Sir, we just remember that example. This is not discussed. You cannot ask an example that was not discussed in the class.
Custody. We have to listen what Mukesh Ambani.
some positions.
Possession or custody? Custody. You tell me, Mukesh Ambani wants to go right. Can you go left? You'll be removed, that's all. Yes or no? Agreed? So what you have is custody, meaning the car is with you, but you cannot make decisions. Possession means you can make decisions. The product will be under your control. So here also my control on you, sir. Gear nane actually. I understand. I'm talking about decision on the road. Clutch and all, it is yours only. I'm not at all denying it. I was getting it. I will give one more example. Now, whenever I keep my gold in bank's safety locker, will you call it as custody or possession? It is called custody because they do not know what is inside. They have it with them only, but it is not under their control. Correct? Understood? Okay then. Types of bailment: gratuitous, non-gratuitous. What do you mean by gratuitous bailment? Free of cost. There is no consideration involved. It's called as gratuitous bailment. Example. Giving to friend. You're giving your book to your friend. Giving umbrella to friend. All this is called as what? Gratuitous bailment. I hope you guys will not charge for it. Okay. Next one is non-gratuitous. What do you mean non-gratuitous? Not for free. You're charging. Giving your bike for service. Getting paid. Zoom cars. You pay. Ulu bikes. You pay. So all of this will come under what, people? Non-gratuitous bailment. Clear? In bailment, there are how many parties total? Two parties. Bailer, bailee. The one who gives the possession is called as bailer. The person who takes it is called as bailee. Okay, done now. Position, classification, done. Okay. Next one, rights of bailer. What are rights of bailer now? To terminate the bailment, if bailee acted inconsistent with the terms of the contract. Agreed, Zoom car is given to you. Imagine you take bounce bike. Chetan will take bounce bike. Going on one wheel. If bounce sees it, will he be okay? Huh? No. Inconsistent use means that you are not using the product the way it has to be used. Now what can they do? They will terminate the contract. Next one, premature termination. If a gratuitous bailment, now remember people, if it is a bailment for hire, meaning money is involved, you cannot pre-terminate the contract. If I have taken Zoom car for rent for 10 days, they cannot cancel the contract on the 6th day. No sir, we have to cancel. Then it should be only on the grounds of inconsistent with the terms of the use. They have said you cannot go beyond the city. I have taken the car beyond the city. They can come and terminate. They have said do not drink and drive. I mean, what about, you should not like this. Yes, so that you are doing. So in such case what happening? They can come and terminate the contract. But what if it is a bailment for gratuitous purpose? Meaning it's for free.
To pay the amount that he has incurred loss.
So exactly. Gratuitous bailment, can I terminate it? Yes, you can. Just that if at all the person, imagine the bailee, if he suffers any loss, you said you keep my car for 1 year, but I'm coming and asking back in 5th month only. I said free, you keep the Chetan, you only keep it. But in 5th month I'm coming and asking back. Now he thought he'll be using 1 year, he would have made necessary things like service or whatever is required, repairs, he might have incurred that money. Now because I'm taking it back in between, it's a loss for him. I need to compensate for that loss. If I do a pre-terminated bailment, in the case of gratuitous bailment. Clear all of you? Next one, suit against wrongdoer. If a car is hit by someone, bailer also can file a case, bailee also can file a case. Get the point? Now Zoom car you are going, someone comes and hits. Whoever is driving, I am driving, I can also fight it. Zoom car will also have a right to fight it. That's why Zoom doesn't pay, they will literally not care because they take insurance for every ride. So that they need not have to go behind this nonsense. Clear? Right to sue the bailee for compensation for loss by negligence of bailee, one wheeler. Compensation for unauthorized mixing.
Land.
So you cannot treat my product and your product together. You cannot mix them. Compensation for unauthorized use of the goods. You're not supposed to use them, right? To demand back the goods. Once the purpose is served, I can ask for the product back. Right to accretion to the goods billed. Right to accretion to the goods billed? Yes, let us imagine I am a portfolio manager of you. I'm maintaining your stocks. When you gave it to me, you had 100 shares of Infosys. When it was with me, Infosys declared a bonus share. His stock only, from 100 it became 120. After 1 year, I'm transferring all his stocks back to him. Should I transfer what he gave or should I transfer all the bonus also? Technically that he did not give to me, but it is his only. Understood? Cow, calf also, same thing, pregnant cow. Poultry, yes, eggs and all you need to give as the case may be. Correct. Yes. Duties of bailee includes Tony. Take reasonable care of goods. It is your duty to take reasonable care of goods. What is this reasonable care of goods? So if you take your friend's umbrella, when it is with you, if it breaks, who will pay the compensation?
If you take as if it is our
You're walking people. From behind one truck hit you. One umbrella and screw is gone. Who will bear the loss then? Friend only?
No, sir, we will not.
Okay, normally think that you took one umbrella from your friend. While you are taking the umbrella, some car came and hit you from behind. Your one leg is gone and one umbrella is gone. Let us imagine.
Yes? Who will pay? For leg or for umbrella?
Umbrella.
For umbrella, friend only will pay. It's not your liability.
Reasonable care we took.
Where did you take? You should have taken the umbrella, that's it, and you should have kept your hand. Where did you take reasonable care? You only one leg is gone.
Reasonable care.
You had second one also. You could. You did not. You did not have an intention. Okay, understood. Remember, it was not at your mistake. You did not do anything. You took a normal care. You were just walking. Who will bear the risk? It is your friend who will bear the risk, not you. Now look at the. Yes.
What if it's not there?
Non-gratuitous bailment.
Both have right to sue.
They can sue. Yes, that is there. People, now let us imagine your friend gave you an umbrella. Now you guys know how you guys behave with umbrella. You will become one king. You will come up, you will do this and all, sangre and all you will do. I don't know, girls, boys, so definitely they will do. They have at least done once in their life all this. Yes? You should either be a boy or you should have done this. What you agree is left to you. So you tell me you have done this? No. Yes or no? You have done? Every time. Okay. You are gentleman. Okay. Now yes, understood. Now people, while you are doing this, imagine you did this samurai move. Inge on the truck came and hit your umbrella. What came back is on the handle. Who will bear the risk? Obviously it is you, because you have not taken reasonable care. In this place, obviously it is you. You did not take reasonable care. Ingella.
I will do the same thing with my umbrella.
That's why it's saying reasonable care. A person with a normal prudence. For example, you share this example with girls. They will say, hey, what type of person you are? Because girls can't relate this. Yes or no? You guys want to know all this and all. See? Very only. Not to set up adverse title. You got umbrella. Obito, you just sold it off to this Dosa Angdi because UPA was not working. Can you do that? No. Not to make inconsistent use of the goods. Inconsistent use of the goods? It was not authorized to do so. You did not take it for that purpose. You cannot use it for that purpose. Return and accretion from goods, same thing, share. Return the goods according to the bailor's discretion. Once the purpose is served, give it back. Not to mix the goods. You have to always keep it separated. Finder of lost goods. What should the finder of lost goods do? Tell me, finder of lost goods, the entire right. First of all, my question to you, all exam questions only. I found the purse. I went to the owner. I incurred 200 rupees. The purse had 800 rupees in it. Now my first question, I went to the owner. I asked him, can you please give me my 200 back? I'll give you your purse back. The owner said, I won't give you the purse back. What is the right I have?
You can hold back the purse until we use the 200.
I can hold the purse with me?
Until we use 200. Yes, sir.
Is it? Can I sell the purse to someone?
Only 2/3 expenses are incurred. Then we can sell it.
No, in this can I sell it?
No, sir, we cannot sell it.
Can I not sell it? No?
No, sir.
Not possible? Okay. Second question. With regards to, what is that? When I gave this particular purse back, the owner promised to pay me 500 rupees as a token of appreciation. Thank you for bringing it back. But after going there, this person did not pay me 500. Now I want to file a case on the owner. Can I file a case on the owner? Can I file? Now my question, forget about 500. 500 is not there. This 200. Can I file a case on the owner?
No, sir, you cannot sell the case, but you can hold back the purse.
This 500 you guys understood, huh? When he has said, I will pay you reward amount. I can file a case to recover that money. What is the provision? Past voluntary services. Firefighter. Yes, here it is not my duty. In the rule of come and I'll repay. That's not my duty.
Okay, next one. Now I went to this person to give this purse. I've incurred 200. He did not give me that 200. Can I file a case on the person for recovery of 200 or not? Can I recover or not?
No, sir.
Hello?
No.
Madhya Pradesh, Uttar Pradesh? Hello? Hello? Thank God you didn't say hello. Hey, answer, huh? Huh? Can I not file?
No, sir.
No, sir.
They have asked this in the exam, people remember. First thing, whatever is the money you have incurred to give the product back, you incurred it voluntarily. It does not give you any right to file a case. For 200, you cannot file a case. But sir, he did not give me 200. You have a right to keep the wallet with you only until 200 is paid because that is your right. Third one, if at all any reward amount has been promised to be paid for the reward amount, it creates a legal right. You can file a case to recover the reward amount. Now the third thing, can I sell the product to someone?
You cannot.
Only if it is perishable, you can sell it. Perishable, edible items, you can sell it. Non-perishable, if the value of the product is 2/3 of the amount of expenses that is incurred to find the owner.
Then we can.
Meaning what? How much money is there in the purse? 800. The value that is to find that person, I am incurring 500. Is it 2/3? Beda, maths. 600. Now the amount I incurred to find him is coming to 500. Now I'm saying I can just sell because to find him I need to spend 500. And what is there in the purse is 600. Now can I keep it with me? The answer is yes. Now the next question, whenever I decide to resell the goods, if I decide to sell the goods to someone, or we'll do this in the Sale of Goods Act. Anyways, we'll get that.
A person will find a ring, diamond ring.
All in versus all. Huh? Now imagine I find a diamond ring. Now I will search for a owner. Let us go to this T only. We searched for the owner. We did not find. What will we do? It was found in that place. So we know for a fact next day he might come. He might come in search of it. What will we do? We will give it to a cashier there, telling him to give it back to the owner whenever he comes. Now this cashier papa takes a printout of it. He puts it on the shop. He will say, anyone who can come and prove that this is your ring with evidence, we will return this particular ring back. So he has spent some money also. After 1 week also he was not able to find the owner. Now after 1 week you go. Whoever has found the ring, you have found the ring, you gave it. You go and ask him, sir, did you find the owner? He said no. Then you said, okay sir, then give it back to me. He said, no, I can't give it back because I have incurred some money. Now you say, sir, I found it. It has to belong to me. Now the question is, own or forget, you are not able to find. In between you, whom does the ring belong to? Is it the cashier or is the person who found it? Who will?
Person who found it.
Person who found it. I believe the person who found it.
So remember, the rule says people, whenever you find the lost goods, the goods will belong to a person who first saw it. Who first found it? Who found it first? The person who saw it on the road. Whoever took it first, he will become the owner, provided the cashier has spent some money. It is your responsibility to pay the money to the cashier. Now you might have spent some 200, 300, 500 rupees. It is your duty to pay for that. Understood? Huh? This is what is the case law, Hallin versus Howler. Diamond ring case.
And the true owner will go and ask the other person that this is my ring. So the person is liable to give back the ring to the owner.
If other party is in advance,
We'll see that. Now you can see it here also. Now first question is, now you found a product. Now my first question, can you sell the product? Do you have a right to sell? So the question is, you need to keep the product with you. Correct? So the diamond ring you had to keep it with you until the owner is found. Now the question is it a perishable goods? No, it is not going to diminish in value also. You have also not incurred any money. So it is your right to preserve the product until you find the owner. Clear? Because you only have a right to retain the goods. Sell only perishable as well as 2/3. Either of these conditions has to be satisfied. Until then, you have to retain the goods.
Any reasonable time specified, sir, after this time I can say.
No, actually no. Because why are you selling? You're making profit out of it, that's all. As per the law, you do not have a right. Understood all of you? Yes? Okay. That's your finder of lost goods, huh? Okay, rights of bailey we saw. Deliver the goods back. Right to indemnify if at all you suffer any loss. It is my right to give it back. Who is a bailey? The person who is taking the goods. Claim compensation in case of faulty goods. What do you mean by that? I took Zoom car, brakes not working. Can I hold Zoom car owner liable? I have taken Zoom car for rent. Zoom cars, the brakes are not working. Can I hold the Zoom cars liable? Remember, if at all the goods are taken on rent, the other party is liable for all the defects he knows, he doesn't know. For everything he is liable if it is for rent. Imagine I have taken goods for bailment free of cost. This is non-gratuitous. What if it is gratuitous? Imagine you borrow a bike of your friend, brakes not working. Now you meet with an accident. Can you hold your friend liable?
No, sir, we cannot.
You got the question? Liable?
You want to give the correct
That is gratuitous, no, sir.
Friend is giving you the bike.
Sir, friend is liable if it's gratuitous.
So remember people, it all depends on if it's a non-gratuitous people, whether you know, you don't know, the party is liable. In the case of gratuitous payment free, what the friend is giving it to you, the first question asked is, does your friend know that the brakes are not working? If your friend knows that the brakes are not working, people, then the friend will be liable. You can recover the loss from the friend. If your friend is also not aware of the defects, you cannot recover the money from your friend because he is also not aware of it. Hello? Clear? Done. Okay, claim extraordinary expenses. Any expenses you can claim. Right to apply to court to decide the title of goods. When will this happen? Whenever you are not sure. You see the diamond case only. You do not know whom to return to. So in such case, you can go to the court and say, sir, I don't know. 2 people are coming and asking for the gold or the diamond. Whom do you want me to return? You can apply to the court to decide the title of the goods, meaning to decide the owner of the goods. You can go to the court.
Sir, then can cafe owner, I saw it first, sir. I went and asked. Did not give to me and he going to.
You will only win. Because you found it, right? And that is written in the law. Next one, sir. Duties of bailer. To receive back the goods after the time and purpose, you need to take it back. To indemnify the bailey for any suffered by loss. Duty to disclose faults in the goods bailed. People, duty to disclose faults in the goods bailed. Brake not working, you need to disclose. Pay necessary expenses. Indemnify bailey for premature termination. I gave you my car for 1 year. You have spent some money on repairs and garage expenses. After 6 months, I'm asking for the car back. You have spent any money, I have a right to recover that money. Clear? Hello? Okay. Next one, sir. Termination. On expiry of period stipulated. When does the payment come to an end? On expiration of period stipulated. If I have given it for 1 year, after 1 year it will come to an end. On fulfillment of purpose. I gave bailment for repair. Repair is done, bailment comes to an end. By notice, if it's a gratuitous bailment, free of cost, I will just tell him, Macha, give back my bike. He have to give back your bike. Non-gratuitous cannot be terminated at all. If you want to terminate, it has to be inconsistent use. Single wheel. By death of bailey or bailer, in case of gratuitous bailment, a person dies. Bailment come to an end. On destruction of subject matter, umbrella only went. Where is the bailment? So product will come, contract will come to an end. Next one, people pledge. What do you mean by pledge, people? Pledges are bailment for security. When will pledge come into picture? Whenever you guys take a debt loan, you guys give gold for a security, and you guys take loan from them. Now that is why we call it as pledges or bailment for security purpose. Why is it a bailment? Until you repay the loan, your gold is with them, no. Can they use it? Huh?
No, they can't use.
They can't, no. But I've heard from a lot of people that whenever they pledge, they use it, it seems.
For what? How they manage it?
There are some shops which charge rental and all. But I'm not saying with big people, small people it will happen. No, big big people are not doing racism here. I'm saying, no, there is Muthoot, Manappuram. There, the chances of these are less, it seems. But these loans will be even given to you by gold shops also. No, you cannot make inconsistent use. In the contract, have you said that? No. Why have you taken the gold? Just as a security. If you do not repay the loan, then I'll keep the gold. That is the purpose. You did not take it for using it, right? You are technically not supposed to use. But will they? Yes. And this was one of the person was telling me. It seems they use this jewelry work, the stones and all will be there, right? All that will fall off, it seems.
They'll steal.
Still, they'll be using it. That means it is being used. Now you imagine, if it's not yours, how will you use?
We cannot.
I'm saying, even if you're using, will you use it carefully?
No,
Hey, really? That's how you do it, right? When it's not yours. Okay. Pledger, parties, pawner, pawnee, also called borrower, creditor, or pledger, pledgee. Meaning, bailment of goods as security for repayment of debt. Essentials, bailment is for security. Subject matter is always movable. Why? If it's immovable, it is called mortgage. If it is movable, we call it as pledge. Delivery of goods from pledger to pledgee. You have to deliver the gold. If it is with you, it cannot be a bailment. Pawnee's rights and duties, it's same as your bailer and bailee. If you remember one and go, it is same. Why? When I'm taking loan, I'm giving my gold to you. My gold to you. Technically, I'm a bailer only. Muthoot is taking your gold. Technically, they are bailee. Their duties are also same only. So remember one place. You can write the same thing in both the places. Clear? Okay. Pledge by non-owners. Pledgee, mercantile agent, whatever. We'll see this in Sale of Goods Act. We'll be seeing same thing. You'll be seeing it as sale by non-owners. Same concept will come. We'll see it there. Yes? Done. The next unit is the last unit of Indian Contract Act. Contract of agency. Contract of agency. Contract of agency. What is the agenda? A party acting on behalf of the principal, representing to the world. On behalf of principal, he will represent the world. It's called as agency. The best example you guys know, agents are insurance contracts. Agents, insurance agents you guys call it, no? You would have heard of it also, right? Yes. Okay, parties, principal, agent. Principal should always be a competent person, major or sound mind. Agent, can it be a minor? Possible. The reason is, for whatever agent does, principal will be liable. So, principal should be a major. Our agent can be A minor also. I'm not saying he should be a minor. If you're taking it at your risk.
Sir, but technically law does not accept.
Does not accept. That's what. If you're still allowing it, then it is your karma. That's what they're saying. Okay, next one. How is agency created? One is express. Express means you are my agent. That is express. Implied means what? Based on circumstances. Circumstances means what? Someone is allowing you. Now imagine, someone is, say for example, I had to pay money. Someone is paying on behalf of me. Next day, again someone is paying on behalf of me. Now it has become an implied thing. Now imagine people in that shop, last shop. Now 3 people will go every day. On behalf of the 3 people, I will only give money. Next day, I will only give money. For almost 1 month, on behalf of all of them, I have been giving money. The next day, they will go and drink coffee and they will say, sir will come and pay money. Whether the shop owner will give it or not. Yes, because you have accustomed. That is called as implied. You have created that in their mind. Yes. Next one, estoppel. Estoppel means what? I have made a promise. I have to stand by it. Next one, necessity. Necessity means people, agency created out of emergency. Emergency, when will it happen? Emergency. Huh? You should be in the possession of principal goods. You should not be in a position to communicate with the principal. It should be a literal commercial emergency. You should have taken that decision, which is the best possible thing at that point of time. It is the point? Yes. For example, this will happen in ships. Now in a ship, what will happen, people, when they are taking the cargo on the ship? At times what will happen, the ship, because of turbulence, because of the waves, the ship might have to offload some cargoes at times, rarely. But they might have to offload. They might have to push some containers. They don't have a choice. At that point of time, the captain of the ship is being a representative of the company, of the ship's company. If he is pushing something, you are doing the best possible alternative at that point of time. If you do not push that cargo, that container into the water, entire ship can drown. Now what did you do? Can I contact the principal from ocean? No. Hello sir, you can say no. And whatever I did is the best possible commercial output. That's the best possible decision. Now whatever that person did there is called as agency by necessity. Who will bear the loss for that cargo? You cannot say captain is liable. Who will be liable? The principal, the owner of the ship only will be liable.
Why you are saying best commercial?
Meaning, if there is, what if there is some other option also? At that point of time, whatever is the best one. If you have 3 choices, you should have chosen the best one. Now imagine, I know there are 3 containers. One has 1 crore worth goods, 80 lakh worth goods, 65 lakh worth goods. I have disposed of 65 lakh worth goods. That is what I think is the best commercial possible thing that point of time. Clear? Okay. Last one is called as ratification. Ratification means what, people? People, ratification, we have seen in minor agreements.
To make something right.
To make something right. In the past, you had no right to do it. But in the future, I am giving you a right. It's called as what? Example, what did we see in the class? Huh? Minors liabilities cannot be ratified. What is the example? Let us imagine, people, I have a building. I am going to US. I want someone to take care of this building. Now I ask Chirag, can you take care of this building? I'll be back in 3 years. You just maintain this. You don't do anything. Make sure it is everything properly. Someone comes and cleans and goes. You just maintain it. I'll come back after 3 years. Chirag, after 2 days, Chirag's business brain started working. Chirag felt he's just left this property vacant. Why can't we just give it on to someone on rent? So Chirag gives it on rent. It is giving us 50,000 rupees per month. All the floors put together. Into 12 months, giving us 6 lakhs. Into 3 years, which is giving us 18 lakhs. As and when I came back from US, I'm seeing the building. Munde on the cabling ide. The gate is doing the sound. Full dust there. I was about drawing on the wall. Chirag Lahus. Okay. So yeah, some drawings are there. So people, I was about to call Chirag and say, "Dude, Chirag." Now people, Chirag came. Chirag said, "Sir, check your account. Some credit message would have come." I checked people. 18 lakh rupees credited. I said, "Chirag, Kanna, how are you? Did you have coffee?" Yes or no? Why? I wanted to literally scold him. And it became Kanna. Why? So people, now I said yes. Correct? That means what? The moment I took 18 lakhs, I accepted 18 lakhs. I'm accepting whatever decisions Chirag has taken. That means that entire property, whatever has happened, I'm accepting that also. Now this is only called as what? Agency by ratification. I'm saying yes after the entire contract is done. First you should give it, actually what is the procedure? You have to appoint an agent first and they will enter into a contract. Here what is happening? He is first done everything. Later on I am giving him the power. That is called as what? Agency by ratification. Only in the ratification. An act where a person, when he did the act, will not have power. But later on, he will be given power for whatever he has done. An act which was initially invalid will be made valid in the future. When he made it was invalid, I made it valid in the future. Agreed? Remember, illegal acts can never be made valid. Illegal acts can never be made valid. Is clear? All of you? Pakka? So this is ratification. Remember, important, they can ask you a question. Appointment of subagent. Can you appoint a subagent? Is appointment of subagent valid? Delegatus non potest delegare. What do you mean by that? I have appointed an agent because I believe in Chirag. I gave the work to Chirag. Chirag believes in Chetan. I gave the work to Chirag. Chirag is giving it to Chetan. Now people, I have some trust on Chirag. I have given it to him. Now this is called as agent. When my work is given to you, you further delegate it to someone else. This person is called as subagent. Remember, by default, appointment of subagent is not valid. Appointment of subagent is not valid. It is invalid. You cannot appoint a subagent. However, there are some exceptions. What are some exceptions? It is the usage of trade. Exceptions. The terms of appointment allows, meaning when appointing itself I told, sir, I will not be doing, I will be appointing someone else. Is it okay? While appointing only I am telling you. Is it okay? Yes. Next one, custom of trade provides for appointment. The trade works like that. Example was marriage contracts. Marriage contracts, you will appoint one person called as event manager. He will further delegate all the work, catering, it can be decoration, it can be whatever it is. You are appointing one person, he is further appointing everyone, but the point of contact is him only. Third one is unforeseen emergency, shippo. Anything happens there, if he takes decision, if he wishes to further delegate the work to someone, even that will also be valid because necessity. Clear? Yes, correct. When he is medically not in a position to fulfill your job, he can further delegate it to someone else. The next one, sir, is there a difference between sub-agent and a substituted agent? What do you mean a substituted agent?
Agent referring to another agent.
Agent referring to another agent.
Principal, the
So
principal
there
will be
the
knowledge
knowledge
about
about the subagent.
Principal will be knowing about the sub-agent.
Agent refer, agent to a person.
So I will say, I have this work. Do you know how to handle? He will say, sir, so sorry, I don't know. You do one thing, I'll give you one number. You contact him. So you contacting him, people, is called a substituted agent. Substituted agent is nothing but people, a agent giving a reference of another person who will have a direct privity of contract with the principal. What is the difference? In substituted agent, principal, under him agent is working. Under him, substituted agent is working. There is no privity of contract. You are reporting to him. He is reporting to you. In substituted agent, what is happening? I will give you the reference. Sir, you call this person. Directly, they both will take it forward. There is a direct privity of contract. Are you getting a point? Yes. But in substituted agent, will the initial agent be liable for anything?
No, sir.
Will he be?
No, sir.
He will be liable if at all he does not refer a person in a good faith. Meaning, why did I refer? Because I'll get some commission. But is he fit to do the job? That you don't know. So if you are just referring a person for your commercial gain, and if I lose any money there, can I recover it from the agent? Answer is yes. So all that you need to do here is to be aware when you are referring a person to another person, you should have used your prudence brain. You should have not cheated. If that is the case, yes. If not, if you do not do it, you will be held liable. Understood, Ram? Hello? Any doubts? Okay, then that is substituted agent. Next one, sir. Rights of an agent. You have a right to remuneration, of course. Right to retain out of sums received on principal, advances, expenses. What do you mean by that? If at all you do not give me money, if I have any goods which belong to you with me, I'll keep it with me until the money is paid. Agents lien on principal's property. Same thing. I can take money also. I can take the goods that is with me. I can keep this or that. That is left to me. Next one, right to indemnity. What is indemnity? On behalf of you, I will be entering into many contracts. If I suffer any loss, you have to make good that loss for me. Because I will be representing. People will file a case on me. You have to come and back me up. You have to support me. If I lose any money, you have to pay for that. Because I am entering into a contract for you, not for me. Right to indemnity. Next one, duties of agent. Duty to execute mandate. What do you mean by duty to execute mandate? Imagine I am giving you one consignment worth of 10 crore. I clearly told you to take an insurance. Now you did not take an insurance and the goods is lost because of some, bad weather or some calamity, natural calamity. Who will bear the loss? It is a loss of the agent. I clearly told you to take insurance on the goods. You missed to take it. It is your liability. Why did you not take? That's the meaning of duty to execute mandate or duty to follow the instruction. It's a duty. Yes or no? Next one, duty of reasonable care and skill. What do you mean reasonable care and skill?
You have to take the goods as if our goods.
You have to make sure you take reasonable care of the goods. If it is you, if it is yours, whatever decision you take, you treat it in the same way. Next one, avoid conflict of interest. Manager, paper, Arivu. I tell you to hire the best seller in the bidding. Printing department, 100, 120, 130. But which one we will select? The one which will give you more commission.
No, sir, 100.
Correct? No, that is what they are telling you. Avoid conflict of interest. Do not select a person which will give you profit. Select a person which will give the principal the profit. Communicate with principal in case of difficulty. If you are not able to make decision, ask your principal and then communicate. Not to make secret profits. This is the main rule. You make 1%, but disclose and make. To render proper accounts, do not cheat, not to delegate. You cannot appoint a sub-agent by default. But exceptions, those three. Pay some receipt for principal. Whatever money I have received, I have to give it to the principal. I cannot keep it. Not to use confidential information against principal. You guys are the best example for this. CAs are the agents. You guys will be representing your clients in various legal fields. You have you have access to the entire world of his. You have their bank statements, you have their P&L, you know their wealth, you know their property. Can you use it against them? Siraj like, sir, you become my client, I'll show you. Principal of agent's liability to third party. Principal liability for act of agent. Whatever agent does, who will be liable? Principal or agent? By default, principal will be liable. If he has acted within the scope, if he has acted beyond the scope, agent will be personally liable. So, agent is not personally liable by contracts on behalf of principal. Generally, who will be liable? Generally, it is principal. But in some cases, agent will be liable. What is that? One is pretended agent. What do you mean pretended agent? I am in fact not an agent at all, but I am telling to the world, I am agent of Ambani. I am making my world. I am living my life. Can we do it? When they get to know, of course Mukesh Ambani is not liable. I am making up the story. Who will be liable? Agent only will be liable. Foreign principal. Indians we are not able to catch. So principal is staying abroad. But the agent is in India. Whom will I catch? I will catch the person in India. Agent does not disclose name of the principal. So imagine there is a legal dispute. I am asking you, tell me your principal's name. He is saying, no. You will tie him to the chair. You will hit him. You will not tell. You will take cutting player, pull his nail.
Sir, for money what, sir?
You will take one nail and hit it in his toes. Hinge. He is not telling. Then who will be liable? Agent only.
Civil law.
You will take one hot coffee and you will pour. You don't watch movies? Okay. Incompetent principal. If you are acting on behalf of unsound mind, that time who will be responsible? It will be you. Okay, next one. Authority. Principal's liability. When agent exceeds authority, I told you to do a contract up to 1 crore. He has done it for 1.5 crore. 1 crore, I am liable.
0.5
0.5 agent is liable. Any notice given to agent is equivalent to giving it to principal. I speak to agent, I will not speak to principal, but it is equivalent to speaking to the principal. Effect of misrepresentation or fraud by agent. What do you mean by that? I ask my agent to sell my car. Because he gets commission, I clearly tell this car gives a mileage of 10 kilometers. He says because he gets commission, so this car gets 18 kilometers per liter. But to sell the car, he has lied. Whether will I be liable for it?
Yes, sir.
As a principal? Answer is yes, I will be liable. Because why did I select him then? It's my responsibility. I am liable for whatever he says. In between us we can fight. But for the world I am liable. Correct? Hello? Okay. Rights of third parties. Contract made by undisclosed agent. What is contract made by undisclosed agent? A agent is acting on behalf of a principal. He is telling I am an agent. But he is not disclosing the name of the principal. I am telling I am an agent. Who is your principal? You are not telling. If you get to know who the principal is, the third party, if he is not okay to go ahead, he can cancel the contract. He has that right. Yes? Next one. Performance of contract where agent is supposed to be principal. Meaning agent does not disclose at all that I am an agent. In such case, what will happen? I have a right to file a complaint against agent only, or I can even complaint against principal only. Option of third party to sue the agent or principal where agent is personally liable. We saw where agent is personally liable. Where and all agent is personally liable. Foreign principal, pretended agent, outside the scope. In all these cases, I can file a case on agent only. Consequence of inducing agent or principal. What do you mean by inducing agent? Inducing agent means, imagine in the car case, the car dealer, that is a broker, he is telling, sir, you take the car. If anything happens, you come to me. If anything happens, you come to me. Something happened. Will he come to the principal or the agent? 100 times you have told, come to me, come to me. He'll come to you only. Yes or no? That's what they are telling. Consequence of inducing agent to to act on the belief that principal or agent will be exclusively liable. You are clearly telling, I will be liable, you come to me. So you will only be liable, yes or no? Okay, the last one, sir, termination of agency. When will the agency come to an end? On completion of business, sell the car, sold the car, done. On expiry of time, I've appointed you for 6 months, 6 months, done. Principal became insolvent. Ultimate liability is his only. He only became insolvent, done. Revocation by principal, have appointed you, I'm taking back the authority. It is done. When you can take back, I can also give back. Renunciation. Revocation is with the principal. Renunciation is with the agent. Renunciation is giving up. But remember, I have appointed you for 1 year. If I am removing you in 6th month, it's entirely a breach of contract. I have appointed you for 1 year. You are only living in 6 months. That is also breach of contract. Both of them have to pay compensation because it's a breach of contract. Last one, death or insanity of principal or agent. Dies or he becomes unsound mind. Obviously, the contract will come to an end. Effect of termination, when will the agency come to an end? Whenever you communicate it to the agent, when he gets to know, he reads the letter, from that the agency will come to an end. When will the agency come to an end? To the outer world, to the third parties. Whenever they get to know. Agency will come to an end when he gets to know. When will the third parties, when will the contract get come to an end for the third parties? Whenever they get to know. They can build a case here also. They can ask you an indirect based question here. Clear? Yes. Hello? Yes, hello? Yes, okay. We'll do up one or two units, huh? You guys can take from 5-10 minutes break. We can take some 4-15. At least some 2 units of Sale of Goods Act. Yes? Hello? Okay. Take some 10 minutes break, come back. Let's do a Sale of Goods Act. In the next cycle, I think in September, they'll be doing JM in Bangalore. You all should be there. Huh? So, Arivu's felicitation. Whenever you guys clear the course, once, 2 times in a year it will happen. So, tomorrow it's in Chennai. So, first half year it will be in Chennai. Second half year it will be in Bangalore. So, next half year you guys should be there. If not, Chennai will be far. Illa? Okay, you get it. Okay, next chapter we will easy chapter, Sale of Goods Act, formation of contract of sale. Yes, people. Hey people, what do you mean by goods? Goods means every kind of movable property other than actionable claim, money in circulation. Actionable claim is dealt under negotiable instruments. Money in circulation. Money in circulation. Currency. Antique coins does not come here. So antique coins can be considered as goods. Also includes stock, share, growing crops, grass, things attached to the land and agreed to be severed. Agreed to be severed, this means nothing but timber. A tree which is grown for the purpose of using it in the furniture and construction, we call it as timber.
The animals.
Good one only. Allah, you asked things attached to the land and you said animals, alwa. I thought which is that animal which is attached to the. I was thinking on those grounds. Sorry. Nande mistake. Livestock cannot be goods. If it's meat.
It is applicable, sir. This act.
Yes, meat it is applicable.
Like elephant.
Huh?
It won't applicable on normal animals like
Normal animals, no, meaning something which doesn't breathe or something like that. Elephant normal animal. ಏನು ನಿಮ್ಮ ಮನೆಯಲ್ಲಿ ಬಾಲ್ಕನಿ ಬಂದ ನಾರ್ಮಲ್ ಅನಿಮಲ್ And who will buy and sell an elephant?
Like there is a trade for elephant, like giving for the festival or something. That's not as a meat.
Sir, I'm not telling in pieces, sir. I'm telling in full. Okay. So, right, okay. Okay, next one is classification of goods. Goods can be classified into what? Existing goods, future goods, contingent goods. Existing goods can be further classified into specific goods, unascertained goods, ascertained goods. What do you mean by specific goods? Specific goods means people, the goods which are identified at the time of contract of sale. When offer and acceptance are being made, you exactly know which goods you are going to get. So, what do you mean by specific goods? The goods which are identified at the time of contract of sale. All your offline transactions will come here. Now, imagine you want to buy a shirt. You go, you pick it, you have it in your hand, you know which one you are going to get. So, that is called as specific goods. What do you mean by unascertained goods? All not identified. What do you mean by unascertained? A goods which is not yet identified at the time of contract of sale is called as unascertained goods. That means the goods are sitting in bulk. Hello? Getting it? So the goods are sitting in bulk. For example, you order something online. You select a specific model, but the seller has 500 pieces of that model. Which one you are exactly going to get? How do you know? So out of the bulk, they will select one after you place an order. So contract is already made, but the goods are identified after the contract is made. Identified means which one you are going to get is identified after the contract. Is called as unascertained. From the bulk, if one product is separated, it becomes ascertained goods. Understood, all of you? Next one is called as future goods. What is future? When the contract is entered, the goods are not yet produced, manufactured, acquired. It is not yet made, but it will be made in the future at the time of delivery. It's called as future goods. Example, agriculture. Example, carpentry. You give an order to make a sofa for you. Hello? It's a future goods. What else? Agriculture, as the case may be. Next one, people, contingent goods. What is contingent goods? Chirag's bike. Contingent. I do not know whether he will give it or not. Yes or no? That is called as contingent goods. Okay, done. Feeling cold, huh? It's clear? Yes, Sam. Online now. Next one, delivery people. Types of delivery. One is called as actual delivery. What is actual delivery? Like this. I take it and I keep it in your hand. It's called as actual delivery. Physical delivery of possession of goods is called as actual delivery. Constructed delivery. Without change in custody is called as acknowledgement. When does it happen?
Parking, not parking. So in all will be parking. So in go down, go.
When the goods are in the go down, what will we do, people? Let us imagine we are doing a really bulk deal. In the go down, there is almost a goods worth say 50 crore, 100 crore. Now when I sell it, I will not go and transfer the goods from one place to another. What will I do? We will do a trade by transferring the go down only completely. The goods value is 100 crore. So what will I do? Let us imagine till now a manager is taking care of one go down. He will be reporting to a person called A. A has sold all those goods to B. A will tell the goods now have been sold to B. Now you need to report it to B. You will be a manager, but not for me, but for B. Now manager calls B and says, hello sir, the goods are safe. I got to know now that you will be taking care. The goods are safe as of now. Your goods are being taken care by me. The goods were there only, before the contract also. The goods are there only, after the contract also. The goods did not move an inch, but the delivery took place from A to B. How? By an acknowledgement, meaning by a call. Telling the manager is telling, I am reporting to you now. Delivery is made. This is called as what? Constructive delivery. Get the point? Yes. So, and delivery happens due to acknowledgement. Someone signifying you that yes, I have received the delivery. Getting the point? The third one is called as symbolic delivery. What do you mean symbolic? Car delivery. You will, correct? No. You will stand in front of the car and you will smile. So that is called as what? Symbolic delivery. Are you taking the key there or car there? The picture is key, but you are taking car. Correct? No. So that's the meaning of symbolic. We are giving you key in the symbolic delivery of a car. That's the meaning of symbolic delivery. In token of delivery of one thing, some other thing is delivered. Hello? Okay. People, document of title, document showing title. What is the difference?
We lost the document of title. We lost the ownership.
Yes. If you lose a document of title, you lose the ownership. If you lose a document showing title, it just is a proof of ownership. For example, your RC card says you are the owner. If you lose your RC card, whoever finds it will not become the owner. Share certificate is a document showing title. It just says you are the owner. If you lose a share certificate, whoever gets it will not become the owner. These are all the examples of document showing title. What is the example of document of title? Currency notes. Yes? Railway ticket? Is it? Morning only I told you. You cannot go. Vouchers? Yes. Blank check? Yes. In our apartment, in our shopping, they will give that token. You go and give your bag. They will give you one token. You lose it. Someone else will give it. They will get the goods. Yes or no? Will they ask you for Aadhaar and all? No. Then, so that is called as document of title. Got it? Warehouse certificate, go down certificate, war finger certificate. All these are the examples of document of title. Next one, contract of sale. The contract of sale are of two types. One is called as sale, one is called agreement to sell. What do you mean by sale? Sale means immediate transfer of ownership. In Sale of Goods Act, property means ownership. So immediate sale of ownership is called as sale. If at all today you are agreeing to sell the ownership in the future, it's called as agreement to sell. So here immediate transfer, here the ownership will be transferred later. The future risk is with the buyer, risk is still with the seller. Damages will be suffered by the buyer, damages will be suffered by the seller. So that entire list will be writing here. Okay, next one sir. What is we see in first order? Difference between sale and bailment. What is the difference? Sale and bailment. In bailment only possession is transferred. Sale ownership is transferred. Possession will be transferred back. Sale possession will not be transferred back. What is the difference? Consideration is mandatory, optional here. What is the difference between sale and hire purchase?
will get to ownership in the last installment.
Very good. In hire purchase, the ownership will be transferred after repayment of last installment. In sale, that is not the case. In sale, the ownership is transferred immediately. In hire purchase, risk is less because you would have given the product. If at all the person does not pay an EMI, you will go and get back the product. In sale, that you cannot do. Agreed? Yes? Okay. That's your okay. And price. How do you determine a price? In a contract of sale, how do you determine the price? The first one is by contract. By contract. Next one, the course of dealing with the parties. Next one, by third parties. That is valuer. Fourth one,
Reasonable price.
very good, reasonable price. When a product is transferred but the price is not agreed, what you will give is a reasonable price. Agreed? Hello? Okay. Next one, unit 2, conditions and warranties. What is the condition and warranty? Whenever you buy a product, the seller will tell 100 things for you to buy the product. That 100 things is called as stipulations. Meaning for you to be convinced, they will tell 100 things. Yes or no? Now, these stipulations, some things can be important to the contract, some things cannot be so much important to the contract. If it is very, very important to the contract, we call it as condition. If it is okay to the contract, we call it as warranty. If a condition is breached, you can cancel the contract, you can claim compensation. If a warranty is breached, you cannot cancel the contract, you can only claim compensation. Remember, breach of condition can be treated as breach of warranty, but breach of warranty cannot be treated as breach of condition. Example for breach, what is condition? Example?
The main purpose of
It's the main purpose of the contract. For example, I go to an automobile showroom, I say, I want a car which gives me extraordinary mileage. That's my main purpose. He suggests me one car. Everything is good, but mileage is 10 kilometers per hour. My whole purpose of buying the car was mileage. I have a right to return the product, get back my complete money. Because my condition is so essential. What do you mean by breach of warranty? I ask for a car. The car I will get. It is giving 25 kilometers per liter. But okay, indicator or light is not working. Or AC is not working. I'll say take back the car, give back my money. They will just replace the bulb. Correct? So in warranty, repairs, those things will happen. In condition, it cannot be. It is basically cannot be corrected at all. It's called as breach of condition. Clear? Something which can never be replaced. Condition. Which can be replaced, warranty. When can breach of condition be treated as breach of warranty? When buyer waives off. Meaning, all of us we fall here only. Correct? No. We buy a product, defective product, what will you do? We keep it. Yes or no? We waive off. That means you're giving up your right. Treats breach of condition as warranty. You have a right to return. You will say it's okay. Just give me compensation. I'm happy with it. Next one. Contract is non-severable and buyer accepts it as a whole. What do you mean by that? Now, whenever I am taking a contract which is having two things. I buy a bike. I like the entire performance, but mileage is not working out. I like the entire product as a whole. I cannot separate them. I will adjust. I'll think it's okay. I'll keep it. That's called as non-severable. Next one, people. Fulfillment is excused by law. Debt, impossibility, change of tax. Because of that, the contract is not being able to perform. You cannot cancel the contract. The contract will basically become void. That's all. Next one, people. Stipulation. Now, there are two types of conditions and warranties. What is that? One is implied, one is express. Express is left to the parties. You can decide whatever you want. Implied, people, is agreed by the law. There is implied condition, implied warranty. What is the implied condition? First one, implied condition as to the title. This pen is for sale. Anyone wants 100 rupees? You want? Yes, he wants. People, he will say, sir, is it working? I'll say it's working. Sir, is it new? I'll say, yes, it's no. Sir, is it apple? I'll say yes, it's apple. He asked everything. I said yes. But he did not ask, sir, are you the owner? You will never ask that, right? Yes or no? Have you ever asked that? Now we assume that you are the owner. Law says, I will protect you if he is not the owner. Getting it? A person who is selling a product should be the owner. That is what is the title. Sir, what if I am not the owner? I gave it, I went off. Now imagine Arjun sir came and he said, hey, why are you having this da? He said, sir, Sai sir sold it to me. How can he sell da? It is company's property. Give it back.
I'm a good more.
Who should give it? Now you tell me da. Who will keep it?
No, I will keep it. Or no, whoever it is.
Arnav can keep it?
But no, sir.
Of course.
But sir, that much good
He purchased in the good faith. Remember, Arnav cannot keep it. Arnav should return it. A person who does not have a title, it's not mine. I cannot sell it. Hello?
Sir,
Again, good faith, anything, you have to return it.
What if he further sold?
You sell 100 times. When I don't have a ownership, I cannot give you ownership.
sir, he will, Arjun sir can fight with him. Like, he will take case on you and he will recover and he is.
No. See, the first thing is he is the owner. I will have to give it back to him. Now Arnav can file a case on me. We will fight. But whose product is this? Truly. Arjun sirs, it has to belong to them because it is not mine at all. I don't have ownership. How can I give him ownership?
But in that Tipu Sultan night something. You told before, no, sir.
Tipu Sultan case, I made 2 sales. Meaning, imagine this is Arjun sirs. Tipu Sultan says what I am saying. Imagine this is Arjun sirs. Arjun sirs sold to me also. Arjun sir sold to Arnav also. That was Tipu Sultan case. Here I am not the owner at all. Clear, huh? Next one, people. Sale by description. Description is what? Sale by description. Description means what? Fresh mango. Chandari silk. Kolhapuri slipper. Dharwad peda. Mysore silk. Assam tea. Guntur karam. Mahesh Babu movie. Really karam? Okay. Chili. Chilies, okay. Mysore pak. Pakistan. Sorry. What else? China. China noodles. China noodles is famous? Munyamma Bhaji shop. Very famous. Correct. So when you are describing the product with something, it has to meet with a description. Fresh sweets. You go to a bakery. You ask for a bread. All our father, or our mother, or all our uncles, they'll ask one question. Bread fresh, Anna? Eagle madito. Just now it came hungry. You see, you put your hot. Correct. He acting alla agatte. Yes or no? When you say fresh, it has to be fresh. Next one is sample. Sale by sample means what? Whatever you see is what you need to get. Yes, here scam happen a lot. Yes, now imagine you take any sample of sweets. They give it to you like this. That sweet will be good. He will pack the one which is towards him. When he is giving you sample, he will give you one towards you in a glass. That will be fresh. Towards him, yesterday, day before yesterday, last week, last month, you never know. Yes or no? Last year. Yes, sir. So, now after going home, it is not the same as you tasted. Can you file a case? Answer is yes. Clear? Yes. That is what is sample. Next one, sale by sample and description. That means what? I'm telling you the sweets are fresh. That is description. I'm giving you sample also. It has to meet with sample. It has to meet with description as well. If you remember Basmati in that. Quality or fitness. What do you mean quality or fitness? whatever is the purchase I'm making, it has to fit my purpose. That means I've made you know my purpose. I want a car which suits my mileage. You give me a car. If it does not fit my purpose, that means people, I will not buy it. I have a right to return back the product to you. Fitness here means not fitness. Adalla, fitness means the product you purchased, is it serving your purpose? For whatever you purchased, is it serving that purpose? If it's not serving, then why did you buy? The whole contract is depending upon that, yes or no? That's what they're telling. Getting the point? And remember people, generally it is caveat tempter. When you are buying on your own, then the seller is not liable for this. When will seller be liable? When you make the seller know about your purpose. You are going and asking him, sir, I want a car which suits my mileage purpose. He tells you one particular a car, he suggests you. You rely upon his decision and then you are cheated. That will come here. You only go and say, sir, this is good, sir, you fall, you will die. If you take that, it is your risk. Yes or no? Okay. Next one, people, merchantability. What is merchantability?
It should be fair.
Someone else first can buy the same thing as I.
So it should be good conditions.
Nothing simple, free from defects. Merchantability means it should be free from defects. Wholesome means
Applicable for eatable.
it is applicable for edible. Merchantable, we use it for non-edible items. You buy a mobile, there should not be cracks. You take bread, it should not be spoilt. It should not be a stale bread. That is called wholesome. Edible products we call wholesome. Clear? Done. Next one, implied warranty. Warranty has to undisturbed possession. What is the undisturbed possession? You can club these two and understand. Now imagine, I gave this tab to Arnav. I sold it off. But if you see, I've taken this tab on EMI. I've sold Arnav with 30,000. I've taken money. I did not repay the EMI. Now every day Arnav is getting a reminder. Your EMI is for due. Your EMI is for due. Or imagine even it can be a bike. I've taken a bike on EMI. I sold my bike to Arnav for a complete price, 1 lakh. But I did not repay the loan. Every day the Bajaj Finance people are calling. I did not pick the call. One day they are in front of Arnav's home to recover the bike. Now can they recover the bike? Can they recover? So now remember what you will do. Arnav has two options. One, repay the loan, recover the money from me, or file a case on me to repay the loan. You have both the options.
But first we have to give vehicle.
First you have to,
Give vehicle.
they will come back and take. Yes, they will not leave. That is only called as warranty as to undisturbed possession. As a buyer, you have a right to enjoy it without someone coming and keep on disturbing it. You have a right to enjoy. Next one, quality or fitness by usage of trade. What do you mean by that? Quality or fitness by usage of trade. One people, you are intimating, I want to buy this product for this purpose. If it doesn't serve the purpose, you can return the product, get back the money. Second one people, you are not letting know the purpose. But a particular product would have been used for a particular purpose over a period of time. If the product does not serve that purpose, it will come under implied warranty. Example, if you remember, we had seen in the class, umbrella. You remember? Gucci umbrella? Gucci and Adidas, they have come with an umbrella. That 1,20,000 or 1,40,000 rupees umbrella. Gucci and Adidas both have it. Umbrella, they have it. I think we have seen in the class, all umbrella pictures and all we have seen. So they have an umbrella, Gucci and Adidas. Why do you use umbrella for? Apart from fighting, why do you use it for? Rain, correct? But unfortunately, this Gucci and Adidas umbrella, which is around 1,40,000, does not stop rain. It is not rainproof. It is not waterproof. It is there, you search Gucci and Adidas. You search for umbrella, you will get the dispute only. You will get the case. Yes? Then why did people buy it? It seems that is used as a interior decoration.
Sunlight also.
And second one for tan.
That's a different word.
Yes. I'm saying, why is the umbrella used traditionally? It is for rain. Boys, so we don't even know what the tan and ban and all is. Yes or no? Then, so traditionally when a product is used for a particular purpose, if your product does not serve the purpose, it is your duty to disclose. If not, it will come under implied warranty. Getting it? That is the meaning of trade. Usage of trade means a particular product from a long time, it is used in this way. You need to use it in that way. If you what do you say? You divert from what it has been, use it for, you have to disclose. You have to clearly write in bold. Umbrella not made for rains. Yes, that's how you need to do it. Next one, disclose dangerous nature of goods. This is all you know. So cigarettes, it will be clearly written that it is smoking kills. Everything, right? If you take deodorant, it will be written, right, highly inflammable. Medicine, keep it away from the children. Yes? They will write, no, keep it away from sunlight. They will write it, right?
Don't expose to
Yes. Yes. Last one, sir. KV counter. Let the buyer be aware. Fitness as per quality are used. We have seen this. Priest versus last. What is the case law? He took a what is it? Flask. He took a flask. He put hot water in it. He gave it to the wife. It became atom bomb. Wife, Papa, it exploded while it was in her hand. Immediately, he didn't even take her to hospital. He went to the shop and he asked, give me my money back. And also claimed compensation for damages suffered. Whether the person will be liable? Yes. Clear? Sir, first question, did he ask her that it is for hot water?
it is implied.
Very good. Remember, when a product has a single purpose, flask is meant for single purpose. It is, you know that you put a hot water in it, it has to withstand. When a product has a single purpose, even if I do not express that I am using it for putting hot water, even then I can hold you accountable. Getting it? Okay, next one. Goods purchased under brand or patent name. I told you our books has mistake here, not my book. I am saying institute material only says you cannot claim the fitness or usage if you have purchased the goods under trademark or brand name. But here it is coming under exceptions to caveat emptor. Correct? Hello? So what do we do? You write this only as heading. Explanation, write that only. What is the explanation? Whenever you purchase a goods under a patent or a brand name, remember a consumer, that is a buyer, can never file a case on the grounds of implied condition or implied warranty. Because you are buying that product because you want that brand. The seller did not sell it there. He did not make any promises there. You chose that brand. Getting it? So technically it should not come here. But they have still put it. Even in our exam we will be writing it. You write the title. You explain whatever is there in the book. Clear? Next one. Goods sold by description. Caveat emptor only, no?
Yes.
Merchantable quality. Sale by sample. Sample and description. Trade usage. Umbrella. Seller actively conceals the defect. Fraud. There is a crack in this particular podium. They have been covered it with laminate. Fraud. Yes or no? Okay. How many? What else do we have? 2. Partnership 3. 5. Negotiable 6. Companies Act 7. LLP 8. LLP is manageable.
Negotiate.
Okay, done it.
Okay, we can do it on Monday.
Yes.
Okay, done. Let's discuss on Monday. Huh? We'll take it up on Monday. Meanwhile, you guys also try to do whatever is possible from your end. Try to solve. You will have a group or something that they have created.
I see the.
For others, it's not there. Okay. Yesterday night I came. Very, very tiny. I thought I'll cancel your class. Yeah, next day also same thing for you. Huh? Kalla. Okay. But the event was very nice. You guys, I think every celebration between Jan to June happens in Chennai. July to December happens in Bangalore. So you guys will fit in Bangalore or Chennai, yeah? Bangalore. Okay. All the very best. ಗೊತ್ತಿಲ್ಲ ನೀನ್ ರೈಲ್ವೇಸ್ ಹತ್ರ ಮಾತಾಡ್ಬೇಕು ಹಿಂಗೆ ಓಕೆ ಓಕೆ ಲೆಟ್ಸ್ ಸ್ಟಾರ್ಟ್ ಹಾ ಆನ್ಲೈನ್ ಏಬಲ್ ಟು ಸಿ ಹೇಳ ಆನ್ಲೈನ್ ಆಡಿಬಲ್ ಪರ್ಫೆಕ್ಟ್ okay unit 3 people I think we had stopped at unit 2. Okay, transfer of ownership and delivery of goods. Why do we need to know that transfer of ownership? We need to know transfer of ownership because we need to know when does exact point where the ownership transfers. What is the exact point? So when does a ownership transfer in a goods depends upon what type of goods it is. Whether it is uncertain goods, specific goods, or future goods. Depending upon that, we will decide when does the ownership pass. Now, sir, passing of property. If at all it is a specific or an ascertained goods, when will the ownership pass? They're telling people if it's a specific or an ascertained goods, whichever is in deliverable state. What do you mean by deliverable state? The product is complete. There is nothing else that is to be done to the product. That means you just go to the shop, you pick it up, you go home. In such particular goods, when does the ownership pass? The ownership will pass whenever the contract is made. What do you mean by contract? Offer plus acceptance plus essential elements. That's all is a contract. Always remember a questionable point here would be that price and delivery is not at all relevant to decide the ownership. What do you mean by that? It can so happen that the price is still not paid. The delivery is also still not made. Ownership will still be passed. So remember that. Because whenever a product is in a deliverable state, the ownership will pass when a contract is made. What do you mean by contract? Offer plus acceptance. That is agreement enforceable by law. That is when the ownership will pass. So after that any loss happens, any damage happens, the damage will be on the buyer. If it is before that, the damage will be on the seller. Next one, if the product is to be put into deliverable state, what do you mean by product is to be put into deliverable state? That means there is something still pending that we have to do to the product. Only then the product will be complete. Example for this people, any example, product is to be put into deliverable state. Belt and clothing, yes. Branded pants, yes. ಅದೇ ಕೆಳಗೆ ಸ್ಟಿಚ್ ಮಾಡಿರಲ್ಲ ಅಂತ we would have taken. ಇದೇ Chetan remembers damn. Okay, what is a belt? Why is a belt example? Now whenever you go to a shop, you want to pick up a belt. The belt is ready, but when you see it, it might not fit you. So what will you ask the shopkeeper? Can you please press a extra hole? Now the product is ready, but still something is to be done so that it suits your requirement. Now that is only called as what people? To be put into deliverable state. So there is still something to be done to the product. So this is only called as what people? A product to be put into deliverable state. And when does the product ownership will pass? If at all a product has to be put into deliverable state, the ownership will pass when the product is put into deliverable state plus the buyer has a communication of it. Meaning the buyer should be aware. What is the example we saw in the class also? For example, you have given your clothes for tailoring. Hello? Imagine people, you might have given your product for tailoring. The product will pass, the ownership will pass when? Once the product is complete, tailoring is done. And the tailor informs you the product is complete. Only then the ownership will pass. Yes, what will be the exam based question here? Imagine you have given your product for stitching. When the product is with a tailor, what if the product catches fire? Imagine the entire godown caught fire. With regards to the product you gave, who will bear the risk? Is it you or the tailor? Tailor, because the product is not complete yet. Are you getting the point? Yes, okay. Next one, goods to be goods in deliverable state. Seller has to do something to ascertain the price. What do you mean by that, people? Goods are in deliverable state. Deliverable state means what? You can just like that pick it up. But seller has to still do something. What is that? What does seller has to do? Seller has to do something to ascertain the price. Meaning it can be weighing, it can be numbering, it can be counting, it can be measuring. Imagine you go to this Chickpet and all, old Bangalore. You can still buy cloth in Tan. Do you know Tan? Illa. You're all, Egin, Gen, Beta, na what? Gamma is going on. Gen Z is, sorry, you are all Gen Z only, no? Oh, sorry. Okay, now Gen Z, for you and all will just take one shirt. Our days and all what? Tan only. What is Tan? You go to one place, you pick up a cloth which you like. He measures like this. Now this is called as one Tan. Tan is nothing but a measure. So a person will take up a cloth from here to here is called as one Tan. Now a cloth is there only. I say I want this cloth. Is the ownership passed just because I said I want to buy this cloth? No. He has to still measure it. He has to cut it. Now that becomes mine. That is when ownership will pass. That is when the risk will pass. What do you mean by that? You know how a question can come. I hope you are able to envision. I don't know if you have seen it. If you go to this ready or not ready made, what do you call them? The tailored fit. So the cloth will be there in a bundle, in a roll. Yes. Now imagine when the bundle I selected, there were 15 colors. I selected one, say for example, a purple color. I said, you bring it up. He comes and keeps it on the table. I say, I want this. I said, I want this. Now imagine on this people, some coffee spills over. Who will bear the risk? Is it me or the seller? There was unascertained goods in the bulk. I have identified what I want. It has become ascertained. Now there is a damage that has taken place. Who will bear the risk? Is it me or the seller? Seller or buyer? Seller or buyer? Why seller? So I selected that I want this. In that how much I want? Yen I will take. Is it for stitching for elephant or for me? Yen I'll take the entire roll and do what? This uniform also for entire. What will I do? So there is something seller which has to be done. What? Measuring. I just need something that suits me. Exam only, this is how they'll ask. We'll understand one example and go. After such thing is done, he has to measure. And the buyer has noticed, sir, the total requirement of yours is say 1 tan. That is say for example 2 meters of cloth. That is what you need to pay. That is when the ownership will pass. Here, most of the students will get confused. Have I ever spoken about money? Money is irrelevant about when the ownership is going to pass. Second thing, Delivery. Did I ever say I took the delivery only then the ownership is passed? Delivery and money are irrelevant to decide the ownership. You just need to see these conditions. Getting the point? Hello? Okay, next one. Unascertained or future goods. If at all it is a unascertained or future goods, when will the ownership pass? Unascertained or future goods, people, for the ownership to pass, you need to first appropriate, ascertain the goods. In the bulk, your goods has to be first separated, ascertained. Agreed? Now the question is, sir, who is ascertaining it? I go to say for a roadside vendor. Now I need to buy some tomatoes. There is a huge heap of tomatoes. Now I need to just buy 1 kg from it. He has totally 100 kgs. When will the ownership pass? It is still in the bulk. Now something happens. All the tomatoes fall. I have already asked him. I need 1 kg. I have said this. Now the entire thing falls down. Imagine some cart, someone comes and hits, everything falls down. Who will bear the risk? Seller. When will the buyer bear risk? After that 1 kg is put it in a cover. It is kept aside. Now my question is, who selected this 1 kg? You selected, I selected. Whoever, the only condition there is, the other party should have agreed for you to select. That is what you guys would have studied as a condition called as appropriated by the seller with the consent of the buyer, or by the buyer with the consent of the seller. What do you mean by appropriation? Appropriation means selection, separation. Who is separating it? If the buyer is separating it, seller should be like, okay sir, you take the booty, you only put it, I'm okay. Whatever you give, I'll weigh it. Or other way around, seller, buyer says, I trust you. You separate it. Whatever you give, I'll take. That is when the ownership will pass. Not when the money is paid, not when the delivery is made. Is it clear? Don't get confused. Clear? Okay. Next one, people. Always remember, whether if I give it to buyer or if I give it to a carrier. Carrier means what? Courier. A delivery agent. It is like giving it to the buyer only. Example of this, sir. Now you guys will be buying some goods on Instagram. Boys don't, girls will. Yes, sir. Namig will not understand. Bidri. So girls will. You guys have purchased something on Instagram. Nowadays, that correct? No? That sale is becoming more today. Yes, there are these individual makers. They will only design. They will wear and they'll show. That I believe that that market is building a lot today. Now, how is the shipping done there? Amazon person will come? No. It is courier, that to Indian Post, because it is less. Now the question is, you purchase it from an Instagram person, they give it to an Indian Post. Something happens when the product is in Indian Post. Who will bear the risk? Seller, buyer. See, it is on Indian Post, but at least someone should roam around to go and fight with them. Should I go and fight, or the seller will go and fight? Who will go and fight? So who will bear the risk? Seller, buyer? Seller, buyer? Buyer, seller? Remember, that's what I said. Don't put common sense or reality when answering question. This is where your fundamentals come. Just now I explained. Now you are telling, sir, illa sir, I think buyer, sir. Sir, I think seller, sir. What did I say? It was unappropriated goods. That means it was in the bulk. In that they have shipped what I need to get. This goods are appropriated. In an online sale, buyer is always giving a deemed approval to the seller. That you select it, I'm okay with it. If not, you only go and buy there. Online sale, how else it can happen? Are you getting the point? But in reality, what is happening? We are all driven by our own terms and condition. Amazon says, you have a right, sir. You take it. You see it for 7 days. If you are not okay, you give it back. That is what is it called? Sale or return basis. So the ownership will not pass until that time. But in this case, what will happen? The moment it is appropriated, done. That is what is this point. Giving it to the carrier is like giving it to the buyer only. That means the Instagram person, when they give it to the Indian Post, it is like giving it to the buyer only. Who will bear the risk? The buyer will bear the risk. Understanding? This is where I'm telling you, provision you guys have to nail it. In provision you guys are going wrong. Correct your provision. That's where everything has to be fixed. Getting it? All of you? Okay, next one. Sale or return basis. What do you mean sale or return basis? The Amazon. You buy it or return it. Who will bear the risk? Seller will bear the risk. If anything happens to the goods, who will bear the risk? Seller or buyer? Now when you buy it from Amazon, something happens to the goods, who will bear the risk? Huh? You let us imagine I give Arnav this mic. Arnav says, sir, I don't know whether it is working or not. You have given this so many times example in the class, so I want to try, sir. 3 days I want time. If I'm happy using this product for 3 days, I'll buy. If not, I'll return it. Now I gave this product to Arnav. Hello? I gave this product to Arnav. While it was with Arnav people, let us imagine something happened. What happened? Earthquake came. The earth here only it split. Mike Inge it fell. And again earth came back. Now people, who will bear the risk? Arnav or seller? Is it Arnav or me? Seller only. In exam, they'll give it in a different way, but this is how the questions will be. Who will bear the risk? Remember, people, seller will bear the risk. But tell me why. As long as the product was with him, it was on sale or return basis for that 3 days. Because it was sale or return basis, the ownership is not yet passed. So even the product is with him. Who will be the owner? I am the owner because he has that 3 days time to return the product. I am only still the owner. So anything happens to the product, it is on me. Now the only question I'll ask Arnav is, did you take reasonable care of the product? Reasonable care means what? When the earth was splitting, did you hold both the pieces like this? Did he try? Let us imagine. Reasonable care of the goods means what, people? He was not negligent on the goods. He could not do anything. It was not in his hands. Now whether Arnav will be liable? The answer is no. He has taken reasonable care. So that is the only question we will ask. Has he taken reasonable care? If he has taken reasonable care, Arnav will not be liable. Seller will be liable. Now you guys can think, sir, in Amazon it will not happen like that. No, sir. Again I am telling you, Indian contract, Sale of Goods Act, Partnership Act, they are all private contracts. What do you mean by that? If at all your terms and conditions, you have entered something, that will prevail. When terms and conditions between you are silent, is when act will prevail. That's why all the sections will start unless otherwise agreed between the parties. If you guys have agreed something, you follow that. You don't follow the act at all. Act will be silent for you. Act will apply only when you guys have not agreed anything. Getting it? Okay, on sale or return basis, when does the ownership pass? On sale or return basis, when does the ownership pass? After acceptance, time period, or did something equivalent to acceptance, like pledging, subselling, or gifting, as the case may be. The last one, people, reservation of right of disposal. What do you mean reservation of right of disposal? It is an instruction given by the seller to the delivery agent that until something is done, do not give the product. What can this be? It can be signature, it can be cash on delivery, it can be returning the old product. You guys will do it, right? Exchange. Until the old one is given, the new one will not be given. Cash on delivery, until you pay, the product will not be given. buying your phone, returning the old phone. Until that is done, the new one will not be given or pay the difference. So, sir, that is only called as reservation of right of disposal. Until the condition is met, the ownership will not be passed. Clear, all of you? Yes? Okay. Risk transfers with ownership. That's the rule. However, there is always an exception. What is that? If delivery has been delayed by seller or buyer, whoever has made the delay will bear the risk. Next one, sir. The duties and liabilities as a bailee of goods will remain unaffected. Arnav, has he taken reasonable care of the goods? Clear? Done. Sir, next rule, sir. Nemo dat quad non habet. What do you mean nemo dat quad non habet? No one can give what they do not have. What you don't have is title. Title means what? Ownership. So what is this rule? Whoever is not an owner cannot give the ownership of the product. This mic is not mine. Can I give it to someone else? Can I sell this mic? Not possible because it is not mine. How can I give it to someone? But this rule has some exceptions. Same exceptions will apply to pledge also. We saw that we'll be seeing. Okay. First one, mercantile agent, right? Mercantile agent is what? I appoint a manager to my business. I won't go and sell every day, but someone else is selling on my behalf. Is that sale valid? Yes, I only authorized him to do. Next one of the joint owners. Two people together buy the product. Whether both of them, either this person can sell or the other party can sell, it is still valid. Sale by possession in a voidable contract. What are the examples of voidable contract? Coercion, undue influence. Correct. We saw in other days class to sell bike. We saw. We said I'll force him to sell his bike. Now imagine I forced him and I got his bike. I took the bike and I also sold it to someone else for a higher price. Will this sale be considered as valid? Will the sale be valid? I hope you guys understood the question. A forced B and made him sell a bike. A further took the bike, sold that bike to C for a higher price. The question is whether will this person get a good title? Whether C will get a good title. Good faith. C purchased it in good faith. Whether C will get good title. C will be the owner or not.
No, sir.
A has to have good title.
But contract is not a question.
I didn't get you. See, A made B sign on transfer documents. How? By force. Undue influence. It's a voidable contract. This is a voidable contract. Now I got the bike. I further sold it for a higher price to C. This is in good faith. C did not know all of this. On papers and all, I am only the owner. C purchased it. C will get good title or not? He will get it or not? Remember, sir. What? C.
It's a good title. It's a good.
C will get a good title provided B has not taken any action against A. How will the world know that? Just looking at the documents, in all this story will come like Magadira flashback. How will the world know? All of this happened. World will just see documents on paper. On paper signature is there. So what is the responsibility of B here? B should take an action within reasonable time. What is reasonable time? You go to court and cry. You go to court and say, sir, someone forced me to sell a product. Can you please help me in this? You go and stop this within reasonable time. If you don't do people, then it will not happen. Whether C will get, answer is yes. C will get a good title. That is why you are seeing it under Nemo dat quad non habet exceptions. Clear? Hello? Sale by a person obtaining possession before passing of property. Nothing but example is sale or return basis. Meaning Amazon delivery. I say I have purchased the product today. I have 10 days time. It is a sale or return basis. For 10 days Amazon is only the owner. But I would have given an instruction, gift wrap it. Why? I want to gift it to someone else. So on the second day only, I go and gift it to someone else. When will I gift a product? When I assume that that product is mine. So in a sale or return basis, doing something equivalent to an acceptance. You are not yet a owner at that time. You will become a owner. Correct? Gift will be valid in this example. Next one. Sale by person who has already sold the goods but continues in possession. Yesterday we saw this example. I mean in Saturday's class. Somewhere I had given you. They tipple the knife da. I sold him also. I sold him also. Who will get the ownership? People. A has Tipu Sultan knife. I sold it to B also. First. I sold it to C also. Second. But for second I gave the goods also. First I sold it to B. Next I gave the goods also to C. Huh?
Already contract is done.
Already this contract is done. Very good. It is a existing goods, specific goods, identified goods. When will the ownership pass? When the contract is made, delivery and goods price paid, irrespective. Yes, sir. Who will get the ownership? I explained the law also, madam. Who will get the ownership? Sir, sumne D ಕೊಟ್ಬಿಡಿ. You give it up to D. Huh? C or B? Yes, people, you're right. Who? So people, C will get the title. That's an exception. Why? Ownership is passed to B. Whether B will get the title, the answer is yes, he got the ownership. I'm not denying it. Now my question, okay, when I've given an existing goods to B, forget about C. Let us assume C has not yet come into the picture. Tippu Sultan knife I have posted on OLX. I have said 20,000 rupees. B replied, I want it. B replied, I want it. 20,000, I'm okay. I will pay it in one shot. I'll come this weekend and collect. Has the ownership passed?
Yes, sir.
You guys understood the question? OLX have posted Tippu Sultan knife for sale, 20,000 rupees. B replied, I want it, 20,000. When you want? He said by this weekend. I said okay, I'll come and pay. Now ownership is passed or not? Sir, it's a knife given, not it. He will come on Saturday. This is still Monday. Is the ownership passed or no? Passed, Ownership is passed, How will everything know? Okay. Yes. Come on, Jago Grahak. Yes. Why do you think ownership is not passed? Sir, my sense is saying it shouldn't pass. Why? Remember, that is what I told you. What is the first rule, people? If at all the goods are in deliverable state, Tippu Sultan knife is in deliverable state, Ayo, illa sir, you still sharp it. Let us assume it is in deliverable. It is sharp. Cut madra hange cut agbidutte. Let us imagine. Yes, it is in deliverable state. Yes. When will the ownership pass? I told you, price, delivery, irrespective. I know it is hard to digest it. We are so used to reality. Sir, when we get the goods is when ownership is passed. I know. Aditya, I put a disclaimer. Price and delivery are irrespective. So ownership is passed. Hello? Now tell me. When he gave it to Tippu Sultan, when he has given it to B, he has said yes. Has the ownership passed or not? Okay. Saturday he said he will come and collect. Meanwhile, C came on Friday, gave 25,000 rupees, took the Tippu Sultan knife. Let us imagine I have some 10-15 pieces. Let us not imagine specific performance and all. Let us not bring it here. Because I told her I am just taking Tippu Sultan knife here. Yes, okay. Let us imagine that knife is there. Now C came on Friday, gave 25,000, took the knife also. Now tell me whether C will get good title or not. So good faith. That's what you are saying. Yes. Remember, that is the point you are seeing. Why is A coming under exceptions to Nemodat Quad non Abed? Is A the owner now? No, because ownership is with B. You have agreed to sell on Monday only. Sale is done. Ownership is with B now. But the product is still with you. The world will not know this message and all. Getting the point? That's why we are seeing this entire scenario under exception. Now, whether will C get a good title? The answer is yes. Getting the point? Sir, then what is the remedy for B? Remedy can file a case on A. B can file a case on A. For what? For breach of contract. Now, why is that right coming to him? Because contract was made, ownership was passed. If not, B cannot file a case at all, no? Are you getting the point? Now, why did C get a good title? The product is still with me. The documents are still with me. How will C know that all of this was happened? So he has given, that is done. He got a good title. With B, B will fight in the court for compensation. Are you getting the point? So this is the complete scenario. Whether C will get the product, yes. What will B get? B will fight a case for compensation, breach of contract. Getting the point? Yes. Now what will be breach of contract? It is nothing but ordinary damages. Let us imagine, you told me, let us imagine it's not tipples or knife, it is some phone. Now you did not sell. Of course that model is available to me in the market from someone. I will be able to still buy it. Now you sold it for 4K. You did not give it. I had to sell the same one. I had to buy it the same run from some other person for 5,500. 1,500 I will recover it from A for breach of contract. Hello?
Yes, sir.
Okay. Next one, sir. Estoppel. What is estoppel? You have promised, you have to give, you have to give. I'll explain this in probably when we are doing Indian partnership. Unpaid seller, last act. Other act, last per unit. Other acts, people, under other acts it is allowed. Example, we only know, finder of lost goods. When the value is 2/3, whenever the goods are perishable, it's not mine, but perishable goods, it gave me a right to sell, no? Then am I the owner of it? No, but I'm selling it. Is it valid? Yes. Next one is liquidation. What is liquidation? Whenever in a company, when a company goes for liquidation, it has assets, liabilities. I will sell assets, repay liabilities. Who is selling assets? A court will appoint a representative. He will come. He will sell the assets on behalf of the company and repay that money to the liabilities. That is whoever are the creditors.
Sir, then what is difference between liquidator and agent?
Agent is appointed by you. Liquidator is appointed by the court. Agent can be appointed for anything. Liquidator only for liquidation purpose. Understood all of you? Okay. That's the thing. Rules regarding delivery of goods. What is rules regarding delivery of goods? Simple one. Unless and until buyer asks for delivery, seller is not bound to deliver. Seller will give the product wherever he is. But it is buyer's responsibility to ask for delivering the goods. Place of delivery will be as per the contract. If contract is silent, place. One is, if that is depending upon the contract. If contract is silent, people, wherever the products were at the time of contract, that is where the goods will be delivered. If it's a shop, when the contract was made, the goods will be in shop. It will be delivered in the shop only. Agreed? Okay, next one. Time of delivery. If at all you guys have, people, this is what I told. See here, unless otherwise agreed. What do you mean by this? In the contract, if you guys have agreed something, go as per that. In the contract, if you guys have not agreed anything, then it should be delivered within reasonable time. What do you mean by agreed in the contract? Your Amazon clearly says tomorrow by 10 p.m. it will be delivered. It is agreed, no. You have to deliver as per that. If nothing is agreed, it has to be delivered within reasonable time. What is reasonable depends Upon product to product, perishable goods should be delivered within half an hour, 1 hour. Imagine that in our class we would have seen an example. You order Zomato, you order two things. One is ice cream. One you order something biryani. Biryani might take 1 hour. You check with ice cream. Ice cream will be delivered to you on priority. Reasonable. Same Zomato person. Why can't that happen with biryani then? The algorithms of Zomato works like that. Now imagine if at all it is an ice cream. A Zomato agent who is nearby the parlor will be given the order. He need not have to travel a lot. And distance is a criteria. They will filter it out. 10, 12 and all, they will not take it up generally. Because we have to give you the ice cream in as good shape as possible. Correct? No. But what if it melts? Who will bear the risk? People, I purchased ice cream on Zomato. By the time I took it, milkshake is there. Who will bear the risk? Is it buyer, Zomato, or the hotel, ice cream parlor? Now I immediately raised the concern. I ordered for ice cream, the milkshake has come. Milkshake means melted thing has come. Who will bear the risk? Zomato or me? Zomato or me? Zomato or me? Ultimately Zomato, but today it is buyer. Okay, my question, he is telling, sir, it is not on the seller, it is on the buyer. But if buyer fights with Zomato, he will get his money back, is what you are saying. My question, will the buyer get the money back? Will the buyer get the money back? Yes or no? You guys are 100% wrong people. You will not get the money. Why? We had seen this. People, whenever you are buying a product, if you know that if this product will be deteriorated because of time or because of the nature of the product, ice cream will melt. Do you need Einstein's brain to think, no, it will not melt? It will melt. If you order it, you are accepting the risk. We had seen this one example. One more example, iron. When you order an iron from a very long distance, you are accepting a risk of rusting. Iron will rust. Ship example. When a ship takes 40 days, 45 days, 2 months, 3 months to deliver, the product, iron in the container will rust. Color at least will change. If you want recent thing, I'll tell you. I was driving my car, it was raining, so the car went in a lot of places where there was water that was stagnant. We went there and we parked the vehicle and it was 6 hours. The drums inside was completely rusted. And we had to drive it back. We didn't know. After some 2 hours of driving, we started getting a very unusual noise. Because the grease is gone. I'm saying 5 hours of driving. Now I cannot go and complain on the car manufacturer. Iron is rusting. Iron will rust. It just costed me another 10,000 rupees. Yen madana? I thought simply on cabalo. Then what to do? Clutch plates had gone. Yes? That BMW? ಏನಂತೆ? Who has BMW? Oh, me, Oh, tell like that, don't lift everyone. Time for tender of delivery. You have to deliver within reasonable time. Effect of part delivery. When you are giving part delivery, you are giving part delivery of ownership. Next one, goods in possession of third party. Goods in possession of third party. What was this now? What type of delivery is it? What type of delivery? When the goods are in third party, possession of third party. What type of delivery? Constructive delivery. What do you mean constructive delivery? The goods example, go down. That one. Installment delivery. Can I take installment delivery? I ordered for a bike. First tire came, then the steering came, then brake came. So generally, buyer is not liable to take goods under installment delivery unless left to the parties. But I'm not. Now imagine that you order for a book. I'll give you 30 pages first. Next another 30 pages I'll send. Are you okay with it? You're not liable to take it. Remember that. Next one, delivery to carrier is giving it to the buyer. Deterioration during transit. What do you mean by deterioration during transit? When the value of the product is gone, goods deliverable are at a distant place. If it is distant place, deterioration incidental to the course of transit is always on the buyer. What do you mean by that? You know, for us common sense, it will melt and you still order. Who will bear the risk? It is a buyer. This is the point. Provision. Understood? Buyer's right to examine the goods. Whenever I am buying the goods which I have not seen, when I am accepting it, I have a right to check. Flipkart. I think now you guys have that OTP. They will come, they'll open and show you mobile, laptops and all. If there are any external damages, you have a right to return it there only. Agreed? That is what the thing here is. You have a right to examine the goods when you have not seen the goods at the time of purchase. If there are any defects, you have a right to sell it back. Agreed? Okay. That's your unit 3. Unit 4, sir. Unpaid seller. Who is an unpaid seller? What is unpaid seller? What is an unpaid seller? Da? Feeling cold? It's fine. Should I turn on the swing? Who is an unpaid seller?
Whole price is not.
When a whole price is not paid, we call such person as a unpaid seller. Unpaid seller means what, people? A whole of price is not paid. When a particular goods is sold on credit, or when imagine some check is given, if it is dishonored, or if the money is completely not paid, we call such particular thing as unpaid seller. Unpaid seller has two rights. One is, people, right against the buyer, right against the goods. Why do we call it as two? Imagine I told someone, I'll keep this bottle. Arnav says, I'll auction this particular bottle. Who want to buy? Now imagine Arnav says, sir, I want to buy it for 100 rupees. I'll say, okay Arnav, you take it. Arnav says, sir, I need time till tomorrow. I'll go home, I'll get it. But you please keep this to me. Sale is made. Existing goods. Hello? Existing goods. When does the ownership transfer? When the contract is made. Offer 100 rupees. Accepted. Done. Ownership is transferred. Money is not received. Delivery is not made. Still the ownership is passed. Now I'll say, Arnav, I'll keep it here only. By tomorrow you need to come and take it. Now the question is still how long I'll wait. I'll wait till tomorrow. Even if tomorrow is not coming, now what will I be called as? I'm an unpaid seller. Technically, as per the contract, I've given him the ownership. Now I have two rights. One against him, one against this. Now what will I do to this? Again I'll come tomorrow, I'll say, people, this person didn't come. Again I want to sell this. Is anyone interested? This is only called as what? Right to resell the goods. The first right is what? Arnav will say, sir, you give, sir, I'll come and pay tomorrow. I'll say, no, Arnav. You bring money, is when I'll give it. Sir, you give it, sir. Anyways, ownership is passed. No, you give it. I'll bring it tomorrow. I'll say, Arnav, no. I will keep this goods here only until the price is paid. Now, me keeping this goods with me until the price is paid. What type of right is this? Right to lien. Right to retain the goods until the price is paid. Hello? Are you getting it? Okay. Now next one, sir. Let us imagine Ganesh, Darshan, Chetan, Yako martogtade. Okay. Chetan, now I'll ask Chetan. Chetan, anyways you are going to Arnav to do combined studies? You guys do no? No? Illa sir, the people I'll tell Chetan, anyways you are going to him. Can you please go and deliver this particular thing to Arnav? I give it to him to go and deliver it to him. Hello? Now while Chetan was in, you know Chetan will not go directly. Chetan, we go always U-turn only. Now Chetan, while he was in Jainagar, I called Chetan because I got to know from someone Arnav has become insolvent. Arnav doesn't have money. If this bottle is given to him, I'm not going to recover my money back. Now what will I do? I will call Chetan. Chetan, U-turn Maro. Don't give the product to Arnav. Bring it back. Because Arnav doesn't have money. If we give, it is gone. I call up Chetan to bring back the product. What is this right called? Right of stoppage in transit. When the product departs from me, I give it to the courier, delivery guy. Now he is going and delivering it to the buyer. Now in between this, if I get to know that Arnav has become insolvent, I have a right to recall the goods. It's called as what? It's called as stoppage in transit. First right, I had the goods. I keep the goods with me. This is called as right to lien. In the exam, you need to underline the word right to retain the possession. When midterm, I was correcting the answer. See, I'm telling how people will go wrong. They have written right to retain the ownership. Ownership Allah. Ownership is with Arnav only. Then what am I retaining? I'm retaining the possession. Now you tell me, should I give a mark for the student or not? Then retain is correct, but the essential word is wrong. Retain goods is okay. Retain possession is okay. You cannot retain ownership. Gone. I gave 0. Now this is what will happen. Keywords. I'm not telling your 5 lines has to be correct. I'm telling those 3 words has to be correct. And that you need to underline. Hello? After Sale of Goods Act, after Indian Partnership Act, we'll see. We'll take up one paper or we'll complete and we'll take up. How to present, I'll tell you. We'll also see it with regards to how our institute is presenting the answer. We'll at least take up 2 papers. Some recent MTP, recent RTP. Yes? Hello? Okay. I have also solved your recent question papers. Last 2 papers was already there in YouTube. Watch that. Clear? Okay. Understood? One is right to lien. One is right to stoppage in transit. I'll tell Chetan, bring it back down. Chetan brought it back. Now again I kept it here. Now what will I do with the goods? How long will I wait it here? I'll wait until tomorrow. My money I didn't get. What will I do? Right to resale. I'll come and I'll ask you guys, do you want to buy it? 3 rights. Any doubt? One is right to lien, right to stoppage in transit, right to resale. What is the difference between right to lien and right to sit? Right to retain is lien. The other one? Word. One is retain. What is sit? Regain. This was with me. It will continue to be with me. Retain. Regain. I gave it to Chetan. I will take it back. Regain. Underline should be there. Keyword. Hello. Okay. Next. What is the other right? Right? Ding. Difference. One you guys said. The goods. Yes. Same thing. The goods are not in my possession. Okay. And important ones you guys are not telling.
Right to lien, the product is not transferred. It's not.
No, people remember, right to sit will start when right to lien ends. Now this right to lien is right to retain. I gave it to Chetan. Right to lien ends. Now Chetan takes it. Right to stoppage in transit, that right will start. So this is one end. One more right will start. Next one, most essential one. When will you exercise right to lien? Very good. When the price is not paid, when the period of credit is over, when a buyer becomes insolvent, in all the cases you can exercise right to lien. When can you exercise right to sit? Very good. Only and only when the the buyer becomes insolvent. Not in any other scenario. Getting the point? Right to lien. I told Arnav to bring the goods tomorrow. To bring the money tomorrow. He didn't bring. Credit period is over. I am exercising my right to lien. In right to sit, credit period is over. But on those basis, I cannot bring back my goods. Only and only right is when he becomes insolvent. In first case, did he become insolvent? No, he just didn't give me the money on time. Papada. You tell me what will happen. It's a contract. It's a legal representative right. You tell me skill, huh? Then right will pass on legal representative. You tell me under which provision will you write? The answer is this only. This is taken by Arnav. Let us Arnav alla, yaro Pranav. Pranav dies. Now you tell me what will happen to the contract.
Pranav is also there.
Sorry. Yaro Bana. Chetan. Sorry. Yaro Ganesh. Ganesh? Okay. Ganesh. Ganesh will die. What will happen to the contract? Legal representatives have to buy the bottle. Yes or no? Yes, sir. Under what grounds?
So consideration can be from a person or
No.
from sales.
No. It will come under Indian Contract Act.
Asking for
I am asking for proper provision. Under what grounds you are telling legal representative has to take the bottle? What is the provision? Whoever tells it will give you a chocolate. Notary, bribe. Tick tick 5, tick tick 2, tick tick 1. Tick tick 4, tick tick 3. Done. Which one? Who should perform the contract? First one, promisor himself. Where? Oh, yes, when there is any skill is there, then the promisor himself has to perform to take the delivery of the bottle. Okay, what skill you require? Nothing. Legal representative. This is how it has to work. Hello. Okay. Eldry. Okay, right of lien. When can it be exercised? Good is not sold on credit. If sold, expired, insolvent. Correct? What about sitter? I told you, when and all you can exercise right to lien. I should have not sold on credit. If sold on credit, credit period is over. Or he has become insolvent. In all three cases. People, one more biggest misconception we all have. If they are asking a difference between question for 4 marks, every point is 1 mark. Is a misconception we have. In your book, if they have written 8 points and the question is 4 marks, you are expected to write all the 8 points. It is a student that has come up with this logic. Sir, for 1 mark we are writing this side, that side. My God, every side we are writing 0.5. That's a misconception we have brought it with. That is not a right one. If book has 8 points, you are expected to write all the 8 points. It is a point. Okay. Termination of right to lien, delivery of goods to the carrier or bailey. Of course, when does lien come to an end? When it goes away from my hands, lien is coming to an end. Buyer or his agent obtains possession, seller waived off his right, meaning, now imagine, I have kept it here, he has not paid. Arnav is coming, while going, he is taking and going. I saw it. I just like that kept quiet. Then what am I doing? I had a right to stop. I didn't stop. I gave up my right. This right is nothing but waiver. That is what is given here. Yes. Next one, estoppel. Estoppel means what, people? This is also the same thing. I've behaved in such a way that even if you do not pay the price, I am not going to stop you. I've behaved in such way. In such cases, right to lien will come to an end. Next one, right to stoppage in transit only when insolvent. It is stopped while in transit. Right to regain the possession and retain them until price is paid. Okay. When does transit come to an end? When buyer or bailey obtains delivery. Chetan reached Arnav. Carrier or Bailey acknowledges to the buyer that he holds the goods for him and seller has not reserved the right of disposal. Chetan reached Arnav's place and said, "Sir, where are you? I've got your bottle." Next one, goods delivered to the carrier hired by the buyer. Now, buyer, Arnav only booked Danjo. Now, he will listen to what Arnav says, not what I say. Next one, carrier wrongfully refuses to deliver the goods. What do you mean by this wrongfully refuses? Imagine there's a conflict. The delivery agent reaches the buyer. He says, "I will not deliver the product to you." Once you have reached the buyer's destination, if you wrongfully refuse to deliver the product, it is assumed that the delivery is complete. Even though the product is still with the delivery agent, we assume that the delivery is complete. Next one, part delivery. If part delivery is considered as part delivery or part delivery is considered as full delivery. We had seen, if you remember in the class for tomatoes example, we would have seen. Yeah. Okay. Goods delivered to ship chartered by buyer, international sales. Here I am giving you a bike delivery. In international sale, of course, the goods will be shipped by a vessel, meaning it will be taken in a ship. So whatever bike example here, Chetan, the same example there is for a ship. It happens in an international sale. So whether you give it to a bike sent by Arnav or you give it to a ship sent by Arnav, answer is same only, no, they will listen to you. Yes or no? Yes. How is stoppage in transit affected? How do you implement stoppage in transit? Two ways. One is call him. Second one is overtake him, chase him, Singham style. Inge jeep inge issa karke. Don't wait for it to stop. Ange get down. So you can do that and you can go and bring back the bottle. Or just call him. That's what they are saying. By taking actual possession, Singham style. By giving notice. Hey Chetan, come back. Effect of subsale. What is subsale da? What is subsale? I have sold the goods to Arnav on credit basis. The goods are still with me. Arnav has agreed to another person, say for example Pranav, that you can take the goods. Getting the point? Now this is called as sale. Arnav has done one more thing, that is only called as subsale. Now what is happening? Let us imagine Pranav has given money to Arnav. Money is paid. But Arnav has not given the money to the first seller. Money is not paid. If money is not paid, I become an unpaid seller. Agreed? Now because I am an unpaid seller, I have exercised my right to lien. But Pranav has made the payment. Pranav is coming and asking for the goods. The question is, can the seller still exercise right to lien? So you imagine here only, Pranav is here. Pranav wants to take this bottle. I will say, Pranav, I cannot give it. Now you tell me, can Pranav take the bottle or not? Pranav has paid the money. So can Pranav take the bottle or not? Good faith. Of course, everything is good faith only. If cheating is there, definitely he can't take. Can Pranav take the bottle or not? He can take or not? Yes sir, is my friend only. I'll support him. Yes or not? He can or not? He can or not? He cannot. ಎಪ್ಪಡಿ ಕಾನ್ ಹೇಳಿದ್ನಲ್ಲ ಮ್ಯಾರಥಾನ್ ಆಗಿ ನೀವು ಇಂಟರ್ ಬಂದು ಅಲ್ಲೂ ಇಫ್ ಐ ಆಸ್ಕ್ ಫೌಂಡೇಶನ್ ಆನ್ಸರ್ ವಿಲ್ ಸ್ಟಿಲ್ ಬಿ ಇಂಟು ಮಾರ್ಕ್ಸ್ ಓನ್ಲಿ. Yes, remember people, only question whether Pranav will get the bottle or not depends upon only one condition. What is that? Did I agree for subsale? Did I give the right to Arnav to sell it to Pranav? Did I agree for it? Did I? Now you take a scenario. If at all I had agreed, then people, I cannot stop Pranav because I have given a consent for subsale. When I have agreed, when he has sold it, I cannot hold it back. Now what should I do? I have to give the goods to Pranav. Between me and Arnav, I have to fight. It's my karma. What do I do? Because I have agreed for subsale. Sir, what if I have not agreed for subsale? Now people, I can say until my money is paid, it is left to you both. I will not give you the goods. Can I stop it? Answer is yes. Understood all of you? Hello? Huh? Correct. Ownership is transferred, but I have a right as unpaid seller, no? So my right as unpaid seller, I have two rights. Say three rights. I have right to lien also. So the question is that only, if there is a subsale, does right to lien come to an end? The answer is no. Right to lien will still continue. But when will right to lien come to an end? When you have agreed for a subsale, whether expressly or impliedly. What do you mean by impliedly? Express is yes. I clearly tell her, no, it's okay, you can make a subsale, I don't mind. Impliedly, Arnav says, you give me the goods, sir, I will further sell it to someone, they will give me money, no, that time I will come and pay you the money. Now I know for a fact, Arnav to get money, he has to sell it to someone, I have agreed for it. Now this becomes implied. Hello? Pakka? That is what you guys would have seen in the case law. Mount DF Limited versus J&J. Subsale. A person agreed for collecting the price after he subsales. Remember this? A sold goods to B. B said, I will further sell it to C. I will get the money. No. That money I will give it to you. Are you okay? A said okay. It become an implied acceptance for subsale. C gave money. B did not give money to A. A wanted to exercise right to lien. The question was, can he exercise? Answer was no. The right to subsale, the right to lien was gone because he impliedly gave acceptance for subsale. Understood? Pakka na? When document of title has been transferred to buyer and he further transfers it to person on good faith, then if it is a sale, lien and stoppage in transit is defeated. Next one, if it is a pledge, lien or stoppage in transit may be exercised by requesting the pledgee to use goods of pledger first to satisfy his claim. What do you mean by this, sir? Now imagine to Arnav, one is people, me agreeing to the goods. Second one, people, we have something called as document of title. What do you mean by document of title? The document which says who is the owner. Whoever has it will get the ownership. That is called as document of title. If at all in a sale, if you have given the document of title to someone, have given him of the title, that means people, if you have this document, you are the owner. If you have given away the document, people, ownership is gone. In a subsale, now imagine A gave B document of title. Now B has further given to C document of title. Now people, if document of title is gone, your right to lien is also gone, your right to sit is also gone, because document itself is gone. Why? Document is ownership. Understood all of you? Pakka? Understood this? Okay.
So what if there's a fraud or something?
Like?
Assume that there's a land and the person you're selling the property, and then you get the check. Then you give it to someone else. But the land is, the ownership of the land is with someone else. So what's going to happen?
First thing, it will come under transfer of property.
Then you cannot get the.
No. Different law will apply. Movable, because sale of goods, only movable, no? Yes, Sam. Getting it,
Movable better.
Like, how?
After something.
Huh.
You're sending it to someone else. But it's the ownership is with someone else. It's towards.
Like, give it to me, I'll say. How is it?
The same case, like land, I told you. Instead of land, you take after bunch of apples.
No, that's what you tell me. I'll just take it, huh?
Arnav's.
Okay, Arnav, Apple. Huh.
I sold it to you.
You sold it. So you're a middleman.
I'm the middleman.
Okay.
Writing the check. I
Huh.
give to someone else.
Now my question is, has Arnav agreed to appoint you? Then no, you cannot sell. How will you sell something which is not, you also have not been appointed, have not authorized you also, then you cannot sell. Or imagine that Arnav has appointed you. Now question is, are you an agent?
If I'm an agent,
Yes, mercantile agent. Sale by a non-owner is still valid. Nemodat non-habet. Exception. Mercantile agent. Valid. Got it, huh? Yes or no? Okay. The last right people, right to resale. What is resale, da? Resale, sir. Resale. Now people in the resale, da, Arnav did not buy this product. Arnav did not buy the bottle. I further sold the bottle. The bottle price was 100 rupees when I sold it to Arnav. Now I did not give it to Arnav. I gave it to Darshan. Now sir, I gave to Darshan at 80 rupees. I incurred a loss of 20. Can I recover it from Arnav? Is it possible? Depends.
Already inform of resale is he will be if not inform it, you should.
Very good, sir. Was Arnav given notice? I'm going to further resell the product. If notice is given, loss can be recovered. If notice is not given, loss cannot be recovered. So remember, right of resale. If a notice is given to the first buyer, if you do not come and repay within next 2 days, I'm going to sell it off. If this information is given and if he still doesn't come and give people, then the whatever is a loss, I can recover it from Arnav. If I did not give this intimation, if I incur a loss of 20 rupees, I cannot recover it from Arnav. Is this clear? So remember, right to resale, you need not have to give a notice in 2 scenarios. Law only says, in 2 scenarios, you need not give notice. One, if it is a perishable goods. Now imagine instead of this bottle, it was some edible item. It can be, say for example, 1 kg of apple. It deteriorates. I know for a fact. I can't wait for him to give notice, him to respond. Time taking. With every day the apple deteriorates. Without giving notice itself, I can sell it off. First. Second one, if right to resale, I have reserved this right in the contract we entered. In the contract I have clearly written, if at all you do not come and buy the product on time, I have a right to resell this product to someone. I will not give a notice to you at that time. I have reserved this right in my contract itself. In this case, people, I need not have to give anything to Arnav. I have a right to resell. I can sell it off. Is this clear?
Yes.
In 2 scenarios. One, when it is reserved in the contract. Second one, perishable goods. You need not have to give notice, but still you can recover the loss. Understood? Understanding? Pakka? Okay. Next one, sir. Right against the buyer. What are the rights you have against the buyer? Suit for price. I can recover from Pranav 100 rupees. Next one. Damages.
Earned by seller during the resale.
Same thing applies. Whenever there is a profit, what will happen? Unpaid seller can recover the loss. Unpaid seller can retain the profit. If at all I have made any profit, it belongs to me. If at all loss, I can recover it from you. When? If at all I have given the notice. It is mine only. Profit is always mine. Clear? Okay. Damages, same as contract. Ordinary, special, as the case may be. Repudiation of contract. What if Arnav comes day after tomorrow and says, sir, give me the bottle. I can cancel the contract tomorrow only and say, Arnav, our contract is done. If you come in the future also, I am not liable to give you the bottle. Done. Repudiate means people expressly cancel the contract so that in the future again you don't have an obligation. He will come, he will again ask. You can put an end to the contract once for all. The last one, people suit for interest. What is suit for interest? Now imagine if I can recover some 100 rupees or I'll recover some 80 rupees from Darshan. If I had recovered the money today, on that 100, I could have done some other business. I could have invested in some FD. I could have earned some money.
I got 80 today, but I got it late. So remember, I have a right to recover interest as well. Somewhere like 6%. Court will also order you. I don't know if you know it or not.
Up to 8 years, sir.
In simple case, I'll tell you one case. Government of India filed one case on Vodafone. One tax issue. Tax. Vodafone lost the case. And Government of India told Vodafone to pay a tax of 11,000 crores. How much? 11,000 crores. You know what Vodafone did? They paid. Vodafone said, what is this? Appeal. Sir, the lower court, I'm not happy with what they did. They went for an appeal. They went to High Court. Again, High Court said what Vodafone has to pay is right. Government of India is right. 11,000 crore was upheld. Vodafone said, sir, went to Supreme Court says what Vodafone did is right. What Government of India did is wrong. And Supreme Court reversed the decision. And Supreme Court said, whatever, remember when you want to go for an appeal, you need to first deposit the entire money. Yes. So Vodafone had paid 11,000 crore to the Government of India. And for this entire appeal, for the entire thing to conclude, it took around 7 years. 7 years. Now Government of India, Supreme Court reversed the decision. They said, no, Government of India, you should not take that money. You are wrong. Return back. Now people 11,000 crore I'll get back. But how many days did you have it? 7 years. Then with interest, Supreme Court said you need to pay 55 crores as interest to Vodafone, and Government of India paid. Vodafone India, tax case, a very popular case. Yes, sir. Details and all in CA Inter I'll tell you come. Yes, sir. Understood interest, So in courts, interest will play a value. I'm getting my money back. Who will give me opportunity cost? 11,000 crore for how long? Getting it? Angirutte. Okay. Next one, right of buyer. One was right of seller, one is right of buyer. Damages for non-delivery. I said Arnav I'll give bottle, I did not give. What right he has? He also can file a case. Next one, suit for specific performance. I said Arnav take 20 rupees da. He said no, I want this bottle only. Can he get it? Will he get suit for specific performance? Question asked will be, is it a special kind? Is it antique? Does it has any emotional value? Only then they will get. If not, no. Next one, suit for breach of warrant. That means you can claim damages, you cannot cancel the contract. All this we have already seen, no. Repudiation before the due date. Breach of contract, you can cancel the contract. Suit for interest. What if Arnav had paid advance money? He can also claim interest on it. Yes or no? Okay. Last one, sir, auction sale. What is auction sale? Is your auction, no? Auction is a process of giving the product to a bidder. Whoever bids the highest value is called as an auction. In auction, people, there will always be a base price. I will come and say this bottle will start with a base price of 100 rupees. We call this as a base value. And people, a product can be sold either in standalone or you can sold it in a group. Meaning what? Let us imagine I have 3-4 products. I can say all of these 3-4 products are coming together as a bulk. You can sell it like that also. You can sell it in individual lots also. You can sell it however you want. Both are valid. Clear? Yes? Meaning what? I can say 1 bottle at a time. If I have 3 bottles, I can even sell 3 bottles at a time. Both are valid. Yes or no? Okay, next one. Remember, pretended bidding is always invalid. What do you mean pretended bidding? Pretended bidding means people, it is a person. This happens in IPL also. They will say one player is for sale for 2 crore. One team will wantedly take it to 8 crore and they will drop off. But you guys can ask, no, then why is it valid there? You prove that it was pretended bidding. It will be invalid. But you have to prove. That's what you need to do. I think Rishabh Pant, it happened. 27 crores. Correct, no? Rishabh Pant. Everyone bidded. Even I think RCB also bidded, no? Yeah. Yes, that's called as pretended bidding. In a auction sale, how will a sale be complete? It can be as per the contract. You can choose. In some cases it will be hammer. In some cases it will be bell. In some cases it will be expressly shouted. Once, twice, thrice, done. And remember, once it is done, the ownership will transfer. So in an auction, as and when the sale is done, ownership will transfer, whether the delivery is taken or not. Clear? So once the ownership is transferred, the risk passes on to the buyer. Yes? Okay. Right to bid may be reserved. Remember, can a seller participate in an auction? Yes, provided you reserve the right to bid. If you do not reserve the right to bid, it will be considered as invalid. It will be voidable. It can be treated as fraudulent. Clear? Hello? Reserve price, pretended bidding, voidable, completion, fall of hammer. It can be sold in lots or it can be sold individually as well. Okay, Indian partnership, shall we see one unit and go for breakfast or what you will do? PG will be football over. Now you want to go? Huh? Chetan is in PG now?
Today morning itself.
From today morning. ಅನ್ಕೊಂಡೆ ಇದೆಲ್ಲ ನೋಡುವಾಗ ಏನೋ ಇದೆ. Okay, go for a break and come then. How long? 30 minutes? Day too long da. One day, I think today is the last marathon noda. Huh? Okay, go 30-35 minutes, come back. Yes, people, let's start. The next chapter, people, Indian Partnership Act. Let's first finish off the easy one. Unit 1, General Nature of Partnership. Okay, elements of partnership, definition of partnership. What are the things? You need to have at least 5 things to be called as a partnership. The first one is association of 2 or more person. It can be individual, it can be companies, anyone can come and enter into a partnership. Next one is agreement. It is a voluntary relationship. No one should have forced you to enter into a contract. And next one, people, business. Remember, you cannot do a partnership for non-profit organizations. It cannot be for charity. You have to be doing business. That's mandatory. Next one, there has to be an agreement to share profits. So, can one partner take all the profits?
No, sir.
Can one partner take all the losses? Yes, possible. Okay, next one, business carried on by all or all of any of them acting for all. This only is called as cardinal principle, also called as mutual agency concept. Why last bench? You don't like them? No. Phone usage? For phone, huh? Promise on you? Phone only, huh? Okay. I was there only. That last bench, I was behind you when I was studying. Yes, huh? So remember, we came from there only. Yes. Okay. Don't get distracted. I know it's, see, 1 or 2 days. Pull your full self in and complete it off. Yes. In the break also, that is what I was telling you. You guys are doing something. It's difficult to achieve. You guys need to have your utmost presence. So, with half and half, you will not be able to write it. And that too, you know the new syllabus, how it is happening. New syllabus, CA foundation is difficult. They are filtering out candidates. It's actually a good thing. Because imagine, earlier it was opposite, right? See, no, I know it. See, you are feeling demotivated. That is correct. But if you see, imagine clearing CA foundation easily and struggling in CA final. You're into it. You can't come out also. Now it works in a different way. Entering is difficult. So people will write 2, 3, 4. They will quit here and they will mind their other life of probably some other thing. What you go to the yesterday you should see the felicitation. We had few people 35, 40-year-old. One person was 40-year-old. Executive. So I'm saying, look at the age. So early realization is there. Very good. But I'm saying maturity should also be there. That is, you're not signing up some application, some we'll write off, we'll finish it off. It doesn't work like that. And I always say that if you've taken something, be conscious on what you have taken and give your fullest. Yes, one answer. What is that? I would say, he was asking me, sir, what is the right age to quit CA? Yeah, very correct, no? I would say the answer for that. I would say this is the attempt. No, this attempt only. Give your fullest. Didn't work, leave it. Very hard to digest.
Yes, sir.
I'm saying, then give your fullest. Then you are only not prepared to clear this attempt. Allah, you are only not prepared. You do not want this attempt then. You're telling mentally, it's okay, let's take next attempt. Then don't do. If I were you, I wouldn't have done. Pakka. When I wrote my first exam, only one thought I had. If I fail the first attempt, then this course is not for me. But this first attempt will be my best attempt. I struggled, I wrote, done. No coaching, nothing. For all of us, nothing. Only one regret. Yesterday also I was sharing the same thing on the stage. The one regret I have in my life. I generally am a person who carries zero regrets. One regret is that we had no awareness on ranks. I didn't know. Okay, if you write both the groups, you'll be able to get a rank. We didn't know. I took up one group, I finished. I took up another group, I finished. Rank is something where you can cherish for your entire life. Now imagine, now you know passing is difficult. Imagine getting a rank.
You're also doing the same thing.
It's same thing. I'm not saying it doesn't change, but there is an identity you create. It will stand with your name forever. So yesterday we met both kind of people. A few people coming and asking, sir, how do we clear? And that is one group. Second group is how do we get a rank? Are you getting in?
Yes.
So intent matters. Taking it up, you take it up. The problem is that intent, you only get distracted. I'm saying what effort you put in as a person to bring your consciousness back into the class. One is my attempt. I'll try my best. Okay, what is it you bring in, you tell me. Now you get distracted. Let us imagine after 40 minutes, you might get distracted. You tell me, how do you pull yourself and bring back to your class again? I'll tell you, you will not do at all. Now I'll say, I'll also not do. Why do I have to do? Something called as self-responsibility. Yes? So bring yourself in. I'm saying never do anything for namesake. You guys have to give your complete efforts. If not, this thing will take time. And every year that passes, remember, you're delaying your success by each year. A person who should become a CA by 22 is becoming by 23, 24, 25. And with every year, your mindset will change. Now you guys are 18 to 20 categories. The mindset you have now, the amount of the grasping power you have will deteriorate eventually. By the time you become 21, you're the most distracted soul. College is done. By the time you're 23, 24, the amount of things you understand at once that'll reduce. A person who was coming 2 down, 3 down is coming 6 down, 7 down. Age is not just a number always. Are you getting it? I'm saying there is something to learn there then. People are paying lakhs to come and see it, but he's not able to. We cannot say, why didn't you come and bat? Dhoni is not able to bat. He's aged. You look at the society pressure, franchisee pressure. The day Dhoni retires, CSK is different. CSK has to win another 3 titles to bring back the fandom. Because it is Dhoni's Super Kings, represented just as C. Getting it? Then age is not just a number. Something is happening with age then. Most fittest person is not able to come and bat 10 balls. Why? Don't you think you guys also mentally it will age? Things will change. Trust me. I had signed up for one course called MCom. Yeah, I just have to write 4 papers. My MCom was done. I didn't write. This was the last year, March 31st March 2025. I should have written my 4 papers. I didn't write. I don't have a mindset to write now. Done 4 papers, 1 degree, PG. I didn't write. It'll change. So never hit that bottom. You guys have to be, self-pumped to achieve something big. Yes?
Yes, sir.
Okay. Come. Business carried on by all or any of them acting for all. So this is a cardinal principle. What is this? It's nothing but when one person signs a contract, he is binding all the partners. You cannot say I did not authorize and all. You are liable for the entire thing. True test of partnership, agreement, same thing, mutual agency, sharing of business. In some things, what will happen? There will be sharing of profits will be there. Some money will be being given to a person. We should not mistake that to be a partnership. Example we saw, whenever in a business transaction, there will be a creditor who gives loans to a debtor. He will do a business out of it. I will regularly pay interest. You should not mistake it to be a partnership. You should clearly feel it as a loan agreement. The relationship is not partners. The relationship is debtor and creditor. Next one, in some partnerships, after the death of a partner, the partnership firm follows a principle of giving something called as annuity, monthly maintenance to the family, because the partner worked with them. You cannot treat the family members now as partners because we are paying monthly income, or we call it as pension usually. You should not treat them as partners. Now, whenever there is a person working for you for a monthly remuneration, you should not treat that person as a partner. It's an employment. So there will be money getting paid. One more thing, co-ownership. What is co-ownership? Most asked question. What is co-ownership? Joint owners. Whenever there is a property owned by 2 partners, 2 or more people, we call it as co-ownership. There will be sharing of rent, but we still do not call it as partnership. Why? There is no business that is being carried forward. It's only one property that is earning income. You are not maintaining, you are not running a business as such. So rental income there being divided between 2 people cannot be called as partnership. Then what will it be called as? Co-ownership. It's also called as joint ownership. Clear all of you? Yes? Okay, done. Next one, sir. Kinds of partnership. What are the different types of partnership? Partnership at will for specific period. What do you mean partnership at will?
No fixity.
When the type of partnership is not prescribed. What type of partnership? It is not prescribed. Then automatically the partnership will become partnership at will. What do you mean by that? Whenever one partner gives his intention, let us wind up the partnership firm. The partnership firm will be wound up. So when the type of partnership is not prescribed, it becomes partnership at will. Next one is people, partnership for a fixed period. After the period, now say for example, let us say the partnership will be valid for 5 years. After 5 years, people, partnership will come to an end at their discretion. Meaning we have achieved 5 years. 5 years is done. Now we have a choice. Whether if we want, we can still continue. So remember, after 5 years, a partnership for fixed period, if you still continue, it becomes partnership at will. Next one is people, particular partnership. A particular partnership means nothing but a business that is supposed to do a specific activity. We clearly say we will do education. Next one is called general. We will do education, study center, PG, food. So everything is running under Arivu. It is called as general partnership. Types of partners, people, active partner. What is the specific point with regards to active partner? You guys have to remember. Active partner is a person who is actively involved in the business. When he retires, he needs to give a public notice. That is the most questionable point. Sleeping partner, should he give a notice when he retires? No, the world does not know that he exists also. Nominal partner, what is a nominal partner? The person who lends his or her name to the partnership. Why are they giving it? Because they have some weightage in the society. They have the goodwill in the society. Next one is partner in profits only. Partner in profits only means minor is one of the example. It can be even a normal partner also. Why? Because one partner will take all the losses. That is possible. But one partner cannot take all the profits. When one partner take all the losses, that means all the other partners are partners in benefits only, no? Example. Incoming partner, incoming. Outgoing partner, outgoing. Holding out, holding out. Estoppel. What do you mean by estop? What is mean by partner by holding out? Chirag, Chetan, Arnav. Correct. Chirag and Chetan are the partners in partnership firm. Arnav is a manager there. When they go and meet an outsider, let us imagine a HDFC bank. They were going to take some loan. So they also took the manager along with them. When they were introducing them to the manager, they were introducing themselves to the HDFC bank person. They introduced, hi, I'm Chirag, I'm a partner of this firm. Hi, I'm Chetan, I'm partner of this firm. Arnav says, hi, I'm Arnav, partner of this firm. Now, Chetan and Chirag both kept quiet. They did not correct it. Now, people, Arnav, in the eyes of HDFC, becomes a partner at holding out. That means you have told to the world, I'm a partner, holding out. Holding out. What are you holding? As a partner, I'm representing. Now, for HDFC, in the eyes of HDFC, you will be considered as partner. Sir, there is one more person called ICICI. Now, what happens, sir? This, whatever is the loan that we got, it was completely profitable, that business. Now, the question is, should we share a profit for Arnav out of that particular contract? Should we share?
No, sir.
Yes or no?
No, sir. Yes, sir.
Let us imagine people, HDFC gave a loan, Arnav introduced himself as a partner. That loan people, they ended up in loss. They lost that entire, they took 10 lakh rupees as loan. They lost the entire 10 lakh. HDFC sent a notice to repay the loan. He sent to Chetan, one of the partner. He sent to Chirag, one of the partner. He also sent to Arnav. Is Arnav liable? Now ICICI also got to know that they become liquidation. There is bankruptcy going on. They are not able to pay money. ICICI also sent the notice. You have taken loans from me also, no? Give it to me also. They sent to Chirag. They sent to Chetan. They also sent to Arnav. Why? Because HDFC sent.
No, sir.
So the question is Arnav liable to ICICI? Is Arnav liable to ICICI? The answer is people, Arnav is not liable to ICICI. Arnav is liable only to those people with whom he personally or his partners introduced him as a partner in his presence. Sir, what if HDFC told ICICI? Even when one party communicates to the other party, remember, questionable point. When? Jan 25. They asked this question. What was the question? HDFC informed ICICI that Arnav is also a partner there. You go and recover. The question was whether Arnav will be liable to ICICI. Answer is no. Holding out to happen. Partner should be present or the partner should be present. This is informal, is not valid. Arnav should have told in front of the other two partners, or they should have told in front of Arnav. This cannot give you a right. Understood? Pakka? Done. That's all. That's your unit 1. And difference between partnership, company, LLP, and all we'll do at once. Okay. Next one, we will relationship of partners. General duty is the be faithful, just duty to indemnify. Whenever you do fraud, you have to make good the loss to the partnership firm. Because of you, the money has been lost by partnership. You have to give the money to that. Rights and duties of partners decided by the contract between them. It may be varied by consent of all partners. Agreement in restraint of trade is valid for a reasonable time. That is, there are 3 partners. There is a clause in the partnership. Once you leave the partnership and go, you cannot start any other business similar to this for the next 3 years. There is a restriction written in the partnership. Is it valid? 3 years, is it valid? You should be confident. A reasonable period is not defined, but anything up to 3 to 5 years is still considered as reasonable. You cannot stop a person forever. Okay, let us imagine ABC, they have a clause. What is that? If any partner chooses to go out of the partnership firm, they cannot choose to do business in this area, Koramangala. You cannot do a partnership here forever. Is this restriction valid? Yes or no? As you rightly said, it is valid. It is only Koramangala. Who stopped you from doing in Jayanagar? Who stopped you in doing in some area? Exam question. That's what I say. Reasonable doesn't mean always 3 years will come. All of them wrote that only. Getting it? Hello? Okay. Conduct of business. Who will conduct the business? Partners only will do it diligently. Diligently means carefully. Negligence irbardu. Any difference of opinion in ordinary matters should be decided by majority. But if you want to change the nature of business only, we are into education, we want to get into finance, then you need to take the approval of all the partners. That's the meaning of unanimous. Every partner can inspect and take copies of books except transferee. We have that right. He cannot inspect, he cannot involve in day-to-day affairs. He just is entitled for share of profits. Correct? And at the end of winding up, he is eligible for his share of assets. Mutual rights and liabilities. Does a partnership firm right to remuneration? Is it a right? Can you demand remuneration while you are working for a partnership? It should be there in the contract. What if it's not there in the contract? If it's in custom, can you demand? Remember, custom is a questionable point. What do you mean by custom? In the partnership deed, it is silent. But traditionally, for the last 30 years, 40 years, the partners are drawing profits. They are drawing salaries. A newly incoming partner also said, even I want salary. The old partner says that the right to pay remuneration is not reserved in the partnership deed. Hence, we cannot pay you remuneration. The question is, can the newly joined partner demand remuneration? Customs. Exam question. Hitting it? Okay. Right to share profits. How will we share? Capital contribution, capital ratio? No. Then? If no deed, then equal. Questionable point. Interest on capital? Agreement should give it. If agreement is not, custom should give it. If not, statutory provision, some other law should say that it's okay to take interest. Example, Income Tax Act says partnership can take interest at the rate of 6%. It's okay, now you can pay. Some other law is giving you a right to give interest on the capital. Next one, interest on advances, you can give up to 6%. Whenever someone does a fraud, he has to indemnify the firm. From the firm's point of view, it has a right to be indemnified. Partnership's property. What now is partnership's property? Whatever is a property or contribution brought in by the partners at the time of commencement. Next one, whatever they have earned during the course of business. revenues. The last one, goodwill, value of reputation of the company. Personal profits earned by partners. Can a partner earn a personal profit? Again, a questionable point. They'll ask you here. Now, a partner cannot use the firm's name, firm's contact, firm's property, and make any profit out of it. What do you mean by firm's contact? Now, there is a supplier for Arivu who supplies papers for printing the books. Now, there is a supplier. He gives a supply to the Arivu at a particular price. Now, using that, I will open one more Xerox shop and I'll say, can you supply the papers to me as well at the same price? Now, this is called as what? Conflicting business. And I'm using the business network and I'm making money. I am accountable to the partnership. Whatever profit I make, I have to give a share to the partnership as well. Because I've used the firm's name or I've used the firm's network. Network means connected people. You're not supposed to do. See, ideally, the logic is simple. In a partnership, you cannot make a secret profit. You disclose and do. You take permission and do. But you cannot do secret business. Secret profits is not allowed. Next one, a partner can never do a conflicting business. Conflicting business, I'll start one more educational thing of my own. That is not possible. Clear? Okay, next one. Liable to third parties. All the partners are jointly liable. There is something called as implied authority. What do you mean by implied authority? Every power for a person to work in a business, we cannot write every word in the partnership deed. Now, for example, when we hire a person to take care of manufacturing, now we are saying out of 3 partners, 1 person will take care of manufacturing, 1 person sales, 1 person finance. Now, for example, a person taking care of manufacturing, what, he should only manufacture everything? No, as per the deed we said he can take care of manufacturing. The taking care of manufacturing, it has a right for him to source raw material, enter into contract for raw materials, buy whatever is the machinery is required, buy or employ people. I can hire people. Now all of this is called implied right. Now all of this, every word will not be written in a deed. It will be just written as implied authority. It will be just said that this partner takes care of manufacturing. Under that, whatever is required, this person is free to do it, so that I can achieve my objective. Understanding? Hello? Okay. Next one, liability of the firm for wrongfully acting or wrongful acts of the partners. What do you mean by that? If at all there is a negligence by the partner, the entire firm will still be liable. Agreed? Okay, next one, liability of a firm for misappropriation. They ask you a question here also. What do you mean misappropriation? When a partner takes the money in the partnership and he runs away, the question is the other partners liable to repay the debt? Answer is yes. Agreed? Cardinal principle. Mutual agency, you are liable. Next one, relation of partners to third parties. Partner is an agent of the firm, implied authority which we saw. Next one is partner's authority in emergency. Emergency, same like agency chapter also. All the other partners will be liable even if the partner is exceeding his authority. Only if it is in the good faith and if it is the emergency, necessity. Clear? Okay. Next one, transfer of partner's interest and transferee's right. Can one partner transfer his shares to an outsider? Is it possible? Directly, no. There is a restriction. What is the restriction? You have to first ask the existing partners. If they say no, you can give your share to an outsider. That's the first condition. Second condition, will this person be given the same rights as other partners? No. Does he has a right to inspect the books? No. Does he has a right to take part in the decision of everyday affairs? No. But does he has a right to share profits? Yes. He has a right to liquidate for the assets at the time of liquidation. Yes. At the end of the time of winding up. Upon the order of liquidation, or if the firm decides to wind up the business, from that day he will get the accounts. Clear? Yes.
So does he entitle for losses the firm makes?
Yes. Profits also, losses also. He is. but he cannot involve in regular affairs, that is decisions. And second thing is he will not be entitled for inspecting the accounts and all. Clear?
No.
Losses he will be liable. He will be. The moment you are a partner, you are liable. Okay. Next one. This is transferring only his rights and liabilities. Okay. Minor admitted to the benefits. Tell me minor. So first of all, minor. Can he be entitled for losses?
No.
Profits?
Yes.
Yes. Losses also, I hope you guys know that.
Section 6 months before attaining.
No. If at all the partnership firm is doing multiple business, education, finance, food, hospital, one partnership firm is doing all of this. There is a minor who is eligible only for benefits. Let us imagine the education business is profitable. We made 50 lakhs. Finance business is loss. We made a loss of 20 lakh. Food business, we made a profit of, we made a loss of 30 lakh. Hospital, we made a profit of 2 crore. Now the question is, people, profitable only, no. Now the question is, there are three partners, A, B, C. C is a minor. C's share people is 30%. Now here this person's is 40, B's is 30. The question is, how much will C get in this year?
60 lakh.
C will get 60 lakhs. How did you guys get it?
30% of 2 crore.
30% of 2 crore? All of you did 30% of 2 crore only?
Sir, we adjusted when we.
Okay, how many of you think the answer is 2 crore plus 50 lakh? 2.5 crore. In this, I will give 30% to minor. Anyone think this can also be the answer? All of you are clear? Remember, you can never say that only profits in this I will give 30%, loss is on the other partners. That is not how you need to think. You need to always take the partnership's entire profit and loss as a net. So considering the net, the entire partnership firm is in 2 crore profit. Now in this, the minor will be getting 30%. Let us imagine this 2 crore is also a loss. How much would the minor pay? The minor will pay 0. Whatever is the loss will be distributed amongst A and B only. Hello? Pakana? In what ratio A and B will share?
Sir, as per agreement.
As per agreement, it is clear written profit and losses is 40:30. They will share it in 40:30. If not, equally. Clear?
Yes, sir.
This is one, I don't know why they have not asked this even once. Okay. Clear, Yes, Okay. And next one, a minor has to give his decision within how many days? 6 months of attaining majority. And remember, up to 6 months also you will be treated as minor only. So you becomes 18. 18.6 is when you guys have to give the decision. For this period also you will be treated as minor only. Now once you say yes or a no, if you say yes, you will be liable for all the contracts that were entered ever since you were admitted for the benefits of the partnership firm. That means when you are taken 16, from that time only you are liable. That is the only exception I told you in ratification in minor contracts. Yes? All of you understood? Yes? Okay. And next one, sir. Remember, whenever a minor does not communicate his decision, it will be considered as deemed approval. Yes, sir? Hello? Okay. Next one, sir. Because he would be entitled for all the profits, one. Second thing, from the day one, if the net is coming to loss, you would never accept it at all. Imagine from 16, if the entire contract is becoming loss, you would not accept at all, no? So it's a conscious decision. Okay, next one we will. Legal consequence of partners coming in and going out. Admission of a partner coming in. From when will he be liable? From the day he comes in, or even for the old contracts? From the day he comes in. Can he be liable for old contracts? If he wants to be, can he be? I say I want to be liable from even the day I did not come. For the last 2 years only I should be liable. I am an incoming partner. Can I do? Okay, creditor also agrees. I also agree. The rest of the partners also agree. Can I be liable? What type of contract is this? Contract by novation. The old contract is getting just replaced by one partner's name adding into it. Novation. Yes? Expulsion, or imagine outgoing partner. When will his liability come to an end? On the date of? From the date he giving public notice. Now my question, will he be liable for old contracts? Old contracts. Even after giving public notice. Yes, people, he will still be liable. Remember it. Outgoing partner will be liable for all the contracts that the firm entered. When he was a partner, he will still be liable. Are you getting the point? Sir, no sir, I want to exclude my name. Ask partners, ask creditors. If both of them agree, you can exclude your name. Even that is also called as novation only. Deletion of a name from the agreement. Yes or no? Now imagine there is A, B and C. They had to give money to D. Now C is an outgoing partner. Now, sir, I'll say I'm anyways going out. I should not be held liable. My name, can it be removed from the partnership, from the loan agreement? Can it be removed? You need to ask the creditor. Can it be removed? You need to ask the existing partners. If everyone agreed, can I remove? If everyone agreed, can I remove? Answer is yes. Now what will you call this as? This is also novation. A partner or a party's name getting added or getting removed. Both will be called as novation only. Yes? Okay. Next one, retirement of a partner.
So will the minor's words be taken into consideration?
When he was a minor. For
Let's assume
this business decision, he will not be involved, no? Next one, people, expulsion of a partner. Can you remove a partner? Expulsion, is it allowed? Yes, provided what are the conditions to be satisfied? It must, remember, they will ask you a question. You need to write all the points. Power of expulsion must be there in the partnership deed. Next one, it should be voted by majority of partners. And remember, it should be exercised in good faith, not because of personal rivalry. Rivalry and all is not. It has to be for the interest of partnership. And next one, you have to give a notice to the other party. Whatever he wants to say, you should hear him out. Getting the point? A notice has to give an opportunity of being heard, and expulsion to be in the interest of partnership. Even if one condition is not satisfied, such removal will be considered as invalid. Void. Clear?
Time period of
No. It is absolutely fine. All these are reasonable period. 30 days.
like
30 days. Yes. Next one, insolvency of a partner. Insolvency of a partner, from the day the court passes an insolvency order, from that day, you will cease to be a partner. His share will no longer be liable in the partnership. They can build a question here. Hello? Yes, sir? Insolvency of a partner means what? Whenever a partner becomes an insolvent, from that day, his share will stop to be liable in the partnership from that day. Yes? Next one, liability of estate of a deceased partner. Same thing, upon the death, from that day, his share will not be liable for any longer for the ongoing contracts. From that day, it will come to an end. Agreed? Yes? Okay. Next one, sir. Done. Registrations and dissolution of firm. Okay, the last one, sir. Registration of partnership. Is registration of partnership mandatory? Optional? How do you register a partnership? ROC. You will give it to the register of firms. You give an application along with all the details. Who the names, address, all the details. And remember, if at all you are, can I register a partnership firm after 5-6 years of its existence? After 5-6 years of existence. Can we? 5-6 years. If a late fees of 100 rupees per year. What are the consequences of non-registration of partnership? No. No suit. You cannot file a case on the third parties for breach of contract. Can the other party file a case on us? Yes. Second one. You cannot file a case against a partnership firm or the other partners. Okay. You cannot claim set off up to
100 after more than 100.
Up to 100 possible. Beyond 100 not possible. And you can go for dissolution, that is allowed. And no set off. And a legal representative can come and ask for a share of the partnership firm for deceased partner. Yes, possible. Clear? Yes. Remember, consequence, no suit on civil code against other party, no set off more than 100. Aggrieved partner cannot file a case against firm and partners. Third party can still sue the firm. But exception, third parties can sue, partners can sue for dissolution, that is possible. Power of assignee of court to release property of insolvent partner. Whenever a partner becomes insolvent, what will the court do? The court will appoint a official receiver. That official receiver will come and sell your share of assets in the partnership firm. You cannot say we are not registered, you cannot come. The power of official receiver, whether you are registered or unregistered, will still be the same. Next one, claim set off up to 100, possible. Suit by legal representative of deceased partner to realize the property of the firm, possible. Effect of change in constitution, what is this? Whenever there is a death, A, B, C dies, should we inform this to the register of firms? Even if we have to inform, but even without informing, can we file a case on the third party? Answer is still yes. On the death, imagine there is A, B, C. A new partner gets added. Until this news is intimated to the register of firms, until it is intimated, you will be treated as an unregistered partnership firm only. In the death, that is not the case. Just because one partner dies, if you do not intimate it to the register of firms, you will not be treated as unregistered partnership firm. You can still file a case on the outsiders. But in the case of admission of a partner, until you intimate this news, you will be treated as an unregistered partnership firm. Clear this part? Hello? Okay, done. Next one, modes of dissolution. How and all you can dissolve a partnership firm? One is voluntary. Under voluntary, you can dissolve by agreement. Next one, compulsory dissolution. When all the partners or all but one become insolvent. Happening of any event which makes it unlawful, meaning change of law. Partnership started for dealing in tobacco business. Now India makes a law, tobacco is going forward illegal. Now law is only changed. You have to shut down your partnership, you don't have a choice. But remember, if at all you are a general partnership firm like ITC, which has tobacco and other products, then only the tobacco wing will come to an end. The other things can continue. Next one, happening of contingencies. What is that? You have said that the partnership will be valid for 5 years. After 5 years, you have an option to dissolve or you can continue, but you can still dissolve. Next one, completion of specific business. We wanted to come and build metro. Metro is done. Private public partnership is done. Death of partner. Remember, it is not necessary that death will result in resolution, but you have an option. You can write it so in your partnership deed. Next one, adjudication of partner as insolvent. Next one, dissolution of notice, partnership at will. Partnership at will, how does it dissolution take effect? One partner signifies his interest in dissolving the partnership firm. He gives a notice to all the other partners. From which date will the dissolution be effective? If the date is mentioned in the notice, it will be from that day. If the date is not mentioned, from the day when you communicated, from that day the dissolution will take effect. Clear? Okay. Dissolution by the order of the court. How? First one, insanity or unsound mind. Remember, this has to be an active partner. They can ask you a question here. They will specifically say, there's a sleeping partner who becomes unsound mind. A partner wants to dissolve a partnership firm on these grounds. Is it possible? Under dissolution by court, it will not give you the ground. Hello? Next one, permanent incapacity, like accident and all that. So permanent incapacity does not include fever or temporary diseases. It is only permanent, like coma, paralysis, all these things will come here. Next one, misconduct. It can be personal life or professional life. If you do a misconduct, it gives me a right to apply for the court for dissolution. Next one, breach of an agreement. Partnership deed, we have clearly agreed the terms. You are breaching those terms. It gives me a right for dissolution. Example, embezzlement. What is embezzlement? I am taking money from the person. I am using partnership firm's account money for my personal expenses. Erroneous accounts, maintaining fake accounts. Holding more cash than allowed. According to partnership deed, we have said you cannot hold more than 10,000 rupees in physical cash. That is just to avoid cash transfers. There will be no acknowledgement, right, in cash transfers. That's why no firms, even we have it, we cannot make, we have told this you in class also. If you guys are a student of Arivu, you wouldn't have paid cash. Cash policies are, Arivu is zero. We will not accept cash at all. Zero fraud. Yes or no? Yes or no? There is no cash. You cannot give cash in any place. And neither will be settled in cash. Yes or no? That's because of this only. Refusal to show accounts. Some partner came and asked, show me the accounts. You are not showing those accounts. One of the ground for dissolution. Transfer of interest to third party. A, B, C. C transferred his interest to D. A and B are not okay with it. They can apply to the court for dissolution. Continuous or perpetual losses. This is also one of the ground. Jan 2025 question. There are three partners. The partnership firm is in consecutive losses. One of the partner wants to apply for dissolution on these grounds. Can this be a ground for dissolution? Does the partner have any alternative? What will be the alternative? Either convince all the other partners and mutually agree for a dissolution. It will come under voluntary. Or if the other partners are not agreeing, you have a right to apply to the court under this ground. Continuous or perpetual losses. Jan 2025 attempt question. Next one, just and equitable. What do you mean by just and equitable, etc.? I cannot say everything. I cannot write every point. So just and equitable is people is left to the court. Tomorrow something can come up. I cannot write down everything. Like that, few things have already come up. What are the examples? Deadlock of management. Deadlock means people, four partners are there. Two says yes, two says no. We are not able to go forward. It's called deadlock. You will apply for dissolution. Management not in talkative terms. Correct? No. Generally, if girls are the partners, loss of substratum. What is loss of substratum? It is lost the purpose. At times, the product will become obliterated. What do you mean obliterated? Obliterate means what? Heard of this word obliterated? Destroyal. Obliterated means no longer accepted. The time limit for that has gone. For example, if I have to say Walkman. You guys know Walkman? Typewriters. You know typewriters? Now typewriters, there are companies which were kings in their domain. Now where is typewriters? Obliterated. The purpose of that product itself is gone. That is a call of purpose. Now when the purpose is gone, there is no longer we have to continue. Getting it? Next one is triple. Partner gambles on a stock exchange. One of the ground for resolution. Then that's your company. Sorry, the partnership. Let's next do of company.
LLP, sir. Finish LLP.
Is it done?
5 minutes break and come.
LLP will be done in 5 minutes only. ಒಡ್ಸ್ಕೋಬೇಡ ನೀನು ವಿಷ್ಣು ಹೊಡೆದ್ಬಿಡ್ತಾಳೆ ಆಮೇಲೆ ನಿಂಗೆ ಹೊಡಿತಾಳೆ ಸುಮ್ಮನೆ ಹೆಂಗ ಅಂತಾಳೆ ಹೊಡಿತಾಳೆ ಸಿ ವಿ ಪುಟ್ ಪಾರ್ಟ್ನರ್ಶಿಪ್ ವಿ ಪುಟ್ ಕಂಪನಿ ಆಮೇಲೆ ಗಿರ್ರಿ ಮಾಡ್ಬಿಡ್ಬೋದು ಒಳ್ಳೆ ಕಂಪನಿಯಾ See, once we are done off with the company, hardly another 1.5 hours. And then we'll see papers. Oh, promise on you. We'll definitely finish. Company is at hardly another 45 minutes done. We'll see whatever we want. For you, let's take it up. Huh? Till 8 o'clock you do, sir.
Yes, sir.
Okay. It's not about 8 o'clock. All the papers are already done. That becomes difficult. We can tell the team to. We'll see. Now you see how many marathons are already done. Other day one process that has to go and sit. You guys have timelines. Life around us has changed. See, right in front of our eyes, today, a complete chapter video is no longer seen, you know. I'm saying statistics. Now, for example, 2 years back, we used to upload one chapter, full video. People used to watch that one full chapter video. Today, those one full chapter videos does not have traction. People will not watch. Only marathon. How and all people's this one can change. I'm saying one chapter where you know you will have doubts there. A student will not watch that video today. The student will directly go to marathon. That's you. What and all you guys will change. But every time, you know, the methodologies, the approaches will change. Today is all what? Short videos. Have to come and tell people 5 things to avoid before you do this. Abag you will click it. If you don't do this, you will fail. You will click it. Ade beku, masala ane beku. Alva? Adralli nothing will be there. Nothing. I'll say. If you don't do this, you will fail. What is that? If you don't read, if you don't study, if you don't carry, adana full intention. If you don't take a pen. But you will click it. Clickbait. Yes or no? Innu what and all will change. Innu what and all will happen. All of you are writing May attempt only, no? Everyone.
Yes, sir.
All of you may only, no? Any self-study students here? You've done self-study. Okay. Anyone else? All of you have taken coaching only. Okay. You guys were there in the class? No. Recorded students? Recorded. Okay. Done. Okay. Yes. Okay, next one. Companies Act. Okay, let's start Companies Act, people. Yes. Next chapter, people, Companies Act. Features of a company. What are the characteristics of a company? Separate legal entity. Remember, in separate legal entity, think of Salomon versus Salomon case law. Company is different from its shareholders, outsiders, debentures, creditors, as the case may be. What do you mean by perpetual succession? Company may die, the company will go on for ever and ever. Sorry, member may die, company will go on for ever and ever. Example is Tata's. Yes. Papa is shocked. Tata no will say Anil, sorry, Dhirubhai Ambani, as the case may be. Limited liability. What is the limited liability? ನೀನೇ ಅನಲೈಸ್ ಮಾಡ್ಕೋ ಏನ್ ಹೇಳಿದೆ ಅಂತ. Partners, there is a limit.
For partners, liabilities are like depends on guarantee or shares or depends on the size. But for companies, it's unlimited.
For owners,
No, for a company it's unlimited, right?
Is unlimited. No, for company liabilities is unlimited.
ಲಿಮಿಟೆಡ್ ಲಯಬಿಲಿಟಿ ಅಂತ ಬರ್ತಿದ್ದೀನಿ ಮತ್ತೆ ಸರ್ಚ್ ಕಂಪನೀಸ್ ಲಯಬಿಲಿಟಿ ಅನ್ಲಿಮಿಟೆಡ್ ಅಂದ್ರೆ ವಾಟ್ ಇಸ್ if it's still assets then it is limited only, no na? Unlimited means what? In a partnership people unlimited liability will come. In a company people it is limited liability. Only to the extent of your capital. The shareholders will be limited. I have given 1 lakh. 1 lakh is gone. My liability is also ending. Partnership, that's not the case. Yes? Okay. Next one. Artificial legal persona. Artificial legal person means a company only will enter into a contract. It can sign contracts. It can hold properties. It can file cases. Sue, be sued. Common seal 2025 is common seal. Mandatory? Optional. From 2025 Companies Act Amendment, common seal is 2015. It is amendment that is optional. Companies Act makes the common seal as optional now. Now today's date, if you do not have a common seal, then how will a company enter into a contract? I hope you guys know what is common seal. A contract which is, it's like a seal which is affixed on behalf of a company. It's like a signature of a company. Now sir, you said common seal is optional. Then in its place what do we have? 2 directors or 1 director and 1 CS if any. If a CS is there, he has to sign. That's what it is. Okay, next one sir. It's turned off.
increased temperature is something. It's on. Yes, it's on.
ಅದು ಏನಂದ್ರೆ they have turned off those two. Now one AC is taking care of 40 students. Okay.
CS is appointed. If it is something like practice and
Practice alla. If you have one CS in employment in your company, if you have appointed a CS, that CS has to mandatorily sign. Yeah. That means not working in a company. Imagine doctor working in a hospital, doctor working for a clinic. Clinic is your own. This is employment. You will be for an employment. Here you will not charge per signature. Practice is different. That is when you will charge per work. That depends upon type of the work. Incorporation, you can charge 20-25,000. That's the minimum fees. Clear? Okay. Okay. Next one, sir. Lifting of corporate wheeler. What is lifting of corporate wheeler? ಅದೇ ಸರ್ ವೀಲಿಂಗ್ ಎತ್ತಿಂಗ್ ಎಲ್ಲ ಹಾಕಿ ಏನ್ ಪಂಚರ್ ನೀನ್ ಹಾಕ್ತಾರ ಲಿಫ್ಟಿಂಗ್ ಆಫ್ ಕಾರ್ಪೊರೇಟ್ ವಾಟ್ ಇಸ್ ಲಿಫ್ಟಿಂಗ್ ಆಫ್ ಕಾರ್ಪೊರೇಟ್ ವೀಲ್ wheel means earpiece. Wheel means people cloth or a mask. So it's a protection that a shareholder is enjoying. Whatever in a company, if it happens, I am not liable, company is liable. But in partnership, that is not the case. No, anything happens in a partnership, partners were liable. Now, example, S Bank, even I was a shareholder. Even I am also owner. They claimed there is some fraudulent activities that took place. Am I liable? No, that is what is called as lifting of corporate will. Something that a company or a directors did, as a shareholder, I am not responsible for it. But this rule comes with an exception. If I did it wantedly, I am taking the benefit of the mask called as company. In such case, for whatever a company does, as a shareholder or as a director, even I will be held liable. This concept is called as lifting of corporate veil. Okay, when can that happen? The first one, when you are dealing with alien enemy. Case law, Daimler Company versus Continental Rubber Tires. In this case, what happened? There was a company called as Continental Rubber Tires. There was one more company called as Daimler. Continental Rubber Tires, in this company, it was supplying tires to Daimler Company. They said we will supply the tires for 5 years. After 2 years, Daimler Company said we do not want tires from you anymore. Now, Continental says if you do not buy as per the contract, it's a breach of contract, we will file a case on you. They said you do whatever you want, we are not going to buy. Matter went to court. In the court, the question was asked, why do you want to do a breach of contract? You have entered into a contract for 5 years, now you want to end it after 2 years only. Why? So in this case, it was held that people, because, sir, Continental Rubber Tires, who are the shareholders? The shareholders are German citizens. Now this companies were in UK. Now, both were in UK. Now, sir, Continental Rubber Tires shareholders are from Germany. Now they said, so what? Company is registered in UK only, no? Company is different, shareholders are different. But in this case, it was held, sir, if I give them money, they will give money to them. That's like we only giving money to them. Indian Contract Act says you should not do any contract with alien enemies. Now it is indirectly we are doing. Even court was satisfied. Lifting of corporate veil. They said the Continental Tires and the German citizens are not two different people. They are one and the same. And hence the contract came to an end. There was no damages that was awarded. Clear? Okay, next one. To evade tax. In this case, what happened? There was a person called as Dinshaw. He floated 3 dummy companies. He gave money 1 crore, 1 crore, 1 crore. This 1 crore they further invested into few actual companies. Example, ITC, Infosys, Reliance, everything I invested. Those companies started giving a benefit, profits, dividends. Now, these companies started making good profits. Imagine it made some 10 lakh as profit. This made some 8 lakh as profit. Now, technically, if you make profit, you need to pay tax. Now, what did this person do? Dinshaw.
He took it as a loan.
He is only the shareholder, he is only the director, he is only the employee. Now, whatever that 10 lakh rupees we made, that he borrowed as a loan, which he never repaid. So technically from the company's point of view, profit was there, but the entire profit became a loss because that was given as a debt which was never repaid. So these companies never paid tax at all. So okay, at least this person has to pay, no, because he has taken the 10, 8 to 5 and all he has taken, he has to pay tax. In which country will you pay tax? On loan. So neither this person paid. So Commissioner of Income Tax, while he was scrutinizing these documents, he got to know there is some affair that these people are doing which is not right. And it was lifted people and they got to know this company and this person are one and the same. He's just taking an advantage of company form of business. He's using a company as a mask. And Commissioner of Income Tax said whatever profit the companies did, you are liable to pay tax. Case law, Dinshaw Manekji Petit versus Commissioner of Income Tax, popularly seen as Dinshaw Manekji Petit only. Re means in the case of. Next one, subsidiaries to act as an agent. Merchandise Transport Limited versus British Transport Commission. What happened in this case? A holding company applied for some license. The license was rejected. Now what did they do? They floated a subsidiary company. They again applied for license. Mask was lifted. It was known a holding company is trying to do something indirectly. If they had applied in their own name, we again would have rejected them. So what did they do? They floated a dummy company and again they applied. The intention was what? The intention was to evade the law. That is, the holding company, if they apply in their name only, then they wouldn't have got the license. So what did they do? They floated a subsidiary company and through that they applied for a license. Again, that was also rejected on the same ground. What is that? A subsidiary was just acting as an agent of its holding company. Just as a mask, they are using a subsidiary company. Clear? Next one, to avoid obligation. Workmen of Associated Rubber Industry Limited versus Associated Rubber Industry. What happened in this case law? Yes, there was one company. The company was, so according to the law of this particular country, whenever you make more profits, you need to give more bonus to your employees. So the company did whatever possible to reduce their profits. It was held that whenever you do something to evade any legal obligation, it is your responsibility, you need to take care of it. In this case, it was held that the company was formed just to avoid legal obligation. Next one, company formed for fraud or improper conduct or defeat law. What is this? Clifford Motor Company versus Horn. One company called as Clifford Motor Company hired a person as its managing director. In this employment contract, it was clearly written that whenever you leave the company, you are not supposed to deal in our company products for the next 3 years. Now, after 5 months of his appointment, this person was removed. Now, what did he do? He started dealing the spare parts of Clifford Motor Company. He started selling. As a sweet warning, Clifford Motor Company sent a notice to this person called as Horn. As per our contract, once you left our company, you are not supposed to deal with the parts of our company. So please stop doing whatever you are doing. Now what did Horn do? Horn did not end there. Horn, his friend and Horn's wife, they floated one company. With that company, they started dealing with the spare parts. In this company, is Horn there? The answer is no. But who is controlling the entire thing? Horn only is controlling the entire thing. So again, Clifford Motor Company sent a notice saying what? Horn, you are doing something indirectly which you are not supposed to do directly. Loophole only, no? Yes or no? That is what they said. So sir, actually he did it with friend. Imagine you did it with a random person. How will you figure it out? Will people do in reality? Yes. People will do this left and right. Yes, 100%. So is this valid? The answer was invalid. Clear? Yes. Remember, you can expect at least one case-based question on any of these 5 scenarios. There will be a question. Clear? Any doubts? Hello? Okay, now we will different types of company on the basis of liability. The first type of company is limited by shares, meaning whatever is the money I have given, up to that extent my liability is restricted. After that, I will not be liable to pay even 1 rupee. Next one, company limited by guarantee. What do you mean company limited by guarantee? Day one, we will not give money. We will just give a guarantee. What is a guarantee? You start continuing the business. On the day of winding up, if you still do not have money, as a shareholder, I will come and pay money at the time of winding up. That's the meaning of company limited by guarantee. You are giving a guarantee only on day one, not money. Yes, sir. Next one, unlimited company. What is unlimited company? Liability of a company is unlimited without any control. Next one, on the basis of control, a company can be classified into holding a subsidiary company. What do you mean subsidiary company? A question can be asked here. A company in which
More than one half of the paid up share capital, or a company which controls the composition of board of directors. Meaning there is a company A, there is a company B. Company A is controlling who the majority of directors should be on company B. Imagine in company B 5 directors are there. In this, company A is controlling 3 directors. Meaning their appointment, their removal. Who is controlling? A is controlling. Now it is considered as B is a subsidiary company, A is a holding company. Second case, A controls B. He holds 51% of share capital in company B. This becomes a holding, this becomes subsidiary. So there is A, there is B. I hold 51% in this company. This company holds another 25% in C company. A holds another 20% in C company. C is considered as what? Is C a subsidiary?
No.
Is C a subsidiary?
Deemed subsidiary.
Is it a subsidiary? C da not B.
No.
B alla. B is a subsidiary company. C is a subsidiary company? C. Think. C is a subsidiary company. Then what is C da? C is subsidiary only. Subsidiary only? Yes or no? No? Why? Less than 51%. Remember, second condition says one company will be called as a subsidiary company. Listen. A company will be called as a subsidiary company when it holds more than 51%, more than one half of the total voting power of a company, either on its own or together with its subsidiaries. Either on its own or together with its subsidiaries. What do you mean by that? In C, da, A controls B, agreed?
Yes, sir.
A is controlling B, agreed? B is controlling C up to 25%. A is controlling C 20%. Don't you think A is controlling B? B is controlling C? Now can I say A is only controlling C for 25? A is only controlling C for 20?
Yes.
Can I say this? Can I say this?
No, sir.
45%? Okay, we have it 45. Chirag, 45%? Is it a subsidiary company? Okay. Chirag, now?
Yes, sir.
Is he a subsidiary company?
Yes, sir.
Now is he a subsidiary company? Remember, this was the question in 2022. Everyone wrote C is a subsidiary company. Okay, first of all, you tell me in this case that 20 and 35. Is C a subsidiary company? Here is it a subsidiary? This all of us are clear? The people, the students are so used to a question that, okay, in this way, I hold 25, you hold 20, okay, indirectly it is, people are used to, they wrote it off as subsidiary company only. But they did not add. Remember, you need to hold together more than one half. In C, how much are you controlling? 20 and 25, 45. Will it become a subsidiary? No. Ama. Aduda. But I'm saying we are so used to that question's mindset. We'll write it off subsidiary. Getting it? Okay. Next one, sir. A holds B 51%. B holds C 51%. This is holding. This is subsidiary. This is holding. This is subsidiary. What about this and this? This is a holding company. This is a deemed subsidiary company. One question you can expect. Clear all of you? 100%. Sir, what if A holds in B 20 percentage? Now the question is, which is an associate of which company? Is B an associate or A an associate of B? Sure? Okay, B is an associate of A. 22 what percentage? Okay, tell me. A is holding in B 50 percentage. What type of company it is? 50. Joint venture is an associate company? Is joint venture considered as an associate?
Yes, sir.
Yes? Remember, joint venture is also considered as an associate. 50 is generally an associate company. 50 is generally a joint venture company. But that's why associate company definition says, section 2, clause 6 says, joint venture means what? Associate company means what? A company in which other company has a significant influence. What do you mean by significant influence? At least 20 percentage up to 50 percentage. The way the words is written, at least 20 percentage, but not a subsidiary company. So 20 to 50 is considered as associate company, and it is written, it includes a joint venture. So joint venture is a associate company. That's clear. And next people, small company. What is small company? A company which paid up capital. A company's equity paid up share capital is 3.5 crore. Preference share capital is 55 lakhs. A company's turnover is 38 crore. The question to you, is this a small company?
Yes.
Is it a small company? Sir, ನಮಗೆ ಬರೀ 4 and 40 ಗೊತ್ತು. We know only 4 and 40. Is it a small company? Yes, sir. Pakkana? Why? We do not include preference share. So is it a small company? Answer is no. The words used are, a small company means a company whose paid up share capital does not exceed 4 crore. Preference is included in the words paid up share capital. Clear? So it is going beyond 4 crores. Hello. Sir, you ಕೇಳ್ತಾರೆ sir. You keep asking. How many questions you ask? Understood? So remember, equity plus preference both put together. Okay, my question, concentrate. A company's paid up share capital is 4 crore. A company's turnover is 39.5 crore. Is this a small company? I know what I'm asking. Exact 4. Is it a small company? What? How many of you think no? How many of you think we don't know, sir? We know only 4. Remember, the words used are, a company is a small company whose capital does not exceed 4 crore. Does not exceed. Up to 4, it is within the limit. So 4 is within the limit. So 4 and 40 is still a small company. It should not be 4.1, 40.1. Yes, sir. What are the companies that cannot be considered a small company? Holding company, subsidiary company, section 8 company, holding company ಆಯ್ತು, statutory company, and that's all. Public company. What is a small company definition?
Small company is a private company.
A company other than public company. Yes. I mean, intention can be private company, but definition is a company other than public company. Clear? Okay. What do you mean by private company? Tell me the definition of private company. A company which, a company whose articles of association restricts the transferability of shares, limits the number of members to 200. In this, there are some exceptions. What is that? Past and present employees will not be counted in the number 200. Joint shareholders should be treated as one. And the last one is, you are prohibited of issuing shares to public. If a company which satisfies any one or all, all is it? Okay, a company, other we didn't say, a company which has all the conditions becomes a private company. Getting the point? Yes. What is a public company? Which is not a private company, is a public company. A subsidiary of a public company? A subsidiary of a public company is a deemed public company. A subsidiary of a government company?
But 51%.
No, government.
What is a government company?
At least 51%.
At least 51% of share capital is held by. Okay. There is a company called as XYZ Limited. There is central government which is holding 10%. There is Karnataka state government which is holding 20%. There is Tamil Nadu government which is holding 20%. There is another company called as ONGC, which is a government company. Now they are holding 5%. Is this a government company? Yes, because the total shareholding is 50, more than 51. So this company is a, this company is not a government company. This company is government company or not? We'll see that. Can you tell me what is the definition of government company? A minimum capital of how much? 51% is owned by? Tell me properly. Central government, state government, or state governments. Okay, central and state governments. This all of us are aware, right? Okay, same here Ella have written government company. When you know that definition, when they put it in practical, how can you guys go wrong? Where have I told this in definition? Did we write a government company here? Then how did you include this? Adida exam. Understood? What is not right, what is not there, here also will come up. So this is a government company. You are not supposed to add this. Getting it? Any doubt? Very good. Subsidiary of a government company is a? Wait, Bhaskar, tell me. Subsidiary of a? Manjuna, change your name? Okay. Okay, Manjuna, yes, Manjuna, tell me. Okay, Manjuna, tell me, when will a company become subsidiary? Tell me. 51%. XYZ is holding 51% in ABC. If this is a government company, you are telling this is also a government company. How much is this? How much is this? When will I tell for 5%? Oh. Correct. Tell me a
provision where you saw if government company is holding 5%, it is, you tell me. What confusion now? You guys added off government company definition and deemed government company definition. You guys made one definition. And you know the beauty, you know both the definitions. But you guys did not interpret it. You know for a fact in government definition, Ittu,
No, it's okay. Thank you. You guys know for a sure, for a fact that
both the things does not include. You know the definition here also? You know the subsidiary company definition also? And I did not do anything. You only said me, okay sir, this is 51%, this is...
So what if ONGC is pulled by any one of the state government 100% fully?
We'll take it. ONGC. Your question, I'll put it, you will get the answer. You only see.
Any one of the state government
State government is holding how much?
100% of its share.
What is this called? You got the answer.
So in that case we saw previously, can we consider it as a state company holding?
What he asked me is whether if we keep this case in that state governments and central governments are
This company is investing in the other company.
So the previous company we saw.
in the first case.
How much is ONGC holding?
So no,
5%. It's not a big.
5%. Wait. Let us imagine another 50% is held by central government. Tell me. Now you tell me government company definition. Only for subsidiary you will include. If ONGC is holding 55%, for that alone, that's a different provision. You are not supposed to add both. That is not allowed. So is this a government company? Answer is no. You are not supposed to add these two. They are two independent definitions, because in a government definition, government company definition, they did not give us a provision to add this. Then how can I add? Have they given? No. Agreed? All of you, exam question now. Associate company only. Is clear, Pakka na? Again, same success rate. 100 only, 99 students have written as government company only. The thing is, that too after knowing the definition. Same thing with small company. I don't know why they have not tested to that extent. Remember, in your exam, Kattappa is preference share. Kattappa. Bahubali. Kattappa is preference share in two subjects. In foundation, I wouldn't say much, but in CA inter law, Kattappa will be preference share only. In your accounts also, Kattappa will be preference share only. You will never know when to take, when not to take. This journey will be the same every place. Because when you read it, you would have read it as capital, and you will not remember paid up equity, paid up share capital. Sir, very anyaya, sir. Okay. Okay, we saw public, we saw private. What do you mean by OPC? 1% company. Who can start a OPC? A Indian citizen, natural person, a resident in India or otherwise. So this person can be a resident or otherwise. Regarding this, in YouTube recently also I have uploaded one video, resident or otherwise. If possible, watch it. There is one in-depth analysis made on that, which is considering all your ICA answers and all. But remember, today it is resident or otherwise. When will a person be called as a resident? The person stays for 120 days in the previous financial year. Okay. And who can be a nominee? Can a minor be a nominee? Can a minor be a nominee?
Yes, sir.
Minor can be a nominee, minor cannot be a principal. Minor can be a principal but cannot be a minor. Nominee. Can he be a nominee? Who? Minor cannot be a nominee. ಏಯ್ ಯಾರೋ ನಾಮಿನಿ ಅಂತ ಹೇಳಿದ್ ಇವಾಗ ನೀನೆ ಏನ್ ಕೊಟ್ರು ಅವನಿಗೆ ರಾತ್ರಿ ಮೈನರ್ ಕ್ಯಾನ್ ಬಿ ಎ ನಾಮಿನಿ ನಾನು ಏನ್ ಹೇಳ್ತೀಯಲ್ಲ ಚಿರಾಗ್ ಅವನು ಮೈನರ್ ಕೆನಾಟ್ ಬಿ ಎ ನಾಮಿನಿ minor cannot be a nominee. Can one person be a member of two OPCs?
No, sir.
Can one person be a member of two OPCs? Can one person be a nominee of two OPCs? Can one person be a nominee of two OPCs? Can one person be a nominee of two OPCs? Member Allah. Can one person be a nominee of two OPCs? Challenge, sir. Sotre? ಹೇಳ್ಕೊಂಡ ಹೇಳುವ ಚಾಲೆಂಜ್ ಟೆಲ್ ವಾಟ್ ಯು ಓನ್ಲಿ ಸರ್ ಪಾರ್ಟಿ ಬಿರಿಯಾನಿ ಪಾರ್ಟಿ ಎಲ್ಲರಿಗೂ ಚಾಲೆಂಜ್ ಮೀನ್ಸ್ ಕಾನ್ಫಿಡೆಂಟ್ ಸರಿ ಹೋಗ್ಲಿ ಇರ್ಲಿ ಬಿಡು ಬೇಡ ಕ್ಯಾನ್ ಒನ್ ಪರ್ಸನ್ ಬಿ ಅ ಬೇಡ ಕಣೋ ಸೇ ನೋ no, one person cannot be a nominee of two OPCs. Huh? Logically think da. Can one person be a member of two OPCs? Can a one person be a member of two OPCs? Why? Okay, when one person cannot be a member of two OPCs, what if he is a nominee of two OPCs, both of them die? If I am a member of two OPCs, if I am a nominee of two OPCs, I am a nominee of two OPCs. This shareholder also will die. This shareholder also will die. That means I will become member of this also. He will become member of this also. That is when one person, can one person be a member in one OPC? Can one person be a nominee in one OPC? Understood? One person can be a member in one OPC. One person can be a nominee in one OPC. Clear? Can a nominee be changed? Can a nominee be resigned? Can nominee resign? No, member is shareholder, director is board. In OPC, minimum how many members? Minimum. How many minimum members should be there in OPC? Maximum? Maximum. Maximum how many? Maximum. Chetan, maximum members in OPC. Members is one only. Clear? Okay. Maximum how many? One only. OPC, one person company. There should be only one person. What? Now what I asked? Members means shareholders. Directors are different. Clear all of you? Other types of company, government company, foreign company. What is foreign company? Company which is registered outside India but has a place of business in India. Whether it can be physically or it can be agent or it can be through electronic mode. Next one, Section 8 company. What is Section 8 company? Never ever write. Section 8 company means non-profit organization. Section 8 company means you should write this one. A company formed for promotion of, objective of charity, education or some sport, some idu, adu. That is what you will be writing. Clear? Huh? It applies its profits to promote its object. Question will come here. Can it declare dividends? No. It is prohibited from declaring dividends. Can it earn income? Can Section 8 can it earn income? Section 8 company. You can earn income, but you need to put it back into the charitable objects. You earn, but put it back into the business only. You cannot take it as dividends. It operates under a special license given by central government. Remember, if you violate, that license will be taken away from you. And what will they do? They may wind up your company, amalgamate with another Section 8 company, or convert its status into any public or private business. Incorporation of a company, you will file some documents and all. What documents? Spice Plus, simplified pro forma of incorporating companies electronically plus. Now this you will be filing it with ROC along with MOA, AOA. In that you will maintain all the details about the purpose of the company, capital, details of the directors, declarations, who are your first shareholders, what is the capital, address of the company, object of the company, everything will be written there. All of this will be filed, and if registrar ROC is satisfied, ROC will give you a certificate of incorporation. In that, sin and date of incorporation will be mentioned. From that day, it is the conclusive evidence of your company getting registered. Next one, sir. If a company is formed by giving incorrect information, the tribunal may, what can it do? Pass an order to regulate, meaning going forward, I will tell you what to do. Liability of the members can be made unlimited. I can remove your name from register of companies, winding up, or such other orders. Types of share capital, equity, preference. Equity can be further classified into normal and DVR, differential voting rights. One share can have less votes but more dividends. Preference share, what do you mean by preference share? Preference share means a share which enjoys priority in terms of repayment of capital and in terms of paying dividends. When compared to equity shares, they enjoy a priority. That's why we call them as preference shares. Companies documents, we have two types. One is called MOA, one is called as AOA. Tell me what are the clauses of MOA. First one, name clause. Name clause indicates name of the company along with type of company. If at all it's a public, you write limited. Private, private limited. OPC, OPC private limited. Section 8, Section 8 private limited. What will we write? What will you write then? Nothing means there should be something, no? Da? You'll be writing the words like foundation, federation, association, chambers, etc. Yes, next. Liability. What is the first one is name, second one is registered office clause. What is registered office clause? State or address? State where the company is registered. Third one, object clause. Object clause indicates purpose of the company. It says education, hospital, food, it will be written here. Fourth one, liability clause. Liability clause says limited, unlimited, guarantee. Fifth one, capital clause. It says authorized capital of the company. How many shares, face value, all of that will be here in authorized capital. Sixth one, association, also called as subscription clause. Who are the initial shareholders of the company? How much shares do they agree to take? Will come under subscription clause. One clause which will never change in the life of the company is subscription clause. It will be same forever. Yes or no? Any doubts?
Shareholder will change upon it.
Correct. Huh.
So we can
Tell me,
change
which one?
association.
So you're saying subscription clause will change is what you're saying. Okay. It says who the initial shareholders were, and it's a written acknowledgement that we are filing with ROC. After the company is filed, sir, these people will take the shares of the company. It's a written acknowledgement we give. Certificate of incorporation. You guys have seen, this Infosys certificate of incorporation. Yes, 1981. Manual written, no, that time and all. Typewriters. Yes, over a period of time. Finally, this is the certificate of incorporation. Can you see MOA? Look at the first one. The name of the company is Infosys Limited. Second one, the register of the company state is Karnataka, state registered class. Third one, object. Can you see? These are all objects. Now you got to know. They have how many? 27. Why 27? Other objects are also there. I'm saying 27 objects. Main objects it's called. 27 objects. Why? Ultra wires. Shouldn't happen, no? That's why remember, object class will be very vast in reality. So it should not become ultra wires. Got it, huh? Taka taka. Fourth one. The liabilities of member is limited. Limited by shares. Fifth one. Authorized share capital. Now come to sixth one. What is sixth one? Subscription, no? Subscription, no? Yes or no? Look at the shareholder. Who is the shareholder? Nagavara, Ramarao, Narayana Murthy. This person only is called as Narayan Murthy, also popularly called as Narayan Murthy. According to you, how many shares will Narayan Murthy have in Infosys? According to you. According to you, how many shares will you have now? Why? With time it should change, no? Oh, no. This is subscription. That means a promise that they made to the registrar. Sir, we are filing everything today. Once company is registered, I will take at least one share. That's the meaning of it. So once company is registered, Mr. Nagavara Narayana Murthy took one share. And that's all. We know only him. Who were the other founders? Which the world never knows. You know this person? No, he is the current chairman and MD of Infosys, Nandan Nilekani. You know Nandan Nilekani? No. But without Nandan Nilekani, your mobile is of no use. Your Aadhaar card is of no use. Nandan Nilekani is a person who worked for your Aadhaar card project. He is a person who worked for Beam, UPI. Without UPI, where is your UPI today? He is a person. We don't know all of them. Understood? All these people said, we will buy these shares. 1981. Did they buy? Yes. Got it? Hello. Yaro? Mohandas Karamchand Gandhi? I know, we did remember him. Clear? Doctrines? Is that? Tell me the doctors. One is ortho. Ortho. One is ortho doctor. Doctrines. First one is ultrawires. What is doctrine of ultrawires? Ultrawires means what? Infosys said we are information technology and they will start one hotel business. Can they do it? So ultrawires means whatever promise you have made to the world and to the ROC, you are not supposed to do anything apart from that. That's why they said 27 things will do. They cannot do a 28th thing. They can do 27, absolutely fine. They can change. How? Call the shareholders for a meeting, pass a special resolution, meaning if 100 people are attending the meeting, 75 people have to agree. Let us add 28th item. You add, intimate everything to ROC. ROC says certified. From now you can do the 28th business. So you cannot first do and then do all of this. First you have to alter and then do the 28th business.
Shareholders agreed and they did the transaction after they implement to our CMA.
No, not valid. That's what I'm saying. That's what you would have seen on Word also. You cannot ratify. Void ab initio. You have to first do it the procedures and then you should do the 28th business. You cannot do the other way. Clear? If done, it is called as ultra vires. Ultra vires transaction is also always considered as void ab initio. Doesn't bind the company. But remember, here also, just like minor agreements, I told you, minor agreements are void ab initio. What if minor has taken money? He has that money. Can the court recover that money? Yes. Same thing here. Meaning, if it's an ultra vires transaction, but company has taken the benefit of it, it is the responsibility of the company to return it. You cannot say it is just like that null and void. Getting it? They can ask you a question in the exam also. Doctrine of equity will come. Meaning, I'll be writing, it's an ultra vires transaction. Company technically should not be liable, but because company has taken a benefit of it, company will be liable for that transaction. Understanding all of you? Hello? Yes. Okay. Next one, what is the ultra vires transaction? Ashbury railway carriage. I hope you guys know this case. Ashbury railway carriage. What happened? They were supposed to do railway business, but they agreed to give finance to someone else. It was considered as ultra vires. Why? Your object clause has manufacturing of railway parts. You cannot finance someone else. On those grounds, this transaction was considered as ultra vires transaction. Next one, constructive notice. What do you mean by that?
It is trade with the company.
Company is protected from outside. Now, did you guys know how company is protected from outsiders? Now imagine you are doing a contract with Infosys. It is your responsibility to come and read here. Read the first object. What do they say? They can carry all kinds of promotion business, in particular to form, constitute, float, lend money, assist, and control companies, associations. No, take over. Okay, read that A, 1 and 2. Read that. What is the object of the company? To establish, maintain, conduct, provide, procure, make available services of every kind, including commercial, statistical, accountancy, medical, legal, management, educational, engineering, data processing, communication, and other technological, social, or other services. Meaning what? We can build an app for engineering, education, management, link, legal, everyone we can provide technological services. Getting? Yes. Hello? Yes. Now, if you can come with a word which is not there, that becomes ultra vires. Understood? Getting it? Second one, to carry on the business of importer, exporter, buyer, lessors, sellers, dealers in all type of electronic components and equipment necessary for attaining the above objectives. Software can they do? They have put electronic items. Can they do software? Can they do? See, electronic components and equipment necessary for attaining above objectives. So software will be covered there. Yes, you can do. Reading the point? That is the meaning of object clause. If you go beyond that, ultra vires. Now you cannot say, sorry, Infosys never told me all of this. Public domain. Mitro. Responsibility. Before you do a contract, it is your responsibility to come and check. Whether you checked or not, we assume that you have checked.
So if there's something in this object clause, but they have a subsidiary company that is doing some other type of business.
That's okay. The moment you are a subsidiary company, it is also a company. Yes. The moment you are a company, you should also have your MOA. Clear? Pakka? Yes. Now, sir, that's why we call Doctrine of constructive notice protects company from the outsiders. We will not give you every document. We have put everything in public domain. It is your responsibility to come and check. Understood? Okay. Next one, people. Doctrine of indoor management. What is indoor management? We protect outsiders from the company. Meaning, we have only written this much. We have not written internal management. What happens in the business decisions of a meeting? Outsiders do not know. How do they have access to it? Now, in such cases, we protect outsiders from the company. So, remember, constructive notice is protecting company from outsiders. Indoor management protects outsiders from the company because not every decision is available in the public domain. Clear? Pakka? Yes. But doctrine of indoor management has some exceptions. Meaning, in some cases, we will not protect the outsiders. We will protect the insiders only. And when is that? First one, actual or constructive knowledge of irregularity. Now, what do you make actual or constructive knowledge? Now, for example, I will come and sell you this camera for 2000 rupees. Will you guys buy it?
Yes, sir.
You guys will buy it? Yes or no? You should know what a teacher can do, what a teacher cannot do. I can come and say I'll sell you a material. You can believe it. I cannot come and say I'll sell you an equipment. How will you believe it? That is the meaning of what? Constructive knowledge of, what is it? Suspicion of irregularity. Suspicion of irregularity means what? Meaning you should have at least some suspicion when you're doing a transaction. Who this person is? Whether this person, common sense. That's a perfect thing. Meaning, you should know whether this person can do this or not. That you should give it a thought. If you do not give it a thought, we will not protect you. Agreed? Yes? Next one is actual or constructive knowledge of irregularity. Okay. Who's the founder of this company? Arjun sir. Is this a company? Once it's a company, does it has separate legal existence? Arjun sir will come and sell this camera to you. Will you buy?
No, sir.
Why? Arjun sir, not me. Arjun sir.
Property of the
Okay, wait. Arjun sir will come and sell. Will anyone buy? One person. Any one person. You will buy. You will buy. You will buy. Yes. Okay. Can Arjun sir sell this particular camera to you? Why? Arjun sir's company it is. But still you purchased.
sir, there's a good section.
Allah, you said separate legal entity. You know it. Company different, shareholder different, everything you know. But you still say I will purchase. This is only meaning of what people? Actual or constructive knowledge of irregularity. Meaning the yalla gottu. But still we will get less. We know everything, sir. But 40 bartilla. Why? Understood? You know that it is right. You know it is wrong. And you still do the transaction. Law says we will not protect you. That's the meaning of knowledge of irregularity. Even after knowing you took risk. Then why should I protect you? Getting it? Hello? Yes. The last ones are forgery. What is forgery? Forgery is always a fraud. When one person signs as someone else. Hello? Yes, now I'll take a checkbook and I'll put Mukesh Ambani's signature. Properly, ange. Is Mukesh Ambani liable for it? Same signature I'll put. So remember, forgery, no matter how innocent I narrate the story, forgery will never give you a right. Forgery is always void. Is this clear?
Yes, sir.
Hello? Yes, sir. Okay. So that's your company law. We have another 2 chapters. You want a 5 minutes break?
Yes, sir.
5 minutes break. Yes. Just go for a 5 minutes break and come. We'll finish off LLP and then we can break for lunch. Then after that we can do negotiable instruments and we can do that. Yes. Just go for 5 minutes and come. Next chapter, people, last part one now. LLP, 15 minutes, we'll finish off. What is LLP ta? Limited liability partnership. So in 2008, there was a combination of partnership form of business and liability form of business, both was brought together. Some characteristics from company, some characteristics from partnership, both was put together. They formed a hybrid vehicle, and that is only called as what people limited liability partnership. That's why you will see some characteristics of company also, some characteristics of partnership also. What are the characteristics of company? All the advantages you can see in a company that will be seen in LLP. Whatever are the disadvantages of partnership, that is eliminated in LLP. What are the disadvantages of partnership? Unlimited liability. It is make limited. What else is the disadvantage? Maximum number of partners. In partnership it is 50. In LLP, unlimited. And what else? Mutual agency. Here there will be no mutual agency. One partner cannot bind other partner. And tell me, what is the difference between company, LLP, partnership? Can we write act first? And this is limited liability, unlimited liability, and here perpetual succession, no, and separate legal entity, no separate legal entity. Mutual agency is not there. It's there, it's not there, it's not there. Here one partner can bind LLP but cannot bind other partners. Here they can bind partners also. Sir, the governing deed, AOA, MOA. Here LLP deed. Here partnership deed. Here it should be, it can be for profits or even no profits. Section 8 company. Only for profits, LLP also. You cannot do non-profit organization. That is not possible. Okay, next one. Minor can be a shareholder. Can a minor be? Directly no, but through guardian, yes. Can a minor be a beneficiary in LLP? Beneficiary? No. He can be in a beneficiary in a partnership. Okay. Next one, who is the owners? Shareholders. Who is the management? Here, designated partners are the management and the owners are, remember, partners are owners. Management also partners only. Designated partners does not have any management business. They are only responsible for taking care of legal compliances. Taking care of business, all of them will take care. Clear? Here, partners. Correct now? Can we write more? Registration, very nice. Mandatory. Here, mandatory. Here, optional. Next one, total number of members in company. Private, 200. Public, unlimited. LLP. LLP, limit how much? LLP. Sure? LLP has no limit. Partnership? 50. What is the minimum number of shareholders required for a company? 1, 2 and okay. Okay, 1, 2 and 7. Next one, people, in LLP? 2. In partnership? 2. In LLP, minimum how many partners are required? 2. How many designated partners are required? How many people are required? If in LLP, how many partners are required? How many designated partners are required? Total how many people are required? Allah, 2 only. The partners only will become designated partners. Visuals can be deceiving. So people, designated partners, it's not any extra partner. Whoever are the existing partners only will become designated partners. Yes or no? Clear? I think more than sufficient. Is this much? If you write, valuer will come and hug you. Okay. Next one. Partners. Minimum 2 partners. Designated partners. If the number of partners go less than minimum, then what will happen? Same as partnership or company?
6 months again.
Is it partnership or company? Same as what? If the number of members, if the number of partners goes less than minimum number, the liability that you see in company, no? Section. This restriction is similar to what you see in company. One is you need to get it within 6 months. The entire provision, if you do not get, what will happen? Unlimited liability for that period. All that is similar to company only, no? Section 3A. Okay. So minimum partners, if it goes less than 2, it is your responsibility to add within next 6 months. If you do not add, whoever are the continuing partners, they will be unlimitedly liable for a period beyond 6 months, not for the 6 months. After 6 months, they will be unlimitedly liable. Wind up is a may. They may order for dissolution. Now imagine you go for dissolution. Your liability is there, you need to repay the debt. Now that time can you say your liability is limited, or you can say your liability is unlimited?
That 6 months is unlimited.
For that 6 months is unlimited. After that
We will go for a disappointment, right?
After that, it's going for winding up. Now you need to pay. At that point of time, you tell me, it's limited or unlimited?
Unlimited.
Remember that 6 months it is limited, because that is a time period you have to increase. That is given by the law only. Why is it unlimited that time? If you do not add another partner in that 6 months, from the 7th month it is unlimited. So imagine in 7th month if it goes for dissolution, that time your liability will be considered as unlimited, not limited. But for the 6 months, your liability is limited only, because it is given to you by law as a time. Hello? Okay. Designated partner, how many should be resident in India? At least 1. Resident means a person who has stayed in India at least for in the which financial year? Previous or current?
Current financial. Previous.
Huh?
It's a current, yes.
Current year? Huh?
Previous. Current financial.
Which year?
Previous.
Andre? Current financial year. OPC? Previous year. Remember da macha? Yake sir? Why? Can't they keep it 1? Why sir? 2, 3 problems. Okay. Incorporation of LLP. How do we incorporate LLP, people? Which form we file? Philip. Form for incorporating limited liability partnership. That's the incorporation form you file. Again, I'll tell you, it's called Form Philip. Form of incorporating limited liability partnership. Form Philip. Clear? Okay. Along with this, you will file all the details of partnership details, contribution, what they are into, the details of partners, details of designated partners, and all the details. You will file everything with registrar of company, registrar of LLP, registrar of companies only. You will file registrar of company. You will file everything. If all the details are fine, registrar of company will issue certificate of incorporation. From that day, you will mandatorily use the words LLP in your name. Certificate of registration. You can say certificate of registration or incorporation. So that will be issued by the registrar of companies. From that day, it is a conclusive evidence. Should a LLP have a common seal? Remember, common seal of LLP is also optional. Can a company be a partner in LLP?
Yes.
Can two companies be partner in LLP? Two companies, can they be a partner in LLP?
Yes, sir.
Meaning Infosys and Reliance together will start one LLP. Is it possible?
Yes,
No.
sir. Yes, sir.
So designated partner should be there. So there should be one individual. So can only two companies start a LLP? So today it is possible. 2022, there was an amendment. We have written in the book also. When two companies are partners, you will nominate or authorize a person as a nominee who will act as a designated partner. Earlier it was not possible. One individual should have been there. But today you can. Only two companies can become partners by nominating one of their representatives as an authorized person. Now they will act as a designated partner. Possible. What is the role of a designated partner? Legal compliances, your financial, taxation, anything with regards to compliances will be taken care by the designated partner. Any penalty will be on them. It's clear? 100%. Can you appoint a foreign partner? LLP. Can you foreign person as a partner? Foreigner can be a partner? No, he is residing outside only. Trump can be a partner? Trump cannot be. Okay. Any random person. Imagine Tom Cruise. Can he be a partner? Tom Cruise can be a partner? Some foreigner. Foreigner can be a partner? Yes? Can a foreigner be a partner in partnership? Not in LLP. Other than that, what is there in that? Can a foreigner be a partner in partnership firm?
No. Yes. No.
Why not? Remember people, in LLP, a foreigner can be a partner. In partnership, a foreigner cannot be a partner. In a partnership, we do not allow it. It is only for Indians. Indian Partnership Act is only for Indians. One of the difference between LLP and partnership. In LLP, a foreigner can be a partner. LLP. Hello?
Yes, sir.
Alright,
Yes, sir.
but yes, you need to pay attention to alien enemies and all that. Yes? Say, who are our alien enemies? Akbutavana. Papa. Now there is no one you should say. Henilla. Okay. Clear? Okay. Can a foreigner be a designated partner?
No, sir.
Try give it a question. No?
Yes, we wait,
Can a foreigner be a designated partner?
Yes, sir.
Yes? Possible? 100%. What's the doubt in that? Agreed or not? Chetan. Can a foreigner be a designated partner? Obviously, right? So remember, one okay. Both cannot be. One person should be a resident. Now my question, can two designated partners also be foreign citizens? At least one should be. I am asking one question. Can two designated partners be foreign citizens?
No, sir.
Yes.
I am asking, can two designated partners be foreign citizens? You tell me the answer.
Yes.
Yes. Can
Problem.
two designated partners be foreign citizens? Both the designated partners? Or any one? Any one, but not both. Because one person should be. Remember people, both the partners can be foreigners. Sir, listen. When a foreigner who is a citizen of foreign country stays in India, you will call him as a resident in India. Citizenship and residency are different. Example alla, Priyanka Chopra, is she a foreigner or is she an Indian?
Foreigner.
Sir, she married him, no sir, foreigner only. So remember, she is an Indian citizen staying abroad. So you will consider her as an NRI. Now even Priyanka Chopra will not fit in our condition. She is not resident in India. Are you getting the point? Citizenship is irrelevant. She can stay abroad. She can still be an Indian citizen. That is possible. You are all Indian students. They are Indian citizens going and studying for 3, 5, 6 years. Yes, same way also possible. Other way around. A person can be a foreigner. He can be staying in India. Possible. Yes? Hello? Pakka? Okay. Registration of any changes in partners. Imagine change in details of the partners. For example, name of change of name. Now you become Gopal. Now you need to intimate the details to partnership LLP. You need to intimate that I am going forward Gopal to LLP. LLP needs to intimate it to registrar. Clear? This is change in your details. Next one, people, change of partner only. Gopal comes out, Tiger comes in. Now Tiger becomes the incoming partner. Again, within 30 days, you need to intimate it to ROC. Now, whenever you think that ROC, I will intimate LLP. What if LLP does not intimate to registrar? To avoid risk, you also have a choice of you personally intimating registrar as well. It is your choice. If you think that the registrar will not be intimated by LLP, you only intimate. Easiest way. Clear? If partner believes that LLP shall not forward to ROC, partner can directly forward the information to ROC. ROC shall confirm with LLP and gives 15 days to respond. Failure to reply will be deemed as approval. What do you mean by that? Imagine now Gopal says, I am leaving this LLP. I am no longer this partner in LLP. He told that. Mia. Mia. Yes, sir. So, if at all he cannot, then people, if I think, because imagine, outgoing partner, if my name is still reflecting in registrar's details, I'll be liable to the world. Now, if Gopal does not want that to happen, Gopal can intimate it to registrar. Clear? Yes, sir. Okay, done. Next one, sir, 30 days, same thing. Incoming partner, outgoing partner. Both has to be intimated to registrar. Remember, when you're writing in the exam, don't write it as registrar of companies and all. Write it just as registrar. Clear? In reality, it is registrar of companies who is taking care. Never write shortcuts. ROC, all that don't write. You are supposed to write it as registrar. MOA don't write. Write it memorandum of association. Sir, imagine in an answer, if MOA is coming 4-5 times, then how do we write? In the first paragraph, write it as memorandum of association. In the first paragraph, you write and write it as MOA. And in that answer, you are free to use MOA. Because you have clearly given an instruction, memorandum of association means MOA. Now this is okay. This is acceptable. One more common mistake people will do. Do not use shortcuts. Agreed? Hello? Okay. That's your LLP? Okay. You tell me, if you guys can sit, we'll do off negotiable instruments also. Food Nindon in food. Bandit ivattu PG ga. Not even one day. He is telling the food will be over. Papa, what should they all say? What time your lunch is generally? Your PG? You guys tell me, if you PG people, if you guys want to go and have food problem, let's go and come. If you guys can sit, it will take another 40 minutes. We'll finish it off. Okay? No problem? All of you? We'll start off? Yes, sir. Okay, done. We'll start off. Negotiable Instrument Act, sir. What is a negotiable instrument, people? People, negotiable instrument is not defined at all. But what are the types of negotiable instruments are defined? Now you can tell there are bill of exchange, promissory note, checks. So what do you mean by the word negotiation? Transferability. Negotiation means transfer. So an instrument which can be transferred any number of times up to the date of maturity is called as negotiable instrument. Negotiable instrument characteristics, it has to be written. See, according to Indian Contract Act, even oral is also valid. But according to negotiable instrument, it has to be written. People, essential elements not given under section 10. It has to be following any other legal compliances, other acts. We saw example, insurance. Other acts, negotiable instrument. It says contract here should be in written. It should be in written. I hope you are able to understand. Okay. So it should be in writing. It should be signed. Next one, freely transferable. No restriction. Unconditional promise. There should not be any conditions attached. If you get married, I'll pay you money. It's conditional. Uncertain event, no. Unconditional, it is uncertain only, right? Marriage is not a certain thing, right? To whomsoever. Marriage is an uncertain event only, no? What, Chirag? Man, you may or ask Salman Khan. Marriage is uncertain event only. May or may not happen. So that's why remember it comes under uncertain event. If a person says, I will give you 1 lakh rupees after you get married, is this negotiable instrument valid? The answer is no. It's an uncertain event. Any certain event is okay. I'll pay you 1 lakh rupees by tomorrow sunset. Sun will set. It's an yes sir. Now I'll pay you 1 lakh rupees when RCB wins. No controversy. Edit. To pay money only. It cannot be kind. Instrument. Cup nam dai. Instrument must be delivered. I need to make the instrument. I have to give it to the other party. I only cannot hold it. Essential characteristics of negotiable instrument. Okay, next one, people, is promissory note. The first instrument. What is a promissory note? It is an unconditional undertaking. Someone is telling, promise, I'll give you money. They will give money. Okay. In the promissory note, there are two parties. One is called as maker. One is called as payee. One is called as debtor. One is called as creditor. Who will draw the instrument in promissory note? Maker. In the bill of exchange?
Sir,
Drawer. Drawer will draw the instrument. He will give it to drawee. Drawee will only keep it? No. Drawee will see it and sign it. Once he signs it, what is he called as? Once he's, your answer is right, my question only is wrong. Okay, I'm sorry. My question is, once he sees it and he signs it, what is he called as? He's saying great on it. And then throw it. Okay, what is he called? Acceptor. And you will return it. Now who will get the money? Accepting. Gopal, what is your name? Ishwar. Why Gopal? You keep a name to him.
Yes.
What is the name? Sabu. Sambu.
Sabu.
Sabu. Sabu means? Sabu.
Yes.
Sabu only, right? Why? What do you mean Sabu?
It's a short form of sabari.
Sabari. Sabari means? Gottilla. Okay. Okay. Now understood? Debtor and creditor. Characteristics of promissory note. In writing, promise only a stamp. What do you mean stamp? Put in the stamp. Revenue stamp. You need to affix it. It's a revenue to the government. Maker and payee to be certain and different person. Remember, you cannot use the word payable to bearer instrument. Bearer cannot be used directly. That right is reserved only by RBI and central government. Okay. Next one, people, bill of exchanges. Meaning, people, it's an unconditional order. Remember, order. That is unconditional undertaking. Someone is promising. Here, someone is ordering you to pay. That's why drawer draws the instrument. It's a condition he is imposing on the drawee. I am ordering you. By drawing, I am saying. That's why it's an unconditional order imposed by one person on the other party to make the payment to him or to the order he tells. So if I tell you to pay to me, you pay it to me. Or I will say pay to Mr. D, pay to Mr. D, pay to Mr. E. You need to pay to Mr. E as the case may be. Okay. Next one, parties. Parties are called as drawer who draws the instrument. Generally the creditor. Drawee. The person basically the debtor or the person who must pay. Payee entitled for money. Payee and drawer can be one and the same or can be different as well. Acceptor, the person when he imposes a condition. Who imposes? Drawee. I will tell, hey drawer, I don't know what you have drawn. I have to see the conditions. You please show me the instrument. I will accept only from that day the instrument will be valid. When I say that, I will be called as an acceptor. Acceptor for honor means surety. Someone comes and pay the money on your behalf is called as acceptor for honor. Characteristics same as promissory note. We have something called as holder in due course. What do you mean by holder in due course? A person who has got the instrument in his name before maturity period for a particular consideration and good faith. A person who has earned the instrument. A person who has earned the instrument is called as holder in due course. Everyone will earn the instrument only, no? Few people will get it free of cost also. Example, gift. You can get an instrument by gift also. I'll gift you a check of say 10,000 rupees. Did you earn it? No. You will not be called as holder in due course. In another example, imagine there was a check in home. A person passed away. His legal representative will be entitled for that money. Yes or no? Now did he earn it? No. Inheritance. Inheritance is not holder in due course. Getting? You will all be called as holders. Yes? Hello? Okay. Next one. Privileges. Characteristics of negotiable instrument. Okay. Based on parties. Classification of negotiable instrument. Based on parties, the instrument can be classified into bearer instrument, order instrument. What do you mean by bearer? Anyone who has the instrument will get the money. It is what type of instrument this is called? What type of title? What type of title? Document of title, document showing title. Remember, bearer instrument is document of title. Order instrument, document showing title. Whoever has the instrument will get the money. Bearer, who should be entitled for money, his name will be written. Order showing title, document showing title. Understood? Yes. Okay. Next one, based on validity. The instrument can be inchoate, ambiguous. Inchoate means what? Incomplete instrument. What do you mean by incomplete? The details of the amount is left blank. Is called as inchoate. Now, all the instruments has to be stamped. Agreed? Yes. What is the difference between holder and holder for value or holder in due course in the case of inchoate instrument? In the case of inchoate instrument, if you are a normal holder, you cannot recover the money more than what was agreed in the contract. If you are a holder for value, meaning holder in due course, you can recover money up to the stamp duty paid. Very, very important. You can expect a question there. Next one, ambiguous instrument, meaning confusing. It's a instrument which can be treated as bill of exchange also, promissory note also. Remember, once you treat it in one way, you cannot later on treat it the other way. It is always at the option of the holder. However you want, you can treat it. Next one, people, based on place, the instrument can be inland or foreign. Inland instrument, remember one you remember and go da. This is again they will ask a question. One you remember and go. What do you say? What is an inland instrument? An instrument which is drawn in India. The first condition, mandatory. Now what if it is outside? That's all. It becomes a foreign instrument. Yes? Okay. An instrument that is drawn in India, and in these two, any one condition to be satisfied. In these two, the up one is mandatory. Agreed?
Yes, sir.
Okay. An instrument which is payable in India, meaning where should I come and collect the money? It should be in India. Or the drawee, the person making the payment should be in India. So payment should be in India, or a person making the payment should be in India. Any one condition to be satisfied. If it's the case, then people it will be called as inland instrument, meaning Indian instrument. Now let us imagine a instrument drawn in India. Where is it payable? It is payable in, say for example, New Zealand. Where does drawee reside? Drawee resides in Canada. What type of instrument it is? Foreign instrument. Clear? So key, remember one thing and go. Other thing is easy to answer. Clear? All of you? Okay. Foreign instrument is regulated by the law of place where the instrument is made payable. Where the instrument is made. If a bill is endorsed, the law of place where instrument is made payable will apply. What do you mean by that? Let us imagine, sir, A and B. Where is the bill drawn? Let us imagine A stays in Canada. Where does B stay? The person who needs to make the payment, where does he stay? Let us imagine he is staying in US. Or let us take, for example, he is staying in Paris. Yes, sir. Now what are you saying, people? By default, a foreign instrument, which law will apply? Wherever the instrument is made, that law will apply. Where is the instrument made? Canada. Now whenever the instrument is endorsed, meaning A is giving it to C. Now where is the, what law will apply? Which rules of, which country's law will apply? They're telling whenever the instrument is endorsed, wherever the instrument is made payable, that law will apply. What do you mean by that? Now C will apply to B to make the payment. Where is the instrument payable? Paris. Now people, Paris laws will apply. Hello? Getting the point? All of you? That's the meaning of it. Okay. Next one, sir, based on time. Demand instrument, time instrument. Demand means what? Whenever I go, I'll ask for money. You need to pay. The names that will be indicated on the instrument will be payable on demand, payable at sight, payable at presentment, as the case may be. Time instrument, a negotiable instrument which is payable after a fixed period, after sight, on special day, on happening of certain event. That is when it will become time instrument. Clear? Hello?
Yes.
Okay. Negotiation of negotiable instrument. If payable to bearer, how will you negotiate? You just have to transfer the instrument from your hand to his hand because it's a bearer instrument. No signature required. If it's an order instrument, how will you transfer? By delivery plus endorsement, meaning you need to sign. Okay. Next one, people. Check. Meaning, people, what is a check? A bill of exchange only. It includes a truncated check as well as check in an electronic form. Truncated check is nothing but you can take it like a scanned check. Yes, sir. Next one, people, check in electronic form. Electronic form means, people, those checks which are signed today in electronic form. Can we do it? Yes. There are something called as digital checks. OTPs will come for you to sign them. So can we do it? Yes. Digital signatures are there. Clear? Business people generally use it. Next one, sir. Types of check. Open check, crossed check. What is open check? Which can be encashed at the counter. You go and give this check in the bank, they will give you cash there only. This is a risky check. If you lose it, whoever gets it will get the money in the counter. What do you mean by crossed check? In a check, on the top you will see two lines. This is called as crossed check. It's an instruction you are giving it to the bank. What is that instruction? Do not give the money in the counter. Directly deposit the account number I have written on the check. Do not pay the money in the counter. It's an instruction you are giving. Customs, remember people, crossed check is one of the best examples for customs. We'll be generally telling no, as per the custom of the trade. So cross check is the best example for custom. Where will you cross the check? Can you, this is where you will cross? Can I cross here? Can I cross here?
No, sir.
Ille, inge. Or can I cross here? Can we? Remember, this is a custom. But nowhere it is written you cannot cross here. You can cross? Yes, you can cross. Then why are we crossing here only? Custom. People are used to it. But today if I cross here, will it be valid? Absolutely valid.
Then it won't be document of right.
Ah, yes. Because you are saying an instrument, you are giving an instruction. Clear? That means what? The money will be credited to the account. So whosoever name is written, only they will get the money. Parties drawer. In a check, who is always a drawee? Always a bank is a drawee in the case of checker. Because bank is the one who always makes the payment, no? Drawee, pay. Pay is what? A beneficiary. Whoever's name is written in the checker. Drawer is a person who tears and gives it. A person who needs to make the payment. Okay, next one, check bounce. Okay, we'll see out the scenario. What is check bounce? Dishonor of a check. So whenever I need to make the payment to someone, I issue a check. In my account there is no money. The person will go and deposit the check in the bank. The bank will say, so sorry sir, this account does not have money. Whatever the bank gives the check back is called as check bounce. You gave it, we are giving it back to you. That's why it is called as check bounce. Logic adu. Just not just that if you drop it, check will bounce. Okay, next one. Because one student asked, why is it called check bounce, sir? Actually, we always think, why, from where did the bounce come? So it's like, you give it, it comes back. That's the logic, huh? Actually, it's a logical question if you say. Then, holder or payee. So the person will go and deposit the check. Correct? Sorry, first where? Drawer is issuing the check for a legally enforceable debt. You know what is the meaning? Legally enforceable debt means, remember, I give a check for your birthday as a gift. When you go and deposit the check, there is no money in the bank. Can you file a check bounce case on me? Why? I only gave. I told him 10,000 rupees. He goes and deposits as a gift, birthday gift. But remember, legally enforceable debt means people, he should have earned it. Gift and all is not earning. Court will not give you a right to fight on something which you got free of cost. So it is not a check bounce. So it will not come under this scenario at all. Hello? Pakka? Okay. See, donation. All of this will not come here. Understood? Okay. Holder or pay. Next one. Holder presents the check to the bank. Within 3 months you need to do. If you do not do it, it becomes a stale check. Check will always have a validity period. The validity period is 3 months. If not, it is always called as a stale check. It's no longer valid. Hello? Yes, okay. Now the bank, if there is money, they will give you money. When the money is not there, what will they do? Check is returned due to insufficiency of funds. It is given back to the holder. Now what will the holder do? The holder give it back to the drawer. He will say, sir, you gave a check, no, that particular check has been dishonored. Within 30 days of getting it from the bank, I need to give it to the drawer. Now, drawer has an option, what? Why to take unnecessary risk? Let me just clear it off here only. So, drawer makes payment within 15 days to holder. There ends the matter. What if he doesn't make the payment even now? The holder will write a complaint to the court. We do not have those courts and all, so ignore. We have until he can write a complaint to the court. Whatever court passes an order, that will be final and valid, and accordingly, you guys will have to pay the money. And remember, negotiable instrument, even check also, all these are compromisable offenses. Meaning you need not, there is jail also if you see. If I say, sir, please, sir, I'll pay off whatever it is with penalty, they will leave you. You can compromise it. These are all civil offenses. Getting the point, I think Saturday's class also we saw some offenses which are, you cannot make a trade of felony. Where did you see that? Opposed to public. What is the word? Stifling of prosecution. You cannot make a trade of felony. Crime, criminal offences cannot be compromised. Clear? Hello. Anything else was there? Anything else in negotiable instrument? When presentment is unnecessary. Keep telling when is presentment unnecessary. Meanwhile, just download the document. When is presentment unnecessary? Da? When? Hello? Oh, see, Arjun sir is also doing bills of exchange only. Yes, da. When is this one unnecessary? Hello? When intentionally prevents? Any other topic you have doubts in negotiable instrument? Huh? Then it's black out. So something happened, Ada? Enguru stuck out. No? What is the difference between negotiable instrument, promissory note, and bill of exchange? One is unconditional undertaking, one is unconditional order. And how many parties? Two, three. Promissory note 2, in bill of exchange 3. Good. And in promissory note it is paid by the maker. Basically the instrument is made by the maker. Here it is always the creditor in bills of exchange. Order bearer. It cannot be made payable to the bearer. One is possible. And
Still in promissory note, there is no acceptance is needed.
Very good. In promissory note, there is no acceptance that is needed. In bill of exchange, a condition can be imposed that acceptance is mandatory. Okay, when presentment is unnecessary. If the maker, drawee or acceptor intentionally prevents the presentment of the instrument. So he is coming, what do you mean by presentment? Presentment can be of two types. You taking the instrument to the other party, presentment can happen two types. One is presentment for acceptance. This can happen only in the case of bill of exchange. Promissory note, this will not come at all. Acceptor will not be there at all, no. Next one, people, presentment for payment. That is, on the date of maturity, I will go and give the bill asking for the money. Presentment for payment can happen both in promissory note as well as bill of exchange. But this will happen only and only in the case of bill of exchange. Now they are telling, I came to present the bill, whether for acceptance or for payment. If you prevent me from accepting it, it is considered as dishonor of a bill. That's what they are telling. If the maker or drawee or acceptor intentionally prevents the presentment of the instrument, we call it as dishonor. Now that other party, whenever I come, even without presentment, you will have to make the payment to me because you prevented me. Next one. If the instrument being payable at his place of business, he closes such a place on a business day during usual business hours. I came to your place asking for payment. You are closed during business hours without any intimation. That's all. Going forward, presentment is exempted. Now, whenever it is, even me without presenting the bill, you will have to make the payment to me. Getting the point? Okay. Third scenario. If the instrument being payable at some other specified place, neither he nor any being present goes there. What is it, sir? I clearly told in the class, if you remember, example, you have to come to Imperial Bank of Rangoon. So I am telling you to come to a different place. At that place, at that time I go, he doesn't come. One was your own place. Next one was some other place where you told me to come and collect the money. I went there. You didn't come. Going forward, I am exempted from making the presentment. Whenever it is, I can demand the money from you. Next one, if the instrument not being payable at a specific place, he cannot after due date be found. What is it, sir? I am not able to find you any place. I am not able to find you at all. Then what is this thing? They are telling me that I am exempted from making the presentment. Whereas I go and present, I am not able to find you at all. Next one, as against any party sought to be charged therewith, if he has engaged to pay notwithstanding non-presentment. What do you mean by that? When is presentment unnecessary? The other party is clearly told whether you present or you don't present, I'll make the payment. With such party, you need not present the bill. He has agreed to make the payment irrespective of presentment. Without showing, without you giving the bill also has agreed to present. With such parties, you need not present. Next one, as against any party, if after maturity, with knowledge that the instrument has not been presented, makes a part payment. What is that? Now, for example, I had to go and present the bill. I did not present, but the other party still makes a part payment. Meaning the bill is 1 lakh. I did not present. He still gives me 50,000. That means what? You have agreed to make the payment without presentment. Now, presentment becomes unnecessary for the rest of the 50,000 as well. Second one, or promises to pay the amount in whole or in part. I said I don't have a bill. He promised to pay even without presentment. He didn't pay now. He promised to pay. Now presentment becomes unnecessary. I hope you are understanding what I mean by presentment. I am not giving the bill. I am still getting the payment. Third one, or otherwise waives his right to take advantage. I came. I said I stood in the queue. When I came, he immediately knew my amount. He gave it. He did not ask for acknowledgement. Meaning he did not ask for the bill. It's nothing but implied. He did not demand for the bill. As against the drawer, if the drawer could not suffer damage from the want of such presentment. What is this, sir? Now, whenever bank dishonored, check bounce happened. People remember, check bounce means I know that my account does not have money. If bank did not pay me the money, what did we do in our case? If bank did not make the payment, what did we do here? Check returned. What is a holder doing? Where is he going? Drawer. Now the question is, should I take the instrument to the drawer? They are telling, don't you think you only know that your account does not have money? Then why should I again come and tell you? They're telling in a case where for a drawer, it does not make difference whether you tell or you do not tell, because he knows. You do not know whether your account has money or not. So in this case, it will not make any difference. In such case, they are telling you presentment is unnecessary because drawer knows that this particular instance has already happened. Getting this point? Okay. Yes, sir. That's the last part. Any doubt there? Rule of compensation we'll see of important I can ask you. Rule of compensation. What is rule of compensation, sir? If at all a negotiable instrument is not paid on time, what and all I am entitled to? The first one, the holder is entitled to the amount due upon the instrument. I'll get the, imagine in the instrument it is written as 1 lakh. I will get 1 lakh. If you had paid me here only, it would have been 1 lakh. You did not pay here. We went to court. I had to appoint a lawyer. Then you also have to pay me the legal expenses, noting charges and all we would have seen. Basically nothing but you can imagine like legal expenses. So along with the instrument value 1 lakh, whatever is my legal expenses, court fees, lawyer charges, I can recover everything from you because you did not pay it easily. It became a case now. Next one, when the person charged resides at a different place. Now what is that? Now you have to pay me 1 lakh rupees. Now where are you? Who are you? Drawee. Where are you? From where are you making the payment? Now when we entered into an instrument, you were in India. Now today you went to US. Now where are you? In US. You are telling I will send you the money, but for that I cannot come. Do one thing, I will send you in dollars. Is it okay? I said okay. But you need to make sure I need to get 1 lakh. You need to send me so many dollars so that after conversion, there will be conversion difference. You need to send me so much money that I will receive 1 lakh rupees here. Because there will be forex losses. Now the question is, what date I need to take conversion? Current exchange rate. When I took the loan, probably $1 is equal to 82 rupees. Today it is 86 rupees. Should I do as per this or should I do as per this? They're telling should I do as per 86 rupees. That means do 1 lakh divided by 86. You will get some number. Correct? So many dollars you need to send from US. So that I will get 1 lakh rupees in India. Apart from that, there will be lot markup charges, GST, all that it is your responsibility to take care. I will not give it in my 1 lakh. You send extra. My account should be credited with 1 lakh. Apart from charges, so commission, all that will come. We call it as markup charges and all. That and all you should only take care. Getting it? Okay. Third one, an endorser who being liable has paid the amount due on the same is entitled to amount so paid with interest at the rate of 18% per annum. So what does that in short I am telling? I can recover the money along with interest at the rate of 18% per annum. Actually, if you want to know it in detail, A endorsed it to C endorsed it to D. D went and asked money from B. B didn't pay. Correct? Bill is called dishonored. Now where will D go?
C.
D will go to C. Now obviously C has to show his face to D. C will make the payment. Now what will C do? Ask the payment from A. Now you immediately give, I'm happy. If you do not immediately give, I can recover the money at the rate of 18% per annum. That is, if you give me after 9 months, 5 months, I will take it proportionately. Understood? Hello? Not only money, 1 lakh plus interest. Vodafone case. Next one, when the person has charged and such endorser resides at a different place, same thing. I am recovering money from A. Where is A? A is in US. Same thing, current dollars. Same rule will apply. Last one, the party entitled to compensation must draw a bill upon the party liable to compensate him payable at sign or demand for the amount due to him together with all expenses properly incurred by him. Now what is that? A needs to give money to C, no. I can tell I will give it to you after 5 months. Is it okay? C can say it's okay, but you give me after 5 months. Now what is the guarantee that you will give? Do one thing for whatever money you need to give. 1 lakh plus for 5 months interest, add one 3000 rupees plus B did not pay. I had to incur some legal charges. You add that also 2000. Everything put together, you have to draw a new bill so that I will have some evidence tomorrow to go to the court. So can I enter into a new bill? Yes, possible, which will act as an evidence for this recovery. So immediately you get it paid. If not, at least get a bill so that tomorrow you can fight in the court for your money. I hope you understood. All of you? Pakka? So that is your negotiable instrument. So this is your Indian contract act. You know the negotiable instrument, and I think we complete your law. Yes, sir. Okay, I hope it was a quick revision. We'll go for a quick break. We'll come and take up your recent RTP and MTP, and I request you to go and search on YouTube past papers, past MTPs, everything is there on YouTube. Just to casually sit and watch. Yes, the more questions you see, the more is the eligibility of you to take up the exam. Clear? Okay, after the break we'll discuss on how to present our answer, how to do all those things. How much break time?
1 hour.
Okay, done. Back. All of you? Yes? Okay, let's take up a paper that is Jan paper, Jan 2025. Where is the remote? Huh? Where is the remote? Wait, turned off. Why? This is cold. Increase the temperature or decrease the fan speed. Increase the temperature or decrease the fans. If that is not off, it will go to one person. ನೀನು ಸುಮ್ಮನೆ ಕಾಂಟ್ರವರ್ಸಿ ಮಾಡ್ತೀಯಾ ಅಂದ್ರೆ ಹಿಂಗಿಡ್ಲ ಓಕೆ yes people, let's start Jan MTP paper. And how will the paper look? Question number 1 is compulsory. That's how your paper also looks. Answer any 4 questions from the remaining 5 questions. So question number 1 is compulsory. So always remember, whenever you are attempting a paper, make sure your first question, should I write always a first question only? You can write in any order. But remember, whichever is the first question you are writing, let it be the most confident question. And you can write it in any order. But always try to take up a paper, take up a question. Once you take up, imagine third question. You have to write all the sub questions under that in one place. And after that, you can go for the next question. Clear? Okay. So let us start the questions. The first one. Mr. A was running an orphanage. His friend Mr. S, a philanthropist, agreed to donate rupees 2 lakh for the treatment of a child who was suffering from cancer. On emergency, Mr. A incurred 1.5 lakh on treatment of child. Now Mr. S refused to pay the money. Whether Mr. A can claim 1.5 lakh from Mr. S with reference to the provisions of Indian Contract Act 1872.
Yes, the 1.5.
So can he recover? Yes. Provision. Payment made by an interested person? Okay, we'll see. Exception to the consideration. Very good. Charity. Charity only, no? I told someone that I'll give you 2 lakh rupees. Now should I give it or not? Now I told you, first one people, whether the liability is taken up or not. Imagine the 1.5 lakh was not incurred. I have a right to deny. I'll say I will not make the payment. That is absolutely fine. I can go back. So in this case, I have agreed to give you up to 2 lakh. He has taken up a payment for 1.5 lakh rupees. Whether I'll be liable? Answer is yes, because the liability is already taken up. Now, how will my answer be written? My answer will be, first, I will start with provision. I will split into 3 parts. The first one will be provision of law. In my provision, I will write down what? What is the I will write the first one. If you guys know the section, write the section. If you do not know the section, then I will be writing as per relevant section. If you do not know, as per the relevant section of Indian Contract Act, I will say as per relevant section of Indian Contract Act 1872, a contract must have quid pro quo, that is give and take. However, this rule has certain exceptions. So general rule is what? Every contract should have consideration involved. But this rule has certain exceptions. That means what? Without consideration also, some contracts are considered as valid. Now you go and see here. Next question the students will have. Sir, should I write all the 3 marks? I mean, for 3 marks, how much should I write? Should I write all the exceptions? Not required. For 3 marks, why so much? So I'll be writing exceptions to quid pro quo. It comes under charity. And I'll say a charity becomes a liability when the other party has taken up a obligation upon the word given by the party. He has undertaken an obligation. Now it becomes a liability on me. I will have to repay. Are you getting the point? Always remember, the provisions can be little lengthy. Explain whatever you know in provision. Now in the facts of the case, the second paragraph will be facts of the case. What do we have to write here? You take up your question only. Try to break the question into 2 points. In the given case, Mr. S, I think, S has promised to undertake 2 lakh rupee as charity, based on which the other party has undertaken obligation of 1.5 lakh. The question in the fact is that, is Mr. S liable? Three points done. My fact has to be very simple. And the last part will be conclusion. My last part has to be conclusion. Now in conclusion, what? Now one more thing. If I have any reference case law, in charity we have seen a case law. Where was this said? If an obligation is taken up, you need to pay. Where is it said? Kedarnath versus Gori Mohammed. That was a case law. I'll write referring to a landmark judgment. Referring to a landmark judgment. That is Kedarnath versus Gori Mohammed. Correct? And the last one will be a conclusion. In conclusion, I will write referring to the facts. Referring to the facts and provision. Now, you don't have to invent the wheel here. Go back. Whatever is given in the question. Mr. S with reference to the provision, where is it? Whether Mr. A can claim 1.5 lakh from Mr. S. My answer will be yes. Yes, Mr. A will be able to claim compensation from Mr. S. So your question will be given there only. You just have to write an answer to that accordingly. Yes or no, true, false. What is that? Tenable, not tenable. They will have asked these words only. You just need to take those words and come here and write it. Getting the point? This is how you need to present. Agreed? Got a fair idea? All of you, if you guys present it this way, then it is very clear. You are telling that what I know, I'm giving it in the paragraph wise. Sir, I'm clearly distributing provision. You just have to find in the first place. Now in this also, remember what is more important. I will write exceptions to quid pro quo. Now wherever I'm writing the word charity, I will underline that. Kedarnath versus Gori Mohammed, underline. Yes, underline. Answer no. Yes or no? And now my answer is complete. Now is when you will get a chance of what? Answering and or getting more on your, if it's a 5 mark question, if it's a 3 mark question, the chance of you getting 4, 5 is more. If you presented it this way. Now if you even refer to, I don't know if you have answer key. Do we have an answer key? So that you will have a comparison, you will know how it is being asked. Got a fair idea now? Yes, sir. Presentation is very important. And did I write any nonsense words and all? Did we use any? No? That's how you need to write. Do not just beat around the bush. Not required, don't write those words. It has to be precise, to the point. How much you write is irrelevant. Now, if you look at it, okay, MTPI, okay, now what are they saying? They have not written provision, facts, conclusion. Let us open it there only, wait. They have not written provision, facts, conclusion at all. Agreed, huh? They've just directly written the answer. Sir, can we write as provision, facts, conclusion? Yes, possible. You can write it. It's okay. You mention it. Provision, facts, conclusion. It's okay. You can write those words. It's okay. Now see what it says. The general rule is that agreement made without consideration is void. Correct? Quid pro quo. Yes or no? However, in the following case, can I say this is provision? However, in the following case, can I say the agreement though made without consideration will be valid and enforceable? Charity, if a promise undertakes a liability or the promise of the person to contribute charity, then the contract shall be valid. Correct? In the instant case, Mr. A can claim 1.5 lakh from yes, sir. If you look at it, provision, conclusion. That's how they are doing it, right? So the other day you were asking, what should we write first? Provision always. If you start anything else, it is not valid at all. It has to be provision. Clear?
Maybe ma'am, we can start from fact of the case.
Go with provision. Yes. I'm just showing you the institute given guideline answer. Yes, it works. Okay, we'll see. Now next question. Let us start working it more. I hope you guys understood. Now tell me only provisions. I don't want that to this. Don't tell me any stories. Tell me provision. Yes or no, that's all. More than sufficient. Mr. L let out his residential house to Mr. M for 50,000 rupees per month for a period of 1 year. According to the rental agreement, electricity bill will be paid by Mr. L, but Mr. L could not pay electricity dues up to 5 months. Due to his financial hardship, the electricity board sent the notice of disconnection if it is not paid within a week's time. To avoid all this, Mr. M paid the electricity bill of 50,000 with penalty. Later on, L refused to reimburse 50,000 and argued that he has paid bill voluntarily because of his own interest. Decide whether, with reference to provisions of Indian Contract Act, whether Mr. M is entitled to be reimbursed by Mr. L. It's a quasi contract. Payment made by a interested person. Now go back. Now see the question. That's how the answer should be. Now again let us see a reference. Correct? You got the provision right? Hello? According to provision?
Previous.
Oh, sorry. According to section 69 of Indian Contract Act, provision a person who is interested in the payment of money which another is bound by law to pay and who therefore pays it is entitled to be reimbursed by the other. In the instant case, Mr. M paid the electricity bill to avoid the disconnection that was pending due to Mr. L's failure to fulfill his contractual obligation. Why this? Logically think, it's a question only, no? And then why did they write? It's a fact. Copy paste. Remember, fact has to be crisp and short. You also know, I also know, Valier also know. You're copying. So don't show your talent there. Yes? Clear? Okay. Where did the point go? Hence, Mr. M is entitled to be reimbursed 50,000 from Mr. L. I would still say, if you write only this much, I would still deduct another 1 mark. Quasi contract is required. Yes, sir. If I am the I'll deduct 1 mark. Clear all of you? Because that is to the extent you guys have to prepare. Hello? Yes, I hope you guys are able to understand. Yes, next question. XYZ Limited was incorporated to hold the patent for a new product. The company is expecting to start its commercial production. We didn't do this in the marathon. Okay. Within the next 2 years. In the meanwhile, for timely installation, the company has placed the purchase order for plant and machinery with a down payment of rupees 1 crore. Referring to the provisions of Companies Act, examine whether the company can go for acquiring the status of dormant company. Can the company apply for dormant status?
Yes, sir.
No.
All of you?
Yes, sir.
No, sir.
Backbenchers, what is happening? Can the company apply for dormant status?
No, sir. Yes, sir. No, sir.
No.
No.
Why can they apply for dormant?
Sir, they can create government company for asset. No, sir.
Definitely in transfer.
They can
Can they apply for dormant status?
no, sir.
Can they apply?
No, sir.
Why can't they apply? Hello? Can they apply? Can they not apply?
Sir, they can apply.
Ira,
No, sir.
can they apply or can they not apply? What is dormant company? Okay. A dormant company is basically an inactive company. What do you mean by inactive company? A company in which there is no operations being carried forward. Meaning legally it is existing, but there are no operations in it. Now what happens in our country, the moment you are called as a company, you are expected to do some compliances like doing your audit, filing returns, conducting board meetings. Because you are a company, you have to do. But if you are a dormant company, you will get some exemptions. Dormant means what? Inactive. We are not doing anything. That's why the law allows you some exemptions. So compliances will be little free. For example, if a normal company conducts 4 meetings in a year, a dormant company will just conduct 2 meetings in a year. So they will give you a lot of exemptions. Yes. Can this be a dormant company, Ada? Can this it?
No, sir. Yes, sir. They can create company for holding assets also.
No.
Correct. Now can they?
Yes, sir. No, sir.
No.
Yes, sir.
Okay, da. They can create a company for holding the assets.
Yes, sir.
Okay. Now,
Plastic machine is also assets.
can they spend money?
No, sir. For holding purpose they can.
Now this one, who I will read?
Yes. Holding purpose.
You thought wrong. That's what I'm saying. In exam mode, don't read questions in isolation. I told you how to read the question. Do not just pick up one word. You have to read the whole question. Yes, for holding a future asset. Possible, yes. But the payment is still pending. They are telling down payment of 1 crore. What about the rest of the payments? And it's a huge transaction you have made. And you should have acquired in the past. Payments are done. You can continue to hold them. That's the meaning. What do you mean by that? Let us imagine in the year 1, I acquired some land. After 2 years, we want to get into dormant status. Now, can I continue to hold land or should I sell it off? I can continue to hold. That's the meaning of holding a future asset. Got it? Now, can I apply for a dormant status? Answer is no, because there is a significant accounting transaction. Getting the point? Hello? Okay. You want to see the answer? Is it 455 of Companies Act, where a company is formed and registered under this act for a future project or to hold an asset or intellectual property and has no significant accounting transaction. Such company or an inactive company may make an application to register for dormant status. In the instant case, XYZ 1 crore. Again, same facts. Conclusion, therefore, XYZ Limited cannot acquire the status of dormant company because there is significant accounting transaction. Now, in my exam, I am clearly writing, this is my provision, here is my facts, here is my conclusion. By clearly underwriting, underlining, no significant accounting transaction, here I will say cannot acquire. Yes, you try your best to show the valuer, here are the answers, you need not have to read it. That is how much difference underlining will make. Heading it? Hello? Okay, now taka read. Mike LLC incorporated in Singapore, having an office in Pune, India. Analyze whether Mike LLC would be called as a foreign company as per the provisions of Companies Act. Also explain the meaning of foreign company. Incorporated in Singapore, having a office in Pune, India. Will they be called as a foreign company? Yes. A company incorporated outside India, having a place of business in India. They have given way too easily. I feel this is a very easy answer. They could have complicated it by saying online presence or the company is present outside India, but there is a dealer that is working in India on behalf of the foreign company to import products into India. Imagine there is a dealer. That person will become an agent. Now imagine I have a foreign car. I cannot directly buy it in India. There are agents here. Through them you can buy foreign cars, but not directly. Because they do not have physical presence in India. Now, can they be called as foreign company? They will be called as foreign company. There is an airline industry which is incorporated in, Dubai. Now, you are able to access their website in India and you are able to book tickets in India. Now, can I consider them as a foreign company? Electronically present. There is an airline industry who has a tie-up with Make My Trip, an Indian company through which you are able to buy the tickets of a foreign airline. Will they be considered as a foreign company? See, I am telling the different complicated ways of asking the same question. That is when difficulty level I would say is medium. This is Goli, easy. Yes, sir. State the modes by which a partner may transfer his interest in the firm in favor of another person under Indian Partnership Act. What are the rights of such transferee? Which today only we saw. How and all I can transfer? I can pledge it. I can even I can sell it. I can transfer it. How and all I can transfer? Imagine I take a loan. I can pledge my share. Second one, I can directly sell it to an outsider. And what are the rights of transferee?
Right for entitled profits.
Profits you are entitled, and upon the date of liquidation you are entitled for assets and to receive the books of accounts after the liquidation. Until then you do not have a right to take care of good day-to-day business decisions. You cannot inspect accounts. All those things you do not have. Today only we saw that. Hello? That's the answer. Sony, a friend of Priya, wanted to buy her two-wheeler. Sony, a friend of Priya, wanted to buy her two-wheeler. Okay. Priya agreed to sell her two-wheeler to Sony and it was decided that the price of her two-wheeler will be fixed by Priya's father, who is an auto dealer. Priya immediately handed over the keys to Sony. However, Priya's father refused to fix the price as he did not want Priya to sell her vehicle. Priya expressed her inability to sell the two-wheeler to Sony and asked for return, but Sony refused to return the same. Explain, can Priya take back the vehicle from Sony? Will your answer be different if Priya had not handed over the vehicle to Sony? Yes, people, understood the scenario first? What are we speaking about? All of you were able to understand. First of all, which act it is? 1 second, wait. Now, this is the tricky part. If at all you guys are not, this is where I would say this question is more than medium, a little less than high. Yes, why I would say more than medium? Have they given which act it is? If they have not given which act it is, first thing that hits our brain, is it Indian Contract Act or Sale of Goods Act? If you look at it, it is taking the color of both. You can understand it this way also, you can understand it this way also. Now what is one thing you guys ask, sir, how do we interpret it when it is confusing between two? Now try to look at the words that are used in the question. Based on that, are you able to relate it to any topic? Now let us go back and see those words. A friend of her agreed to sell her two-wheeler, somewhere movable property. Okay, to Sony, it was decided that the price of her two-wheeler will be fixed by Priya's father. Two parties are entering into a contract. The price is decided by a third party. Now, somewhere I can come to Sale of Goods Act, ascertainment of a price. Okay, who is an auto dealer? Priya immediately handed over the keys. Ownership is passed. Symbolic delivery. Correct? Car yesterday we saw. That means ownership is passed. Now go back and see ascertainment of a price. How and all price is ascertained? The first one is by parties. Second one is by course of dealing. Third one is by third party. Third party is supposed to do. Now whenever a third party is not able to derive the price, reasonable price should be paid. That too when the ownership is passed. If ownership is not passed, then you can avoid the contract. Here the ownership is passed. Hello. So what should we do here? She is telling when two parties are there, when third party is not able to derive the price, but the ownership is already passed, can she cancel the contract? The answer is no. Then what will be the answer? Answer would be the party should be paying a reasonable price. Getting the point? The second one, will your answer be different if Priya had not handed over the vehicle to Sony? Yes, the ownership is not yet passed. So the contract can be avoided. Yes, sir. Next one, define OPC. I hope you are able to understand how to present the same thing. Ascertainment of a price. Fixed by the contract, agreed to be fixed. When they have written so much, go back and see the marks. Correct? Now, are you able to get the proportionality concept? 3 marks. They did not care to write even quasi-contract. 7 marks. They could have directly written a third party, right? Getting it? 7 marks. That's why they are giving you a complete background. Hello? So that entire thing has to be written. Define OPC and state the rules regarding its membership. Can it be converted into a non-profit company under section 8 or a private company? Okay, first to OPC, state the rules regarding its membership. Only one member, maximum one member, and one person can be a nominee and a member of not more than one OPC. And who can be a member? They're asking you the rules regarding membership. Indian citizen,
Not less than 120 days.
120 days, resident or otherwise, Natural person. So this will be my membership rules, huh? Hello?
Consent of
Nominee they have asked? Then why? Early answer, sir. Why? Don't make your answers dump yard. Why? I told you. Day one. Logic is you need to be able to write at least 90-95 marks. The more you can just feel one line. But trust me, there are close to 40 questions. So when you're writing one line more, that means you're writing 40 lines more. That means you're writing 1.5 page more. That means that can be just one answer somewhere. It will save you some time. Okay. Can it be converted into a non-profit organization? Answer is no, not possible. Remember, OPC cannot carry on NBFC activity. OPC cannot be converted into a Section 8 company. That's all right. Will you write anything else? Huh? Again, see, if at all your answer ended there, there is another question which we will all miss to see.
yes, sir.
We'll just write off Section 8. Now you will say, exam, trust me, you will write only Section 8 and come back. Pakka. Based on experience, I'm telling you. Out of 100, at least I'm telling you, 80 people will not write answer for Section 8, for private company. Answer is, there are 2-3 questions here. Membership is 1, Section 8 is 1, private is 3. The third one you will be writing, yes, it can convert into a private company whenever it wants, voluntarily possible. Clear? Hello. LLP is a new form of legal business entity with limited liability. It's an alternative corporate business vehicle that only gives the benefits of limited at low compliance cost. Answer either. Allah son. Keeping in view of the above, define the following characteristics. Body corporate. What is a body corporate? What is a body corporate?
Which are legal existence.
Outside foreign.
Companies registered under Companies Act 2013. Companies which are incorporated outside India but having a place of business India, that is foreign company. LLP, foreign LLP will be considered as body corporates. What is mutual agency? A cardinal principle, an act or a power given by the partner to bind the other partners. Remember, in a LLP, mutual agency concept is not present. However, a partner can bind the LLP but not the other partners personally. Hello?
Yes.
Okay. What is foreign LLP? Same. LLP which is incorporated outside India, having a place of business in India. Artificial legal person, a company which is having or considered as a separate legal person who is entitled to hold properties in its own name, have common seal, can sue, be sued. Yes?
Marks, sir. 6 marks, 4 questions.
See, artificial legal person or mutual agency will be less. Body corporate will be more. At least 2 or it can be 3 also. PQ and R formed a partnership agreement to operate motor buses along specific routes for a duration of 12 years. After operating the business for 4 years, it was observed that the business incurred losses each year. Despite this, P is determined to continue the business for the remaining period. Examined with reference to the Indian Partnership Act 1932, can P insist to continue the business? If so, what options are available to Q and R who are reluctant to continue operating the business? So first one, they are asking, examine with reference, can P insist to continue the business? Can he? Yes, possible. He can ask, is it valid? Yes, it is valid, because a partnership is always run with everyone's mutual agreement. Now, do I have a right to ask? The answer is yes. But the question is, what options are available to Q and R? Today only we saw dissolution of partnership by court. In that, one option, what? Perpetual losses or continuous losses. Hello? Pakka, this is how your provision should be picked. Until the time you find perpetual or continuous, you will not get a mark. Hello? This is why I say law is difficult, but that doesn't mean you guys don't know. The time taken for you to nail those words will make the difference. Hello? Don't get tense, don't get anxious and all, it's absolutely fine. It's not the exam date yet, we have time. We can take it up, we can definitely handle it. Hello?
Yes,
But try to take more and more and more questions. Now you see how much you are able to understand the same topic, same logic. Yes? A and B operate a textile merchant business in partnership. Mr. A finances the business and is a sleeping partner. In the regular course of business, B acquires certain fabric goods belonging to C. However, B is aware that these goods are stolen property. Despite this knowledge, B proceeds to purchase and sell some of these stolen goods. Moreover, B records proceeds from these sales in the firm's books. Now, A wants to avoid the liability towards C on the grounds of misconduct by B. In the light of provisions of Indian Partnership Act, discuss the liability of A and B towards C. Is A liable?
Yes.
Yes. Mutual agency people, whatever this person does, the person will be liable. But because it was fraud, A will be liable towards C. But B's duty is to indemnify the firm for the losses occurred. Hello? Pakka? XYZ is a company incorporated in the Companies Act. The paid up share capital of the company is held by Government of India. Lottery. Today only we saw. Should we do it? Should we do it again? Madi sir, ayyo. Yen mat Indian kilsa madi. Okay, what company appa? XYZ. Government of India is holding 20. LIC is holding 8. Tamil Nadu, Rajasthan, ABC Limited is holding 15%. Add everything.
40%.
40%.
Add Government of India. Add this. Add this. 40%. Is it a government company? Answer is no. So as per above, whether XYZ Limited is called a government company under the provisions of Companies Act? Answer is no. So now what will I be writing? I'll be writing government company definition. What do you mean by a government company? A company in which at least 51% of paid up capital is held by central, states, central and state. In the given case, LIC or ABC Limited holding the shares will not be counted towards a company being recognized as a government company. Hence, a company will not be a government company. Hello? M&N holding 70 and 30% of shares in the company. Both died in an accident. Answer with reference to the provision of Companies Act. What will be the legal effect of the company as both members have died? Characteristics of a company, perpetual succession. So you need to write perpetual succession. In that one sentence is there. Members may come and go, company goes on forever. So in this case, the legal representative of the respective shareholders will have a right to continue the company going forward. 3 marks more than sufficient. Clear? Explain in brief with reference to the provisions of Indian Contract Act. What are the rights enjoyed by surety against the creditor, the principal debtor and co-surety? 6 marks. What is that they're asking? Explain brief. Enjoyed by surety against creditor.
If any changes are made, then
Rights enjoyed. Whatever is the set off, whatever is the EMIs he has paid, you have a right to set off and right to collateral. Security against your whatever you received, right to set off your security. I can take security also, I can also claim set off also. What is the right against principal debtor? Subrogation. Implied contract, no. If I have paid money on behalf of you, I have a right to recover it from you, right? Yes or no? Right against co-sureties. One is equally, or if it is not, it will be in the proportion agreed. If not, it will be equally. So I can do all of this from, that will be my rights. Okay. Mr. J entered into an agreement with Mr. S to purchase his house for rupees 20 lakh within 3 months. He also paid rupees 50,000 as token money. In the meanwhile, in an anti-encroachment drive of the local administration, Mr. S's house was demolished. When Mr. J was informed about the incident, he asked for the refund of the token money. Referring to the relevant provisions of Indian Contract Act, state whether Mr. J is entitled to refund of the amount paid. Under subsequent impossibility,
Yes.
void contract, subsequent impossibility, that words has to be there. Yes. Can he recover? Yes. Yesterday only I told you, any benefit you have given must be returned. Will I get it back? Yes. That's okay, you will get it back. Next one. Rama directs Sham to sell laptops for him and agrees to give Sham 11% commission on the sale price fixed by Rama for each laptop. As Government of India put restrictions on import of laptops, Rama thought that the price of laptops might go up in near future and he revokes Sham's authority for any further sale. Correct, huh? Sham, before receiving the letter at his end, sold 5 laptops at the price fixed by Rama. Sham asked for 11% commission on the sale of 5 laptops for 1 lakh each. Explain under the provisions of Indian Contract Act 1872 whether sale of laptops after revoking Sham's authority is binding on Rama, whether Sham will be able to recover his commission from Rama. If yes, what will be the amount of such commission? What is the provision of law? What is the provision? Revocation of agency. When will agency come to an end? We saw 2 cases. One is revocation of agency from agent point of view, from third party's point of view. When will revocation of agency be effective? When the agent is aware of, when he gets to know the knowledge of revocation. So in this case, what happened? By the time I gave the letter, it reached you, you read, you have already sold 5 laptops. Now, whether this person will be liable to pay the commission, the answer is yes, I will be liable to pay the commission because the agency is not yet revoked until he reads it. Yes, so the first one, will I be liable? Yes, I will be liable. What is the amount? For 11% commission on the sale of 5 laptops for 1 lakh rupees each. Then it will be 55,000. You need to write 55,000 is a commission that needs to be paid. 5 lakh into 11%. He will be liable. Clear? Hello? What are the inchoate and ambiguous instrument? Today only we saw. Inchoate means incomplete. Ambiguous means
We can treat it as a promissory or bill of exchange.
it can be treated as promissory note or bill of exchange. Okay. 7 marks lottery. Direct answer, huh? You need to write full. Yes,
If we don't remember the definition, will they provide marks?
it will be less. Because now what happens is example cannot be completely acceptable also. And example cannot be defined by the blueprint. Now whatever your valuers are correcting, they will have a blueprint. In that they will have a keyword in it. So your answers has to meet the keyword. Getting the point? Hello? Okay. And I will always tell you, whenever you have a lengthy answer, do not write it in paragraphs. Split it into points.
So while they're asking definition, you want to write the example.
Indian Contract Act, Sale of Goods Act, Partnership Act, Negotiable Instrument. When they're asking you any definition, feel free to write an example. All these. Clear? Okay. Describe in brief about the regulatory bodies of Government of India. Regulatory bodies. See, I told you, you can expect. See, that's what I'm saying. It's a lengthy one. You look at the marks. Now, if you look at it, where is proportionality? So there is nothing, no hard rule that one page is equal to 5 marks. If your book has that much answer, you are expected to write that much answer. That's how the proportionality works. Getting it? Okay. Ram sells 200 bales of cloth to Sham and sends 100 bales by lorry and 100 bales by railway. Sham receives delivery of 100 bales sent by lorry, but before he receives the delivery of bales sent by railway, he becomes bankrupt. Ram, being still unpaid, stops the goods in transit. The official receiver on Sham's insolvency claims the goods. Decide the case with reference to the provisions of Sale of Goods Act 1930. Right to stoppage in transit. Okay, can I stop?
So, but his receiver
No, sir.
So out of 200 people, 100 is already delivered. 100 is on the way. They're asking, can I exercise stoppage and transit for this 100?
No, sir.
No, sir, because his
He
official
received
receiver has got it.
Official.
His official receiver is
Official receiver.
Received.
Taken the goods.
So you can't exercise.
No, see, 100 bales by lorry, 100 bales by railway.
For 100 is a reasonable, another 100 he can.
Sham receives delivery of 100 bales sent by lorry, but before he receives delivery of bales sent by railway, he becomes bankrupt. Ram, being still unpaid, stops the goods in transit. The official receiver on Sham's insolvency claims the goods. Meaning what? He's asking, you have to give that 100 also. What is happening? You understood? One person has become an insolvent. Court has appointed a liquidator. That liquidator is telling all the properties that belongs to this person. Oh, Sham. 100 which is already there, he is claiming it. 100 which is on the way, he is claiming that also. They are asking you, can he claim whatever is on the way? 100.
unpaid, sir.
Sir, Rabbit have rights to stop it.
You don't have?
He has
He has the ownership.
It can be
Ownership of the boss.
Is it passed?
Yes, sir. Irrespective of
part
delivery
delivery and not
rights.
being considered.
Irrespective of delivery and price?
Ownership.
So Ram can stop it. Payment is
Sir, I think yes, we can stop.
Remember, the provision here is people. Effect of part delivery. Sir, out of 200, I don't know how do I tell it. In our class, if you remember, part delivery is equal to full delivery. Part delivery is equal to part delivery. You remember that tomato case? If at all I have transferred the ownership, you have taken part, but I have transferred the ownership for full. I cannot exercise the right to stoppage and transit in such case. You're getting that? Right? Part delivery. When part delivery is treated as full delivery, when part delivery is treated as part delivery. I don't know you guys remembering or not. Tomatoes case, that lorry case if you remember. I bring my lorry, space is not there. I'll take only 50% of the tomatoes. You understood that? Okay, in short I will tell you, listen here. You take that classroom example only. There is a buyer who has ordered for 1000 kgs of tomato. He came up with his own vehicle, let us imagine. Now imagine he came up with one auto. He tries loading this tomatoes to his auto. he was able to successfully load 500 kgs. Now the seller has kept the 1000 kgs ready, but the buyer is only able to take a 50%, 500 of it. Now the buyer says, my auto is full, I'll go unload, I'll again come and take the rest of it. Now the seller can tell two things. What? First thing, see da, you told me to get 1000 kgs, I've kept it ready. How much ever you want, you take, but my headache is done. You want take 500, you take 200, you pay me for 1000 and go. Now what am I doing? Even though he is taking only part delivery, out of 1000 he is taking only part, but I am giving the responsibility of full. Correct? If anything happens, I am telling, see, you want, you take 1000 also, you want, you take 300 also, but you asked me 1000, I have kept it 1000 ready. Anything happens to it is your responsibility. It is not mine.
Sir, but you should take reasonable care.
Reasonable care, yes, that is there. Now, I've told this second scenario. I will say, oh, that's all right, it's okay. You take part, I will ship this 500 to someone else. In next 2 days, again tomatoes will come for a harvest. I'll again give it to you. You don't worry, it's okay. I'm telling you, take part only. In the total 1000, you're taking only 500 now. It's okay. You take the responsibility also for a part only. Are you getting the point? Now, even though I've kept 1000 ready, I'm giving the responsibility of only 500. The rest of the 500, I've said I will be responsible. Now, it depends on, in this case, what did the parties treat this particular contract as? Have you treated part delivery as full delivery? Or have you treated part delivery as part delivery? You need to write this answer with an assumption. If part delivery is treated as full delivery, you cannot exercise right to stoppage in transit. If part delivery is treated as part only, you can exercise right to stoppage in transit. Because you gave full responsibility here. Risk also you gave it to him only. If something had happened, he should have borne the risk. Now you cannot say, if the other half is on the way, bring it back. Responsibility was given fully. Now I will bring back fully also. I have that right. Getting the point? This is the thing we had seen in the class. Okay. Next one. Classify the following transactions according to the types of the goods. This one only, no? That's what. See, still unpaid can stop the 100 bales of cotton sent by railway as these goods are still in transit. Now what you'll be writing? You'll be writing the same thing. Part delivery is equal to that's what I'm saying. You are free to assume and write it. You write it. Part delivery is assumed as part delivery. And you can write, yes, for the rest of it, you can exercise right to stoppage in transit. I hope you are able to understand that. Clear? Okay. Next one. Classify the following transactional types of goods. A wholesaler of cotton has 100 bales in his godown. He agrees to sell 50 bales and these bales were selected and set aside. He agrees to sell 50 bales and these bales were selected and set aside. What type? Ascertained goods. First it was unascertained and now after the contract he has agreed to set aside 50. So it is ascertained goods. Next one, A agrees to sell to be 1 packet of sugar out of the lot of 100 packets lying in his shop. Unascertained goods. It is still in the there. I have agreed to segregate. I have not yet done it. Unascertained goods. It is still in the bulk. T agrees to sell to S all the apples which will be produced in his garden this year. Future goods which is not yet existing on the date of the contract. State the circumstances in which a court may, at the suit of the partner, dissolve a partnership firm under the provisions of Indian Partnership Act. Whatever we saw today. Perpetual, a person becoming unsound mind, misconduct, professional or personal, perpetual losses, and what is that?
Illegal transfer of interest.
Transfer of interest. And the last one, just and equitable grounds, deadlock, loss of substratum, speculation. There is one more also. Loss of substratum, deadlock of management. Partners in not talkative terms. Breach of agreement with regards to proportionality of cash holding, yes. In accordance with the provision of Indian Contract Act, answer the following. Rights of bailor against any wrongdoer, duties of the pawnee. Direct one. Referring to the provisions of negotiable instrument, answer the following in the given scenario. Aman drew a bill of exchange on Baban, who accepted it payable to Magan or order. Magan endorsed the bill. Devray. To Gagan. Gagan endorsed it to Akash on the next day. However, on the death of Gagan on the same day, is only son Ankit. Go through and see. Now you only see how you guys will solve in the, look at the names. Whenever there are too many parties, negotiable instrument, all this, take a pencil, go to your answer script, not on question paper. You are not supposed to write anything on question paper. On the answer script, write down parties clearly to avoid any confusion. If not, nazar ati, durgatna gati. Write down and see what they are trying to say. Yenilla. Just give me a moment.
Previous part.
Aman drew the bill of exchange on Baban. Okay. Who accepted it payable to Magan or order. Magan endorsed the bill to Gagan. Gagan endorsed the bill to Akash to be delivered to him on the next day. However, on the death of Gagan, Gagan passed away. On the same day, his only son Ankit delivered the bill of to Akash on the next day as intended by his deceased father. On presenting the bill on the due date, Baban refused to pay, explaining the importance of delivery negotiation. Decide whether Akash can enforce the payment of bill against Baban or the previous parties. Can he do Possible,
Yes,
Hello?
yes,
Can he?
yes.
Remember one thing, people. In a negotiation, two things are important. Transfer. Now, because it is the order instrument, how do you transfer a negotiable instrument? It is to be delivered plus it has to be signed. In our case, Gagan has signed the instrument. But did he deliver the instrument? Now, whenever he is did not deliver, that means, people, the transfer was not valid. Now the question is, whenever a person passes away, can his legal representative deliver the instrument on their behalf? Is that valid?
Yes, sir.
Now Gagan had to deliver. Gagan didn't deliver. His son Akash delivered it to some other party. Correct? Akil delivered, is it? Ankit delivered to Akash. Now the question is, can this delivery happen? Is it valid? Is it valid? Valid? Remember, people, whenever delivery is done by one person, sign is done by one person. This is not valid. It is not valid. It is there in a negotiable instrument only. Remember, whenever a person passes away and the instrument is signed, by just mere delivery, a legal representative cannot pass on the agreement. It is not a valid transfer. Then what would be a valid transfer? You have to sign it. Once you get the inheritance, because it becomes part of your assets, you sign the instrument, you deliver it. But you cannot deliver a father instrument. Now, what is a guarantee? What is authenticity? So, law does not accept it. Now, is it a valid transfer? The answer is It's not a valid transfer. Can you recover? The answer is no, because the transfer itself is invalid. Getting the point? Hello? Which one, da? Importance of delivery. Delivery of an instrument is essential. Payable to bearer or order. Delivery must be voluntary, and the object of delivery should be to pass the property. Okay, then, actually it takes place. Okay. Section 46 lays down that instrument is conditional for a special purpose only. The property in it does not pass to the transferee even though it is endorsed to him unless the instrument is negotiated to him in the due course. The contract until delivery remains incomplete and revocable. Delivery is essential not only at the time of negotiation but also at the time of making. Understood? Mere delivery by a legal representative is not a valid transfer. You cannot do it like that. Someone signing, someone delivering will not give a valid right. When is a transfer complete? When signature and voluntary transfer is done by the same person. Death gives a thought to what has happened. Why is it has happened? So it is not a valid transfer. You are seeing signature here. What if I put thumbprint there? Suspicious, no? Thumbprint, is it valid? A illiterate, how will they sign? Thumbprint, no? Hello? Understood? So that's the answer. No. Akash cannot. Because the transfer itself is invalid. Is this clear? Okay. Question was a little tough only. Reliable Limited, an Indian company, is a global leader in petrochemical products. For payment of sale price of machinery imported from Alex Manufacturing Limited, a US based company, the Indian company drew a bill of exchange on Manish, a resident of Mumbai, who accepted the bill at Mumbai payable to the exporter in Los Angeles. Decide whether the bill of exchange is an inland instrument or a foreign instrument. Assume that the bill of exchange was signed by the authorized person for the drawer company. Now, when will it be called as an inland instrument? First one, it should be drawn in India. Should have they given?
Yes.
The Indian company drew a bill. Indian company drew a bill. Where will Indian company be? India only. Yes, sir. Someone was asking, sir, they have not given the place. No. On Manish, a resident of Mumbai. On him it was drawn. A resident of Mumbai. Who accepted the bill at Mumbai. So, male one condition satisfied. There should be two. In this, one condition is satisfied. What type of instrument? Inland instrument. Correct? Children question. Answer the following as per the provision of Indian Contract Act. Agent cannot personally enforce nor be personally bound by contracts on behalf of principal. However, there are some exceptions to this rule. What is it? Agent exceeds pretended agent. Agent exceeds the scope. Foreign principal. Same thing. Correct? Direct question. State rights of indemnity holder when sued. Yesterday I told you. They will ask you also this question. What are the rights of indemnity holder? That is when I explain you my case also. One is whatever is the amount in the contract plus legal charges plus compensation anything. Mental trauma. What is the meaning of contingent contract? Right, belief leads essentials. What is it? Rules. Contingent contract, you write that rules. Ship. When can you exercise the? I think in the class, what example I gave now? No, today I think guarantee. One I gave you insurance contract. One I gave you enforceable on happening of an event, enforceable on non-happening of an event. J, a wholesaler of premium basmati rice delivered on approval 100 bags of rice of 10 kg each to a local retailer on sale or return basis within a month of delivery. The next day, The retailer sold 5 bags of rice to a regular customer, K. A week later, K informed the retailer that the quality of rice was not as per the price. The retailer now wants to return all the rice bags to J, including the 4 bags not used by K. Can the retailer do so? Also briefly discuss the provisions underlying in this context of Sale of Goods Act 1930. What is it? He can return the 4 bags. Hello, everyone? What is it? A wholesale of premium basmati rice delivered on approval 100 bags of rice of 10 kg each to a local retailer on sale or return basis within a month of delivery. The next day, the retailer sold 5 bags of rice to a regular customer K. A week later, K informed retailer that the quality of rice was not as per the price. The retailer now wants to return all the rice bags, including the 4 bags not used by K. Can the retailer do so?
No, sir.
Because it's specific.
So the ownership is passed to the retailers.
When he say
For 5 bags, you can return 5 bags.
So say that he can't present like intended.
Mm-hmm.
Ownership is passed.
See, on an ideal day, when everything is fine, the ownership is passed. In this case, they are telling sale or return basis, ownership passes when you do something equivalent to an acceptance. That's all they give there. But have they answered about the price and the deficiency in quality? Don't you think that also comes under description?
Premium basmati description.
sale of
Premium basmati description only, sir.
That's what I'm saying. Description is not met. That also we should take care. You guys are seeing sale or return basis. Whether that is right, answer is yes. Now I'm saying here they are telling what? Inform that retailer that the quality of rice was not as per the price. That means what? You have told me premium basmati rice and you have given me something else. You have described it as premium basmati rice. You have given me something else. On those grounds, can I return? Yes, that's what I'm saying. We need to think on both the grounds. One, yes, acceptance, what you said, that is also right. But this is also right only, Description. Description is not met. Yes or no? See once. Where is it? In the given case, delivered on approval 100 bags of rice, 10 kg each, sale or return basis, mandatory, 4 5 bags. It implies that the local retailer has accepted 5 bags. Perfect, sale or return basis. A week later, local retailer received a complaint of some defect. According to the above provision, the local retailer is entitled to return only 95 bags and not those 4 bags which are not used by K. Because as per clause 1, above the local retailer has already sold 5 bags, signifying that he has done an act which implies adopting the transaction relating to those 5 bags. You can write sale or return basis 100% right. But if you can write assumption, if at all it includes basmati rice, description, sale by description, I would still say this is valid only. Can I return? The answer is yes. Yes or no? Exactly right. Now if at all they had given me sample, that means have I checked or not, that will come into picture. Now you have given me bags. Description only, Meaning I have not seen the rice. You have sold me by description, not by sample. Andre, you have not, ನಾನು ಯಾವುದೋ ಒಂದು ರೈಸ್ ನೋಡಿ ಸೆಲೆಕ್ಟ್ ಮಾಡಿಲ್ಲ. You have said it's a premium rice. Believing that word I have purchased. Remember, that is also one point that can be connected. Getting the point? Illa. See, simple. I have told I am selling you a premium basmati rice. You have not achieved the premium basmati rice. You have given me some local rice. Agreed? Now, according to chapter 2, which says stipulation, implied condition, implied warranty, sale by description. When description is not met, what is the right I have? What is the right I have? I can cancel the contract, claim compensation. Now I have purchased. He is telling I am returning. Now the answer is telling 95 bags is you can successfully return. That means can I say you are accepting that the product was not as per description? Yes. Now what about the 4 bags with me also? That is also not as per description. Now can I return it? Answer is yes. You can return. What is the grounds? That's what I'm saying. Sale or return basis, that is 100% right. But I'm saying there is a scope for sale by description also. When you sell a product saying it's basmati, it has to be basmati. Are you getting it? I don't know if I told it in your class or previous class. According to me, they have to mention that also. They just spoke on one ground, they said it is valid, not valid, on sale or return basis. But sale or return basis, you can also sell basmati rice. That means you need to see both the grounds. One is you need to see sale or return basis as well as sale by description also. You need to satisfy this, you need to satisfy this also. Yes or no? Hello? But yes, institute has taken a point that sale or return basis, it's a 5 bags. But I am saying when you say premium basmati rice, there is a scope for us to even think about description also. Sale by description can also be thought of. Getting the point? Hello? And my ground will be sale by description, not sale or return basis. When you guys are writing based on sale or return basis, what you said is 100% right. When you have further sold it, you are accepting the 5 products. So ownership is transferred, done. When I am saying sale by description, I am saying you are not meeting the word basmati. It is not as per the price. Then I will return all the unused quantity. That time it will be 95 plus 4 also. This will come under sale by the description part. Hello? One is used, no. Compensation you can claim. Where will you return it? They are asking returning is possible.
Condition is treated.
You can claim compensation. That is possible. That is 100% possible. But when you have consumed, how will you return? Examiner is telling, they are not telling 4 bags are there. Where will I return 5 bags? Getting the point? Yes. But yes, I mean, if you do not want to complicate, just go on sale or return basis. Then it will be 5 bags. But I'm saying that is also possible. Getting the point? Yes. So that's your paper. Dana. Hello. We'll see one more, we'll end it.
Sir, could you show the other papers? MTP is answered, just like scroll also, so that we can pause and read the answers.
You guys have the MTPs, no? Online iruttalla. ಹಿಂಗ್ ಮಾಡ್ತಾ ಇರ್ಬೇಕಾ? ಎಷ್ಟು ಸೋಂಬೇರಿನೋ ಇವನು. ಇದು ಅದ್ರ ಬದಲು ತಗೊಳ್ಳೋ ಕಳಿಸ್ತೀನಿ. ಯಾವ್ದೋ ನಿಂದು okay. You guys have taken up this RTP, huh? You have done it? Not an RTP? Seriously, Tilda? If you guys have already done RTP, then again I'll not do. Anyways, I'll have to record RTP again.
Sir, make it for our
No, not it, no? It has come, is it? Oh, then I'll just check once. But it is not available. It was available for download? It is available, is it? You need to check now. Okay, I'll check and I'll record it if possible. Okay, we'll quickly finish it off. Explain the types of law in Indian legal system considering the Indian regulatory framework. Direct question. Criminal, common law, civil law, principle of natural justice, and that part. Done. Sri Shivai Temple Trust decided to get renovation. Same. Kedarnath versus Gauri Mohammed. I mean, we should not be so judgmental. Huh? We don't know what the question is also. Same people. A person agreed to donate money, but he did not donate money. But the company, the trust has taken up a liability. Will he be liable? Yes. Question is, the answer is still same only. Exceptions to quid pro quo, charity. Case law, Kedarnath versus Gauri Mohammed. Sahil deals in pre-owned cars. Raju sold his accidental car to Sahil by fraud. Sahil could not find that the car was accidental. Akshay, a customer, visited the workshop of Sahil with intention to purchase a pre-owned car. Akshay informed Sahil his intention with the condition that car should be free from any accident. Sahil sold that car to Akshay on the erroneously believing that car did not face any accident. Afterwards, Akshay found that car was actually an accidental case. He sued Sahil to avoid contract and also for damages for expenses suffered on car. Taking into account the provisions of Indian Contract Act, state whether Akshay was eligible to avoid contract and to claim damages from Sahil. Remember people, there are three people, Sahil, okay, Raju, Sahil and Akshay. What Raju did to Sahil is fraud. What Sahil did to Akshay is misrepresentation. Fraud, you can cancel the contract, you can also claim compensation. Misrepresentation, you can cancel the contract, but you cannot claim damages. So what will be the compensation in this case? Can you cancel the contract? Yes. Can you claim damages? No. Why? The person did not do it intentionally. Fraud? Yes. Damages? No. Clear? Hello? Rahul is manufacturer of jute bags. He contracted with Sonia to supply raw jute for the purpose of making bags. Rahul informed Sonia that production process of jute bags would start from 27/6/2024, but Sonia must supply raw jute till 25 June 2024 so that the quality verifications can be done in the next 2 days. Sonia supplied the jute on 27 June 2024 and informed Rahul that she couldn't supply on 25 June 2024 due to some unavoidable reasons, and she also assured that quality measures were not anyway compromised in supplies. But Rahul wanted to avoid contract as he was not given an opportunity to examine the goods. in light of the provisions of Indian Contract Act, state whether Rahul can avoid the contract.
Yes, sir. Buyers
Grounds?
write a buyer to exam.
Always remember, whenever you were not physically present, when you are buying the goods, when you are receiving the goods, simple, you put yourself in Amazon or Flipkart delivery. Now, can they say that no, I will not take back the goods? We will give you 100% quality material. Buyer right to examine the goods will always be there. Now, can I examine the goods? The answer is yes. Now, can I reject the goods because you did not allow me to? Answer is yes. I have a right to examine the goods. Clear? Okay, done. Next one. Measures Janta Machine Tools and Company contracted with Measures Ruchi Traders to make and deliver certain machinery by 31st July for 15 lakhs. There was a labor strike in the factory of Measure Janta Machine Tools and Company, and it could not manufacture and deliver the machinery to Measures Ruchi Traders. Afterwards, Measures Ruchi Traders had to purchase the machinery from another manufacturer for 18 lakhs, 3 lakhs loss. Measures Ruchi Traders was also prevented from performing a contract which was made with Measures Shiksha Technologies at the time of its contract with Measures Janta Machine Tools and Co. Were compelled to pay compensation of 2 lakhs to Measures Shiksha Technologies. Measures Janta Machine Tools and Co. was very well informed by Measures Ruchi Traders about its contract with Measures Shiksha Technologies. Measures Ruchi Traders sued Measures Janta Machine Tools and Co. for recovery of compensation of 3 lakhs plus 2 lakhs given to Measures Shiksha Technologies. Advised under the provisions of Indian Contract Act 1872. What is the first? Tell me what is the provision? Breach of contract. Under that, remedies. Under that, damages. Under that, specific ordinary or both are there. Ordinary is also there. Special is also there. I hope you guys are understanding. If I am not wrong, there are 2 damages that they were supposed to pay. One that is informed. One
The actual
They suffered.
whatever is suffered. Ordinary, whatever they suffered, can they recover? Answer is yes. Special, can they recover? Answer is yes. Because it was clearly communicated. Here somewhere they have written no. Very well. Informed. So my provision will be, one is general damages. General damages, ordinarily whatever I suffer. If at all I had purchased from you, it was 15. Now I had to purchase from you for 18. So 3 lakh compensation can I recover from you? Answer is yes. Next one, Siksha had very well told you, if you do not deliver the product on time, I have to deliver this particular quantity to them. Now they filed the case. Now will you be liable? Answer is yes. So how much can I recover? I can recover both. 5 lakhs. Ordinary 3, special 2. If you write this much, hug. Prefixed is between us, right? No, I'm telling, if you give it to me, I will have to give it to them. Prefixed is between us. Here there is another party involved. Now in between us it's a prefix, not between two of us. Distinguish between void and voidable. Direct. Ankit has taken a loan of 1 lakh from Kishore on the guarantee of Sudeep at the interest rate of 12% per annum. After some time, due to financial crisis of Ankit and at his request, Kishore reduced the rate of interest to 8% and also extended the time for repayment of loan without the consent of Sudeep. Ankit becomes insolvent. Whether Kishore sue Sudeep, can Kishore sue Sudeep recovery of the amount under the provisions of Indian Contract Act 1872? Grounds? Any variation to the terms of the agreement without the consent of the surety discharges the surety. I'm only telling you the provisions. Hello? Okay. Explain in brief with reference to the provisions of Indian Contract Act 1872 what are the rights enjoyed by surety against creditor. Same thing da. We just saw. Ram Bilas Yadav is a farmer. Anna Chips Company. Anna na Anna na to. Okay, Anna Chips Company approached him and entered in a contract to supply 100 quintals of potatoes which to be grown in the field belonging to Ram Bilas Yadav at 1000 rupees per quintal. Anna Chips Company made the payment of price but delivery to be made after 6 months. Before the time of delivery, the whole crop of potatoes was destroyed due to flood. Anna Chips Company demanded the payment of price which it already made by it. Rama Bilas Yadav denied returning the price by saying the contract of sale was already entered and hence crop belongs to Anna Chips Company. Hence, loss of crop must be borne by it. Referring to the provision of Sale of Goods Act, whether Anna Chips Company can recover amount from Ram Bilas Yadav.
Yes, sir.
Can they recover?
Why can't it whatever
No.
amount you paid, he gets back?
Yeah.
But they're saying money is already paid, ownership is transferred. No, there is nothing like that. Money is already paid.
So equivalent to the same.
Super meaning and responsibility.
Money is already paid. It has nothing to do with ownership. I've already paid everything. So is the ownership with me or is it still with you? I'm just asking. Very good. That's what we saw. Price and delivery is irrelevant. It's a future goods. In a future goods, when will the ownership pass? Future goods should become first specific existing goods and then it has to be unconditionally appropriated. Until then, the ownership will not pass. And this becomes supervening impossibility. It is a void contract. Will I get back my money? Answer is yes. Clear? Ownership does not pass just because you pay the price. Today also I stressed on that point. Payment of price, delivery of goods is irrelevant to decide whether ownership is passed or not. Clear? Supervening impossibility, void contract. I'll get back my money. Kapil entered in a contract with Rahul to purchase 1000 liters of mustard oil at the price which should be fixed by Akhilesh. Rahul already delivered 600 liters out of 1000 liters to Kapil, but when remaining 400 liters was ready to deliver, Akhilesh denied fixing the price of mustard oil. Rahul asked Kapil to return the oil already delivered and avoid the delivery of 400 liters. Kapil sued Rahul for non-delivery of remaining 400 liters of mustard oil. Advised in the light of Sale of Goods Act 1930. We just now saw also that Sony and what is that, Priya. What is the provision? Ascertainment of price. Whenever ownership is passed, in such case, if a third party valuer is not ascertaining the price, you need to pay a reasonable price. For that, you cannot cancel the contract for whatever is not passed. Correct? Saurav purchased electric scooter of Vivek for 5,000 only on the gunpoint. Vivek decided to file the complaint and to avoid the contract on the basis of coercion applied against him by Saurabh. But before he could do that, Saurabh sold the scooter to Vinay, who had no idea about the situation on which scooter was purchased by Saurabh. Vivek sued Saurabh and Vinay for recovery of scooter, referring to the provisions of Sale of Goods Act, whether Vivek was correct in his decision. Today only we saw.
Vivek will get good. Vinay will get good price. Yes. Because he is in good faith.
Good faith. You remember, what is this? Sale by a non-owner. Exceptions to Nemodat Quadnan Abet. A person in possession under voidable contract. Today only we saw this example also, Noda. I think his bike. That was the example, no? Explain the legal rules of auction sale relating to following points. Bid by seller with or without notification. Valid or invalid? Seller can bid with notification. Without you cannot. Bidder to retract from his bid. You cannot retract. What do you mean by that? Retract means I have participated in bid. Can I withdraw my bid? No. Effect of pretended bidding. What is pretended bidding? Today only we saw. Rishabh Pant example also we saw. Can you do it? Answer is no. Explain the provisions relating to the delivery of wrong quantity of goods as per the provisions of Sale of Goods Act. Wrong quantity. If you have delivered excess, I can return the excess, I can keep entire thing or pay for accordingly. If at all you have delivered less, return complete, I keep the entire thing, pay accordingly. Correct? Indian Partnership Act 1932. Amit and Ajay started the business of wholesale trading of sugar. For this purpose, they contributed 3 lakh and 1 lakh respectively. Partnership deed was perfectly prepared, but clause regarding share of profit was not mentioned in the deed. So if it is not mentioned, that's all now. Okay, see, due to heavy rain, stock of sugar was spoiled and firm incurred the loss of 60,000. Amit asked Ajay to contribute equally to the loss, but Ajay agreed to contribute only 25% to the loss. That is in the ratio of capital. Is this correct? Remember, the P&L will always be as per the agreement as mentioned in the deed. If it is not mentioned, you need to do it equally. So whatever his contention is not right, how much to be contributed by Ajay? It should be 50-50 equally. 30,000 only you need to contribute. What is the difference between partnership and this question you guys can expect in the exam? And co-ownership, we saw today only. Ownership. State provision giving reasons whether the following are partnerships as per provision under Indian Partnership Act. X, Y, and Z agree to divide the profits equally, but the loss, if any, is to be borne by X alone. Is it possible? Yes, possible. Profit, full profit by one, not possible. Full loss by one partner, possible. X, a publisher, agrees to publish a book at his own expense, written by Y, and to pay Y half of the net profit. Does this create a relationship of partnership between X and Y? No. Then X, a publisher, agrees to publish a book at his own expense, written by Y, and to pay Y half of the net profit. Does this create a relationship of partnership between X and Y? Why? It is nothing but people royalty payment. This cannot be considered as share of profits. Why? Business is not there. You are just writing and you are going away. Are you participating in the business? Is business present? Answer is no. Then I am giving you money. Can it be considered as share of profit? No. It is called as royalty. Hello? And they have clearly given at his own expense. Anything happens, it's his loss, no? Yes or no? A and B purchase a tea shop and incur additional expenses for purchasing utensils, etc., each contributing half of the total expense. The shop is leased out on a daily rent which is divided between both. Does this arrangement constitute a partnership between A and B?
Yes.
Yes, sir?
Yes. Yes, sir, because they're doing it for business.
Purchase a tea shop and incur additional expenses for purchasing utensil, each contributing half of the shop is leased out on daily rent. Meaning what, people? Partnership or co-ownership? Part co-ownership. See, one thing, people, what are you doing? A and B purchase a tea shop and incur additional expense for purchasing utensils, etc., each contributing half of the total expense. The shop is leased out on a daily rent which is divided between both. Does this arrangement constitute a partnership between A and B? Co-ownership? Co-ownership? Generally, whenever there is a rent that is derived, we generally call it as a co-ownership itself, because there is no day-to-day profit that is done. If at all the utensils are done, everything is done, if they do a business there, then you can consider it as a partnership. Here, what is a business then? Yes. Now the question is that, is the tea shop a business of theirs or they are renting it out to someone and they are conducting the business. And they are doing the business. And what are you doing? You're just charging rent for the property. Co-ownership. Explain about the registration procedure of partnership. You file application, register of firms. Referring to the provision of LLP Act, answer the following. Under what circumstances LLP is compulsorily required to change its name? Also explain the compliance requirement following the change of name of consequence. When is the LLP is mandatory to change its name? Whenever its name is similar to any of the existing company, LLP or a registered trademark. Example, sir, there is a company called as, there is a LLP called as, let us imagine ABC and Co. There is one more, ABC LLP. You are also now getting registered as ABC LLP. You are also getting registered as ABC LLP. There is already one. Now, what will happen to this? Now, this existing LLP is there, no? They need to write it to the central government. Technically, the power is now outsourced to RD. But imagine it is written to central government. Now, central government people will, if at all it is satisfied, yes, these two names are same, they will send an order to the second formed company. Your name is similar to the existing company. I hereby tell you to change your name of the company to something else. Now, this company needs to follow the order within 3 months. Hello? Yes, now, within 3 months, if this company does not change the name, then this central government only will allot some new name to it. Getting the point? Sir, now this old company is there, no? Within how many times should they go and complain? Within what days they should go and complain to central government? They need to go and complain within 3 years. 3 years of what? 3 years of this duplicate company, duplicate LLP getting registered. Getting the point? So this is the total compliance requirement. Now whatever is the new name you chose, it has to be intimated to the registrar. Sir, going forward my new name is DEF. This is a complete procedure. Any doubt? Companies Act, Ratanmul Milk India Limited is a public company and formed 1st January 2020. On this date, Mr. Sharman was appointed as legal advisor of the company. It was mentioned in the articles of the company that Mr. Sharman will not be removed from the post of legal advisor till 31st March 2027. On 1st July 24, a special resolution was passed for the alteration in articles and Mr. Sharman was removed from the company. Mr. Sharman filed a suit against Ratanmul Milk India Limited for removal as a legal advisor. Referring the provision of Companies Act, whether can company remove Mr. Sharman? Yes. Can they remove? Yes. Can they remove? Yes. In the articles, they have clearly written that they will not remove its IMS. Now they have removed its IMS. Can they remove? Yes. Possible? See, 2 points I'll tell you. 2 grounds. First one, you have said that you will not remove until 2027. But they said they are altering their articles of association. Once a change is made, now can we remove you? The answer is yes. The second one, remember, articles of association will never bind outsiders to the company. It's an internal document. It's not an appointment letter given to you. Whatever we have written in AOA, it is for the company's purpose. It does not create any contract with the outsider. Clear? Yes. On both the grounds you can remove. I'll tell you one more point. Not there for your level. Even if alteration is not made, still you can remove. That's what I'm saying. You are appointing someone. AOA is an internal document of the company. Meaning it is for the company's rules and regulation. Now you have appointed a lawyer. Through you would have said, you please come and be our lawyer. Your monthly remuneration will be this. Everything will be agreed. In our AOA, we have written that we will not be removing you. In our AOA, we have written. Remember, AOA does not create any relationship between company and outsiders. It's an internal document. So whatever we have written internal document, outsiders will never get any right over it. So because it is AOA, it does not create any obligation for us to continue the contract with you for the next 4 years. Because it's not an agreement we have entered with you. It's an internal document for us. Have you signed AOA? How, why will an outsider sign an AOA? Then where are we binding a contract with you? Getting the point? So in your level, this is fine. It's you can alter. So can you do it? Yes. And AOA is always an internal document. Can we remove? Answer is yes. Clear? Hello? Okay. Explain the kinds of share capital.
Area, normal.
Equity, preference. In equity, it is
Normal with normal voting rights and differential.
differential voting rights. XYZ Limited was incorporated to hold the patent for new product. The company is expecting to start its commercial product.
Same question.
Dormant company, same thing. It is formed, same. Nothing has changed. Priyansh purchased some goods from Sumit. He issued a check to Sumit for the sale price of 14 June 2023. Sumit presented the check in his bank and his bank informed him on 19 June 2023 that the check was returned unpaid due to insufficiency of funds. In account of Priyansh, Sumit sued against Priyansh under section 138. State with reasons whether this suit is maintainable. Yes? Dishonor of check? Can I file?
Yes.
Answer is yes. It's a legally enforceable thing only, no? Purchased. It's a legally enforceable debt. Can we? Yes. A promissory note payable at a certain period after sight must be presented to the maker thereof for payment. Under which circumstances? Today only we saw not present in the place, or what is that? You told me to come to some other place, or you agreed to make the payment without presentment. You made a part presentment. Yes, we saw that scenarios from the book. The same thing. Clear? Direct question? Hello? Okay. This is your RTP 2025. Yes? May we have. This is May only, not Jan. May. This is applicable for you only. Yes? I'll see if possible sometime I'll take MTP and I'll record it and I'll upload it to you also. Yes? And okay, that's it. If possible, I'll tell them to, when they're uploading this video on YouTube, I'll tell them to give a link to download that important sections I told you also. So you guys can download that as well. Clear? So it will have a list of important sections that you guys can remember and go. At least the important section numbers from every chapter. Clear? So that's it. I hope you guys were able to remember something, and do not feel panic and all. Whatever you guys can write it with confidence and come. Just that complete your answer properly.
Writing the answer, if you write the wrong section, the answer is not considered. In the same way, if you write the wrong case law, is the answer considered?
The answer will still be given some weightage. Yes, I mean, we will not say that the answer itself will be treated as invalid. You're okay to write, that's absolutely fine. But do not write a wrong section. That's 100%. Yes. So never write a wrong section. So, so do keep these things in mind. Whatever we discuss in the class, keep those things in mind. With regards to writing your answers, try to complete as many answers as possible. You have to aim at scoring. Writing at least 90-95 marks. So never score less than that. Never go until less than that, so that it will be a confident attempt. Underline properly and keep all the things that we discussed in the class in mind. Clear? Yes? Sure. Then thank you so much. We'll again meet next time when see Inter. See Inter only, oh? Not here again, no? Okay, good. All the very best. See you all. Wish you the best of luck. Yes, da. Bye bye. See you.